Lordship, we may.
Lord, yesterday's matter, my lord.
Sorry.
Lordship may, but with liberty, my lord, to discharge. Yesterday's matter, seal number 33 in the second
Listed
list.
today?
It is listed today.
All right.
Identical what other seal.
All right.
Your Lordship,
With
Give all the
liberty to
memos.
seek for discharge, my lord.
Give all the fresh memos ಎಲ್ಲ ಕೊಡಿ.
Your Lordship, this is.
Wait.
That this has not appeared.
ಒಂದು ನಿಮಿಷ.
Sorry, madam.
My lord, any rate?
Wait. ಒಂದು ನಿಮಿಷ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ?
ಇಲ್ಲ sir.
ಪೆಂಡಿಂಗ್ ಬರೋಲ್ಲ. ಇಂಟರ್ ಮಾಡ್ರಿ ಇಲ್ವಾ?
ಇಲ್ಲ sir. Crime ಇದೆ.
ಒಂದು ನಿಮಿಷ.
My lord, we have
ನಾನು
invested.
ಮೆನ್ಷನಿಂಗ್ ಇದ್ರೆ ವೇಟ್ ಮೇಡಮ್. ಸೆಟಲ್ಮೆಂಟ್ ಮೆಮೋಸ್ ಯಾವ್ದಾರು ಇದ್ರೆ ಕೊಡಿ. All settlement memos and write on the memo when do you want it. All withdrawal memos kudi, if there is any withdrawal memo. ಇಲ್ಲ ಇವತ್ತಿರೋದು ವಿಡ್ರಾ ಮಾಡ್ತಿದ್ದೀರಾ? Withdrawal of those in the list or you want them to will? Now. We'll send it to the coordinate bench only. Good. Which one, madam? Oh, correct. You want me to send it there? That I can't get here. Because of seniority, it will go there, we'll tag it to that. Tag madangare ಮಾಡ್ತೀನಿ ಕೊಡಿ. All right, yes. That's all right, sir. ಏನ್ ಫ್ರೆಶ್ ಅಪ್ ಪೆಂಡಿಂಗ್ ಹೇಳಿ. ಫ್ರೆಶ್ ಅಪ್ ಪೆಂಡಿಂಗ್. File an application. Yes. Next, file an application for that whatever you need, passport. Yes. Oh, so what? Son's marriage go case pending ಇರಕ್ಕೆ ಏನ್ ಸಂಬಂಧ? You have taken money in performing marriage, ಇಲ್ವಲ್ಲ? ಮತ್ತೆ wait, Tuesday ಕೊಡಿ. ಅದೇ Tuesday ಕೊಡಿ. No sir, Tuesday. Yes. Fresh matter Tuesday ಬರುತ್ತೆ ಕೊಡಿ. That law, it had come before me once. Give it. If it has not come before me, it will come on Tuesday. If it has come, it won't come. We'll see. Give it. Yes. Give the memo. Give all the memos. Fresh matter, whatever it is. Give it. Give all the fresh memos.
Yes.
File an application for passport and then move the matter. Pending matter alva. Fresh passport gene application haki, one IA haki, we will pass orders. Don't get the pending matters by this method. Yes. ನಿಮ್ಮ ಹತ್ರನೇ ಇರ್ತೀನಿ ನಾನು, ಈ ಕಡೆ ಬರೋಕೆ ಆಗಲ್ಲ. ವೇಟ್. ಎಸ್, ವೇಟ್. ಇಬ್ಬಿಬ್ರು ಹೇಳಿದ್ರೆ ನಿಲ್ಸೇ ಬಿಡ್ತೀನ ಎಲ್ಲ. ದಿನ ಹೇಳ್ಬೇಕಾಯ್ತನಾ? ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ ತಾನೆ. ಎಲ್ಲ ಫಾಲ್ಸ್ FIR, ಫ್ರೆಶ್ ಅಪ್ ಪೆಂಡಿಂಗ್ ಹೇಳಿ ಸರ್. ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ಎಸ್. FR ಆಗಿದ್ರೆ ಬರೋಲ್ಲ, ಸೀನಿಯಾರಿಟಿ ಮೇಲೆ ಬರುತ್ತೆ. ಗೋ ಅಂಡ್ ಕಂಪ್ಲೈ. ಎಸ್. ಸೊ ವಾಟ್? ಟ್ಯೂಸ್ಡೇ give it. ಏನ್ ಹೇಳಿ ಈಗ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕಂಪ್ಲೈಂಟ್. So what? ಕೊಡಿ. ಎಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಟ್ಯೂಸ್ಡೇ 6 months ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಎಸ್. Give it. Take that tomorrow. Yes. Why 2:30? ಅದಕ್ಕೆ 2:30ಗೆ ಹಾಕ್ಬೇಕು. No problem. Let him come. Tomorrow, give it. Yes. 2:30 I can't take, sir. Tomorrow. Yes. How many of you speak at a time? Should I tell every now and then? Yes. Give it, sir. It will come on Tuesday on that on maintainability only. Yes. Pressure pending, madam. Give it, yes. Tuesday. ನಿಮ್ದ್ರಲ್ಲಿ ಯಾವ್ದು ಅರ್ಜೆನ್ಸಿ ಇರಲ್ಲ, ಕೊನೆಗೆ ಕೇಳ್ತೀನಿ, wait. Yes. Why connected matter? I think give it tomorrow. Yes.
It's a pending matter. It's a pending matter, Lord.
Entry model ilva?
Yes, my lord.
Entry model ilva?
Entry model is there, my lord.
Idea?
We are settled the amount.
January 2025. Yes,
My
next.
lord, breach of
No.
agreement, my lord, we are settled.
Entry model ಇದೆಯಾ?
Entry model
Settle ಆಗಿದ್ರೆ settlement, settle ಆಗಿದ್ರೆ
coming forward.
I am not going. No, madam. Yes.
My lord, it's both fresh matters. Under the Land Grabbing Act, my lord, proceedings are initiated
Tuesday, sir,
against.
give it.
My lord, the matters on Tuesday,
So what?
for their presence, my lord.
Because of land grabbing court, I should take it.
Allah,
I
Allah.
should regulate my procedure.
Allah, my lord.
Then?
What's happened is that the petitioners, my lord, the complaint has been filed by some Tehsildar who is not even
Maybe
concerned.
on Tuesday, yes.
Is it possible tomorrow, my
No,
lord,
sir.
please?
Yes.
Yes, madam, my lord. I have moved memo.
Tuesday, yes, give it. Fresh matters, please give it for Tuesday. I'm not going to take anything tomorrow. Give it. Fresh matter. Waiting. ಏನ್ ಯಾಕೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ? ಇಲ್ಲೇ ಬರುತ್ತೆ ಕೊಡಿ Tuesday.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಗೊತ್ತರ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು.
ಹಾ?
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಬರ್ಲಿ ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ.
ಆಯ್ತು ಕೊಡಿ.
My lord,
Tuesday.
pending.
This is a press matter, my lordship. There is a matrimonial.com.
Tuesday.
Matter is there, my lord. Press
Tuesday.
matter.
Tuesday.
Please, eight times I filed the memo, my lord.
Even if you file 10 times, it is only on Tuesday. Give it.
Use one of the handicap, my lord.
Tuesday. Yes.
Please, my lord.
My lord,
It's
a pending
matter.
Pending matter, give the memos.
Based on 3 now application, accused is in JC, 16.5.
Accused is in JC, why?
Works of it.
311 application JC go 311 application allow ಮಾಡಿದ್ರೆ JC ಇಂದ ಆಚೆ ಬರ್ತಾರಾ?
ಇಲ್ಲ, ಅದು
ಮತ್ತೆ?
16/5/2020.
Why do you project all that?
16/5/2021 stay has been granted, list after.
ತಗೊಳ್ಳಿ madam. List that on Wednesday.
my lord,
My lord,
crime
please
is pending, my lord, and 22 stay was granted, and after
You are for
that,
the respondent.
and we have invested 1.17
You are for
crore.
the respondent.
Yes, my lord.
ತಗೊಳ್ಳಿ madam ಹಾಕಿ.
My lord,
Tuesday.
5/6/21 ಇನ್ಸಿಡೆಂಟ್ ಡೇಟ್ ಇದರಲ್ಲಿ ಸರಿಯಾಗಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತಿಲ್ಲ, ಡೆತ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಕೈಂಡ್ಲಿ ಮೇ ಬಿ
Pending
ಡೇಟ್ ಮೇ ಬಿ
matter.
ಗಿವನ್.
Fresh matter.
ಇಲ್ಲ ಪೆಂಡಿಂಗ್ ಇಸ್.
Ending ಯಾವುದು ಬರಲ್ಲ madam.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್
ಕೊಡ್ಲೇಬೇಡಿ. ಹಾ? If it has come before me once, it will not come.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಟು
For me once and I am not granted interim order, it will come for admission, but not next week. Yes. If I continue, I'll take it. Yes.
Kindly.
I'm not there. Yes.
Special court matter. Sir, these accused order appeals have been quashed, madam.
19th, sir, give it.
Lord, fresh matter, my lord.
19th. Yes.
Kindly.
Birth ಕೊಡಿ ಯಾವತ್ ಬೇಕು ಅಂತ.
Kindly, your lordship, this pending matter, your lordship. This is the interim consideration
Wait,
of
madam.
interim prayer.
Will you wait? Yes.
Pending 23 matter, interim order was granted subsequently in the next date.
June 2025, give it. Yes.
Not extended, please, my lord.
ಸರಿ ಅದು
Stating that.
ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ನಾಳೆಗೆ ಹಾಕಿ.
But fresh matter,
Being
my lord.
spoken to ಹಾಕಿ.
Fresh matter, my lord, offense under section 3.
Tuesday, give it, sir.
Kindly, your lordship.
There is some
Pending matter.
inconvenience for Tuesday.
ಏನು?
Personal inconvenience.
Personal inconvenience.
Wednesday.
So I have to adjust my court according to your convenience.
As-
ಅದು
check.
list after vacation. Yes, next.
Check up.
Pending.
After vacation, sir. Yes.
Pending.
Don't take that memo. Yes.
It's a disposed of matter, my lords.
Ah.
My lords, I filed an application, my lords, seeking for a small modification of the order. The order would not change its,
ತಗೊಳ್ಳಿ
with
ಕೊಡಿ.
regard to interpretation of section 49, my lords.
Pending matter, my lord, interim consideration of interim prayer. your
Next
lordship.
Thursday.
ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
Stay ಕೊಟ್ಟಿಲ್ಲ sir.
ಕೊಟ್ಟಿಲ್ವಾ? ನನ್ ಮುಂದೆ ಬಂದಿತ್ತ?
ಮುಂದೆ ಬಂದಿತ್ತು, ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಕನ್ಸಿಡರೇಷನ್
Husband.
interim prayer ಅಂತ.
Husband.
ಅಲ್ಲಲ್ಲ sir, ಇದು ಬಂದು ಗಲಾಟೆ
ತಗೊಳ್ಳಿ,
323 ಸ್ವಾಮಿ.
Give it, give it.
Next Thursday.
Kindly
because it's an
Tuesday,
interim
madam.
matter.
Kindly Tuesday.
No, Tuesday, give the memo.
Consideration of
No,
interim prayer,
madam.
your lordship.
No, yes.
Because my lord, that is only 323 offensive.
If I have granted for a few and not granted for someone else, it is
That is
definitely
because
non-grantable till the respondent appears. Yes.
CST, my lord, that is there. Already they
Oh,
have
no
filed the
problem.
wakalat, your
No
lordship.
problem.
Your
Yes.
lordship.
Yes.
Sorry,
Next
Mr.
week.
Okay. You have told, right?
I just
You want to finish the argument now only?
NPMLA matter, my lords, Thursday. There's no urgency for Tuesday or Wednesday, Thursday and
Next Thursday ನೇ ಬರೋದು. ನೀವು ಬೇಡ ಅಂದ್ರೂ ಅವತ್ತೇ ಬೇಕು ಅಂದ್ರೂ ಅವತ್ತೇ ಬರೋದು.
As for the respondent, in this matter, the trial court 138 proceedings is pending from 2019. The state has filed the petition in
Tuesday ಕೊಡಿ, yes.
2021.
ಅಲ್ಲ, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
Matter 2021 ಒಂದು petition file ಮಾಡ್ತಾರೆ, ಅದರಲ್ಲಿ entry ಮಾಡಿದ್ರೆ ಆಗೋದಿಲ್ಲ. Again, subsequently 2023 ನಲ್ಲಿ
Madam, ಅದನ್ನ post it on Wednesday in fresh matters list. Yes. Give all the pending memos, sir. Give all the fresh matter ಕೊಡಿ ಅಲ್ಲ. Huh? Maybe, give it, yes.
My lord, criminal petition 255 or 25
ಏನದು?
for withdrawal man.
ಇದೆಯಾ, ಲಿಸ್ಟ್ ಆಗಿದೆ ಇವತ್ತು?
ಇಲ್ಲ
ಮೆಮೊ ಎಲ್ಲಿದೆ?
ಕೊಟ್ಟಿದ್ದೀನಿ sir.
ಬಿಡಿ,
Fresh matter.
yes. No, I am not taking, madam.
But passport authorities are not giving.
You file an application that passport authorities are not giving. Then I will consider that application.
My lords, I may be permitted to make a submission, my lords. List 2, my lords, serial number 55.
Adjournment,
Not, my lords, I'm requesting to be taken up tomorrow in fresh matters. my
tomorrow,
lords.
why?
I'm an
It
ED
won't reach
officer.
today, is it?
My
Wait,
lords.
madam. We'll see when it is called.
30 lordship.
10 FIRs have been registered.
1 minute, yes, sir. Next Thursday, sir. Next Thursday, alla. Yes.
Under ITP, lordship, 10 FIRs have been registered.
10 FIRs.
Same for the batch.
ಕೊಡಿ, tomorrow ತಗೊಳ್ಳಿ.
It's proportionate asset.
Next week ಕೊಡಿ, sir.
Specific date was given as 10/9. May I request tomorrow?
Another specific date is 29. Give it, yes.
It's a fresh matter, my lord. Kindly post it for tomorrow.
No, Tuesday, yes.
Tuesday.
Yes, Tahir.
Petitioner is seeking a release of interim release for his father, under trial father, lordship.
Interim bail,
Interim bail, lordship. 230 I have
ಯಾಕೆ
claimed, maybe
GML
it's
move
not
ಮಾಡಿ?
fixed. But it is under trial, lordship. Is the
Under trial,
matter is
not parole ಅಲ್ಲ, correct, right.
So maybe on Tuesday also.
I'll take it on Tuesday. You serve the copy on
NI is the respondent, lordship. I'll serve the copy.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ರಿ ಮುಂಚೆನೆ. Tuesday ತಗೊಳ್ಳಿ.
Learned
ಈಗ ಹೇಳಿ.
magistrate have taken cognizance.
Mike.
Learned magistrate have taken the cognizance, my lords. The check is presented beyond the limitation, my lords. Hence, my lords, the
Tuesday, yes.
tomorrow, my lords.
Why, sir? Tuesday, sir.
My lord, the matter was listed under admission yesterday, my lord.
FR number, Avinash. FR.
My lord, the matter was listed under admission yesterday, my lord. It was split up charge sheet ಆಗಿತ್ತು. Your lordship, when I sought for an interim order, ಒಂದೇ ಸತಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದ್ರು. ಬಟ್ interim order ಯಾವ್ದು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಅಡ್ಜಾನ್ ಆಗಿದೆಯಾ?
Adjourn.
Split up,
split up.
Wednesday ಹಾಕೋಣ. ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್.
One matter for tomorrow, my lords.
Why, sir?
My lords, my application under 311, proceedings under
Tuesday,
138
yes.
is rejected.
Tuesday, yes.
Tuesday.
My lord, a date given matter for 11th, my lord. It was not listed, my lord. It was a date given matter by
That's all right, don't worry.
My lord, this is
Interim order ಇಲ್ವಾ?
ಇಲ್ಲ, ಇದು ಟ್ರಾನ್ಸ್ಫರ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದ ಅಕ್ಯೂಸ್ಡ್ ಫ್ರಮ್ ಬೆಳಗಾವಿ ಟು ಬ್ಯಾಂಗ್ಳೂರ್ ರಿಪ್ಯಾಟ್ರಿಯೇಟ್ ಮಾಡ್ಬೇಕಿತ್ತು ಅಂತ.
ಬೆಳಗಾವಿ ಟು ಬ್ಯಾಂಗ್ಳೂರ್.
ದಿಸ್ ದ ದರ್ಶನ್ ಕೇಸ್.
ಬಳ್ಳಾರಿ ಟು ಬ್ಯಾಂಗ್ಳೂರ್.
ದಿಸ್ ಇಸ್ ಫಾರ್ ಅಕ್ಯೂಸ್ 14. ಬೇರೆ ಅಕ್ಯೂಸ್ಡ್.
ಕೊಡಿ.
11th ಡೇಟ್ ಇತ್ತು.
Wednesday 18th ಹಾಕಿ.
Your lordship,
Ganesh?
respondent 500 IPC though. I am 500 IPC. I am for the respondent. Kindly post it.
ಅದು ಹಾಕಿದ್ದಾರೆ ನಿಮ್ಮ ಮೇಲೆ.
Also.
ಕೊಡಿ.
Tuesday.
ನಿಮ್ ಸ್ವಂತ ಕೇಸ?
So respondent, sir. I am the.
ಆಯ್ತು, ಸರಿ, ಓಕೆ.
Tuesday
ಆಗಲ್ಲ.
Fresh matter, sir.
Thursday. ಫ್ರೆಶ್ ಹೊಸ ಮ್ಯಾಟ್ರಾ?
Also.
ಅದೇನು Tuesday ಬರ್ಲಿ.
Tuesday.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀರಾ?
I am the respondent.
Huh?
I am the
Wednesday.
Manchu.
Petitioners, eight petitioners was remaining 2, my lord. The maintainability has been right. Split up charge.
Next Friday ಹಾಕಿ.
Your lordship, this is a fresh matter, your lordship.
Tuesday.
According to seniority wise, ours is senior, your lordship.
ಆಯ್ತು, Tuesday ಬಂದೇ ಬರುತ್ತೆ ಕೊಡಿ. If you are senior enough, it will definitely come.
Only submission is regarding the address of petitioner.
No more memos, Saku. You can't go finish every court and come to this court. I'll be taking memo up to 11 o'clock and stop. Yes, call the cases.
Fresh matter.
Call the cases.
This one, being for
ನೋಡ್ತಾನೆ ಇದ್ದೀನಿ. Coming and moving, finish every court's case and come here. Yes.
Petitioner accused him. 2 crimes were registered. One is crime number 19 and one is crime. But please to grant the anticipatory bail, add entry anticipatory bail in crime number 38.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಇದರಲ್ಲಿ?
ಇಲ್ಲ, ಒಂದೇ ಒಂದು ಲೈನ್ ಅಲ್ಲಿ co-accused in the same crime ಅಂತ ಇದೆಯಲ್ಲ, anticipatory bail is granted in the other crimes.
ಎಲ್ಲಿ ಅದು ವಿಚ್?
List this matter on 26/9 ಆದ್ಮೇಲೆ the third line.
ಈಗ ನಿಮ್ಗೇನ್ ತೊಂದರೆ ಮಾಡಿಲ್ಲ ಅಲ್ವಾ?
ಇಲ್ಲ, ಸೇಮ್ ಅಂತ ಇದ್ರೆ ನಾನು ಮಿಸ್ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದೆ ಅಂತ ಅವರು ಆಮೇಲೆ that way it's difficult to.
Where do I get that?
List this matter on 26/9. 2024.
Owing to the aforesaid ages ಎಲ್ಲ ಆದ್ಮೇಲೆ
ಅದಾದ್ಮೇಲೆ
granting co-accused
ಸೇಮ್ ಕ್ರೈಮ್ ಅಂತಿದೆಯಲ್ಲ
ಅಲ್ಲ
ಅದರ್ ಕ್ರೈಮ್.
ಇದನ್ನ ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಮಾಡಿರ್ತೀನಿ. ಸೇಮ್ ಬದಲು ಅದ ಇನ್ ಡಿಫರೆಂಟ್ ಕ್ರೈಮ್ ಅದು ಡಿಫರೆಂಟ್ ಅಂತ ಆಗ್ಬೇಕು, ಸರ್ಕಲ್ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್
Lordships had indicated matter.
No, nothing special about Prajwal Revana. We'll have it here only. Nobody will, I request the councils not to utter the name of anybody and not to read anything. I will, tell me to read, I will read it myself.
19th Lordships had.
Because, no, 19, I know. We day in and day out here, POCSO cases. What is special about this?
Very.
Yes.
No, I have, no.
Yes. Allah, it's my indication.
No, I understand.
Also, yes.
Our professor suggested
No,
initially.
that's
not for
Entirely in the discretion of the court.
That is why I only request the senior councils to
No, I understand.
not to utter anybody's name and not to read. If it is explicit, I will myself read.
Very
Tell me that's enough.
Very.
Yes, sir. Start.
19th Lordship said.
Good, but what?
In the 19th Lordship.
19th.
Three matters. In fact, Lordships indicated that 19th.
No, if you want a 19, these are bail matters.
Bail.
If you want to start, you can start.
19th Lordship. All the three. We have been
19, sir?
Agbo.
Yes.
charge sheet copy.
Yesterday we have got.
Yesterday you got it. It's only 4 volumes. Yes, sir.
For the purposes of bail.
Purpose of bail, yes. No, I'm also considering only for the purpose of bail. So, why we'll not hold it in camera, we'll hold it
Please.
here on night. Yes. We'll list it on 19th.
Agbo.
Yes.
This 7th and 9th, serial number 7 and 9.
ಅದು
8 and 9.
8 and 9.
ಇವ್ರದ್ದು ಯಾವ್ದಿದೆ?
8 and 9.
Serial numbers?
8 and 9.
2, 8, 9. All right. 2, 8 and 9. All on 19th. 19th in fresh matters alla ide ನೀವು ಅಲ್ಲೇ. Yes. Yes, Bipin sir.
My lord, offense under section 499.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಇಲ್ಲ, fresh matter. Lord, section 202 has not been complied with, my lord.
Besides outside.
Besides outside, according to the complaint itself.
Hardship one memo for respondent.
ಏನ್ ಕಂಪ್ಲೇಂಟ್ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಒಂದು ಮೆಮೊ ಇದೆ, ಇದನ್ನು ತಾವು ನೋಡಿದ್ಮೇಲೆ
ಕೊಡಿ.
Okay, ಸೀಕೆ sir.
ಅಪ್ಲಿಕೇಶನ್ ಅವರು ಡಿಸ್ಮಿಸಲ್ಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ. ನಾವು ಇಟ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಆರ್ಡರ್ಸ್. ಇಸ್ ಪೆಂಡಿಂಗ್. ಅದು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ತಗೊಂಡ್ಬಿಡಿ. At page number 7, your lordship.
That has got nothing to do with this case. Here, my lord.
ಅಲ್ಲ, ಈಗ ಏನಾಗಿದೆ, ಅಲ್ಲೇ ಹಾಕೊಂಡಿದ್ರು ಒಂದು ಅರ್ಜಿ.
This is not a legal point, my lord, which has.
ಅಲ್ಲ, ಅದು ಹಾಕಿದ ತಕ್ಷಣ my hands are not tied.
Correct, that is there.
My lord, offense under section 499. This court has held that, my lord, section 202 is mandatory. The lordships have held that, my lord, it is mandatory.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಇದೆ.
ಏನು?
It is a special court.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಇದೆ.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. ಈಗ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಒಂದೇ ಇರೋದು.
ಹೌದು.
ನಾನು ಮೊನ್ನೆನೂ ಕೇಳಿದೆ. ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಒಂದೇ ಇರೋದು.
Yes, ma'am.
ಯಾವ ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡಬೇಕು?
My lord, that is a procedure, my lord, under section.
Deciding outside the jurisdiction in the normal circumstance to a learned magistrate is fine.
Correct.
Now, this is the only court in the state.
Yes, ma'am.
What
My lord,
jurisdiction?
Though, my lord, it is only state, my lord, and only court, and by a notification it has been done. My lord, section, my lord, clearly says that has to be complied with. Now, my lord, 202 clearly says after the amendment in 2006 that, my lord, an inquiry is compulsory, whether it is a
what
special.
cases?
My lord, whether it is, my lord, a special court or not.
See Chiminova, 2022 Supreme Court.
Yes, ma'am.
It deals with the same circumstance. Not in all cases 202 would vitiate the inquiry, vitiate the proceedings. Because yes, adralli enayitu, it was a public servant who had registered the crime. Then the jurisdiction magistrate was, that is also a case of a special court.
Yes, ma'am.
Court said nothing.
But I will look into that, my lord, as well.
But idralli onde court irodu.
Yes, my lord.
ಈಗ if I say this court is outside the jurisdiction, andre
Other than that also, my lord.
this is magistrate's court.
Yes.
It is not special.
Allah, this is also, my lord, a special court, my lord, which is a magistrate court. I understood, my lord. What
ಯಾವ್ದು
was.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಫಾರ್ ಇವ್ರು ಅಲ್ವಾ? ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಹೆಂಗಾಗುತ್ತೆ?
Now, my lord, before the magistrate, they have gone and given a complaint. The sitting minister now.
Now, who has taken cognizance?
My lord, the magistrate has taken
That
cognizance.
it will go on that ground.
Special.
If it is not presented before the special
Lord, it
court,
is a special court, my lord. Magistrate is also.
ಅಲ್ಲ
how has it been declared to be a special court?
My lord, that is.
It's the court of session.
Both are.
Both are.
Yes.
Both
special
Triable
Sir,
by
yeah.
magistrate, court shall be magistrate.
Yeah, where is it? Where is the notification?
notification.
Notification.
Notification is there.
Magistrate for what purpose?
There are some offences, my lord, are triable by magistrate.
Then 138 ah?
ಇಲ್ಲ,
ಮತ್ತೆ?
499.
499.
499 and 500. All right.
Because the issue was raised. Right of appeal has been lost if you go to the,
No, right of appeal is a creature of a statute. Statute ಅಲ್ಲಿ ಇದ್ರೆ ಇದೆ, ಇಲ್ಲದ್ರೆ ಇಲ್ಲ.
go to the sessions court, they loses one of the right of the appeal. Therefore, the
199, my
subsequently,
lord.
magistrate court also declared as a special.
Lord, section 199 also, my lord, says they can go, my lord, before the magistrate. The public prosecutor can file a complaint, my lord, before the sessions court.
That is there. Now. that
Now,
is-
which is the magistrate court declared to be a special court? Only one court or what?
Only one.
My lord, let them produce those documents, my lord, whether it is there or not. But now. matter has
ಏನ್
been-
defamation ಹೇಳಿ ಈಗ?
My lord, they say, my lord, my entire allegation is one political party, my lord, is, my lord, taking the money from the state, my lord, and utilizing it for the Lok Sabha elections. My lord, if your lordship may kindly see, my lord, page 15.
One political party, yeah.
My lord, in the state, now, my lord, the complaint has been given by the sitting minister.
Correct.
Now, my lord, we have stated, my lord, in the media, that the political party, my lord, is utilizing the funds from here to a corrupt
It
practice.
is political party or this person?
My lord, there is a certain, my lord, allegation.
Where is the
Lord,
allegation?
page 15, my lord, page 15, that is a private complaint. The popular Kannada daily newspaper by name Kannada Prabha, my lord, Bhrashtacharadalli, so and so. My lord, subsequently, if your lordship may kindly see, Congress Sarkara Bhrashtachara ಮಾಡಿ.
Sir, ಒಬ್ಬರೇ ಲೂಟಿ ಹೊಡೆದಿದ್ದಾರೆ.
ಅದಾದ್ಮೇಲೆ ನೋಡಿ, if your lordship may kindly see, my lord, subsequently.
ಇವ್ರು
Entirely.
ಬ್ರೈನ್ ಮ್ಯಾಪಿಂಗ್ ಮಾಡಬೇಕು.
Yes, my lord, it's the
ಆಗ
question.
ಎಲ್ಲೆಲ್ಲಿ ಎಷ್ಟೆಷ್ಟು ವಾಟ್ ಇಸ್?
My lord, now, my lord,
ಆಟ ಮಾಡಿದರಲ್ಲಿ.
I'll tell you one thing. Of course, it's on a political arena. The individual mudslinging should stop.
yes, my
Fight
lord,
with
I totally.
policies.
My lord,
What
subsequently, if
is
your
all
lordship,
this?
subsequently, if your lordship may kindly see, it says that so and so party is indulging in.
Every party member is speaking everything about an individual person. Speak on policies.
Absolutely, my lord, I totally agree.
ಮಾಟ ಮಂತ್ರ.
Non-stop mudslinging of each other. Washing dirty linen in public.
My lord, what we have stated, my
ಮಾಟ
lord, further is.
ಮಾಟ ಮಂತ್ರ
ಅಲ್ಲ, ಗೊತ್ತಾಯ್ತು, ನೋಡ್ದೆ.
ಆಡಿಸುವ ಚಟವಿದೆ.
ನೋಡ್ದೆ. If this is not defamatory, what else can be defamatory?
But now, my lord, therefore, my lord, first question would be, my lord, whether, my lord, inquiry, my lord, is held, my lord, as per section 202. My lord, on that, my lord, I will, my lord, look into that judgment and also, my lord, because, my lord, I was relying upon the judgment of your
No,
lordships.
202 inquiry is a must.
Must.
If the court is beyond the jurisdiction of the complainant.
Yes, my lord, your lordship, kindly see the
No
complaint.
problem. There are Supreme Court judgments on it, no problem. But this is the only court in this state to deal with these cases. How
Lord,
do you say it is beyond?
when it is a only court also, my lord, my humble submission, on that point, my lord, I will try to convince your lord.
ಮಾಡಿ ತೊಂದರೆ ಇಲ್ಲ. But the contents are explicit.
My lord, on that point, my lord, I will try, my lord, as far as 202 is concerned.
202 you try.
Yes,
Otherwise there is nothing on merit.
yes.
Difficult case on merit. Withdrawal of complaint ಯಾರು ಹಾಕಿರೋದು?
Withdrawal.
Dismissal of complaint.
ಅವ್ರ
Allah, your lordship may kindly see the dates. Every 3 dates, my lord, the 482 petition ಹಾಕಿದ್ವಿ. Before the matter could be taken up, my lord, their matter is being taken up. Every 3 days, 4 days, my lord, if your lordship may kindly see.
ಅದಾಯ್ತು. But look at this. This is not correct.
My lord,
If
my
you are
the major allegation.
No, you tell me, if you are standing on this side and offending such action, how can you defend such action? Tell me.
My lord, now on the point of law, my lord. whether-
Point of law, you tell me,
Point
we
of law.
consider.
That is why, my lord,
These are facts.
my lord, otherwise also, my lord, except for the first sentence.
No. What first sentence? ಬನ್ನಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ ಗಟ್ಲೆ ಇದೆ. ಓದ್ಬೇಕಾ? ಓದಕ್ ಆಗದೆ ಇರೋದೆಲ್ಲ ಇದೆ.
What we have stated, my lord, is against the political party.
Oh,
saying
not,
that, my lord, they are-
if that was the thing, I would have stated it immediately. It is not against the political party.
Yes, my lord, on
You
the
have
legal,
gone on the individual.
on the legal
This is
point.
what I'm saying. Nobody is going on the political party, all against individuals. Be it this party or that party, I'm not saying that, all against individuals. How much of mudslinging will you do?
Yes.
Yes,
My lord, on the legal point, my lord, I will try to, my lord,
legal point you do, yes.
because, my lord, in view of this judgment, my lord, where your lordships have held, since it is a special court, my lord, I will try to, my lord, convince you.
ಅಷ್ಟೇ. 19th ಹಾಕ್ಲಾ?
But till then, my lord, let them not, my lord, ಇಲ್ಲ.
19 ಬೇಡ, ಇದು ಆರ್ಡರ್ಸ್ ಹಾಕೊಂಡು 2 weeks.
ವೈ ಅಹಮದ್ ಸರ್?
ಇಲ್ಲ ಕೇಳಿದ್ದು 2 weeks ಇರೋದು.
ಯಾಕೆ 19 ಬೇಡವಾ?
19 ಅಲ್ಲ, ಆರ್ಡರ್ಸ್ ಆದ್ಮೇಲೆ ಹಾಕೊಂಡು ಅಲ್ಲಿ 199 ಮೇಲೆ
ಅಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಏನು ಆರ್ಡರ್ಸ್ ಬೇಡ.
Yes, my lord.
19th I will myself pass the order here.
20th
ಯಾಕೆ ನೀವು ಇರಲ್ವಾ 19th?
ಒಂದು ಬೇರೆ ಮ್ಯಾಟರ್ಸ್.
ಈ ಮ್ಯಾಟ್ರಿಗೆ ಬನ್ನಿ.
ಅಲ್ಲ,
ಎಸ್, ಐ ಟೇಕ್ ಇಟ್ at 4 o'clock ಬನ್ನಿ, ಎಲ್ಲಾ ಮ್ಯಾಟರ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ.
ಹಾಗೆ
ಎಸ್.
Lord, may I
Kannada.
reply till then?
ಕನ್ನಡದಲ್ಲಿ ಎಲ್ಲ ಇವರಿಗೆ ಸರಿಯಾದ ಹಿಡಿತಾ ಇದ್ರೆ ಈ ಭಾಷೆ ಬರೋದಿಲ್ಲ. ನಮ್ ಕೋಪವನ್ನು ವ್ಯಕ್ತ ಮಾಡೋದನ್ನ ಭಾಷೆ ಬಳಕೆ ಬಂದ್ಬಿಟ್ಟು
ಇರ್ಲಿ, ಪರವಾಗಿಲ್ಲ, ಅದೆಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಬಳಕೆ ಮಾಡೋದು ಬೇಡ. ನಾನೇ ಓದ್ಲಿಲ್ಲ ಅದನ್ನ.
ಕರೆಕ್ಟ್.
ಮತ್ತೆ ನೀವೇನ್ ಹೇಳ್ತಾ ಇರೋದು? We'll do it on 19th, but this is definitely not in good taste and on the face of it defamatory.
My lord, my lord, try to convince on the.
See, now we will see a spate of defamation cases that are filed. Why? They're all mudslinging each other.
Yes, ma'am.
ಬೇರೆ ಕೆಲಸ ಎಲ್ಲ defamation. And it definitely amounts to defamation.
Yes. Lawyers are very happy.
That is true. Lawyers are very happy. Yes, yes.
But the matter is there today, my lord. Let them not pass any orders, my lord, till the next day.
List the matter on 19th. The concerned court shall defer its proceedings till the 19th.
Obliged.
19th ಬರ್ಬೇಕಾ ಮತ್ ಸರ್?
ಬರ್ತೀನಿ.
ಇಲ್ಲ ಅಂದ್ರೆ ಅಲೋ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಅಲ್ಲ, ಬರ್ತೀನಿ. ಮುಂದೆ ಒಂದು ಅವಕಾಶ ಸಿಗದೆ ದೊಡ್ಡ ವಿಷಯ. ಬರ್ತೀನಿ.
ಎಲ್ಲಿಗೆ?
ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ.
ಹಂಗೆ
ಬರ್ತೀನಿ.
My lord, serial number 4, 5 and 6. The matter, my lord, where dharnas have been held. Offense under section 188 and 290.
ಯಾವಾಗ ಇದು? ಪ್ರೀ ಎಲೆಕ್ಷನ್ ಪೋಸ್ಟ್ ಎಲೆಕ್ಷನ್?
Pre-election. My lord, 195 1A, my lord, has not been.
Jagdish will have serious objection to these petitions.
Yes, now he'll have, my lord.
Now he has to have.
I raise that objection in coordinate bench, my lord. Page 59. My objection has been over.
Stay ಇದೆಯಲ್ಲ?
ಇಲ್ಲ, my lord, fresh matter.
Fresh matter. Learned additional SPP is directed to accept notice for the ಇಬ್ರು ಅಲ್ಲ? Both the respondents. List the matter on 26th. There shall be an interim order of stay for the proceedings. Quay these petitioners
Page
till the next
59,
day.
my lord. Page 59, coordinate bench.
Covered? Closer ಮಾಡ್ಬಿಡಂಗ.
195 1A, my lord.
ಬೇರೆ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ.
Madam, all three ಅಲ್ಲ ಬಿಪಿನ್ sir?
Yes, my lord.
I think what the same case.
3, 4, 5. The petitioners are before this court calling in question so on. So the learned counsel Bipin Hegde appearing for the petitioner would submit that the issue in the list stands answered by the judgment rendered by the coordinate bench and that of this bench in page 59. No? The coordinate bench considered has quashed the proceedings quay the other co-accused in the very same crime.
Same accused Allah.
Same accused alva?
Same crime Allah.
Has quashed the proceedings. Quashed the proceedings of identical offences against other accused. The coordinate bench is held as follows. 195 bar ಅಂತ ಅಷ್ಟೇ ತಾನೆ?
Yes, 188 ಇದೆ. 195 bar ಅಲ್ಲ ಇದರಲ್ಲಿ. 188 ಅಲ್ಲಿ in fact the coordinate bench not I argue and say that the 188 ಗೆ coordinate bench takes one step forward and say just mere disobedience is not needed. Something more is required.
Yes, ಇದು ಆಮೇಲೆ ಇದನ್ನ ಕೊಟ್ ಮಾಡಿ ಎರಡನ್ನು ಮಾಡಿ close all the 3. Yes. No, these small cases should not remain at all. Yes.
7, order 7. Petitioner, respondent number 2 is the flying squad.
You serve on Sharad Dodwad. Counsel Shri Sharad Dodwad is directed to accept notice for the second respondent petitioner to serve set of papers upon the aforesaid learned counsel forthwith. 26th interim order continues till then. Next. 8 and 9 adjourn agala. Uday.
99. Serial number 10 filed wakalat this morning, my lords.
This is 499, huh?
Howdu Swami? So, because
every week 10 cases are coming. Defamation.
This is only a case where my lords, pass issued by the complainant to the smoke canisters only made a statement saying that if they are treated as anti-socials, then what will be the person who has issued the
Please, my
pass. It's
lords,
only
I shall
coming to me.
produce this thing per se, all the this thing that the speech that has been made is per se defamatory. I don't want to
All right,
read it
you-
out in the open
You
court.
you file your objections.
Please, my lords, a copy may be directed to the
I'll.
The learned counsel for the petitioner shall serve. The first barcode, learned counsel so and so, you have already filed or what?
I filed my wakalat.
Learned counsel submits that he has entered appearance for the respondent, complainant, registry to print the name of so and so as appearing for the respondent. Yes, we'll take it on 26th.
Please, my lord.
You file your objections by then. What's the next date?
It was yesterday.
It was yesterday, my lord.
Andre ಒಂದು 4 weeks ಹೋಗಿರುತ್ತೆ ಬಿಡಿ.
Please.
Yes, and if there's anything, you move the matter before 26th. Yes, list on
25th.
25/9, hangar 19th.
9th.
List on 19th. By then you file.
Please, my lord.
Oblige.
11.
ಇನ್ಮೇಲೆ ಹಾಕಲ್ಲ.
It's a charge sheet which is being filed for wrongful restraint, unlawful assembly and criminal intimidation, my lords. So the facts is, my lords, petitioner,
Office objections.
my lords, to be overruled.
My lord, office objections 1, 2, 3, my lord. Age, address, all of that is from the charge sheet itself. So that may be.
All right. The other ones?
The 4 offenses to be mentioned correctly at para B, we have mentioned the offenses which he was discharged of. I mean, the ones that remain, he was partly discharged.
Okay.
So the ones that remain, that's why they've raised that. Only para.
Now, what's the urgency? Yes.
Urgency, my lord. It's on 18th/9. So it's for
18th/9.
for
All right.
charge.
Basic ingredients itself
Tell-
would be lacking.
tell
My
me.
lords, petitioner, my lords, first petitioner is an MLA, my lords.
All right.
Now the complainant would say, my lords, he had put some derogatory things in the Facebook against the petitioners. So his case is that he was summoned, my lords, he was called to a place, and at that place, A1 and A2 would take him to a room and scold him, criminal intimidation. Now on that basis, my lords, 4 days later, he goes, gives a complaint, and now the charge sheet is for 342, 149, my lords, 504, 506. 342, my lords, is covered by my lord's decision, my lords. When it comes to wrongful restraint, it should be a total restraint. It can't be a case where you take a person to a room, he has an opportunity of walking out. Like in this case, he walks out, my lords. So 342 doesn't apply. 149, my lords, an assembly of 5 persons itself is not there. Only 2 persons, my lords, who have spoken to him and who have reprimanded him for putting derogatory message in the Facebook. So both the ingredients, my lords, would not be made out. And he claims to be from the other political party. my
ಅಲ್ಲಿ
lords.
ಇದೆ ಆಗ್ತಿರೋದೇ ಅದೇ.
ಅದೇ.
ಏನ್ ಬೈದಿರೋದಿದ?
I'm sorry.
Page 26 ಅಲ್ಲಿ.
ಹೌದು, ಹೌದು.
Those 2 lines.
Those 2 lines.
ಏ ಮಗನೇ ಅದ?
Criminal intimidation. And then, my lords, he says he walked outside. After 4 days, I went and gave this complaint.
The petitioners accused 1 to 7 are knocking at the doors of this court, calling in question registration of, calling in question the proceedings in CC 28585 of 2023 for offences punishable under section 342, 504, 506 and 149 of the IPC. If there are only 2 persons, one nimsha, if there are only 2 persons, why are 7 petitioners here?
My lords, what they did is in the charge sheet, my lords, they named 7 persons. But even in the charge sheet, the allegation is, my lords, A1 and A2 are the ones who spoke to him. How could it be an unlawful?
Even in the complaint, it is only 2?
Complaint 3 persons and unknown people. Complaint only. But if the complaint is in A1, A2. If the complaint is in, my lords, may kindly notice the complaint.
The second respondent is the complainant. A complaint comes to be registered on 30th July 2020 on the allegation that the petitioners have posted derogatory statements upon the complainant.
The other way around.
Allah,
It was said-
the complaint comes to be registered that the second respondent complainant had posted certain derogatory statements on accused 1 and 2 on the social media -Facebook. Therefore, the accused 1 and 2 or even 3 had restrained the complainant in a particular room and had intimidated him. Therefore, the offense under section 342 and 504 and 509, including 149, have sprung. The learned senior counsel Sandesh Chowta would take this court through the summary of the charge sheet to demonstrate that the allegation against these petitioners, allegation in the case at hand was that there were only 3 persons. If it was 3, it cannot meet the ingredients of section 149 is a submission. The matter would require consideration. What merits acceptance at this juncture is the very offense under section 342 not being met in the case at hand. Section 342, which deals with wrongful restraint, has its ingredients in section 339 of the IPC. Section 339 mandates that the person who is restrained should not be permitted to move in any direction. It is only then it would become an offense under section 341. The complaint itself does not narrate any such instance at the hands of the petitioners upon the complainant. The complainant himself has walked out of the room later. Therefore, the offense under 342 is loosely laid against the petitioner. The intimidation, the criminal intimidation that is alleged of offense under 506 has its ingredients under section 503 of the IPC. The ingredients of section 503 can be seen to be hardly met in the case at hand. Therefore, there shall be an interim order of stay of further proceedings, qua the petitioner still the next date of hearing. 1 additional SPP, 2 emergent notice returnable by the 26th.
HCGP.
HCGP, sorry. Yes. Returnable by 26th. Yes.
Next matter is
One more.
next matter is even worse, my lords. My lords, CM's convoy goes at Yadgir district, my lords. 15-20 persons come in front of the convoy. And in front of the convoy, my lords, they say, Guru Mittal Youth JDS ki Jai. Police would disperse them. Then comes this complaint. And a charge sheet would be filed. Offenses are again 143, 147.
Ella 2020.
Howdu, my lords? Ella 2020.
Learn HCGP 1.
Please, ma'am.
Additional SP, emergent notice 2, returnable by 26. In the meantime, there shall be an interim order of stay for the proceedings by the petitioners. Next, yes.
13.
The order will take effect after compliance with the office objections.
Yes.
Yes.
Petition. Pray for 1 week time to remove the office objections.
List on 26, the office objections be complied with in the meantime. Next.
On IA 14.
14, please, lords.
Then interim bail.
Everything out of the same first serial number 1, ma'am.
This man is also 70 years old, petitioner.
On age parity or seeking or what?
70 years old. But 26.
Same crime, huh?
Same crime. But after 20 years, my lord, the
ಇದು JK. Serial number 1 ಇತ್ತಲ್ಲ, being spoken to. Same question now. Yes, so and so. Yes.
Disaster Management Act, my lord, covered by decision, my lord.
51B, could you judgmentally?
I have appended, my lord, page number 44, my lord. This was quashed insofar as accused 1 in the same case.
Petitioner is before this court, so and so. The counsel for the petitioner submits qua accused number 1. This court quashed the proceedings in criminal petitions on page 44 in that light. So, yes. Next. ಹರ್ಡ್ ರೀಹರ್ಡ್ ಕೊನೆಗೆ ಇಲ್ಲೇ ಬರುತ್ತೆ.
ಇಲ್ಲ.
ಇಟ್ಸ್ ಟ್ರಾವೆಲಿಂಗ್ ವಿತ್ ಮಿ. ಧಾರವಾಡಕ್ಕೆ ಹೋದ್ರೆ ಬಂದಿದ್ದು. ಎಸ್. ಹೇಳಿ ಸರ್.
The petitioner was working as an assistant commissioner for a period of 1 year.
ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀರಾ? ಆಲ್ ರೈಟ್. ನೀವು ಹಾಕಿದ್ದೀರಾ?
ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಹಾಕಿಲ್ಲ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀವಿ.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ? ಹೇಳ್ಬಿಡಿ.
In brief, what would
ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಹೇಳಿ.
Yes. What would happen is the complaint, the RBI realizes that there's something hanky panky going on with IMA. They would direct the DG and IGP as well as the DCP East to investigate. They would submit a report saying that there everything is correct, there's nothing going wrong with IMA. Therefore, there is nothing for us to take action. Then government of Karnataka writes a letter to the deputy commissioner to direct the assistant commissioner to lodge an FIR. After all of this, I am transferred to that post, I take charge, and then I give a complaint to the police station. The police would reject my complaint and say, we cannot register an FIR, there is no complaint made by anybody. I would write to the commissioner would also reject my complaint. Then I issue a public notice, nobody has come and given any complaints. Then I would request the IMA to give a report, they would give me a report. I would request the government, what should I do on this? Then the government would appoint me as a competent authority.
Yes, later,
they withdraw that authority, saying that you are no more the competent authority. Then I would write to the government saying that, see, these are the reports that are given to me. DC has written to close the complaint. Therefore, I am forwarding this to you. And in that letter, which is now the crux of the matter, I would pinpoint all the government orders and letters of the deputy commissioner and the government and say, this is the communication received. I am forwarding it to you for your further action. I am closing it at my stage.
That's all the allegation.
That is all the allegation. Then, a complaint is given by an unknown person to Commercial Street Police Station, and then, matter 73 is crime number 73 is registered by Commercial Street. That is now, transferred to the Central Bureau of Investigation.
No, is this the same case where the other IPS officer was also?
Yes, it is on his report that I close it at my stage.
IPS officer ಕ್ವಿಟ್ ಪ್ರೋಕೋ ಇರಲಿಲ್ಲ.
ಕ್ವಿಟ್ ಪ್ರೋಕೋ ಇರಲಿಲ್ಲ, ಏನೋ ಸೋಫಾ ಸೆಟ್ ತಗೊಂಡಿದ್ರು,
ಮೆಟೀರಿಯಲ್ ಇರಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಐ ಕನ್ಸಿಡರ್.
ಅದೇನಾಯ್ತು, ಫೈನಲ್ ಆಗಿದೆಯಾ?
ನೌ ಇಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಇನ್ ಸುಪ್ರೀಂ.
ಸ್ವಲ್ಪ ಹಾಕಿದ್ದೀರಾ?
What Commercial Street Police Station registered is transferred to CBI. In the meantime, ACB registers one more complaint. That is never transferred to the CBI. CBI would assume that all complaints are transferred to us, and therefore we will take over jurisdiction and investigation of this complaint also, which is registered with Anti-Corruption Bureau. Registers the separate FIR, takes into consideration the investigation done by ACB, and ACB had not obtained prior approval under 17A. The CBI would look into all those materials which are prior to 17A, take that into consideration, and then file the charge sheet. In so far as IPC offenses, the competent authority has not granted in so far as section 218 of IPC, charge sheet is laid for that also. And in so far as I am concerned,
218 act ಬರುತ್ತೆ ಈಗ 197.
197.
218 IPC act.
IPC ಎರಡು FIR ಇದೆ, ಒಂದು IPC, ಒಂದು PC act.
All right.
Now, in so far as that is concerned, Sanction, I have raised the contention that I am a Group A officer, cabinet. In the reply, specific government is, it is not granted by the cabinet.
Where is that?
Your Lordship, kindly have a look at the statement.
Yeah, Prasanna Kumar objections.
ಹೌದು.
Memo documents objections.
ಅದು ಎಲ್ಲ ಎರಡು ಹಾಕಿದ್ದೀನಿ.
But 26 of the reply statement, para 31.
Para
31.
Objections ಇಲ್ಲ. Reply statement ಕಾಣ್ತದೆ. Synopsis. Let's check this. Reply statement is not there. Para 31.
I've noted it in my synopsis.
All right.
But the quid pro quo.
So it is admitted that
it is the Chief Minister on the last state of hearing. The Lordship will not pose the same question to me. The competent authority will not or present with the original file
where Chief Minister not had signed.
Yes,
With
yes.
not, they had also brought the rules not for your lordship kind
Transaction
consideration.
business rule.
Transaction business rules ಅಲ್ಲಿ, not both in Kannada and English, where not the Chief Minister, not he is the competent. Your lordship
ಕೊಡಿ ಅದು ಮೇಡಮ್ ಅದು.
was brought by the sanction.
I think I saw the file also.
Says your lordship was pleased to see the file and send it back. Now, not he is contending that his earlier contention was Chief Minister should have given. When not file says Chief Minister has given, now he is contending that cabinet should give.
I can't go beyond what the rules say.
I know, we'll see.
irrespective of what I-
So whatever you say is not what is
Yeah.
what the rules say
What
would
the
be
rules
important.
say.
Yes, let's see.
That the quid pro quo that they say in 164 statement in graphic, what they would say is that while I'm sitting in the office, somebody from IMA would come. In graphic detail, if I would raise my hand, my lord, and tell them, hello. For that, my lord, since I show 4 fingers, I have demanded 4 crores as a statement.
ಹೌದಾ?
ಆ ಥರ ಇಲ್ಲ. There are 164 statement of 3 persons, not one.
ಒಂದೊಂದು ಫಿಂಗರ್ ಒಂದೊಂದು ಕ್ರೋರ.
One finger, that is the allegation again.
Yes, Prasanth.
Not your lordship, kindly you may not, in the statement of objections, the primary allegation is.
ಇದೆಯಾ
not,
ಮೇಡಮ್? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ಲ. ಕೊಡಿ
This was filed, not may I just pass on.
ನಿಮ್ದು ಕೊಡಿ ಪ್ರತ್ಯೂಷ್.
Not page 207, annexure R15. R15, my lord, page 207.
Notification.
Notification, not wherein under order notification dated 1/2/2019, the powers of the Assistant Commissioner as the competent authority was withdrawn. It was not handed over to Deputy Commissioner.
All right.
But even after withdrawal of this, not kindly come to the next annexure, not 1 month and 6 days there, 1 month, 7 days thereafter, not the petitioner, though he was not the competent authority, not he would send the report at page 209.
Saying what?
Not saying, not your lordship will find in the next page.
No action can be taken.
No action can be taken against company under so and so. Not this is not his.
That's all against him.
No, this is the report that he gives. Not the case against him is not when he being the competent authority. When RBI may not refers a complaint to him, not he was required to inquire into the allegations. What he does, not he being the inquiry officer, not he will examine the accused number 1. He will examine his officers and conclude that there is no violation of the provisions of the KPAD Act. But he should have not inquired what is the business module. If you are taking 100 rupees, how you are giving 8% per annum or 6% per month every day? Where do you invest money? All that not he has not done anything.
No, that's all right. But he has sent this report after the notification was withdrawn.
No, that is one. Secondly, not your lordship may also have looked at the memo may not be document that I have filed. At page number 39. Not this is the cash flow chart, not downloaded from the
39.
iCloud. Page number 39, Mila. A memo with documents ಹಾಕಿದ್ದೀನಿ ನಾನು ಅದರಲ್ಲಿ 39 ಅಲ್ಲಿ. This is the one not part of the charge sheet. Your lordship may kindly may not come to page 49. 49.
Yes.
ಅದರಲ್ಲಿ serial number 15, 1.5 crores to DC.
49.
Page 49 ಅಲ್ಲಿ.
ಈ ತರ ಇದೆ.
ಇದು ಮಾತ್ರ ಇದು. 1.5 crores to Deputy Commissioner.
DC ಅಂತ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
DC ಇಲ್ಲಿ ಲೆಫ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಸೆಕೆಂಡ್ ಕಾಲಮ್. MMK DC. Then not kindly
Who is
come.
DC? He is not DC.
He is not DC. Not AC ಮುಂದೆ. Then kindly come to page 57. Other expenses, LC Nagaraj, handed over by Nizam Bhaiya, 2 crores.
1 minute.
Page 57. Serial number 620. Idondo. Then not kindly come to page 60. This Nizam also not has given one statement, 164 statement. Then not page 60. Serial 431. Other expenses, LC Nagaraj, Wasim Bro, 50 lakhs. Then not page 62.
61 ಅಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲ
16 ನಲ್ಲಿ 60 ರಲ್ಲಿ
60 ಮಾರ್ಕ್ ಮಾಡಿ
60
ಆಮೇಲೆ
then not 62 all right. Not date and time not has been given. In all, 5.5 crores has been received, my lord, by this petitioner. Total.
ಅಲ್ಲ ಇದು ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್
This is the statement maintained not by the co-accused, not in his iCloud, which has been downloaded, and his 164 statement not has been recorded.
164.
This was entered
Where
at
is
an undisputed point in time. 164 statement, your lordship will find not from page 84 onwards.
Where do you get this figure?
Not about 50 lakhs, your lordship will find this Wasim Nazimuddin, page 84 it starts, at page 89.
No, this 164 statement ನೋಡಿದ್ರೆ there are more skeletons in the cupboard.
Of course. Whoever may
not only this, we have spoken about everybody.
Of course. Then page 89, no? Page 89, para 2. After about 6 lines from the top,
huge number, Radha.
Simultaneously, he sent me
simultaneously. Okay.
Sent me to LC Nagaraj, who was assistant commissioner, and published the above notification. I met LC Nagaraj and submitted the LLP and financial documents and came back. After 1 week, Mansoor Khan asked me to go to him and talk about our files and get his contact number, which I did. After 2 days, Mansoor Khan asked me to go to DC office and wait there. I was waiting there. Suddenly, so and so brought a bag of cash containing 50 lakhs. Then, Mila, kindly also come to page 92. Para 3, Mansoor wanted to so and so. There, he speaks about handing over 2 crores. Idರಲ್ಲಿ, in para page 92.
92.
Handing over 2 crores to assistant, to his assistant Manjunath.
92, which para set?
Para 3. Mansoor wanted to settle matter with LC Nagaraj.
All right. Yes.
Assistant Commissioner and paid rupees 4.5 crores 2018-19. No, this is one statement. Then on page 94, Nizamuddin.
This is 164 statement.
This is 164 statement. Then what is actual statement starts from page 97. Relevant at page 98, Mula. After about 5 lines from the top. ನಂತರ ಮನ್ಸೂನ್ ಕಾರ್ ಅವರು ನಾನು ಎಲ್ಸಿ ನಾಗರ್ ಅವರನ್ನು ಮೀಟ್ ಮಾಡಲು ತಿಳಿಸಿದ್ದರು. ನಾನು ಸೂಕ್ತ ದಾಖಲೆಗಳನ್ನು ಅವರಿಗೆ ಸಲ್ಲಿಸಿದ್ದೆ. ಹಾಗೂ ನಟರಾಜ್ ಮತ್ತು ಅವರ ಕಾಂಟ್ರಾಕ್ಟ್ ನಂಬರ್ ಅನ್ನು ಪಡೆದು ಮನ್ಸೂರ್ ಖಾನ್ ಹೇಳಿದೆ. ಮನ್ಸೂರ್ ಖಾನ್ ಒಂದು ವಾಟ್ಸ್ಆಪ್ ನಂಬರ್, ಒಂದು ಚೀಲವನ್ನು ಒಬ್ಬ ವ್ಯಕ್ತಿ ಬಳಿ ನಾನು ಕಳಿಸಿದ್ದರು. ನಾನು ನಂಬರ್ ಕಾಲ್ ಮಾಡಿ ಒಬ್ಬ ವ್ಯಕ್ತಿಗೆ ಚೀಲವನ್ನು ಕೊಟ್ಟೆ. ಅದರಲ್ಲಿ 50 ಲಕ್ಷ ಇತ್ತು. ಮನ್ಸೂರ್ ಖಾನ್ ಬಂಗಾರದ ಒಡವೆಗಳನ್ನು ಕರಗಿಸಿ ಅದನ್ನು ಮಾರಾಟ ಮಾಡಿ ಬಂದ ಜನರಿಗೆ ಕೊಡುತ್ತಿದ್ದ. ದೆನ್ ನಾಟ್ ಲಿಟಲ್ ಬಿಲೋ. ನಂತರ ಎಲ್ಸಿ ನಾಗರಾಜ್ಗೆ 2 ಕೋಟಿ ರು ಕೊಡುವಂತೆ ಮನ್ಸೂರ್ ಖಾನ್ ತಿಳಿಸಿದ ಮೇರೆಗೆ ನಾನು ಹಣವನ್ನು ಮಂಜುನಾಥ್ ಎಂಬ ವ್ಯಕ್ತಿಗೆ ಕೊಟ್ಟೆ. ನಂತರ IMA ನೌಕರಾದ ವಸೀಂ ಮೂಲಕ 2 ಕೋಟಿ ಹಣವನ್ನು ಮಂಜುನಾಥ್ಗೆ ಕೊಡಲು ಕಳಿಸಿಕೊಟ್ಟು ಅದನ್ನು ನಾನು ಮಂಜುನಾಥ್ಗೆ ಕೊಟ್ಟೆ. Then one more 164 statement at page 106.
Every statement is there.
In every statement is there.
106.
106. Relevant, my lord will find at page 113.
Entries pertaining
to cashing of cash, so and so. Para A and B. Then my lord, further statement.
164 is 161.
Yella 164 is all are 160. Then not page 125, Wasim. Adil Wasim bro ante yadu onde ಹೆಸರು.
Wasim bro.
Wasim bro. Then what is relevant at page 128. It starts from 125. Relevant at page 128. Last but one paragraph, man.
During 2018.
During 2000, after about 6 lines, once on the instructions of Mansoor Khan, I had received cashback containing 1 crore from Mansoor Khan. I delivered the same to Sri so-and-so on his residence at Jayanagar 7 block. On 28/11/2018, but he is one of the co-accused. I have delivered 50 lakhs to Nazimuddin on instructions of Mansoor Khan, and later came to know that his amount was delivered to LC Nagaraj. Then the last statement, Wasim, what is page 130, relevant not at page 138. Fifth line from the top. Mansoor Khan ಹೇಳಿದ ಹಾಗೆ IMA ಆಫೀಸಿನಿಂದ ₹50 ಲಕ್ಷ ನಗದನ್ನು ಕಲೆಕ್ಟ್ ಮಾಡಿಕೊಂಡು ನಿಜಾಮುದ್ದೀನ್ಗೆ ಕೊಟ್ಟಿದ್ದ. ಅಲ್ಲ, ಮೇಲಿಂದ 5ನೇ ಲೈನ್ಸ್. Page 138.
ಮನ್ಸೂರ್
ನಾನು
ಖಾನ್
ಹೇಳಿದ
ಹೇಳಿದ
ಹಾಗೆ
ಹಾಗೆ.
IMA ಆಫೀಸಿನಿಂದ ರು 50 ಲಕ್ಷ ನಗದನ್ನು ಕಲೆಕ್ಟ್ ಮಾಡಿಕೊಂಡು ನಿಜಾಮುದ್ದೀನ್ಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ. ನಂತರ ನಿಜಾಮುದ್ದೀನ್ ರು 50 ಲಕ್ಷ ಹಣವನ್ನು ಎಲ್ಸಿ ನಾಗರಾಜ್ಗೆ ಕೊಟ್ಟಿರುವುದಾಗಿ ತಿಳಿಸಿದರು.
ಆಮೇಲೆ
Sir, all the 164 statement coupled with not the entries in the cash flow statement which were entered at an undisputed point in time. Sir, later will not download.
ಇಲ್ಲಿ ಫ್ಲಾಗ್ಸ್ ಕಾಣ್ತಾ ಇದೆಯಲ್ಲ ಅದೆಲ್ಲ ನಿಮ್ದೆ.
ಅದೆಲ್ಲ ನಂದಲ್ಲ. ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ನಾನು ಇನ್ನೊಬ್ರು ಕೊಟ್ಟೆ LC ನಾಗರಾಜ್ ಕೊಡಕ್ಕೆ ಅಂತ. ನೆವರ್ ದೇ just have a look at.
Now come to those statements.
Yes. Would you like to come to page number 92? That was one of the statements that are.
No, we'll go one by one.
Yes.
Come to
First of all, at page.
first bank account ಬನ್ನಿ.
Yes. ಇದು ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಯಾತಿಗೂ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರೋದು ಅಂತ.
ಅಲ್ಲ ನಿಮಗೆ ಬಂದಿಲ್ವಾ ದುಡ್ಡದು?
ಇಲ್ಲ, ಬ್ಯಾಂಕ್ ನನ್ ಇನ್ ಮೈ ನೇಮ್ ದಟ್ ಇಸ್ ದ ಎಕ್ಸ್ಪೆನ್ಸ್ ಇನ್ಕರ್ಡ್ ಬೈ ದೆಮ್ ಅಂತ ಹೇಳಕ್ಕೆ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್, ದಟ್ ಇಸ್ ದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಂಟೈನ್ಡ್ ಬೈ IMA is what is alleged. Now, my lord, would your lordship have a look at page number 84?
84.
Yes. This is the 164 statement, my lord, that was read out.
Yes.
May I point out what is common in all these 164 statements are all these statements are now made after the charge sheet is filed. This
After the charge sheet is filed?
No, they are all approvers.
All
Approvers.
these persons are approvers. And it is their statement, my lord, after the charge sheet is filed. After they have turned
Approver statement.
There are approval statement, but not when we downloaded. The entries were not from the iCloud.
The first of the statement is at page 84. It starts.
Wasim bro is an approver.
Please. Nizamuddin, which is reading.
All right.
All these statements, my lord, would connect to Nizamuddin. 50 lakhs was handed over to Nizamuddin to be paid to me. Please have a look at page 92, the statement of Nizamuddin.
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಪೇಜ್ 89 ಅಲ್ಲಿ he himself has handed over. ಅದು ಓದ್ದೆ ನಾನು.
Third paragraph. Mansoor wanted to settle the matter with LC Nagaraj Assistant Commissioner and paid 5.5 crores in 18 and 19 January. The amount was delivered by me in front of CCD Sadashiv. Initially, I delivered rupees 50 lakhs in front of DC Office Revenue, rupees 2 crore at CCD, 2 crores. It was paid to his assistant Manjunath village accountant as instructed by Mansoor. Manjunath gave clearance letter signed by M. Nagaraj. Therefore, my lord, it is never their allegation, my lord, it was paid to me. Their allegation is it is paid to Manjunath. And now, my lord, Manjunath's statement does not say. Would your lordship kindly, that is also, I have filed it along with my writ petition, my lord. That would say, Manjunath also tells that he never handed over to me.
He kept it for himself?
No, my lord, he has handed over to one person by name Chandru. That is the statement of.
Who is this Chandru?
Nobody knows. He is not an accused. He is not a witness in the charge sheet. And these are, my lords, the admitted statements available only in the charge sheet. I am not, my lord, looking into any material other than what is produced.
No other statement was available prior to the filing of the charge sheet.
No.
All have turned statements are all an approval statement.
So far as my lord, payment of money is concerned, they're all based on the approval statement. And my lord, what is downloaded from the iCloud, the entries for my lord dates back to the date on which amounts are paid.
In so far as the letter that I have written, my lord, closing the case, I would make a specific reference to the order of withdrawal and make a statement, my lord, saying that this power is withdrawn to me. This is the letter written by the DG and IGP as well as the DCP West and the Deputy Commissioner. And my statement is, I am awaiting further instructions and forwarding this to the government for approval. I am closing it at my case level. That is all that I would say.
Page 89, just only not page 89.
Yes.
But para 2, last 5 lines, no? Suddenly, Wasim brought one bag containing 50 lakhs rupees and Mansoor Khan gave one WhatsApp number.
Came back.
To hand over that money to LC Nagaraj in person. Accordingly, I have handed over the bag and came back.
It was for 2 months.
In person. Accordingly, I have handed over. Matter was closed off.
If I hold it to be approvers on that ground, everybody will be left off the hook. Will pass out.
Please.
Heard reserved.
Please.
The transaction of business rules early.
Please. That's all.
Yes.
Great.
Next.
Admission 17.
At 17, my lords, I appear for the respondent. I'll only pray for.
ಎಲ್ಲಿ ಸಾರ್ತಿ
I'll file my objections in this case, my lords. Need to file. my
ಕೋರ್ಟ್ಗೆ ಬರಲ್ಲ ಅಂತಾರ ಅವರು.
Objections file ಮಾಡ್ತೇನೆ ಸ್ವಾಮಿ.
ಗೊತ್ತು. This is a ಧಾರವಾಡ ಮ್ಯಾಟರ್.
ಹೌದು ಧಾರವಾಡ. 2 weeks time ಕೊಟ್ರೆ I'll file my objections.
Bail refuse.
Yes, yes.
Then that was confirmed.
To be connected
Again,
with.
quashing her to rule. That was also.
That was withdrawn.
Withdrawn.
ಅವತ್ತು ಅಲ್ಲೇ ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡಿ ಬೇಲ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದೆ ನಾನು.
Now, the simple ground raised is bail is granted without complying with section 15A.
So I'll
You are
file-
not notified?
No, my lords, interim bail has been granted. Regular bail, my lord, they have been served with a notice. They have come on record. They
ಇಂಟರಿಮ್
have
ಬೇಲ್ ಯಾವಾಗಿಂದ ಇದೆ?
filed Anticipatory bail 438 ಅಲ್ಲಿ ಕೊಟ್ರು.
ಅಲ್ಲ ಆಯ್ತು, ಇಂಟರಿಮ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್.
Pending, please, my lord, the notice they have, it was given, sent to them.
If that is their contest, ಅದನ್ನ ಮಾಡಿ ರೆಗ್ಯುಲರ್ ಬೇಲ್.
This order has to go.
I'll file my objections to this matter.
That is.
ಯಾವ this has been languishing
No,
since
sorry.
2023, sir.
I am sorry.
We're not filing objections.
I'll
We're not
file-
going to-
1 week
This
I'll
is
file.
1 year ಆಯ್ತು, ಇದ್ರಲ್ಲಿ ಏನಿದೆ objection?
I'll
ನೋಟಿಫೈ ಆಗಿತ್ತೋ ಇಲ್ವೋ? 15 ಕಂಪ್ಲೈ ಆಗಿದೆಯೋ?
go through this whole thing, lords. I'll,
Can you see
in
the
1 week I will.
Order that is passed on the face of it is wrong.
I will argue, please, my lords, in 1 week's time.
Argue.
Alla, I'm not
Yes, sir,
prepared in
ನೀವು
this
ಹೇಳಿ.
matter, please, my lords.
May please.
Lords, Senior was engaged in this, lords. He's slightly inconvenienced
No
today.
problem, sir. Tell
I
me.
will argue it.
Last 3 weeks this is happening.
Let's Tuesday ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ argument. But
Tuesday ಆಗಲ್ಲ.
ನಾಳೆ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ.
ನಾಳೆ
Tomorrow I will.
ಇಲ್ಲ, sir. Yes.
Tomorrow I will. Morning, first matter I will argue. my lord.
ಅದೇ
I'm not-
first matter.
Alla, I'm not prepared in this. I'll argue tomorrow. First thing, one opportunity, tomorrow I'll argue.
ನಾಳೆ ತಗೊಳ್ಳಿ.
I apologize, my lords, the senior counsel also.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಅವರು ಆ ಕೇಸ್ಗೂ ಇದ್ದಾರೆ. ಡೋಂಟ್.
It has to be connected with the 482, man.
ಹಾ?
482 also pending.
ಏನ್ ಹಾಕಿದ್ದಾರೆ?
They have filed for quashing.
26th will not take us, directed me to take notice. And I said that party is not, ಅವ್ರಿಗೆ notice.
ಅಲ್ಲ 482 ಹಾಕಿಲ್ವಾ ಇದು?
ಹಾಕಿದ್ದಾರೆ ಅದನ್ನು. Your lordship, come before your lordship.
Your lordship is posted back.
Which one?
They have filed a 482. The discharge they have filed has been rejected. Against that they filed a 482.
ಎರಡು ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳೋಣ ಹಾಗಾದ್ರೆ.
Please.
ಅವತ್ ಮತ್ತೆ ಅದರ ರೆಡಿ
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಒಂದೇ ಮಾರ್ನಿಂಗ್ ಐ ಗಾಟ್ ದ ಫೈಲ್. I'll argue it next day. Sorry.
ಮತ್ತೆ ತಗೊಳ್ಳೋಣ. Yes. It's he's already set on liberty. To withdraw it, there should be a strong ground. We'll see. Yes. Less this matter heard the learned senior counsel, Professor Ravi Kumar appearing for the petitioner and KB Monish Kumar. The learned counsel for the respondent seeks time, yet again to go through the papers and make his submissions. List the matter on 26th. The counsel for the petitioner would submit that another petition is filed by the respondent seeking quashment of the entire proceedings. In criminal petition,
888-2, please, my lords, of 2024.
888-2 of 2024. Tag this petition along with 888-2. List them both on
26/9.
On 26th in the fresh matters list. Yes.
That is not last petition.
ಸುಮ್ನೆ ಹೇಳ್ದೆ ಸರ್.
Sorry, my lords, about today.
No.
Please.
18?
I appear for.
Jagdish sir. You have appeared in the court today.
Please, my lord.
Yes.
As my lord said.
ನೀವು ಬಿಸಿ ಇಲ್ಲ, ಗುಲ್ಬರ್ಗ ಹೋಗ್ತೀರಲ್ಲ, ಧಾರವಾಡಲ್ಲಿ ಇರ್ತೀರಾ?
ಆ ಸರ್ಟಿಫಿಕೇಟ್ ಒಂದಲ್ಲಿ ಇದಾಗ್ಬಿಟ್ಟಿದೆ ಬೇಡ ಜಂಗಮ್ಮ ಡಿವಿಷನ್ ಬೆಂಚ್ ಬಂದು
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತಾ ಇದೆ.
Nothing, my lord. Earlier in election petition, what the law has been.
ಇದು ನಾನೇ ಒಂದು ಬರ್ದಿದ್ದೀನಿ.
ಮಾಡಿದ್ದು. My lords have written that he has made an attempt to steal the constituency meant for a genuine scheduled caste. We have earlier to that, my lord, in view of the election petitions order, we registered a criminal case against him.
But that order went ಅಲ್ಲ.
What has the Supreme Court has not set aside that order?
I know. I have again reiterated that.
Reiterated. My lords have reiterated and had elaborated that and said that.
ಏನಾಗಿದೆ? ಫೈನಲ್ ಆಗಿದೆಯಾ? ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ಇದನ್ನ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಾಕಿದೆ. ಡಿವಿಷನ್ ಬೆಂಚ್ಗೆ.
As of now, it has not listed, no stay.
ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ? 1 ವರ್ಷ ಆಗಿದೆ ಆರ್ಡರ್ ಮಾಡಿ.
ಅಲ್ಲಿವರೆಗೂ virtually amount to allowing a thief to retain a stolen property, as my lords know that. Often I argue that.
ಬಹಳ ದಿನ ಆಗಿದೆ ಇದು ಕೇಳಿ.
ಅದು being an MLA, he has stolen the constituency. Lord,
but I have already written.
That precisely my lord has written.
Let me go through the objection.
Nothing is there. I have not added extra to that.
Let me prepare for this also.
Ian prepare, he has participated in the writ petition in both the election.
I have said, see, by stealing away a constituency that was meant for a person genuinely belonging to a scheduled caste.
And committed a fraud. Even in election petition also, that is the Milord, a specific issue has been framed. No.
But it comes.
Perhaps I have to say that, Milord.
The order passed election petition redundant in view of the Supreme Court. I'll address the argument.
What redundant? Nothing. Supreme Court said reconsider this matter. So I have reconsidered it and passed the order. And I have not absolved you of the blame.
Lord,
In fact, cemented it.
My Lord, I added extra strength to that. Page number 30 may be kindly seen, Lord, for a moment.
30.
30 for criminal petition. Specific issue has been framed.
One nimisha, sir.
Does the petitioner, your lordship's got it, Milord?
Page 30 na?
30.
ಈಗ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ.
Petition ಅಲ್ಲ. ಇದು ಬೋಪಣ್ಣ ಸಾಹೇಬ್ ಇದು.
ಬೋಪಣ್ಣ ಸಾಹೇಬ್.
ಅದು ಗೊತ್ತು, ಅದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದೇನೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಫ್ರಾಡ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ತಾವು ಅದನ್ನ ನೋಡ್ಕೊಂಡು ಮತ್ತೆ ಏನ್ ಬರ್ತೀರಿ? ತಾವು ಫ್ರಾಡ್ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
One thing is, this went to the Supreme Court.
Yes, madam.
Supreme Court, the apex court directed this court to reconsider it without being influenced or whatever it is.
My lords have dealt that, my lord. Now order has been passed. Now this order has not been set aside by the Supreme Court. My lord, based on this order, we have lodged a complaint. He has obtained an interim order and he is enjoying that. Should he not face a trial? That too being a my lord has said that while passing this order, he has become a lawmaker. Allowing a thief to become a lawmaker means what would happen?
ಅಲ್ಲ ಅದೆಲ್ಲ ಬೇಡ ಯಾಕೆ?
My lords have observed. My lords have observed. It's not my say.
I have not so said.
No, my lord, kindly see, my lord. Kindly see my lord's judgment.
Page.
My lords have said that, my lord, which on the facts, my lord, page 65.
Which on the face of it is false and becomes a lawmaker.
The order
even
of the DCVC
by stealing away the constituency that was meant to the person genuinely belonging to the scheduled caste. It is this act that fringes on the borders of fraud on the constitution. That's what I have written. Therefore, action against the petitioner must ensue. And they are.
It is clear case that the petitioner contested the election on a caste certificate.
Correct.
Which was on the basis of the false and became a lawmaker.
Correct. ಅದೇ ಓದಿದ ಅದೇನೆ.
Lawmaker.
Thief to become a lawmaker ಅಂತ ಬರ್ದಿಲ್ಲ.
Thief ಅಲ್ಲ, ನಾ ಹೇಳ್ತಿದ್ದೀನಿ.
ನೀವೇ.
So my lords have declared that he is a stolen that constituency.
ನಾನು ಬೇರೆ ವೈ ರಿಟರ್ನ್ ಅಂತ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
Your lords have not written. It is my say.
Him statement.
ಹೌದು.
Amplify ಮಾಡ್ತೀವಿ.
Amplify ಅಲ್ಲ.
ಅಲ್ಲ, ಅವ್ರು ಆಂಪ್ಲಿಫೈ ಮಾಡೋದು ನೀವು ಸಿಂಪ್ಲಿಫೈ ಮಾಡೋದು ಎರಡೂ ಬೇಡ. ಇದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಈಗ ಹಾಕಿದ್ರು.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೊಟ್ರ ಈಗ?
ಅಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರೋದು. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಆಡೆಡ್ ಎನಿಥಿಂಗ್ ಟು ದಟ್.
I'll take it on 19th. We'll finish it on 19th.
Please, my lord.
ನೀವು no. That's how long? 2018, sir. 2018 pending to 2024.
Pendency ಇರುವಾಗ
6 months ಅಲ್ಲಿ election is contested when the matter is pending.
ಬೇಡ.
No. 19th.
19th
Yes. If you want to submit on 19th, or else I will close this.
26th.
No, sir. 19th. 2018 matter.
ಅವರು he has taken the matter.
ತಮ್ಮ ಮುಂದೆನೆ after the election petition, kindly see my lord, after my lord's order has been passed.
Whoever has dragged the proceedings, it is not passing the buck here. This court will not drag the proceedings. Next week, finally, list on 19th as a last chance. In the event no submissions are made, the petition would be answered on the averments made in the petition or the statement of objections. Next.
19.
Statement is served now. Objection is served. So matter, my lords, where I have pleaded absence of sanction under 197 for IPC offences.
ಯಾವ್ದಕ್ಕೆ?
There is an interim order. The interim order granted by the lordship.
Lapsing. Yes. List on 26th. Interim order subsisting shall continue to the next date of hearing.
My lord, I represent the petitioner.
One moment, sir.
Yes, sir. My lord, in identical matter, this honorable court has already quashed the proceedings.
Kudi, sir.
My colleague is handing over the order which was already passed.
Yes, Srivatsa, sir. Huh?
Yes, my lord, yes.
All right, yes.
Two offences were registered for identical reasons.
195 the DK Shivakumar's matter. Disaster management. 188 bar.
ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದಾರೆ.
ನೋಡ್ಬೇಕಾ ನೋಡಿ.
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದಾರೆ. 195 ಬಾರ್ ಬರಲ್ಲ.
ಅಲ್ಲ, that's what he says covered ಅಂತ. ನೋಡಿ ಬೇಕಾದ್ರೆ. ಕಾಪಿ ಕೊಡಿ.
ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
List the matter on 26th. Interim order subsisting shall continue to the next date of hearing. We'll quash it on the next date if it is quashable.
Obliged. Obliged.
Please.
21.
Appear for petitioner. 171 C and F, my lord. Yeah. Yes, uploaded in his social media, in his WhatsApp about the campaign using the public.
Time 26th IO. Okay. 26th IO extended to next.
Last time my friend produced the order under 155 too. And it was not within the parameters, as laid down by lordships. That's
Yeah, no. Permitted,
illa order madidare, but not the reasons which are expected while
What do you want? What do you expect?
That's what the
Expectations
lordships
differ from case to case.
No, I follow that, but the lordships did.
ಇದು ನೋಡಿದೆ ಇದೆ ಏನ್ ಅಲಿಗೇಷನ್ ಸ್ಪೀಕಿಂಗ್
Yes.
That will not stop.
We have advised him seriously.
ಈಗ ಯಾಕೆ
Already last time ಕೊಟ್ಟಿದ್ದೀನಿ.
ನೋಡಿ ಜಗದೀಶ್.
My lord, identical circumstance. Then moreover, my lord, I went for the my lord to flag was the my lord Hanumadhoja, wherein my lord the Karyakarta has called. Whether my lord,
let him see. 19th
disagreement by hosting the flag, my lord.
interim order ಕೊಟ್ಟಿದ್ದೀನಿ. 19th, yes, list on 19th at the request of learned additional SPP. Interim order subsisting shall continue till the next date of hearing. Please.
24.
Lord, 24, I'm appearing for second respondent. Lord, during the course of the day, I will file objections.
Learned Counsel Sharad Dodwad seeks a week's time to file statement of objections. List the matter on 26th. Objections, if any, by then interim order subsisting shall continue till the next date of hearing. Next.
Allegation is been kidnapped during the election. Kidnapped during the election by the accused number 223, 225. And on 1/4/2024,
363 ಹಾಕಿದ್ದಾರೆ.
353
363 ಹಾಕಿದ್ರು.
ಯಾರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರಿ?
ದೊಡ್ಡವ್ರನ್ನೇ.
He is saying that we have forced him to wear the BJP shawl. This is the allegation he has made.
Now ಆಗಲ್ಲ, next week ಮಾಡ್ತೀನಿ.
Entry madam.
List on 19th in the fresh matters list, but list on 19th, interim order subsisting shall continue to the next day. Next time we're going to finish this. Yes,
please.
Next. The matter was listed on 29/8/2024. There was no representation on behalf of the petitioner. Even today, there is no representation on behalf of the petitioner. Matter dismissed for non-prosecution. Next.
27.
27, I'm appearing for R2. Copy notes.
I'll serve it.
Copy kudi. Learned Counsel Venkatesh Dalwa is directed to furnish set of papers to Sharad Dodwad. List on 26th. Objections, if any, by the second respondent, by then I will to continue.
28. Hearing for petition.
28, my lord, I am for a second response, Lord. May kindly grant me some time, Lord, get instructions.
Same order, 26 Sharad Dodwad. ಮುಂಚೆ ಮಾಡಿದ್ನಲ್ಲ madam?
Let's interim order maybe.
Interim order subsisting will continue. Yes.
Oblige.
Happy for the petitioner, my lords. My lords, Learned Counsel had asked for few documents, my lords. This is regarding the swap of the properties, my lords.
Touch one property, my lord, they are alternative property, they have to give attachment, but.
Giving the alternative property, my lords, for attachment.
ಆಯ್ತು ಅದೇನ್ ಮಾಡಿ list on 26th interim order subsisting shall continue to the next date of hearing. Next.
30.
My lord, for the election speech matter, my lord, covered by
It
your
is covered by my order.
covered by your lordship judgment, my lord. Page number
ಆಯ್ತು
52.
list on 26th at the request of the additional SPP. Interim order subsisting shall continue. Interim order is also mine.
Yes, my lord.
Interim order subsisting shall continue till the next date of hearing. Yes.
31.
Of the cognizance order. We'll send it back.
No, covered matter. There is no ingredient at all.
Then we will hear it.
Ingredients are not there at all.
We'll, then I'll post it on 26th.
Please.
Well, today it may not be possible. Yes, we'll hear it on 20th. List on 20, heard the learned senior counsel B.V. Acharya appearing for the petitioner. List on 26th, interim order subsisting shall continue to the next date of hearing.
32.
Same. Yes, same order.
33 week.
Correspondent. 33. For the respondent.
Yenidu?
So case, so matter pertains to ex-MLA.
2017. Yes, sir.
Ex-MLA.
Yes, Manjunath, sir. Ready?
Request for a
2017, sir.
tomorrow mail and I will go on.
ಅದೆಲ್ಲ ಅಡ್ಜರ್ನ್ ಮಾಡಿದ್ರಲ್ಲ 22, 24 ಎಲ್ಲ.
Okay. Tomorrow I will do.
I'll vacate the interim order. Interim order ಇಲ್ವಾ?
Kindly passed over mail. There is an interim order.
Interim order ಇಲ್ವಾ?
Interim order ಇದೆ. Connected matter ಇದರಲ್ಲಿ ಎರಡರಲ್ಲೇ ಇದೆ.
ಏನ್ what is the offense?
Lordship, there is a misuse of power by a ex-MLA along with his two sons who encroaches the government land, which is adjacent land of his own land. Survey number 12 and 13. Survey number 11 land is a government land. Influencing the municipal officials, he encroaches the land, your lordship. Government land and convert those.
How is it pending for 7 years now?
Initially, it was
6 months ಅಲ್ಲಿ clear ಆಗ್ಬೇಕು ಅಂತ.
the stay was granted saying that ACB is not a police station.
So already that is over in 2022 itself.
You have matters which seems to have not been clubbed along with those matters.
The matter is of the year 2017. The council, council for the petitioner seeks time, yet double T ಹಾಕಿ, yet again. List this matter on 19th as a last chance. In the event no submission is made, the petition would be dismissed for its non-prosecution. Interim order is on the aforesaid condition shall continue till the next date of hearing.
Sorry, my lord, I could not.
No problem. Next, last ಅಷ್ಟೇ. Getting ಕರಿಬೇಡಿ. Getting ಕರಿಬೇಡಿ ಆಮೇಲೆ 26th. ಅದು ಏನು ಇವತ್ತಾಗಲ್ಲ ಹಾಕಿ. I'll post it on 26th ಅವತ್ತು ಮಾಡ್ತೀನಿ. File whatever you want. Jayasham, on 26th we'll do it.
Copy.
Copy ಅವರು ಕೊಡಿ. Please. Sridhar Prabhu sir.
36.
ಏನಿದು?
That lordships have heard it on 2 occasions, my lord, that defamation case, where my lord the complaint
Oh,
is that
that I-
politically I was attacked. Political attack camouflaged as the.
We'll see. Yes, either 30, which is serial number 36. 36, 26th. List on
I've heard
20.
it substantial.
20, no problem. 26th. Interim order subsisting shall continue till the next date of hearing.
Bill for 35, 35 ballots, which is there for dictation. Ballots that pertains to that 2000 metric tons of iron ore value of 50
I know. Yes. Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
Stale ಆಗಿದೆ. It is only for dictating.
I'll do it today. 26th.
26th one.
26th will dictate all this
Okay.
because I'll be at the end of this roster.
I get it.
We'll do it.
ಸರಿ ಮೇಡಮ್ 18 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಷ್ಟು
ಕಂಟಿನ್ಯೂ. ಎಲ್ಲಿ ಮೇಡಮ್ ನಾನು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡಿ, ಅದೇನು ವರಿ ಮಾಡಿ. ಹಾಂ ಎಸ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಶುರು ಮಾಡಿ. ಬಂದಿದ್ದಾರ petitioner single sir has come. Then
Before my learned friend begins, I just want 1 minute. my
ask
lord,
him to come. The moment he comes, I'll take it.
my lord, before my learned friend begins, I just want 1 minute of your lordship's time, my lord, to bring a subsequent event that has taken place. to your
Let him come, sir. Let him come.
Very well.
Yes. In his absence, yeah, let him come.
Very well. Very well.
Yes. Yes. The next second is Karbadi.
This number 2, fresh matter, number 1.
Petitioners here for offense punishable under 92, section 92 of the Factories Act, show cause notice was issued. I have replied, but that was not considered. Similar matter is already, identical matter has been stayed by this. Your lordship.
Take this petition along with so.
There is a direction issued to them to show if any compensation was paid to the victim.
That also have been produced. Those documents have also been produced.
7/2/2024.
Yes, sir. Have you complied with that order?
Yeah, we have.
No, yeah. Yes.
Apologies. We have, that is document number 1 in my additional documents I produced at 22/2/2024. We have paid 42 lakh rupees to the person who suffered the.
ಹಾಕಿದ್ದೀರಾ? ಅದು ಕೊಡಿ. Tag this petition along with so and so. In the light of the interim order subsisting. ಅದನ್ನು 42 lakhs ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ನೋಡಿ. In the light of the interim order subsisting in the companion petition, there shall be an interim order of stay in the case at hand as well. Next, Raghavendra.
I'm here for the petitioner. Your lordship heard me on more than one occasion. There is son filing a case against the mother and
Sir,
brother.
I think there is one more matter where Pramod Nair has filed and I have granted stay. You have registered a case against them?
Well, that is for misappropriation of 100 crores.
No, it's appearing to the respondent.
That has nothing to do with this case.
All right, sir. Yes. List the matter on 25th. Interim order subsisting shall continue till the next date of hearing.
Please.
Today it may not be possible, sir. Yes.
Number 3.
I appear for the respondent number 2's comes. Seems like just last evening, they've reached out to say that they want to resolve the matter. They just look into it.
Learned Senior Counsel submits that talks of settlement are held.
Learned friend appears for the petitioner.
Talks of settlement between the two are on, which is acknowledged by the counsel for the petitioner. List the matter 25th.
Please.
List on 25th.
Please.
Yes, next.
4.
25th. IO idre continue ಮಾಡಿ. Next.
5.
This matter, I am appear for the petitioner.
Post immediately after service of notice upon the respondent. Interim order ಇದೆಯಾ? Interim order subsisting shall continue. Next.
6. My lord. Mediation is going on. The next date of mediation is on 17th, my lord. So kindly post this matter after meeting. Mediation is going on, my lord.
Going on. All right. List the matter on 24th. The learned in the light of the submission of the counsel with the respondent that talks of settlement before the mediation is on. Yes. Interim order subsisting shall continue till the next date of hearing.
7.
My lord, I appeal for the petitioner. The petition has been filed calling in question the FIR for offence under 420. First, my lord, I file a complaint in memo dated 9/9/24, my lord.
Yes, tomorrow in the fresh matters list.
Even 8, please.
Yes, next.
8.
It's matter, POCSO matter.
Settlement.
Victim is 17 years, 11 months.
20th.
ಏನ್ ಆಯ್ತು ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾರಾ? Tomorrow. Custody will take it tomorrow. 17 years, 11 months, there should be some in the will. I'll look into the judgment only and pass. Not to worry. Yes. Hard realities of life, sir. Yes, we'll see. Yes, next. List tomorrow in the fresh matters list. Halima madam.
The only accused number 7, he is number 7, he is the only one remaining. Lord.
Split up.
All other, yes, split up.
Split up.
Yes,
ಈಗ ಇವತ್ತಾಗಲ್ಲ, ನಾಳೆ.
losing job.
ನಾಳೆ.
Fast because of this. But ನಾಳೆ, please, ನಾಳೆ ಮಾತ್ರ ಮಾಡಿ. It's the third date.
You should be reasonable at least in your expression. Yes. Next. 10%. ಇದು ನಾಳೆ ಕೇಳೋಣ, tomorrow. Plus tomorrow. Yes.
Serial number 11, I approve for the respondent.
Respondent has to file objection. 11.
Serial number 11, I represent.
List on 25th, 24th, objections if any by the next date of hearing, interim order to continue. Next.
But I appear for the petitioner's counsel. This is a forest matter. The government was directed to obtain instructions in relation to
I'll file my objections, my lord.
List on 20th.
May I persuade the honorable court to have it tomorrow because the FIR is registered.
No problem, sir. List on 20th. Yes. I will, the other matters after the completion of that third list matter, I will take.
List 3.
I'll be withdrawn. Don't. Yes, adella same order will pass. Yes, Shatabish. On his legs.
On his way. Written synopsis is well.
ಹಾಗಾದ್ರೆ ರಾಘವನ್ sir ಹೇಳಿ, you make a note of it. Yes sir.
My lord, I want to bring to your lordship notice, my lord.
ಅವ್ರು ಮುಗಿಸ್ಲಿ ರಂಗನಾಥ್, ಆಮೇಲೆ ಮಾಡಿ.
A subsequent development that has taken place.
Subsequent development?
Yes, my lord. Subsequent to the last meeting. My lord, on 31st of August 2024, the government, my lord, has passed an order placing an officer of the Muda under
My lord, I have objections. This cannot be put on record, my lord. In fact,
how is that relevant?
And we have withdrawn that also.
Sir, if the officer of Muda is placed under suspension due to this, you tell me.
I will. That is please.
Large scale corruption in Muda.
Answer is yes, please. Give me
that has been withdrawn all.
Before I am able to complete it, if my learned friend interferes, what shall I do?
We know what the.
Kodi, sir.
We have withdrawn that also, my lord. That cannot be relied upon. A document.
No, they have withdrawn that suspension.
Doesn't matter, my lord. I am
document.
My lord, if my learned friend will bear with me for a minute, I may be wrong, but I am entitled to be heard.
All right. Yes, sir.
Lord, please look at page
suspension or government then.
Lord, please look at page number.
Where is the copy given to the other side?
My lord, we've given a copy yesterday, my lord. Copy was served last week.
Yes.
Lord, please see page number, internal page number 3.
My one request.
Say what I want to say. Then my learned friend can say what he wants to say.
I don't want him to say. That's the point.
I may be wrong.
VC and this problem. ನೀವು VC ಹೇಳ್ತಾ ಇರ್ತೀರಾ, ಇವರು ಇಲ್ಲಿ ಹೇಳ್ತಾ ಇರ್ತಾರೆ. Yes.
ಇಲ್ಲ ನನಗೆ ಅವಕಾಶ ಕೊಡಿ ಅಷ್ಟೇ. ಸರಿ ಹೇಳೋ ಸರಿ.
He says it's already withdrawn.
No, my lord, there's a fact which is stated. I want to point out to your lordships that.
The fact of the error, my lord, which we have withdrawn. That's the point.
We have objected.
But can I point it out?
Material on record. It has no bearing on the case. This cannot validate the government.
No. Even otherwise, the submission of the Advocate General is it is withdrawn. If it
yes,
is,
but I'm pointing out a particular fact which has been stated in this order.
No, in an order that is withdrawn, what can
doesn't matter. The suspension might have been withdrawn, but the facts are there. Kindly look at that fact. My lord, I may be wrong. Look at it, my lord. Please look at it.
Let me see. So.
Lord, please turn to page
Lordship may kindly go to page 12.
1 minute, my lord. My learned friend will kindly bear with me.
That's why you should be here, sir. VC litre the problem.
Supreme Court matter irbeku.
My lord, page number 3 ನೋಡಿ ಒಂದೇ ಒಂದು ನಿಮಿಷ.
Yes.
ಅಲ್ಲಿ ಬಾ ಅಂತ ಇದೆ. ಅಷ್ಟೇ ನಾವು ಓದೋದು, ಇನ್ನೇನು ಓದಲ್ಲ.
ಏನ್ ಯಾರು ಕರೀತಾ ಇದ್ದಾರೆ?
ಇಲ್ಲ ಬರ್ದಿದ್ದಾರೆ. ಅದು ಬಾ. ಇದು ಬಾ.
ಬಾ ಅಂದ್ಬಿಟ್ರೆ ಆಮೇಲೆ
50 ಅನುಪಾತಿತ ನಿಯಮಗಳು ಅಂದರೆ ಕರ್ನಾಟಕ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಅಲಾಟ್ಮೆಂಟ್ ಆಫ್ ಸೈಟ್ಸ್ ಇನ್ ವ್ಯೂ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್ ಫಾರ್ ದ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ಡ್ ರೂಲ್ಸ್ 2009 ನಿಯಮಗಳು ದಿನಾಂಕ 30/7/2001 ಜಾರಿಗೆ ಬಂದಿದ್ದು ನಿಯಮ 3 ನಿವೇಶನ ಹಂಚಿಕೆಯನ್ನು ಲಾಟರಿ ಮುಖಾಂತರ ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಂಡ ಬಡಾವಣೆಯಲ್ಲಿಯೇ ಮಾಡತಕ್ಕದ್ದು ಎಂಬ ಅವಕಾಶವಿದ್ದು ಹೊಸದಾಗಿ ಕೈಗೊಳ್ಳುವ ವಸತಿ ಯೋಜನೆಗಳಿಗೆ ಈ ನಿಯಮಗಳು ಭವಿಷ್ಯವರ್ತಿಯಾಗಿ ಅನ್ವಯಿಸುವುದರಿಂದ ಈಗಾಗಲೇ ಅಭಿವೃದ್ಧಿಪಡಿಸಿದ ಹಳೆ ಬಡಾವಣೆಗಳಿಗೆ 2009 ಜಾರಿಗೆ ಬಂದಿರುವ ಮೇಲ್ಕಂಡ 50/50 ಅನುಪಾತದ ನಿಯಮಗಳು ಅನ್ವಯವಾಗುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಪ್ರಾಧಿಕಾರದಿಂದ ಬದಲಿ ನಿವೇಶನಗಳ ಮಂಜೂರಾತಿಗಾಗಿ 50/50 ಅನುಪಾತದಂತೆ ಕೈಗೊಂಡಿರುವ ಯಾವುದೇ ಕ್ರಮವು ನಿಯಮ ಬಾಹಿರವಾಗುತ್ತದೆ. That is the stand taken by the government that 50/50 allotment is subsequent. Now here in this case,
who has passed this order?
Government, my lord. It is passed by the government.
Not government, my lord.
In the name of his law, it is passed in the name of the governor.
Your lordship may kindly.
Now, my lord, let me complete, sir, if you don't mind. Now, my lord, all these.
My lord, all this is. I mean,
sir.
It's already been withdrawn. My lord. What's the?
Finish it.
Okay, let him.
You read the withdrawal order. He will read the order.
And has no relevance to the case, my lord.
ನಾನು ಮುಗಿಸೋದೇನು ಇಷ್ಟು
ಸರ್ ಮುಗಿಸ್ಬಿಡಿ
ಅಷ್ಟೇ ಇಷ್ಟು ಮುಗಿಸೇ ಬಿಡ್ತಾ ಇದ್ದೆ. The illegal allotments not in favor of the petitioner's wife. The allotments
that is in general in Muda.
Correct. No,
that is where a committee was constituted to go into the corruption in Muda. That is already told.
No, I am not on corruption in Muda, my lord. I am on the government stand with respect to the applicability of the 50/50 rules. The 50/50 allocation, even according to the government, I am on the content of this order, is post 2009. Here, my lord, all these sites were allotted in 2003. Therefore, the 50/50 would not apply for allotment in favor of the petitioner's wife because the illegal encroachment was in 2003.
Sir, that's by a separate notification. We will consider that.
That's all that I am saying, my lord. This is a piece of the jigsaw puzzle.
Yes, sir.
Please, man. Yes, ought to be. In fact, your lordship.
Where is the order of withdrawal, Kodi?
Your lordship may kindly see page number, my lord. Page number 12, my lord. In fact, my lord, what has happened pursuant to that, my lord, a representation was given by the said officer saying that these are factually incorrect statements have been made in the suspension order. That is at page 8, my lord. Pursuant to that representation, my lord, it was forwarded to the Department of Personnel, UD department. Then they sought for certain clarifications. Pursuant to that clarification, my lords, we have passed a fresh order of withdrawal of suspension that is dated, my lords, 3rd September 2024 at page 12. So, in fact, my lord, having produced this order, my lord, they ought to have produced the withdrawal order. They can't mislead, my lord.
The withdrawal order communicate ಮಾಡಿದ್ದಾರೆ.
No, we didn't communicate to the suspension order also, my lord.
ಅಲ್ಲ ಆಫೀಸರ್
ಯಾರಿಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ ಮಾಡಿದ್ದೀವಿ. And it is between us and him.
ಅವರಿಗೆ ಪತ್ರ ಲಗತ್ತಿಸಿದೆ ಅಂತ ಕೊಟ್ಟಿಲ್ವಾ?
ಏನಿಲ್ಲ.
Yes. All right. Yes, sir. Yes.
Lord,
Senior counsel has come. ಅವ್ರು ಮುಗಿಸ್ಬಿಡ್ಲಿ ಏನ್ ಅರ್ಜೆಂಟ್ ಇದೆಯಾ? ಏನ್ ಹೇಳ್ಬೇಕಾಯ್ತು?
Written synopsis filed.
ಯಾರ್ದು?
Respondent number 3. Lord, one aspect, my lord, the earlier occasion.
ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀರಾ ಸಿನಾಪ್ಸಿಸ್?
Please.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ಅವರೇ, ಸಿಂಘ್ವಿ ಸರ್ ಆಮೇಲೆ ಪ್ರೊಫೆಸರ್ ಮುಗಿಸಿದ್ಮೇಲೆ ಮಾಡಿ.
Because there are some issues they are ought to answer.
Only 2 minutes.
Please.
You should also sprint in 2 minutes.
Please.
Yes, sir. Yes.
I thought it was.
No, it's finished. File kodi, madam. Main file kodi. So we're going to conclude this today, sir.
Yes.
Yes.
Wait, please, my lord.
Yes.
Whereas I am going to give your lordship say written submissions in the form of whereas extracts are also there.
Yes, sir.
Everything is in one place.
Yes.
And whereas I'm going to read some parts of it, but I'm going to whereas just develop the nuances of some principles of law. Your lordship may not find it in the sequence in which it is argued, but I'm going to be rejoining to each point.
Yes.
But in a different sequence.
Yes.
Your lordship may not whereas possibly get the answer to a particular question in the sequence your lordship expects it, but I'll do it in that way.
Yes.
And I will deal with all the issues raised. But let me at the outset, before I hand it over, give your lordship a summary of what I want to sketch out. And then continue in that line, in that sequence. Well, it's the first part is, of course, to keep in mind the backdrop of the umbrella of statutory protections provided, especially to an elected public servant, paving the way for an inquiry or investigation, which has very serious implications of diluting or unseating or creating a mandate contrary to the election. So that has to be interpreted in that contextual manner. That it is not just a walk-in, walk-out system. There must be a proper protective umbrella which is given its proper full letter and spirit. Implementation is a general backdrop point. Now, the other part which I will develop, I'm just giving a summary, is that it is a mistake to suppose by just citing MP or one or two judgments that the moment any government minister or chief minister is involved, automatically this very well and old and long established jurisprudence about governors having extremely limited circumscribed powers to act in their discretion, so-called discretionary powers, is automatically overridden. So the Constitution says, and Shamsher Singh remains the bedrock, says that the discretionary so-called exceptional powers of the governor are so limited and so specific. You now read onto it a proviso which is not there anywhere in no case law, and it's a misreading of both Shamsher Singh and of MP to suggest that there is. You engraft upon it a proviso to say the moment automatically, and I repeat the word automatically, a chief minister is involved, you must assume that the advice of the council is biased and engraft the discretionary power. That is not what either Shamsher Singh, MP says. Does not. It's a much more nuanced law. The nuance is that the law remains the same. The governor has no discretion because it is not part of his list of discretionary power. Obviously, we are not dealing with the discretionary power. Those are different areas. So in the normal course, the governor has no power. However, if it is shown, and the word shown is important, that in a particular case of sanction, the order denying or recommending no sanction suffers from transparent apparent bias. That is to be demonstrated. And the second thing was completely forgotten in the respondent's arguments last in the manifest irrationality. So there is no auto. But as I come, it's a slotting machine. I'm a chief minister. There is a cabinet, therefore auto. MP, you must straight away ignore, and the governor is free to act. No. The governor has to demonstrate that I am now acting in my discretionary powers because of A, this apparent shown bias. Shown means prima facie shown. Yes. And second, where there is no bias shown, and this is one case, and MP is very interesting, not a case of bias at all. The case went on, the demonstration that this order suggesting no sanction, words are, is manifestly irrational. Once you demonstrate that, then your discretionary powers come in, is the nuance point, much more nuanced than the generality of what was argued. That look, I have told you, this is a cabinet, this is a chief minister's case. No such concept. We state of apply. That I'll be demonstrating, Manas. The third aspect I'll be demonstrating is that your lordship has a very interesting order. According to this short point which I'm now saying is sufficient to set aside the order. I'm not saying your lordship will set aside on only one point. I'm just saying it is sufficient. It's so important and it should be given its due importance. My lords, without prejudice to what I'm saying about the nuance of Shamsher Singh and MP police establishment, without prejudice to that, the entire 5-6 page order of the governor impugned is only on one point. I am deciding independently. I am not bound by you, the order. Entire, I repeat. So the most important part of this case, if your lordship were forced to single out the most important part, is that for a minute, if your lordship accepts that he is not bound, without me conceding at all, I am always very heavily opposing it, but that he is not bound. The governor has not gone beyond those 5 pages to add a word as to how, not being bound by these people, I find how, what, when, or where the CM is complicit, prima facie, and therefore I grant sanction. His role, that is the CM's role in this file, the CM's decision on that day, the CM's ministry on that portfolio, the CM's file noting on that particular event, nothing is to show prima facie complicity, but I grant sanction because I'm not bound. The Honorable Governor, therefore, commits a very serious constitutional sin of answering a very important constitutional question by the answer, why not? The Constitution asks him to say why, not why not. Your lordship knows what is the why not versus why.
Yes.
Why not grant? We'll see. Sorry, that's not the constitutional thing with this. You have to show affirmatively why your lordship should be. Your lordship doesn't decide matters by saying why not. We allow or why not we dismiss the petition. Your lordship is forced to give reasons for this as to why. So that's the test. On this short point, Wallace, the impugned order is liable to be set aside because it does not address the question. It does not deal with it.
No.
Now, the fourth point.
One clarification.
Fourth point.
You said that the governor has passed the order without arriving at a conclusion that the cabinet was biased, or without even observing.
Without any material.
Without any material to show
says
that.
it is. I'm sorry to interrupt, my lords. He does say, this part he addresses.
Yes.
The other part, he does say, the cabinet is ultimately the cabinet headed by CM, therefore it must be biased.
So, no, he presumes it to be biased.
I'm very grateful.
Is
Presume
what
the
you
right
say.
word.
Presumes it to be biased. There's a concept of unconscious bias or subconscious bias.
Maybe.
Now, which cabinet will tell their leader to be proceeded against?
Well,
Which cabinet will approve, saying that yes, he is our chief minister, governor has sought opinion of the cabinet, and this cabinet is going to permit sanction or approval for proceedings or sanction for prosecution. Which cabinet will do that? Which cabinet will go against their leader?
No,
So this, if not apparent bias, or rational apprehension of that bias may have led, but that should be reasoned out.
May I answer?
Yes.
So first part is not reasoned out.
Yes.
First part is that. But second part, your lordship query is more important. Well, then, if your lordship were to accept that as a principle, then it is a case of presumptive bias. Then your lordship is not doing, kindly see what your lordship is really doing. I'm answering my lord's query on an argumentative basis. My lord has put a very important question.
There was a clarification.
No, it's a very important question. But just see, suppose your lordship's formulation as a question
Only
to me,
clarification.
only to elicit from me. Suppose your lordship's formulation was correct, just for a minute, obviously your lordship is not giving any, your lordship is only
That's true.
discussing. Suppose your lordship's formulation was correct. It would mean exactly what I said in the previous sentence.
Why not?
Presumptive, assumed bias in every case. Well, tell me which case your lordship will have of a sanction where your lordship will not have to apply this principle. But the law, the constitutional law is not that. Because your lordship then has the moment, then what is your lordship doing? Then my lord has in the constitution, A, B, C, D are only 4 discretionary powers of the governor. My lord is making this a fifth category. Always. Always. Then, my lord, why does MP go on? MP, my lord, doesn't go on the bias. If presumptive bias was correct, it had to be finished. It goes by analyzing that the reasoning of the cabinet is not right. It is manifestly irrational. And it is not irrationality, manifestly irrational.
A little higher pedestal of irrationality.
I'm very grateful.
Like how it is arbitrariness and manifest arbiter.
So, Malas, I'm very grateful, in fact, for the clarificatory question. The only case chosen by the Honorable Governor to cite is MP. But I've analyzed MP very carefully now, Malas. I hate to say this, but possibly the governor has not been assisted sufficiently, he's not a lawyer, to analyze it equally carefully. MP does not go on bias, which answers my Lord's query, because in every case of a cabinet and every case of a governor, then MP must be read to mean it's a sixth category of discretionary power of governor. MP doesn't say so. Secondly, if my Lord's the clarificatory question was correct in the conclusion, then there will be no manifest irrationality. Which governor needs to go to manifest irrationality, Wallace? Doesn't need to. Your Lordship is not to waste your Lordship's time to go to manifest irrationality when it's presumptive bias.
It was only a clarification. That
no, I'm not saying your Lordship. I'm answering your Lordship's question. The governor doesn't have to waste his time. If he has, why should he examine manifest irrationality? So suppose, Balas, and there are two categories. One is, Balas, your Lordship has given me the category where which cabinet will go against. Of course, Balas, in politics there are enough cabinets which go against. It is not, Balas, so sanguine and so uniform as your Lordship might think, Balas. These are very turbulent waters, to put it mildly.
Yes.
But that apart, your Lordship is not looking at the other aspect which my learned friends will, my learned friends are not looking at other aspect which your Lordship will appreciate. That cabinet, if it gives, forget this case for a minute. I'm testing your Lordship, the proposition. If the cabinet in a hypothetical case gives perfect reasons, right, it says this chief minister has done nothing.
That's what the cabinet noticed in the case.
I'm not saying my case.
Yes.
Forget my case.
All right. Hypothetical
case. That this cabinet has said that this chief minister is always sitting at a 10-mile distance from all these decisions over 20 years. But in fact, it's a very unusual case. I mean, I'm going to be delivering all this. It's a very, very interesting case, fellows. 23 years. More than 23 years, at least 23 public servants must have been involved in this. The list of dates your Lordship has got from my side and this side.
Yes.
One person is singled out by these complainants, 3 complainants, with somewhat dubious antecedents sketched in my petition. One public servant is culled out after 20 years. And in those 20 years, this man, has been a minister from his 1984, I think he became a minister in the 80s. Across, he's held many portfolios. No particular portfolio on this issue, no particular file, no particular decision, no particular recommendation, no particular approval. Your Lordship will not easily find a case like that. Your Lordship finds. Now, I can understand a governor saying, despite this, I find Mr. Singhvi's reasoning wrong by 1, 2, 3. But more importantly, apart from Mr. Singhvi's reasoning being wrong, I find that Mr. Siddaramaiah is complicit or is involved prima facie or needs to be given sanction prima facie because of ABC. He doesn't say it. He doesn't say it. He doesn't address the issue. Which brings me to the next point. And therefore, very important clarification. I'm very genuinely grateful for your Lordship's query. 2 answers to that. 1, your Lordship is not carving out a new category of presumptive bias. 2, MP, which is the only case relied upon for only by the other side, forget the other side, by the governor, is a case where they did not take up apparent bias in a cabinet governor case. And 3, it must show, therefore, a perverse 2 + 2 = 5 error amounting to manifest irrationality, which the governor has not said. He's not even said so. If he had said so, I would have shown he's wrong. But I don't need to show that because he has not said so. Now, which is why it brings me to my third point. It is because of the previous point that my learned friends do something very extraordinary, that is, well as the state government. I'm sorry, the person representing the governor, not the state government, the person representing the governor. Of course, governor acts to the state government, but well as he's represented by a separate council. Very extraordinary thing. Keeping in view that there is nothing about manifest irrationality. There is nothing about any reason by the governor and nothing reflecting the process of ratiocination. A lot has put it very nicely in many judgments. These are the materials. That is the conclusion. The chain which links the material with the conclusion is known as the process of ratiocination, the process of reasoning. Now, there is no reasoning about why he is guilty, prima facie, or why the cabinet is wrong. The only reasoning is that the presumptive doctrine my lord put. Per se the cabinet, per se the chief minister, therefore I must act. Why I must act is not there. Which is why a third point is pressed into service after the case starts. What is that third point? Knowing that there is no manifest irrationality commented by the governor, knowing that he has not dealt with any issue about Mr. Siddaramaiah, knowing that he has not found any reason to deal with the cabinet itself. They say now, after the case is started, we will not file an affidavit. We will produce files. And well, I mean that, well, like Alice, it gets more and more curious. So first thing is, I will produce files. Files are produced. Second thing is, in the files, there is only, if you also look carefully, a chart saying 2. He then, Wallace, puts the 2 versions, and in the entire bunch, big fat bunch given to your lordships, he doesn't say anything except at the end, I think it should be given. But more importantly, none of the reasoning in the files by the lower officers, not one word is reflected in the impugned order. There is no law that I know of that you produce material and say you deem this sanction order to be valid, because at the back of my office, people gave me 5, 10, 12 versions with 1,000 pages of files. That is like saying that I will be the inscrutable sphinx. Behind the inscrutable sphinx, the pharaohs put a lot of gold and a lot of saman inside.
The silence comes about.
So I will remain the sphinx, but the saman behind in my grave can speak for Malus. It all lying in the...
That's right. The inscrutable face of the sphinx has something behind it which cannot be projected by that silence.
And your lordship as a judge should be deemed to validate the inscrutable face because of the saman behind it. But what is interestingly, that huge treasure house of saman is not finding a word of reflection in the order. Well, I can understand. Nobody is saying that the governor is a judge who's writing a 50-page judgment. Nobody is suggesting that. The governor could have given some reasoning culled out from those 2 versions and 1,000 pages. It is not for your lordships to rewrite the order of the governor. That I am the judge, you have thrown at me 1,000 pages, the order says nothing. I as the judge will ex post facto validate it by giving these reasons. Which ultimately comes back to the same point, Maris. The point remains the same. That your lordships is entitled to quash this order on the short ground that it is not dealing with these issues. Neither manifest irrationality nor why. You are saying, of course, that there are reasons inside. But Maris, and 2 versions is not a sufficient ground at all. Much more so, Malas, when you are disagreeing. You are disagreeing.
Yes.
You are not upholding. Your lordship knows, Malas. There's a difference. Your lordship judicial review is much more heightened when the primary matter is coming on a disagreement. Your judicial review is a little different when it's coming on an affirmation. So that was the third and fourth point, Malas, which I'll be developing. The other point is, Malas, about 17A. Now, Malas, there are 2 facets there I wanted to just touch on, then I'll be developing them later. Well, 17A is not, Malas, in any manner, 2 or 3 points. First, in 17A, the interpretation canvas for your lordship is to an extent, Malas, faulty and erroneous, is my submission by the other side. Why is that? A very broad brush blanket proposition is thrown at your lordships. Lalita Kumari test is 17A. I strongly object to that. Lalita Kumari test is not 17A test. In fact, it's very interesting. I've now investigated the legislative history of 17A. The idea of 17A was to provide a genuine, strong filter.
Yes, a protective layer.
Protective layer is the correct word, filter is the correct word, and umbrella of protection is the correct word.
No, both are used to protective layer to protect the innocent and not shield
Not
the
shield the
guilty.
guilty. Correct.
That is what is said
correct.
in
Absolutely. But Balaz, Lalita Kumari, born much later, can't be just read into 17A.
No,
His
when
tests are all mixed up.
17A comes into the statute,
Yes.
Lalita Kumari is 4 years before the 17A coming into the statute.
No, that's true, Balaz. But the FIR test of Lalita Kumari could have easily been put in 17A.
Oh, that is not put in it.
No, not only that. I show that, Balaz. In fact, the legislative history originally of 17A provided for the filter through the Lokayukt. That's very interesting. The idea was that I am now not on the deletion because the first argument is deleted, which means the filter is on. That's not the argument. But what happened was that they went through very draft. I've got in my note. Broadly, it said it is a protective. They were emphasizing the protection. Otherwise, governance will come to a standstill. That's the whole idea of this. We have enough people taking pot shots every time. And according to me, this is a classic case because after 20 years, your lordship has different kinds of. But the protective layer originally envisaged was A, a full substantive, and B, it had to go to a very detailed scrutiny, and they put the Lokayukt. Then they said Lokayukt will be a different institution. So we change it only as to the hooper, not the test. We change it to the government or the police officer. So the change is from him to me. The change is not of the degree or the heightened degree of scrutiny required. That's going to be my point. Then, to dissolve it from that higher test into a Lalita Kumari test. Lalita Kumari test is a very, you should know what Lalita Kumari test is, at the end of the day. It is ultimately, you go and file something and you're supposed to act on that. That is, reducing the entire object of 17A. And then, I'm also going to be showing to your lordships that, and this, your lordship has a judgment on this, Shirupa's, but I have a different nuance to it. I've quoted it as to the nuance. I believe, and this is going to be one of the arguments, that it is for the investigating officer to first form an opinion that inquiry or investigation is warranted. I'm choosing my words carefully. The investigating officer must first form an opinion that inquiry or investigation is warranted. I am the investigating officer, I form the opinion about him, and then I seek approval for that opinion, having that first form the opinion. According to me, to allow a outsider, a third, not out, let me go to third party.
Who is the third party here?
Third party,
the complainant?
Complainant.
All right.
The third party could be, outsider or complainant or whatever, third element. To a stranger, to come into it is to actually remove a very significant part of the protective layer. Because I am the investigating officer, I form an opinion about it. I take it elsewhere for approval. Thereafter, people, it's not that it's the end of it. There are so many other remedies. But here, my formation of opinion is the first step. Approval is the second step. Before these two steps, the third party actually removes the protective layer altogether. That's the second error on 17A, is going to be my submission. And Shirupa is being wrongly read. The lordship has not changed this law, according to me. And of course, other issues will be there, which I will be coming to later. So let me, and of course, on the facts, I'm saying. On the facts, that's a separate argument. On the facts, if your lordships, and this is wholly without prejudice, applies even Lalita Kumari. You don't even satisfy Lalita Kumari. You don't satisfy Lalita Kumari. Because it's the same question. On Lalita Kumari, you have to show some complicity, some involvement, some what, where, how, when.
That's para 120.1.
It comes to that, ultimately. I am trying to assist both on the legal principle and then, of course, the facts. Now, let us just, this is a fairly long preface. Let me start with the note. Give the copies on the side.
So this was a preface?
No, it's a summary, not a preface, a summary. Just tell us. No. Now, Malas, I'll be reading parts of it, but and then Malas, let me read the first part of it.
Yes.
At the very outset, it is most respectfully submitted the present case falls for this honorable court's consideration of an action taken by the highest constitutional functionary of the state, by which the umbrella of statutory protection accorded and afforded to public servants has been lifted. Case involving the elected chief minister, paving the way for an inquiry or investigation. As such, shorn of the personalities involved and the positions which they may presently hold, this honorable court must subject such action. That's the point I'm trying to make. It's your lordship's scrutiny.
Where are you reading?
Oh, I'm very sorry.
Yes.
I'm very sorry. Para 1.
Oh,
My apologies. I thought your lordship.
yes, sir.
And it will be faster reading many parts of it because of quotations,
No
but there are very important points. The nuances are important. That's the.
Yes.
So now the first para is not about chief minister. It's about the heightened scrutiny of the court required. That's what I'm on. At the very outset, most respectfully submitted that the present case calls for the honorable court's consideration of an action taken by the highest constitutional function of the state, by which the umbrella of statutory protection accorded and afforded to public servants has been lifted. In a case involving the elected chief minister of the state, paving the way for an inquiry or investigation, as such shorn of personalities involved and the positions which they may presently hold today, this court must subject such action. This is the proposition. This court must subject such action to the necessary judicial scrutiny, such that the fine threads of constitutional democracy are kept in balance, are not frayed, unduly stretched or torn asunder. Little rhetorical, otherwise, the following points are highlighted.
Yes. Asunder is apart. Yes.
Correct, absolutely. The order of granting approval must fully disclose a reasoned application of mind by the authority concerned. In the instant case, the impugned order of the governor fails to meet this test, the fact there exists this power, albeit an extremely narrow one. Now, this is the nuance. It exists. Nobody is denying. My learned friends have argued as if it's an automatic. You just call out two names: cabinet, governor, chief minister. New discretionary power. No. Narrow one, to differ with the aid and advice in certain situations, I'll be demonstrating this, does not exempt or relieve the governor from the obligation of passing a reasoned order disclosing application of mind. Because they are doing a double whammy. Just note this. Actually, in the normal course, the governor is a no-go area. You are allowing a special area to the governor in a matter where also additionally having taken that power, he's not disclosing his mind. I will call it, Malos, in loose colloquialism, double whammy. The governor anyway can't enter this house. In the case of a chief minister, a nuanced, limited case, he may enter the house. But having entered the house in an exceptional area, he also gives no reasons. It's a double whammy. It's a double constitutional whammy. The reliance by respondent to on file notings and comparative charts, tables or notes analysis as dictated by the governor. Well, I take it when we say dictated by the governor, no governor dictates what your lordship saw. We all accept it. We can say dictated by governor's office, no problem. Don't say dictated by the governor. I don't think anybody here is so gullible to think the governor has the time or what is the interest to dictate what your lordship saw in the files. So let's call it governor's office. Is wholly impermissible. We live in the real world. We have to smell the coffee. We can't be in some other land. Is wholly impermissible in the absence of these documents being placed on record under cover of an affidavit. That also I let go. The affidavit is not put. Let's leave that. It's a point to be noted nevertheless. Moreover, in any event, the impugned order itself refers only to allegations in the petitions and the supporting documents and makes no reference to these charts, tables, notes, analysis in the order. No reference, Malas. Not one word. Not a word. I've checked it, Malas. And therefore, it is not an order which refers to or is based on antecedent file notings, nor does it endorse, accept, adopt, or in any way engraft such notings. All those 4 words. Endorse, accept, adopt, or engraft. Malas, if this principle is accepted, which judicial review can your lordship squash? I am putting the same kind of question in a different way. Which lordship will never have a case. The file speaks for itself. I have written an order, matter dismissed. Please check up the file and find the reasons. I have a very impressive staff. I have thousands of pages. I have people making notes. I have dismissed your matter. Check up the reasons for the file. That's not the law, Malas. The whole administrative law, public law will fall to the ground. Your Lordship's doctrine of judicial review, forget Tata Cellular, my lords. Ordinary principles of judicial review will not be there. The nature and extent of judicial review as it applies to such actions of the governor, applying his independent discretion. Now, my lords, here you are more. Your Lordship knows you are going to exceptional area. Therefore, judicial review is more. Therefore, reasoning has to be more robust. The other nuances which have been missed out, with great respect, I say so, my lords, in the respondent's approach, must be all the more robust in cases where the governor is exercising a power that ought ordinarily to be exercised only on the aid and advice of the Council of Ministers. Thus, in cases where a different view is taken, the burden is higher to show that there was manifest irrationality. This is a phrase of Wallace MP. In the advice of the Council of Ministers, thus requiring the matter to be considered decided independently.
So whenever the cabinet he is disagreeing with the cabinet, the reason should be on a higher pedestal.
A, starting point is that. B, your Lordship's scrutiny also is correspondingly more heightened on those reasons.
Yes, we will do.
It's not, nobody's final, only your Lordship's final, that too on subject to Supreme Court.
Yes.
In fact, the Supreme Court joke is the Supreme Court is right because it is final. It is not final because it is right. Nobody is final except God,
Yes.
But in our hierarchy, the governor is not final.
No, we are reviewing it now. Yes.
So, these two double heightened is important. You are going to an exceptional area. The very nice, those debates are worth going every time back. When I read those debates, Mr. Ambedkar, there's a huge long debate about governors. He says, why should you not have elected governors? Very strong, genuine proposal, bona fide. Then there's another debate about how will you find good people? So he says, Mr. Ambedkar replies, says, there cannot be two swords in one scabbard.
That's why Article 143 of the debates was reduced to 163.
163, no, and then he says in the debate, he says there can't be two swords in one scabbard. Then he says that we are in fact thinking, it's a very interesting passage, we are thinking of nominating governors and the post is so kind of non-active that we are very doubtful that we'll get any applicants for the job. That's not true today, Manas. But Ambedkar certainly thought that, Manas. Anyway, the idea of a governor was a no-go area in 95%.
No, if you see the Constituent Assembly debates,
yes,
where it was, the draft was drawn first. Article 143 dealt with this.
Yes.
Governor has to be elected, nominated or otherwise.
Exactly.
Then 163 is the final form that has come.
In between is this discussion, he said, no, elected means he's also elected chief minister. I am also elected governor, two spots in one scabbard.
That's why it was
want to neutralize him and put him only as a nominated. Then he says nominated also with very little powers. Nobody may want the job at all. Then what is the next point? The power of granting approval under 17A of the POCA is not an independent discretionary power of the governor, but an executive power or executive function which should ordinarily and normally be exercised by the governor only on the aid and advice. This is consistent with both some last sentence in my proposition, wrongly suggested to your lordships otherwise. A broad brush is done. It is thrown, some share had this, on that one word, not exhaustive. Lordship remembers the argument, it's totally wrong. Exhaustive doesn't mean Lordship is rewriting the constitution with a number of new engraftments of the governor's power. The exceptions to this rule are not an open-ended category, nor did the Honorable Supreme Court in some shades should set forth a non-exhaustive list as sought to be contended. Now, real para is, this is IR 154. And there is nothing in the majority which is inconsistent with 154. Nothing. As part of the concurring judgment, there is no variance by the majority to this concurrence. I'll be developing all this, but it's just a summary. The decision is MP Oil carves out a narrow MP Special Police, I'm very sorry, narrow and extremely limited exception where the governor may differ from the aid and advice. Now just see the nuance. Where there is overwhelming material on record on the basis of which prima facie case is clearly made out and yet the council has refused sanction. I'm taking Wallace. Forget this case, I'm giving the law Wallace. Then to the extent the decision of the council is ex facie or manifestly irrational. Manifestly means ex facie actually. Or relevant material has not been considered, the governor may take a different view. That's the nuance. The findings in para 32 of the judgment, which are cited in the impugned order, relate to manifest irrationality and not to apparent bias. Now look at the error now. This is a matter of caution. I don't want to oversimplify, I don't want to exaggerate. Just kindly consider this. The governor, the honorable governor cites one para of MP, which is 32. And then entire 5 pages is bias, presumptive. The clarificatory question which my lord put. Presumptive bias, automatic bias. And he cites this one para. There is a manifest error by the governor himself because the para cited does not touch on bias. It says apparent bias, which means demonstrated bias. Somewhere, he's attending the meeting. Demonstration is not difficult. I attend the meeting. Or I don't attend the meeting. I attend the meeting and I say, I will go out to the room and have a cup of coffee. You go and decide. Or I recuse myself. Whereas this meeting is separate, and otherwise the man is fully in every ministry dealing with the subject. It's possible. It happened partly in Antule's case, where I had the privilege of assisting the court. Antule, your lordship sees the file notice that directly is involved in so many things.
Yes.
So now in that case, apparent bias may be demonstrable bias. But if subconscious bias was the test alone, then your lordship doesn't have to go to manifest irrationality. And the moment you have a paradigm of a cabinet, a chief minister and a governor, it's automatic.
No, the two are contradictory. Subconscious, any concept of subconsciousness need not be manifest at all. This is the subconscious level.
Yeah, no, I'm saying subconscious will mean manifest is to create the reasons. Manifest is not create bias. Manifest is create irrationality in the order. I'm saying, if your lordship were to accept presumptive automatic bias, then the law would be that in any case and every case, without examining the reasons of the cabinet for being wrong or right, merely because it is the cabinet and merely because it is the CM, the governor must automatically deny or grant sanction, as the case may be, on the ground that MP means that the moment there are 3 entities, governor, CM and cabinet, bias is established. I don't have to examine the order of the cabinet to see whether it is manifest irrational. I hope I'm clear. That's my proposition. So that's the proposition.
So you're saying that irrationality should be palpable and demonstrable.
In the order, no.
In the order, only then that would come about. That is your suggestion.
He must address it. I will let it put it lower. Let me put it lower. For my lord is absolutely right according to me in the way your lordship is formulated. So that is number 1. But let us take a worst case against me. I am now deliberately testing. First point is what your lordship has said. That's the perfect formulation for manifest irrationality. But now I'm taking a point against myself. Let me assume that the governor doesn't delve into the way your lordship has put it just now. He must show something that, look, I have read para 50 to 80 of this cabinet decision. They missed out that in para 69, this gentleman was actually handling the portfolio, or he gave an instruction, or he did sign the file. This is the error of the cabinet. And therefore, I believe prima facie there should be some inquiry. What the learned governor does is, he doesn't address, he doesn't go down that path at all. He says only, I'll read the order again.
Yes.
He says, because this is a cabinet is deemed to be, I wish chief ministers would appoint cabinet the way the governor thinks they can. A lot of chief ministers would be very wistful to be told that every member of the cabinet is appointed by them. Your lordship knows that, all of us know it. But let us for a minute assume the only reason given is cabinet is deemed to be part of Mr. Siddaramaiah. Siddaramaiah is the head, and the constitution says that the cabinet is represented through the chief minister. He's the first among equals. Therefore, presumptive bias, what your lordship put to me in a question form. Therefore, there is no question of my going and seeing where in para 89 they have messed up or given an irrational reason. I don't need to go there. Why? Because para 32 of MP Oil says so. But MP Oil never talks of bias. I'll read that. MP Oil goes into and says the cabinet is wrong for these reasons. And therefore, the governor must do it independently and decide it like this. This is the error of the approach. Para 2.3.4.
No, are you saying that the governor should not have disagreed with the cabinet?
Not at all.
So his disagreement should have been found in the order.
In his
reasons
order,
in the
in
order.
the governor's order.
Governor's order. That
Absolutely.
is your submission.
That is right. I can never say that he can never disagree. That is an extreme proposition and that will never be said.
So the disagreement should be found
And
by reasons recorded in writing in the
First
order.
part is just your lordship, full stop on the first sentence. Disagreement must be found in the order. That is enough, full stop.
All right. Yes.
Second part of my lord's formulation. If it is found in the order must demonstrate manifest irrationality in the cabinet with which he is disagreeing.
Why should it be found in the order only if the files contain reasons?
He has to know. Files will contain. He has to, not by, he has to give some process of reasoning by which he comes to that conclusion.
Yes.
The third part, if the second part is not correct, then the order will say, I grant sanction. Go and find the reasons in the file. Then what is your lordship going to do? Judicial review? What is the heightened judicial review? What is the meaning of manifest irrationality of MP? Your lordship will have then the sphinx. Then the sphinx comes in. Your lordship has to dig behind the sphinx and find out something.
Yes.
Last one. MP police is not an authority for the proposition that there is any presumptive rule of apparent bias. I'm addressing the issue. Your lordship's clarificatory question is more pointed, but in a sense I've addressed it here, partly. Without your
No, I am just getting clarification what is running in my mind. So you should not.
I am very grateful. I am genuinely grateful.
I'm not disturbing your flow.
I am genuinely, I would not say it otherwise.
Yes.
I am genuine because it helps us to clarify as we go along. Any query, it's most welcome, but it genuinely helps me to clarify because this is a matter where we are in the frontiers to some extent. Lordship should get the law right, apply to the facts secondly.
Because the submissions are so much, the horizons are so wide now. I need to take some clarification somewhere.
Great respect, it's most welcome and I'm absolutely grateful. The proposition that there is any presumptive rule of apparent bias on the basis of which the governor must always independently consider the matter when an allegation relates. I'm denying that is so. The first sentence. Paragraph 2.3.4, page 5.
Yes, I'm there.
The question of apparent bias did not arise in that case. Rather, that case concerned a question of likelihood of bias, also expressly rejected by the Supreme Court at So, subconscious bias is out. Your Lordship knows subconscious is not likelihood. Likelihood means I must show that there is some facts which will show bias against him. So that was the case. Even that was rejected. But still the matter went the other way. Why? Because of irrationality. That's what is developing now. The reliance on para 17 in the written submissions is misplaced and misleading. The MP Special Police Establishment case is not and should not be read as general authority for the proposition that in every case where there is an allegation against the Chief Minister, the Governor can exercise discretion independently, even absent any irrationality in aid and advice given by the Cabinet. The mere fact that the Governor may, in certain very limited situations, differ from the aid and advice of the Council of Ministers does not imply that every such different view of the governor is to be automatically preferred. Just like every view of the cabinet need not be preferred. My lord is absolutely right in that query, but I'm not suggesting that. In fact, the ability of the governor to decide to differ, this is very important, with that boldface. The ability of the governor to differ is itself necessarily linked to a showing of manifest irrationality of the advice received. And that makes sense, fellows. Your lordship has a proper governance up to the judicial system then. Somebody gives an advice, don't prosecute him. That is not final, fellows. It can be rotten, can be horrible. Somebody here gives an advice that I agree with that advice. He can be equally horrible, he can be good. And your lordship is the ultimate master, ultimate meaning in the judicial hierarchy. How does your lordship do your job, fellows, if these two people don't give anything and they say we just decide? And the test your lordship applies will always be of irrationality. Has to be, fellows. There is no basis to suggest in the present case, either reflected in the governor's input or otherwise, that the decision was in any way irrational. Forget your lordship reviewing, there is no such reason given by the governor. Even the written submissions on behalf of R2 do not canvass irrationality at all. They get stuck, fellows, by misreading 32, the other side, in the submission, and they just quote MP, because the governor quoted it. Not realizing that the governor never went on bias, fellows, in that case. Rather, the submission is entirely based on apparent bias, assuming it to be a presumptive rule that where there is an allegation against the Chief Minister or member of council, the council is automatically disentitled or disabled. This is exactly the query I think now, that fits in, which your lordship put to me. It's exactly that issue. The council is automatically disentitled. The word automatically is important for me, or should be underlined. Disentitled or disabled from divested from exercising its powers. These powers are instead vested as discretionary powers. The decision of the Supreme Court and MP does not mandate any such presumptive rule, nor ought such a blanket rule to apply where executive powers vested in the state by statute are transposed as discretionary powers of the governor merely because the allegations relate to a chief minister or member of council of ministers. The reference to the file put up to the governor and comparative charts, as well as notes dictated by the governor as part of a decision-making process, do not suggest any reasons as to why the advice was manifestly irrational. An optical juxtaposition of two versions in a comparative table cannot be equated with an application of mind. As your lordship said, I could have made 3 columns. Also, I could have made 4 columns. Why does the lordship prefer that column to this column, to this column, to this column? Let there be 5 paragraphs, 3 paragraphs, 2 paragraphs. Why that is preferred and this is not preferred, this is preferred, this is not preferred. I can't make a table and give a lordship. These are the various versions. The process of ratiocination required a link, a chain, or a clear nexus between these materials, the reasoning, if any, of the impugned order, and the conclusion there is. All this is conspicuous by its absence. The impugned order of the governor was passed in undue haste with a predetermined mind and exhibits a cherry picking. This word cherry picking is very important. I'll just show in a minute. But this is a case which demonstrates without doubt there is cherry picking. Without doubt. And very interesting. It shows cherry picking in the wrong and it shows cherry picking in the right. I'll just show that in a minute. Very interesting case. Where the present case was unduly and hastily fast-tracked, while several other applications for prior approval remained pending for long duration. My lord knows those 6 examples I gave. One year, one example is 2 years. 2 years. 2 years. Interestingly, while your lordship is hearing that matter.
Still pending?
No. While your lordship is hearing the matter, perhaps somebody's arguments have had some effect. One of those 2-year applications has been decided on 8th of August. And that is the cherry picking I'm going to show in a minute. After your lordships have heard most things just now. And it's very interesting. It's very instructive as what the governor could do, should not do, and did do. That is one of the complaint of which month in 21? 2021, which month? It's in 21. Decided in 24. Mine is taken up the same day and show cause is issued. Nobody's going to come and say this Article 14 arbitrary written on the file. Your lordship, read between the lines.
That was sanction or approval?
That was approval.
17A.
Your lordship would not even find a 17A pending for 17 months. Here we are 3 years. Give me the date of that application.
But in other cases, sanction was sought.
No, it is it sanction or 17?
I don't want to be wrong. I am told it is
19th.
Give me the date. I am instructed.
No, it can't be 17A, I guess.
But it should not be. Is different from can't be. It is.
This is 17.
You sure?
Page 127. Do you want me to give you?
120. Give it. 127. We have the order. Let's be factually correct. Give it. This is issued while your lordship is hearing the matter. So.
Not while hearing the matter.
One minute.
You appear for the complainant, not the governor.
No. What is this?
After the PM's reply, this particular document, just come to 127 minutes. After this, the chief minister, my client, replied. When did I reply? 3rd of August, I replied. 9th of August, this order comes. As directed, I am enclosing a copy of the decision of the competent authority for permission to conduct inquiry under 17A. So first point is 17A. I hope I am clear, Malas. It is 17A. Against Shishikala Jole, former government, etc., etc.
It is permission is denied.
Yes. That part is not surprising, but that is different. This is denied. It is. Now, let's not get into details, but this is a supposed sting operation on camera for a person supposedly supplying eggs, etc. for midday meals of schools, recorded on candid camera, where the Honorable Governor takes 2.5 years to apply his mind, and after 2.5 years or 3 years rejects it. In my case, for 20 years, not a single file dealt with by me, and he issues show cause on the same day. Well, this is not Article 14, it's shocking, is the word for it. But at the moment, I'll be coming to this thing. 17A is important, the question my lords asked. Give me the date when they are. I'll not give you the date. It's 2021 someday. 9/12/2021. And the decision is 9th August 2024, exactly 3 years. 4 months less. That's all right. You don't get into details. Well, the application is also in this bunch at page 693. In the writ petition, Annexure J, is this application which I talked about. December 2021 is when the application was made to prosecute or to get this 17A.
Yes.
This small digression, I'll spending a minute, half a minute onwards on Article 14. As I've said so many times, the two most important articles, and even more than 21 is 14. And 14 had 3 phases. Give me a minute to digress. I know it's a digression, but it's very important to emphasize. Till when it came in, your lordship knows those so many decisions, Charanjit and R.K. Dalmia. We had basically the discrimination facet of 14. Classification, doctrine, and discrimination, but classification mainly. In Royappa, which came 30 years after 74, 30 years after independence. Justice Bhagwati, for the first time, brought in the seeds of arbitrariness. Then those 70s and 80s, the same Justice Bhagwati developed it beyond compare in all the Ramanna Shettis and all the cases. I hope I'm clear.
Yes, yes.
So you had a second facet of 14. Then the third facet came in Maneka, developed later, or procedural due process. We still kept the figment of the fig leaf of denying that we have no substantive due process in our constitution, because the lordship knows Venegal Rao had gone abroad.
Yes.
Frankfurter said, do anything, but for God's sake, don't put this phrase, due process. So Article 21 had a due process clause, or the counterpart article. So when Venegal Rao met Frankfurter, who was a very restrained, limited judicial review man, he said the bugbear of American jurisprudence is this crazy phrase, due process. Don't use it, do anything else you like. So Venegal Rao came back and reported. So they put this phrase, except in accordance with law from the Japanese constitution. They dropped due process. So we like to say that we had no due process, but Maneka brought in procedural due process, clearly. So that was phase number 3. Then finally now, in a trinity of judgments authored by Justice Nariman, there is full substantive, full-blooded substantive due process. Both Venegal Rao and Frankfurter must turn over in their grave. Because triple talaq, this adultery, then that Swiss ribbons, all of them recognized IBC under different. That substantive due process is a part. So your lordship can see the degree of unjustness to strike down. Now, I am saying that if your lordship were to apply even the old test of 14, now we have 4 facets of 14. This kind of conduct that you take 3 years minus 4 months for a 17A and then reject it for a candid camera, the complaint is there, it's a recording of what is done about midday meals. And on the same day for a person who for 23 years has not signed a file, not made a recommendation, not been anywhere, you issue a show cause, then you don't need Article 14 for that, you need common sense, is all that I'm saying. You don't need Article 14 to make out clearly. Now at 2.9. No, I'm sorry, 2.8 is very important. 2.8 your lordship is marked cherry picking. Now your lordship will come to 2.8A. Two facets are interesting and ironical in this regard. None of the diverse complainants seek any sanction, prior approval in respect of any of the multifarious public servants alleged to be involved in the present case, stretching from 98 to 21 over a period of 23 years. I'm sorry, My lord has got it. I'm very sorry.
Yes,
2.8a.
there.
The last sentence, please read. Petitioner CM is singled out for the affection of the complainants. 23 years, hundreds of officers, not a single one. Secondly, in stark contrast to the impugned order, which does not contain a word as to how, what, when, and in which manner. This is very interesting for us. The governor finds the petitioner even remotely culpable for the purpose of granting sanction or prior approval. The very same governor gives specific reasons in the order of 8th of August regarding lack of culpability while rejecting the proposal of prior approval in the case of Shashikala Jole. A case specifically stated in the pleadings pending before the governor for several months. Well, the sentence is not correctly drafted. It should be comma, maybe continues. The point is, Wallace, I am not asking for reasons, inviting. I'm saying the order is bad because it has no reasons. But is it not relevant that your lordship is hearing a matter? 8th August is hardly a month ago or whatever, Wallace. Your lordship gets an order which has reasons copiously saying why don't grant sanction. Because this person is not prima facie complicit. Because this person is not prima facie found to be involved. And in my case, on the same day show cause, not a single reason. Then 2.9. The manner in which approval has been granted is contrary to the statutory scheme and judicial interpretation of 17A. The statutory restraint is on the investigating officer. It is thus the investigating officer to first form an opinion. Their inquiry, this point is important, Wallace, in the nuance of the interpretation. I'm coming to that later. Thus, for the investigating officer to first form an opinion, don't prevent him from doing that by this lateral entry. That inquiry or investigation is warranted and then seek approval or inquire investigation. The statute does not contemplate the said approval being sought by a third party, namely the complainant. The respondent wrongly contends that the test to be applied at the stage of 17 capital A is only whether the materials disclose the commission of a cognizable offense. The legislative history behind the introduction of 17A does not support such a contention, as is demonstrated later, even assuming that 17A is different from the standard of sanction. I'm assuming it, my lord has got that para. That does not mean that it is a Lalita Kumari standard. The lordship may add in hand here, third point. Even Lalita Kumari is not met on the facts. That's a third level argument for us. Because the same reason, doesn't tell you how I'm involved, when I'm involved, what did I do, recommendation, signing, event, decision, minister, portfolio, nothing. Even if the Lalita Kumari test is applied, in the facts of this case, it is clear on record that do not disclose the commission. The complaint request for prior approval does not specifically advert to any recommendation made, decision taken, or even any action. This is the single most important point in this case in my respectful submission. As obvious from the reading of the order. The complaint request for prior approval sanction proceeds on a series of surmises and conjectures casting doubt on official actions taken in the ordinary course by different officials at different times under different administrations. They also proceed to disregard several registered deeds and instruments which ought by the nation not to be doubted. It is clear that the petitioner himself had no role to play in the decisions or even deliberations. I've added at the end a list of dates for lordships, which I'll be coming to. It's very, very important on the facts. All this prejudice was created. Oh, there's a writ suppressed from you. The order in one case is this, in your case is this. It was never denotified. It was never factually wrong. Documents of registered deeds are there. They argued all this. I'm only rebutting. They argued the facts copiously. The poor cabinet has gone into it. My writ petitioner has got the documents. Still they argued those facts. So I put a list of dates at the end, Malas. Only for prejudice. Only to prejudice your lordships. That look, all these years, there is no acquisition. The acquisition is valid. The acquisition could not have been given back. 48A is wrongly done. Notification is wrong. Everything is wrong. Document said otherwise. Now, this 50-50 rule. It is clear that the petitioner himself had no role to play, or even deliberations leading to the decisions in the case of denotification, registration of deeds, decision by Muda with regard to 50-50 rule being applied, and allotment of compensatory sides to wife of the petitioner. Otherwise, had I got a role to play, I would certainly not have taken at least a decade to get this done. And had I a role to play, some of the most operative decisions would not have been taken when I was in the opposition. Some of the major ones. In fact, the Muda decision was taken in 2020 and implemented in 21-22 at a time when the petitioner was in opposition and not even a part of the government, and this is given to 19 or 20 or whatever number of other people also. It's a general policy decision, nothing to do with me.
But your son was a part of the board there in.
I'll be showing that board. That's part of my list.
By being an MLA.
MLA. He's ex officio.
Ex officio member of the decision-making body on that particular day. Your son was a part of it.
Which, Malas, is A, ex officio requirement A, I did not make him. B, the decision is across the board for so many people.
No, true, it's across the board, but.
And I'll be dealing with that.
2 meetings.
That's not the point. And Malas, he is fortunately not named as
Two
an accused.
meetings, one in 2020 and one in 2021.
Yes. And Malas, they have not made him an accused. They have not short sanctioned.
They have not.
Is the constitutional or formal head. The president as well as the governor exercises his power is the constitutional or formal head. The president as well as the governor exercises his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. Wherever the constitution requires the satisfaction of the president or the governor for the exercise by the president or the governor of any power or function, the satisfaction required by the constitution is not the personal satisfaction of the president or governor, but the satisfaction of the president or governor in the constitutional sense in the cabinet system of government. That is, satisfaction of his council of ministers on whose aid and advice the president or the governor generally exercises all his powers and duties. And Malas, that old saying, the elected people have a fundamental right, a duty, I would say, to do good. But they also have a right, not a fundamental right, to do bad and wrong. But it is their right to do wrong. It is my right to do wrong, and this population will set me right. It is not the governor's right to set me right, or the president's, is what Shamsher Singh's soul and spirit is. That's the meaning of elected democracy, or in a parliamentary system. It may not be in a presidential system the same way. Then, Malas, 54. The provisions of the Constitution expressly require the governor to exercise his powers are contained in articles to illustrate. Now, one article is given on the third line. Come to the boldface. The other articles which speak of the discretion, there are typos here. Typos have not been seen. Paras, what is that section? S2 and 18.3 of the 6th schedule. Then articles so and so. The discretion conferred on the governor means that at the constitutional head or formal head, the part. This is one of the Northeast. Those powers, your lordship has special powers there, Malas. Then Malas 55.
Yes.
This is the failure of constitutional machinery. In the context, Article 163, I don't know why, Malas, only the articles are wrongly typed. Everything else is correctly typed. The number is 163.
Article 163.
Somebody is going with the uppercase and the lowercase is this.
That's not correctly typed. That's all.
It's 163 actually.
Yes.
Multiple, all of them.
163.2 it should be.
In article, in this context, 163.2 is explicable on the decision of the governor in his discretion shall be final and the validity shall not be called in question. Next, 2 lines later. In all other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The constitution does not aim at providing a parallel administration in the state by allowing the governor to go against the advice of the council of ministers. In such matters where the governor is to exercise his discretion, I'm reading para 56, he must discharge his duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. For the foregoing reasons, we hold that president or governor acts in the aid and advice of the council of ministers, with the prime minister at the head in the case of the union, chief minister at the head in the case of the state, in all matters which vest in the executive, whether those functions are executive or legislative in character. Neither the president nor governor is to exercise executive functions personally. I try and summarize some things in page 12. Next page. In relation, I've put them point formulas. In relation to functions that are vested in the executive, the governor shall act at the aid and advice of the council with the chief minister at his head. The governor shall not exercise executive functions personally. 48 and 57 paras. Where the constitution provides that the governor shall act in his discretion, here the articles are correctly put, Malas. Even in these matters, the governor shall act in harmony with his council of ministers. These are, Malas, nuances which we tend to forget. It is not, Malas, very interesting nuance. This Shamsher Singh, 74, Malas, is saying that even where he has a separate power, He must act in harmony with me in that. Look at the whole delicate balance. You can't say automatically I receive the cabinet decision because the chief minister is involved, I'll defer. Thus, there is a constitutional restriction on the discretion which is not to be exercised as a personal function or as a function conferred on him, eo nomine. In very limited scenarios, such as under 356 is a classic case, and 200, the governor may act in his own discretion even against the advice of his council. In such cases, the governor is to exercise his duty to the best of his judgment. That's para 55 and 56. Now, the most important, Justice Krishna Iyer. Now, why it is misrepresented, Justice Krishna Iyer is right. Not a word in the majority. He's concurring. He's concurring. Not a word in the majority dilutes or overrules or goes against him. Then why should Lordship not read Krishna Iyer? Justice Krishna Iyer just brush aside, he's a concurrence. But concurrence is not a dissent, brothers. Please don't read the concurrence as a dissent. You can point out that this concurrence is violated by this part of the majority. That I can understand. Not a word. Ignore it because of the concurrence. And Justice Krishna Iyer spoke for himself, Justice Bhagwati. If the inner voice of the founding fathers may be any guide, para 113, it is proved beyond reasonable doubt that the president and for sure the governor enjoys nothing more and nothing less than the status of a constitutional head in a cabinet type government, a few exceptions and marginal reservations apart. Mark this word, a few exceptions and marginal reservations apart. Yes. Actually, the governor has more powers than the president. Yes. People tend to forget that. President is even more limited. Governor has little extra powers. For example, president has no 356 powers. Yes. Our Pakistan president has a 356, which he has liberally excised 2 or 3 times. He dismisses the national government with us. We decided against having that in the president. We had it only for the governor. Nobody can dismiss the central government here with us. Of course, there is some qualitative difference between the position of the president and governor. The former, under 74, has no discretionary powers. The latter too has none, save in tiny strips. Look at the approach. Tiny strips covered by, please forgive me for the typos, but it's 163, somehow coming at 1C3. And all the others are given. These discretionary powers exist only where expressly spelled out, and even these are not left to the sweet will of the governor, but are remote controlled by the union ministry. This is very important. Well, the governor, when he acts independently, so-called, is independent of the state government. But the union government is answerable to parliament with a whole set of provisions. Lord should know the 356 proclamation expires if parliament doesn't approve it within a certain time period. Again, a minimal area centering around reports to be dispatched may not, that's for 356, not 35C, may not in the nature be amenable to ministerial advice. Now come to page 14. Even where express conferment of power of functions is written into the article, such business has to be disposed of decisively by the ministry, answerable to the legislature, and through it vicariously to the people, thus vindicating our democracy instead of surrendering it to a single summit soul. These are the simplest language which Justice Krishna Iyer may have used. He's erring on the side of oversimplicity. But a single summit soul has a rhythmic alliteration, which exactly describes the reason to avoid the governor or the president. That single summit soul is the governor or the president, whose deification is incompatible with the basics of our political architecture. Lest national elections become but Dead Sea fruits, legislative organs become labels full of sound and fury, signifying nothing, and the Council of Ministers put in a quandary responsibility to the House of the People and submission to the personal decision of the head of state. A parliamentary-style republic like ours could not have conceptualized its self-liquidation by this process. On the contrary, democratic, etc. Well, sometimes I think that how times have changed. Well, as today, even if you have a person like Krishna Iyer, he could never go onto the bench. Because we are into narrow confines. You can't be in public life, you can't be in law, you can't be on the bench.
No, he was in public life.
Actively, a minister.
Yes.
Forget active life.
As a minister for 3 years.
And then became a judge.
Then became a judge of the Kerala.
Which is why he never made it to the top, but he was a senior judge. But nobody could raise a finger. That is the spirit of the times. Nobody could even suggest this. One of my most cherished memories is that as a young student, I wrote an article in the Illustrated Weekly.
of the then Illustrated
Illustrated Weekly, a
yes.
very famous magazine, was
Yes,
about
yes.
election law. I had been in some elections seeing something. Election law, elections, law and reality. So I was juxtaposing. So but, Justice Krishna had retired by then in the 80s.
Yes.
Wrote a very nice note handwritten to me, saying, I read the article. He knew my father was, so he took the trouble of writing a note to me personally. And he read the whole thing and he wrote something which overwhelming to have him. Then 152. Long arguments on the terminological niceties of the various provisions, divorced from the essentials of parliamentary perspective, will land us in Himalayan constitutional blunders. Similarly, expressions like is satisfied, opinion, as he thinks fit, if it appears to, have to be interpreted by superimposing the invisible but very real presence of the ministry over the head of state. Opinion of, in the view of, appears to be. We declare the law of this round. This is 154, which was brushed aside by saying this is only a concurrence. So I've quoted it. Please tell me which part of the majority dilutes or violates 154, or tell the Lordship it is the overbreadth. Unless you do that, you can't just brush it aside. Supreme Court, 7 judges. In that way, Bomai could be, Bomai Lordship had 9 judges with 4 or 5 judgments. Most for all concurrences.
Yes, concurring.
Your Lordship doesn't brush aside just like that. Very Karnataka flavor, Bomai. The most important change in 356 has been that Mr. Hegde, by the time Bomai was delivered, he was the petitioner originally.
Yes, yes.
By the time Bomai was delivered, the government had changed 2-3 times.
Yes.
He never got the fruits of his victory. Subsequent to 2000, there are only 7, 8, 10 356s. Because your Lordship's judicial review was not only the same as Bomai, very swift. Very swift.
So many things.
No, your Lordship's judicial review was very swift. I've had the privilege of assisting the court in Uttarakhand, Karnataka,
yes,
Maharashtra. Your Lordship decided within a few weeks, this way or that way. So 356 did not become a very valuable tool to dismiss government because your Lordship said reinstall him back. In all these cases, Uttarakhand, Karnataka, have the elections or have a floor test and all that. Bomai took 3-4 years before the man lost several governments. So he got a Pyrrhic victory.
Yes, it was a Pyrrhic victory.
It was a Pyrrhic victory, although he established law forever. We declare the law of this branch of our constitution to be that the President and Governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon in accordance with the advice of their ministers, save in a few well-known exceptional situations. Without being dogmatic or exhaustive. This was read to your Lordship, so I'm reading it, Please see the totality. Is it a fair interpretation? To say that this means non-exhaustive, means each case by case your Lordship will keep adding to the governor's powers. That's not fair, It's against the constitutional scheme. Without being dogmatic or exhaustive, these situations relate to the choice of the Prime Minister, restricted through this choice by the paramount consideration it should come on. But this word exhaustive here means something totally different. They are saying we are obviously not itemizing everything. It is not a license or an invitation for my lords to keep on having adventurous additions, which is what they are suggesting. The dismissal of a government which has lost its majority in the House but refuses to quit. The dissolution of the House for an appeal to the country is necessitous. Although this area, the head of state should avoid getting involved in politics, must be advised by the Prime Minister, who will eventually take the responsibility. We do not examine in detail the constitutional proprieties in these predicaments except to utter the caution that even here the action must be compelled by the peril to democracy and the appeal to the House or to the country must become blatantly obligatory. Now my conclusion, on this part. As such, the declaration of law in 154, which forms part of a concurring judgment, must be seen in proper context. By no stretch of imagination can the judgment in Shamsher be seen as providing an open-ended, non-executive list of subjects. That's the crucial point, where the Honorable Governor may exercise, etc. But rather the court expressly said it is confined to a few well-known exceptional situations, which your Lordship may in a very calibrated, controlled manner, restrained manner, sometimes allow. Then the last judgment is where happened recently, the Maharashtra thing.
Court officer? Court officer? Court officer?
So far as plea of malice is concerned, the same must be attributed personally against the person concerned and not collectively. Well, the whole counsel is malice.
Yes.
My whole counsel is malice attached in a uniform manner. Even in such a case, the person against whom malice on fact is alleged must be impleaded. However, here arises another question. There are two competing orders. Now, this is where the thing changes. One of the council, another by the governor, one refusing to grant sanction, another granting. The Council of Ministers refused to grant sanction on the premise that there existed no material to show that R4 in each appeal had committed an offence of conspiracy, where the governor in his order was clear of the view that materials did disclose. An FIR was lodged in relation to the commission of the offence. Now, this is enough, I would say, for your lordship to send any matter back saying counsel is wrong.
Matter back?
Any matter your lordships can say the counsel is wrong if para 28 exists.
Yes.
Anybody would say it. I'll not read it. How is it that the council ignored a Lokayukt report of such detail? It's as simple as that. And this case is being applied for the other point, for the bias point. This para 28 in my case applies in my favor. I hope. 28 is omission of looking at Lokayukt. The omissions of looking at reports are by the governor in my case, today's case. What your lordship said there applies to the governor here. And we'll just see the report of the Lokayukt itself gives the material at the bottom of that page. Your lordship is ignoring everything at the Council of Ministers, then why will your lordship not intervene? At the bottom of that page 230, the Lokayukt is quoted. The point is not that they are right or wrong. The point is they should have noticed it, dealt with it. They did not. And then 29 Malas, they say how high the Lokayukt office is.
No, 29, sir.
Yes.
Last 5 lines.
Yes.
30
30?
and 32.
Your lordship is on 30?
30.
Yeah. May I read the last 5 lines? It is now
last 5 lines of 29.
Yes. Now, while settle that refusal to take consideration relevant factor acting on the basis of irrelevant experience not germane to the purpose would vitiate an administrative order. In this case, on the material disclosed by reward Lokayukt, it could not have been concluded that no case was made out. This is their talk about the council.
Yes.
Now,
it
is well settled exercise of administrative power will stand vitiated. There is manifest error of record or the exercise of power is arbitrary. Similarly, if the power has been exercised in the non-consideration or non-application of mind to relevant factors, the exercise of the power will be considered manifestly erroneous.
Now 32.
We have, well, just 31 for a minute also.
Yes, sir.
31. We have no hesitation to hold that decision was ex facie irrational. This is that manifestly irrational. This is about the council. Exactly these words apply to the governor with great respect. Whereas the decision of the governor was not. That's the competing thing your lordship is looking at. Is your lordship told after so many days of hearing which part of the governor's report tells you, which your lordship is reviewing, that this part of the Council of Ministers has omitted this? It's as simple. Well, we can all argue all these things. Has your lordship been answered that simple question by the governor? My lord is not sitting as the reviewing authority of the council first. First comes the governor.
No, of the governor, yes, correct.
In a situation of
32,
this
32 is what the apex court.
the facts of these cases, the governor cannot act in, there would be complete breakdown of the rule of law, be open for governments to refuse. This is in the light of that he must act at his discretion because he finds that the Lokayukt is missing. Does it say, Malaj, that governor can act at his discretion after Shamsher Singh downwards without giving a single reason as to what is wrong with the report in which he is acting in his discretion?
So everything boils down to the fact that he is entitled to disagree. The disagreement, yes, should be recorded. What is irrational in the note in the cabinet decision should be recorded.
That's
and the decision should
crux.
be taken.
That's the crux.
That is all.
That's the crux.
Yes.
But only with one caveat, even the starting point should be a little cautious. You should not say that first thing is I can jump in. You must look at it cautiously in a harmonious manner and then say, look, I am not for a minute suggesting that your lordship has a case like this, where he has not looked at Lokayukt. I am the governor, I point out Lokayukt, and your lordship says, no, the council is right not to look at the Lokayukt and the governor is wrong. I can never say that. But it's very, well, nothing is not rocket science. It's very commonsensical. And this also gives the court proper basis for review. It gives the proper test for review also. But Balas, it leads to the interesting conclusion that MP in last sentence on MP Malas is either completely in my favor or completely not applicable on bias
Yes,
or completely misapplied by the governor.
that we'll see.
All these three things.
Yes, the apex court holds it is not a judgment for real likelihood of bias as well. So.
Yeah, well, they didn't go into it. They said that, but one of that
But
sentence.
the submission itself is negative.
Negative. And Malas, 1 second, I'm sorry to repeat. One of the reasons negative is the last line of 18.
Yes.
That is the reason it's negative. They are saying, well, actually they don't say it in one sentence, they say it in two different sentences. It is negative, as the Lordship says, because they are rejecting the doctrine of presumptive bias.
Yes.
That is the point.
Yes.
That is the take home as far as I am concerned.
Yes, yes.
That doctrine of presumptive bias is rejected at bottom of 18 and top of 19.
Yes.
They are saying it amounts to this, that you are saying per se there is a cabinet, there is a governor, and there is a chief minister, therefore out you go. Now let us page 21. Now this is the heart of the matter. As I said from the beginning, this is by itself sufficient ground to quash it. Just see the actual exercise of power. Now I am assuming for the minute they're in exceptional. I am never agreeing, Malos, that in the walk-in, walk-out manner in which they are saying. Exceptional cases, I am agreeing. Your Lordship is the judge of exceptional, not a judge of Malos, just people coming and telling you that they say you can walk in because there is a 154 paragraph, Justice Krishna Iyer, and the rest of the judgment doesn't repeat it, or because the MP means this. No. But yes, exceptional, where our Lord is satisfied, then yes, you can walk in. Even assuming that the governor has in exceptional circumstances to depart from the aid and advice, the power not to be bound does not ipso facto justify the exercise of the power in every case. This is the presumptive argument, where approval under 17A is granted based on the independently exercised discretion of the governor. The validity of the exercise of this power requires two further conditions, which are both conspicuous by their absence. I'm repeating one, though, but I must repeat here, because this is a separate head. Two conditions what I told you, Lordship, must indicate why the advice of the council is manifestly irrational, or at least substantively indicate why he is persuaded not to follow such advice, which in the normal and ordinary course is bound to do. The governor must affirmatively, although not exhaustively, indicate why upon a consideration of materials he has formed a view that inquiry or investigation is warranted. A negative and a positive, or whichever way he wants to put it. Both these tests are not even addressed or applied. Forget your Lordship finding and then reviewing. Not applied or addressed. In terms of the decision of the MP, paragraph 15, the power of the governor to differ with the aid and advice is predicated on a finding that the aid and advice is manifestly or ex facie irrational. It is therefore incumbent on the governor to record reasons as to why he is constrained to differ from the aid and advice, as also state the factors that weighed with him in arriving. Now, Vittal asks an interesting case, fellows, on sanction. It's rather well put, fellows. Sanction lifts the bar for prosecution. The grant of sanction is not an idle formality or an acrimonious exercise, but a solemn and sacrosanct act which affords protection to government servants against frivolous prosecution. Sanction is a weapon to ensure discouragement of frivolous and vexatious prosecution, safeguard for the innocent. Next sentence is important. The validity would therefore depend upon the material placed before the sanctioning authority and the fact that all the relevant facts, materials, and evidence have been considered by the sanctioning authority. Consideration implies application of mind. I'm relying on these 5 lines very much, fellows. The order of sanction must ex facie disclose that the sanctioning authority had considered the evidence and other materials placed before it. Then they cite a series of judgments, fellows, and I'll skip fellows to save time. Kranti is cited by me in para 17. And if your Lordship goes beyond Karti, the next page, 2010-9 SCC, where the summary I have reproduced with 2 or 3 underlinings at page 24 of my note. In India, the judicial trend has always been to record reasons, even in administrative decisions, if such decisions affect anyone prejudicially. And D, recording of reasons also operates as a valid restraint on any possible arbitrary exercise of judicial or quasi-judicial or even administrative power. And then, Malas, it's a very long list and it's a useful list. So I've read, Malas, A and D, and then read L also for London, Malas, L. Reasons in support of decisions must be cogent, clear, and succinct. A pretense of reasons or rubber stamp reasons. This is another very interesting passage. Had your Lordship got the formality of reasons, your Lordship is not obliged to accept it. Your Lordship is not looking at rubber stamp procedures. Is not to be equated with a valid decision-making process, but your Lordship is fortunately at a one stage anterior. There are no reasons to this issue. The reason is why I'm not bound. That's all, nothing else. Chairman Mullahs of Kakkar's case at page 26. Now this passage I picked up because this ratiocination is very well defined in this para, rather well put. Come to page 26, fourth line, fifth line. Reasons are live links between the mind of the decision taker to the controversy in question and the decision or conclusion arrived at. Reasons substitute subjectivity by objectivity. The emphasis on recording reasons is that if the decision reveals the inscrutable face of the sphinx, it can, by its silence, render it virtually impossible for the courts to perform their appellate function or exercise the power of judicial review in adjudging the validity of the decision. How much more will it apply than in this case? Well, I throw a bunch of 1,000 pages at your lordship and say, look, my order is 5 pages. I don't address it, but you'll find something there. And then your lordship looks there, finds a comparative chart. Directly this para, I would say, well, I may be wrong, applies to my case. Right to reason is an indispensable part of a sound judicial system. Another rationale is that the affected party can know why the decision has gone against him. All these are reasons, fellows, why it has gone against him. One of the salutary requirements of natural justice is spelling out the reasons for the order made. In other words, speaking out. Speaking judge, a speaking out. The inscrutable face is ordinarily incongruous with a judicial or quasi-judicial performance. Although the governor is no doubt a high constitutional functionary, this is my submission. The very nature of the power being exercised in this case, the fact that it's an exceptional power, as he is ordinarily to be bound by the advice of the council, would suggest that the exercise must be accompanied by reasons. The governor's impugned order instead presents the inscrutable face of the sphinx, and it is impossible to discern from what factors it has arrived at and weighed with disregarding. Now, as your lordship decided Shrirupa for 17A, yes. I don't think Shrirupa means what has been said to your lordship it means. It is very clear what it means to me, and I have tried to explain that at 27. 17A casts an obligation of application of mind on the part of, just pause here, Malus. Forget 17, 19, 80, whatever, 287, etc. The concept is basically a lordship should be satisfied of substantive application of mind. Otherwise, lordship is not allowing shadow boxing by saying this is little less, this is a little more. Substantively, the section makes it clear that no officer shall conduct any inquiry without previous approval. Therefore, the approving authority will have to look into the materials, applied minds in each of the 3 contingencies, inquiry or investigation. This should go someday. This E and I difference is very, very difficult. And it's, well, sometimes it really becomes a technical one. They should use a different word in the CRPC and this thing. You're all arguing about inquiry all the time. Though inquiry and inquiry are often used interchangeably, there exists a difference between the two. Etymologically, the source of both inquiry and inquiry could be the same, as EN is derived from French and IN is from Latin. Inquiry has a formal and official ring to it. Inquiry is informal and can be unofficial. Inquiry would even mean a question to question. Inquiry is a formal investigation. Investigation is search. Now I'm reading what is the underlined portion. Therefore, the Act casts an obligation of application of mind upon the authority to consider whether approval is sought for an inquiry or an investigation. It becomes imperative for the authority to apply its mind to what is brought before it, as application of mind is the bedrock of any order that an authority possesses. Failing it should be contrary to the principle of natural justice, as non-application of mind is itself violation of the principle of natural justice. There is no answer to this to say, my order be damned. The application of mind is in the interstices of the mass of 1,000 pages which I have in my office. That's the crux of it. That's the only thing they are falling back on. And that is, well, a travesty of how I will appeal, how I will react, how I will deal with the order, how your lordship will review it. It's only, well, a desperate attempt to justify it because they have not done it. So now they've come up with this thing about, well, papers in the office. Application of mind by an authority is demonstrable. Mark the word demonstrable. Only in the order that the authority makes. Now, I'm asking myself, what are we talking about, Wallace? This is my Lord's judgment which was cited against me. What is my Lord? I was not aware, Wallace. I'm not there in the matter. I have not checked the facts of Shrirupa. I can guarantee that Shrirupa could not have been a case of a 5-page order with a 1,000-page file. It must have been a better case.
There was nothing in the file, nothing in the order.
Now, Wallace, application
because
of
file
mind
was summoned.
No, but your Lordship puts it very clearly.
Yes.
According to me, the Lordship has to have black and white, which is what your Lordship has done here. See the first line. Cited against me. That's the irony of it. Is demonstrable only in the order that the authority makes. my humble and respectful service, that's the correct view, Manus. We are not playing Manus games here. For the order to demonstrate application of mind, it must contain the reasons. So your lordship goes further. First is what is on the order, not what is in my almirah. Second is the reasons in that. As recording of reason and order is the only way that can constitute such application of mind. Then your lordship gives this very felicity. That's why I quoted the Supreme Court first. Reasons are the links between the mind of decision taker to the controversy and the decision arrived at. Ratiocination, I call it.
Yes.
Reason and application are impregnable. That's a new word, Malas. Ratiocination, impregnable. No, because this is important, Malas. This is how administrative law is built
it
up.
is inseparable.
Public law builds up like this only, Malas.
It is inseparable.
For an order to sustain the scrutiny of law, be it administrative or quasi, reasons in every circumstance need not be elaborate, no problem. Nevertheless, should bear application of mind. The case at hand and the order impugned will have to be tested on the anvil of the magistrate statute, the intent and the rule of application of mind. If on a coalesce of all the facts that are narrated herein above, and the order that is impugned on the anvil of this object and reasons, it would fall foul of the same as the order, now let's kindly bear with me here, as the order, except saying there is nothing indicative of the fact that it bears application of mind. Granting approval for setting the criminal law in motion cannot be a frolicsome act as is done by the state in the case at hand, as it does not even bear any semblance of application of mind. As this frolicsome should also be adopted by some other courts.
Playful act.
I go for my frolic of my own. This used to be used in those public servant cases, where it's within the discharge of your duty. So you used to say that in the English cases, he went on a frolic of his own. So
that's the...
Now, I just pause here. This, my case, is actually in a way a better example against them. In a way, it sounds like a better example against me, but no. Your lordship, this case had possibly no reasons. I've not examined the order.
No reasons at all.
In my case, there are all reasons, but for one issue only. And equally for the other issues, zero reasons.
It contained only those words, checked and found correct.
Checked and found correct. My case is the same. For the issue which it had to address is my submission.
No, there are reasons. It's not that it is...
For the issue it had to address. Malo, I can write a 100-page order.
But it is not a case where it does not bear even a semblance of reason.
No, Malo,
but it is.
That is actually, my lord is absolutely right. Malo, it's an order which has to address Y. Writes 100 pages for X and doesn't address Y. It can't fool a court, Malo. It can fool an ordinary person.
That is Wednesbury, taking irrelevant consideration.
I'm saying the 100 pages valid and relevant, let me assume. But Malas, that is deciding issue A. Today, the argument is on issue B. I will be reading the order. Your lordships cannot find a single word on issue B. It's the same case as your lordships. This one, Shirupa. The difference is that you wrote 6 pages on an issue which takes you neither here nor there because it doesn't give you the reason why I am to be sanctioned. But on the issue of why I am to be sanctioned, which is issue B, there is 0. And this was 0 also. In fact, this was more, but I said corrected and found. The governor didn't say that also about me.
That was a case of that kind.
Now, verse 21. The impugned order does not demonstrate any reason, I'm applying it to my case, any reasoned application, especially to the core and crucial aspect. This is the aspect on which there is 0. Kindly see the aspect of how, why, in what manner is there any connection of the petitioner, much less prima facie culpability, with any decision, recommendation, act or event justifying the grant of prior approval. Not a word. It regards the constitution of a committee under an IAS officer and a commission of a retired judge as an acceptance that there is a big ticket scam and does not inspire much confidence. So it uses the other 2 things. I'm dealing with every reason that is there. There's no other reason. It says that because the commission inquiry is made, that is proof of a big ticket scam, therefore I must give sanction. It doesn't deal with one question my lord put in the hearing also, because I heard it, I was here. My learned friend didn't answer it. How is this petitioner involved?
That is...
No, that's only a question. I mean, your lordship putting questions to me also. I'm just saying, well, this is the heart of the matter. This is despite the fact that by his own earlier letters of 5th of July and 15th of July, the governor himself had drawn the attention of the chief secretary. Now, this is very interesting, Wallace. He says, I have read of a commission inquiry set up by you that itself makes it clear that there is a scam and therefore I give sanction. See the next sentence. The same governor on 5th of July and 15th of July drew the attention of the chief secretary to the matter of alleged site allotment scam at Muda and requested the government to look into the matter and submit a detailed report. Just pause. Suppose the chief secretary had said, sorry, Mr. Governor, I will not have a report to you because you will use the report as an admission of somebody's guilt. Suppose the chief secretary had said so. The chief secretary would have a huge controversy on his hands. So as he has an inquiry, that inquiry becomes a noose around the neck to say, I am now finding culpability. But in both the actions of the chief secretary and the governor, there is no mention of the chief minister role. CM's role, zero. This is despite the fact that, I'm sorry, it states that even after such grave allegations being involved in the present matter, and the fact that the materials prima facie support, therefore, now this is the total reason. What is the reason I'll find here, Malas? This is the total reason. Please read it for yourself, Malas, 21.2. Even after such grave allegations being involved, so allegations become a basis of conclusion. And the fact prima facie supports the allegation, therefore the decision taken is irrational. Here again, Malas, he is not giving you any single reason. And most important, the role of my client, the petitioner. I'm myself putting everything which is there against me. The said statement is entirely unreasoned and opaque, especially since all material is fully considered. Then 21.3. The order further says that since the prior approval is sought against the Chief Minister in the Cabinet resolution, therefore it would not inspire confidence to act on the aid and advice. In support of this view, the Governor refers to para 32. Now, I have done this fully. Leave it to yourself, your lordships, to consider, is it a fair understanding of MP? The nuance which I pointed out, the meaning of 32, nothing else. Finally, the governor notes that there are two versions in relation to the same facts and therefore a neutral, objective and non-partisan investigation. This is very interesting. The two versions test is plainly an insufficient basis on which to disregard the aid and advice of the cabinet. As in every case where the cabinet declines prior approval, there would necessarily be two versions. My lord rightly put it, 3, 4 or 5 versions also. Truth has many facets. That is an old saying. What is that Sanskrit saying? Forgetting. It's, in Hinduism especially, we say that the path to truth. In other religions, maybe 1 or 2, but we have multiple paths to truth. So therefore, bhakti yoga or karma yoga.
Yes, yes.
So the truth must have many facets. Here talking only of 2 facets. It was for the governor to point out some manifest irrationality in the version as outlined by the cabinet failed to do. Instead, he treated the complainant's version, a complainant of dubious antecedents, as at par with the considered view of the cabinet after seeking opinion of the Advocate General and decided there were 2 versions. A neutral inquiry or investigation was called for. This supplies the fallacious test of why not the correct test of why. Yes. And if your lordship takes this test, then there is no reason required at all. Further, it is evident from the written submissions filed by the R2 that the decision of 1-8 was placed before the governor on 6th of August. Now kindly see this sequence in para 22. The governor asked that it be put up before him along with the comparative statements, the chief minister's reply and the cabinet decision. It is then stated that upon reviewing the file along with such comparative statements, certain notes, analysis and points were dictated. I'll put that dictated in inverted commas based on the comparative statement in the documents. On 16th of August, the file was once again put up before the governor along with the dictated notes. It is at that stage that the governor made the impugned order. It is relevant. Now this is one of the bullets. None of the materials placed in this para so-and-so have been placed on record by way of an affidavit. More important. Further and most significantly, if there were notes or analysis points that had been dictated by the governor, it is inexplicable why such analysis would be excluded from the impugned order. Well, my 22.2, I may be wrong, is my most important para on this topic. 22.2. Well, it is never, you dictate a long order in the file and you pass a 6-page order on bias only. Moreover and crucially, while the written submission of the respondent rely heavily on the file notings culminating in the impugned order, the impugned order itself makes no reference to such file notings or the comparative charts, tables, or the notes and analysis which have been dictated. and with which the file had again been put up for the governor's approval. If these were indeed the factors that had weighed with the governor would certainly have said that in view of what is set out at flag X or flag Y of the file, it should be Y, not X. He accords sanction approval. Thus, this is not a case where the impugned order of the governor endorses, accepts, or engrafts into itself a previous file noting. Where the order itself does not do so, it is not open to the respondent to portray the decision as if it is based on such notings. The impugned order refers to the governor having perused the file and to the allegations and having independently submitted a report of the same. There is no reference of the charts or the notes or the analysis in the file. The petitioner had submitted a detailed reply, that is my reply, on 3rd of August, raising several legal and factual issues for the consideration of the governor. Apart from meeting point by point the allegations made against me, however, there is not even a whisper with regard to my reply and its consideration, either in the impugned order or in the file notings. The impugned order does not assign a single reason as to why the prior approval is being granted. No reasons as to why the detailed reply is not being accepted. No reasons as to how the petition complaint allegations make out a prima facie case against me. Very importantly, no reasons as to what role of the petitioner, while acting as a public servant in discharge of his duties at any stage, in the detailed factual background, is made known either in the impugned order, the file notings, or in the statement of objects or during the course of arguments. This goes to the root of the matter. Then was 22.5, reasons ought to have been assigned, etc. Both the paragon reasons. Now, I'm just dealing with three aspects of 17A, which is that number one aspect is that your lordships does not equate it to Lalita Kumari. Second aspect is the police officer being the first filter.
Yes.
And third aspect is the impugned order is ultra vires 17A also and 218 also. So these three aspects I'm now dealing with.
218 comes at a later stage.
Later stage. Correct. Now kindly come to this. Okay. 218 was largely conceded, but I'll just deal with it. I'll come later. Just come to 32 minutes.
Page 32?
Yes, page 32, para 23. The power to grant previous approval is not to be exercised in a manner analogous to the test for registration of an FIR. The submissions proceed on the fundamental erroneous premise that the principles set out in Lalita are relevant for ascertaining the scope of the inquiry. The analogy seeks to draw between registration of an FIR and a grant of approval to inquire or investigate is misdirected, also oblivious of the legislative history behind the introduction. Now, this I'm not going to go in detail, but I must let your lordship know that the intent could not have been a FIR level inquiry. That's all. I'm just giving a lordship, if whatever is worth is not dealt with any judgment, it may help your lordship.
In fact, the genesis of why this amendment had to come about sprang only from Lalita Kumari in 2014. The first law commission, I think, is in 2014.
Well, I've dealt with part of that.
And then it took 4 years to come about. Because approval was sought to be given to the hands of Lokpal and Lokayukta for approval.
And that was a much higher scrutiny. Only the person was changed.
Competent authority comes
in. That's all. But the degree, that's my core point. The degree was not reduced is my submission. That's the only point. Your lordship will summarize it now. The initial idea was a proper filter and safeguard. That remained the idea. The power was taken from him and given to me.
Yes, it was initially envisaged to be given to Lokayukta or Lokpal.
He is the Lokayukta, I am the authority. It came
now it is to the competent authority.
But in that process of transfer from him to me, the diminishing of the power to the extent it did not happen.
No, the provision remained the same, or the idea remained the same.
So
it is only the person who grants approval.
I am very grateful. That's the crux of my submission. The idea is my point.
Whatever protective
idea remained the same.
Protective filter that was envisaged in 2014 remained the same.
And the degree and quantum of that remained the same. The person exercising it changed.
It took 4 years to come into this form.
That because of all these committees back and forth. Well, there's a delightful phrase for committees, it's a wag. Your lordship will pardon me. It is not meant for any committee. But a wag generally commented that a committee is usually a group of the unfit appointed by the unwilling to do the unnecessary. So these delays happen because you want to also take off the time. Well, it's 24.1. The Prevention of Corruption Amendment Bill was introduced, did not contain any 17A. Then 24.2, it was first considered by the Rajya Sabha Standing Committee in its 69th report.
No, all that I'll go through.
Then, well, I'm not reading it.
Yes.
Then it was brought in 24.3. Then that bill went to the Law Commission.
Yes.
In February 2015. Now, this just see the middle, Malas. It is clear that the previous approval will be granted by Lokpal or Lokayukt and would be conveyed by an order under Chapter 7. Now, this Chapter 7 outlines the procedure for a robust and elaborate procedure, including calling for explanation. Therefore, from a mere perusal, it is clear that it is my submission. From very inception, the amendment proposing 17A as an additional entry checkpoint protective filter, entry checkpoint protective filter, was contemplated as substantive protection and nowhere close to the standard for registration of FIR. That's my proposition, but it's for Lordship's consideration. Then went to select committee, skip that, come to 25. No, I'm sorry, 24.5 is very important. I'm very sorry. The select committee proposed a further amendment where the power to grant approval was given to the appropriate government and not to the Lokpal. Thus, a change was made as to who would exercise this power. But it is clear the intent was always that the protective filter would be a substantive protection. Also, it's very clear, Manas, I happened to chair this committee in 2011 when the Lokpal bill was passed. We piloted the Lokpal bill.
Yes.
Now, when the Lokpal, delay is inevitable. That is the main reason for this transfer actually.
Yes, yes.
Because the Lordship give it to the Lokpal and give it to a competent authority. There's a vast difference of time. That's all. It is not that you are making the power less. It is just that you make it faster. That's really the bottom line thing. But anyway, this unfortunately not decided by any case. Then, Malas, Shirupa at page 34. However,
that's a coordinate bench judgment where 17 and 19 are considered differently, and it is said that 17 need not bear that much of an application of mind like 19. This
Right.
coordinate bench judgment.
right. So therefore, Malas,
Which distinguishes the judgment that I had rendered.
but Malas, I am relying on a Lordship judgment. I am
Yes,
not
yes.
distinguishing it.
Yes.
I am adding to it with
Yes.
this para and underlining what I'm relying on this one also.
Yes.
I have no contradiction in my mind. Malas. They have the ones who argued, may have argued differently. Malas. They thought that Shirupa is against me. I demonstrated that part of Shirupa, Lordship judgment. Now this one, just see what I'm relying on.
Yes.
Middle of page 34. In a sense, a public servant is placed on a pedestal and treated differently as compared to a citizen against whom an allegation of an offense is thrown. The law thus grants an extraordinary layer of protection. This is the idea.
Yes.
Then 35. I'm not trying to avoid anything. I've quoted it, but I'm just reading
Yes,
faster too. Has some credible evidence on the basis of which he forms an opinion that an investigation is warranted. Who is he, Malas? This he here is the police officer. This he at 35, credible evidence on the basis of which he forms an opinion that an investigation is
Police officer is what you are trying to say. Yes.
Then, no, the whole para, just give me a minute. Let's come to para 30 at page 34 bottom.
Yes.
It is therefore not necessary there should be a clear incriminating evidence with the IO.
At the stage of him seeking
At the
approval
stage of him
under
seeking
17.
prior, all that is required in the provision of the Act is that the IO has some credible evidence on the basis of which he forms an opinion. This part is clearly IO, Manas. He gives me the information, I am the IO, I form an opinion, then I seek approval. There are 4 steps or 3 steps. Information, formation of opinion, seeking of approval. As a consequence, the state government would be required to only consider the opinion that is formed by the investigating officer. Why is the Lordship saying all this? And the material that he possesses while considering the request for approval. Since the public servant is yet to be investigated, the question of considering an India, I'll skip that. 34, next para. It is also clear from the wording of section 17A. The state government is not required to exhaustively and meticulously consider all the material available with the investigating officer at the time he seeks approval. It is only required to
This is where it is different from what I have said.
Correct.
It need not apply its mind is what is said here.
Well, I see the difference in emphasis, but I don't think it would be right to say that your Lordships is wrong in saying application of mind. That would be, well, say, something which will possibly not stand the test of law, is my submission. And this, even though it's worded differently, should not be read to mean that application of mind is so diminished as to be a formal administrative entry in the register.
Yes, that is.
That is the way I would look at it, because according to me, 17A is somewhere between 19, etc. and Lalita Kumari. That is the correct way to look at it. please don't reduce it to a just a Lalita Kumari level. Please don't elevate it to a 19 level.
Yes.
Because it's a fair way of looking at it. Otherwise, Manoj, why have all these select committees, parliamentary standing committees, law commission? I mean, was it the intention, Manoj, to make this kind of a provision? You already had Lalita Kumari. It would have taken 2 sentences to say we apply the Supreme Court. Lalita Kumari, we are doing this. Manoj, your lordships is being asked to dilute it to a level which is not fair on the legislative history of 17A. It is not borne out, certainly not by my Lord's judgment, but also not by this judgment, which should be read in harmony with the Lordship judgment, instead of deliberately saying we must drive a coach and four between the two.
No, because para 34, if you see at page 35.
Yes, sir.
That is what is not required to exhaustively metically consider all material available within.
It is put in that
at
way.
the time of seeking approval.
And it is only required to examine and consider the opinion formed. Now, I would, if that is the argument of the other side, I would say maybe when he gives it to approval, he may not put everything. But in his own formation of opinion, the lordship tests remain. If I am the IO, my formation of opinion must bear a full application of mind. Maybe, Manoj, when I reproduce it for approval, this judgment can be read otherwise. Then just come to 36, Manoj.
Yes. 36 itself. Para 36 at 36.
The grant of sanction to prosecute and the grant of approval to investigate are two very different concepts and would be governed by completely different parameters. At the stage of seeking sanction to prosecute, the IO would have completed the investigation, would also have collected material which, in his opinion, would prove that the public servant is guilty of the offence alleged against him. In other words, at the stage of seeking sanction to prosecute, the IO is well armed and certain that there is material to establish the guilt. In respect to according an approval to investigate, obviously the situation will be completely different. Since at that juncture, the IO would not normally have any incriminating material, only possess credible information about the commission of an offence. It is this credible information that is required to be considered and analyzed by the government. It is thus clear that the parameters that govern the according of approval should be completely different, and the government would have a much wider discretion while considering the request of the IO. I am on a different point, Bharat. I am not on this point. I am not on this perceived collision between your lordship's wording and this wording. I am on a totally different point. Who is all this? It is not a direct lateral entry by somebody without the police officer IO, whether he does this much application of mind or this much. It is he who does it, not a lateral entry bypassing him or overriding him. That's my argument. Page 37, para 46. Law, except there be different standards for granting approval to investigate or granting of a sanction, one cannot be equated with the other. To put it differently, the parameters that are to be applied to investigate a public servant are not as stringent as the parameters which provide for granting sanctions.
This is what is...
no, that's true.
The application of mind varies from 17 to 19.
Let us, for my purposes, accept that.
Yes.
I am saying, Malaj, don't reduce it to the vanishing point of Lalita Kumari. Don't elevate it to that side.
19.
And secondly, it still has the police officer. This lateral entry I'm not agreeing to. I'm trying to build up that argument. That's the second part of my argument. Just come to the bottom.
So it is only the police officer who can seek approval.
Start this whole thing. Because he's supposed to be the custodian.
All right.
And without a statutory custodian, it is not that he's the best custodian, but he's a statutory custodian. He's a persona designata.
Now, in a private complaint, how will it work?
It must go through this first.
No. How can it go? They go to the police first.
Yes. No, because it's not the private complaint which determines this.
No. Straight away 200 will not spring.
Yes.
154.1, they will go to a police station. Jurisdictional police, they will not register. Then a higher officer under 154.3. Then they approach 200. In 200, where is the police officer unless it is referred to investigation?
Now, Malas, two things. The number one answer. The test is based not on private or public complaint. The test is based who's the accused. That's one way.
Accused may be anybody.
No, public servant.
Of course, if it is Prevention of Corruption Act 17A comes only because it is public servant.
So first and foremost, this is a safeguard for a limited class of people.
True, it is public servant. Now, in this functioning, the police station, yes, police officer should seek approval, no doubt about it. In a private complaint, where police officer is not involved, police officer comes into picture only when 156(3) or 175 reference happens. Reference happens for what? For registration of a crime. If registration of crime already happens, where is the question of approval?
There, Balus,
That is why that
there, Balus, either
the police officer only should seek is a little
I
difficult to.
understand, but there, if that is the case in a private, but then the private complaint example can't take over all the non-private complaint cases. That's answer number one. The Lordship will not read it in a way.
In a non-private complaint, obviously it will happen by a police officer.
No, but then
Approval will be sought by a police
Then
officer.
your Lordship, even in that category, is giving the possibility that it can be somebody else altogether. That can't be the law. But second answer, Balus, then in that case, the magistrate will have to iron out the problem.
No. That is why in that judgment, what I wrote was, in a private complaint, you are taking away the 17A approval and directly getting the crime registered. That protective filter goes away. It is rendered odious or rendered redundant.
Yes.
For that reason, whoever approaches the magistrate who would wanting to register a crime against a public servant, it is his responsibility to get an approval. Without the approval, the crime cannot, no reference can be made under 156(3) is what I have said. Their police officer comes only after 156(3).
What my Lord is
How
saying is that
do you harmonize the two now?
my Lord is right that the Act is not thought of this problem. They should have, but Balus 156(3), should it not be coming after 17A stage, Balus?
Yes, that is what I have written. That is exactly what I have written.
No, Balus,
Kindly consider this. If this interpretation is given, will the protection given under 17A still continue to be available to a public servant? If you allow anybody and everybody to walk in and seek protection?
No. That is exactly why 17A is made applicable to private complaints also. See, now imagine a hypothetical circumstance that 17A, one complaint is registered before the Lokayukta. The Lokayukta police will seek approval of the competent authority under 17A and try to invest and begin a register FIR, begin investigation. Now that procedure will be obviated. Ultimately, what the complainants would want, registration of a crime against a public servant. Now 17A is a bar. If private complaint is a stranger or citizen, any criminal law can be set into motion by anybody. So they go before the magistrate, register a complaint under section 200 for various offences, including PC Act. Now straight away, reference is made for it is referred to the Lokayukta. FIR is registered, investigation commences. Where is 17A? The very purpose of 17A is lost. That is the reason private complaint also.
the other, of course, if I may say, the casus omissus possibly in the Act also.
Casus omissus, yes.
That's not your Lordship's problem, that's not my problem. That's
Yes,
the
that is the legislature. That's the.
Is it possible to say that the 156(3) must come and then you go through 17A after that? Because 156(3) brings in the magistrate. And then well as the private complaint goes on. But then before you proceed further, the 17A approval comes. That's another way of looking at it. I'm just thinking.
That can also be done. But prior to beginning of investigation against a public servant, 17A compliance is mandatory. That is what exactly I've said. Because what used to happen in so many cases is, they don't go before the Lokayukta, they don't go before the police. Straight away register a private complaint. And once it is referred for investigation, the police have no jurisdiction except to register the crime.
Qualifying 17A.
No, defying 17A.
Question of locus did not arise either in Dr.
No, locus is alien to criminal law, sir. Locus to apply. Locus to apply is.
In Dr.
Locus to apply would locus would become applicable to the person who wants the complaint to be registered. Now the police officer wants to investigate, he will seek. That is under the Act. Now the complainant wants a private complaint to be registered against a public servant for offences under the PC Act, he will seek.
So there is a problem. The only thing I can think of is that there is a 156(3) going to the magistrate and some procedure of 17A follows that. That's one way of looking at it, but
We'll try to harmonize in this case.
Your Lordship is good, because
yes.
If 156(3) goes first and 17A follows, your Lordship is having fidelity to both. That's what I was just trying to think out. But there may be some other problem I'm not able to think out immediately.
No, why I wrote that order was I'm trying to. Otherwise, 17A becomes.
The Lordship may consider this, that your Lordships should preserve the primary filter of the police officer. One way of preserving it is to have the 17A cases in a private complaint go through the filter, of course, as it does through a 156.3, followed by the requirement to get a 17A.
Well, accept that. Now, in a given case, 17A approval will be sought. For what? It may not proceed further.
No, but your Lordship is only concerned with the approval being sought and going through a police officer's filter.
That's what. Whether it is the police officer or the person who sets the criminal law into motion.
Well, it can be with 156.3, there is some greater harmony as I see it here. Any magistrate may order an investigation in 156.3.
Order an investigation.
But if 17 has to have meaning, then why?
No, now against a public servant also, a magistrate can order investigation.
But then, exactly. But then, because he's a public servant,
17A should be there. That's exactly what I've written.
But after the entry of 156.3,
29.5.
Well, I have tried to answer it somewhere lower down, but let me just read through it. These are the only two answers. The harmony can be that your Lordship does not render a 17A to be diluted.
No, the language in 17A is no police officer shall commence inquiry, or investigation. Fair enough.
All three covered. All three are covered.
All three, no problem. No police officer can commence without prior approval under this provision by the competent authority.
Technical sense, the magistrate.
Who seeks the approval is not there in the statute.
That is a separate matter. Whether locus is not there, criminal law has locus or not, all that is separate. My point is, whoever it is, let's say assume a stranger is there. Your Lordship gives a definitive role to the police officer. The first port of call is a magistrate who is not a police officer. He initiates or allows their filter of 156.3. The second port of call must be a 17A police officer. And then, that man, if we say no, then the locus ends.
Now 156.3, magistrate refers. Will the police officer who has been directed to conduct investigation wait for an approval from the competent authority?
No, that's then the answer is clear. Once your Lordship accepts that, answer is yes, he has to. Otherwise,
that is why, that is why, to obviate that procedure of once referring the matter for investigation and registering the crime, so taking 17A approval for conduct of investigation. If a prior approval is already there, magistrate will refer it and the investigation will commence immediately.
That will,
that is what
I understand. Your Lordship may consider harmonizing in this way because that means that the primary port of call of the police officer is ended or diluted. That is my problem. I am trying to harmonize that part. In this other model I am giving your Lordship, which is not fully thought out, maybe I can give a supplementary one-page note after thinking it out. It appears prima facie that your Lordship does not violate any of the provisions of the statute. Because the outsider chap goes to the magistrate, he gets some order. Then it must fully satisfy the police officer who will say no. That's the end of the story as far as he's concerned with that point.
No, he has no jurisdiction to say no once the magistrate refers the matter for investigation. The investigating agency cannot say I will not investigate.
That's the point.
That is why that protective layer should spring prior to the complaint.
Therefore, your Lordship judgment will have to say that the 156.3 order cannot violate a 17A order. Your Lordship will have to say that a 156.3 order must then thereafter...
Cannot violate a 17A order.
No, not cannot violate. Must not override a 17A order coming later. This 153 will say, I am referring it, but this part will be done first, 17A. PCA. Because this was, in fact, the more we discuss it, it's becoming partly clearer. Your Lordship is having a limited class. It is not except outside the PCA Act and public servant. For that limited class, suppose the magistrate says, he will not say it generally, he'll only say under your Lordship's orders. Otherwise, High Court has to lay down the law. That, look, I am issuing a direction, I'm initiating this investigation, but where 17A is required, it will proceed further only after 17A is given or not given.
So now, magistrate refers under 156.3.
But then comes
the
17A.
Jurisdictional police or the locator at whom it is referred, he may have to wait for 2 months, 3 months for approval and then begin.
That is one way of looking.
And then begin. Is it not that if the approval is already there, And a private complaint is preferred. Reference be made prior to approval. Is not a better circumstance.
Then your lordship is bypass the police
No,
officers.
we are only permitting police officer only to investigate. Nobody else is investigating. After reference, only the jurisdictional police or the lokaयुkta will investigate. But he will investigate only after the approval is there under 17A.
I understand. There's a slight issue there. Initiation is not by the police officer in your lordship's formulation.
Yes.
Initiation is by the police officer under the magistrate rule. That's the only difference. If your lordship finds that the initiation power is preserved in my model, I mean, in case it's just loud thinking, because there's nothing so clear here. In case the initiation power, which is clearly borne out by the language of 17A, I have no doubt that 17A language bears that out
No
also.
problem. Yes.
It is not, I mean, your lordship can interpret differently, but it does not rule it out. If that power is borne out, then it is possible to harmonize that initiation power under 17A with the private complaint and public servant character through 156.3. It will require some obvious harmonization, but well, that's a possible view. Anyway, when I leave that, I come to 38. Sections, this is only an alternative argument in the sense that it's not, I mean, it's not dispositive either way of any of our cases. 17A places a public servant on a different footing and grants to such public extraordinary layer of protection. This extraordinary layer is set by our lordships, not by me, not by. The protection of the pre-investigation may not be as stringent as stage of sanction. I've already said.
That is by the coordinate bench. Yeah.
Yeah, I mean,
Yes,
by the
yes.
court, not a submission.
Yes. Sir.
Then 26.2 is neither as weak as Lalita nor as high as sanction.
Yes, that's fine.
26.3, not be necessary to have incriminating material to show conclusively, but it's still necessary for credible information. Then while I'm trying to harmonize to the extent I can, while a microscopic examination or meticulous consideration may not be needed, cryptic orders will nevertheless fail to meet the requisite test. In this case, at para 51, the court concluded a clear opinion had been formed by the investigating officer that he suspected the commission of an offense. Subsequently, on considering the material, the state government came to the same view. In the present case, certain important factors must be borne out. I'm applying it here. There is no view at all found by the IO. Now, this is what I want. This is my problem. There should be, otherwise, the lordship is opening the floodgates. And my word friendly governor was not intended as a mark of insult. I'm talking of a constitutional lacuna. If this 27.1 is accepted by your lordships against me, it's my submission, but if it is accepted against me, then your lordship is allowing this friendly governor or a opposite political color state government. And whereas all these concepts of governor above politics and neutrality is now gone. Let's not live in fictions. Whereas we have governors, we have got governors who are resigning from governorship and fighting elections.
No, now to seek.
There is no such thing.
Correct. No, now if your submission is that the investigating officer only should seek sanction, approval from the hands of the competent authority, who is the investigating officer here to seek approval? There is no investigation now? Not yet commenced?
No, that he will
Not yet commenced?
That's a procedural matter. Somebody will, if somebody goes with a complaint,
that's what.
Somebody
Somebody goes with a complaint. There is no investigating officer to form an opinion and seek approval. Who will seek approval?
Complaint was, now, let me answer my lords. First of all, your lordship will decide it in a true case. Your lordship will not be asked, as they are doing, to decide a hypothetical.
No, I am only.
Now, on the inquiry, no, I'm giving lordship an answer. So, there's a very clear answer to lordship. The dates in this case give the answer. This man files on 18th July. And the governor.
No, 18th July, he registers a complaint.
Then 25th additional.
No, that is not taken note of, because I see the order. For want of approval, he does not proceed further.
Then second is 25th of July, he files a further information to supplement the initial.
Yes.
Then 26th, he goes directly to governor in less than 7 days, 6 days. Now, the query my lord is putting in a case where there is no action. Maybe a writ will lie to create an action. You can't say, I go today, give him 3 days and I go to the governor and bypass. 17A can be bypassed because that's the way to do it. But therefore, the escape route to your lordship's very valid question would be that if I try to defy and don't ever give anything. I have no inquiry officer, I have no policeman, I have nobody appointed. Well, the Lordship's writ court will settle in 2 minutes. But whereas here, these dates are important because you are actually bypassing the system of 17A. 3 dates. 18th, he lodged a complaint with the Lokayukt police. 25th, he filed a supplementary information. 26th, he went to the governor. Where will the poor police officer will not function so fast? Even if they have to function. Yes. If I am deliberately not functioning, if I am a police officer, if I am the state,
First,
etc.
154(1) was 3 days before they going to the governor or registering the private complaint? No. When was the first complaint registered?
It is 18th.
18 June.
No, July.
18 July. First complaint.
Yes. 1 minute. 18th July is the first complaint by Mr. Abraham. Yes.
All right.
And he never approached the court saying that Mr. Policeman, you are sleeping. Mr. State Government, you are doing nothing. Please give a mandamus. Maharaj, if this is so, what prevents your Lordship from having hundreds of people coming and saying, 17A be damned, I am going straight to the governor? That's a point to be considered, Maharaj. Your Lordship will
And
then
when
have...
did you go to the next higher authority? 12/8. Huh? 5/7, sir. 5/8. And before that, you had already sought.
He closed the doors. Actually, Maharaj, if your Lordship investigates a very important question more, he then has power to go to the court. Not your Lordship, writ court. He can go under 154(3) to the SP.
No, that's what I'm asking. 154(1) jurisdictional police, no action. 154(3) SP, no action. 200 magistrate.
No, I am going further. Writ court will give it for the asking.
No, that also. A mandamus to register the complaint.
But you do nothing. You come on 18th, you go home on the 26th and say, look, I am bypassed. Thereafter, nobody is going to touch it. You go to the highest officer in the state.
All right. Yes.
So these harm. Now, Manoj, just look at the reverse for a minute. Just look at the reverse. This is all right. You don't have an inquiry officer. You did this. Look at the reverse. Is your Lordship not being asked to accept a gigantic principle, subversive of the discipline of law, that Manoj, this 17A, what is left in it, if everybody is going to the governor first? That's my reverse question.
No, everybody, why will they go to the governor? Governor is the competent authority only to a few, not to everybody.
No, for any case, Manoj, it is not at nobody's case that 17A is not required.
17A is required. Yes.
Now the question is that in every public servant case,
to the competent authority.
No, governor oblique competent authority, obviously. Governor competent.
Yes.
Point is, where does the role of the police officer then remain?
After the registration of the crime.
So that's the debate.
That's where we left to answer.
That's the debate.
Yes.
That's the debate. Then, Malas, 27.1. In this case, directly approached, 27.2. The governor not concurred, took a different view and passed a cryptic order. Then, Malas, come to page 40. This, Malas, I have covered now.
Yes.
Police officer is fully covered in the debate which
this argument is over now. Yes.
And then, Malas, your Lordship's judgment is also cited.
Yes.
Now, Malas, para 29, Malas, is really a para about this act. It's a point I'm keeping alive. I'm not, Malas.
Yes.
It's a point I've fully said there. Not by any remote stretch shown to be part of the discharge of my official duties. That's the
now we have come to the crux.
So therefore, Malas, Section 17 grants protection from decisions taken or recommendations made in the discharge of their official duties. All relevant timelines and record. Now, Malas, this is not by itself the crux. It is the crux because in this case, you have shown me nothing as to how I have been involved in the discharge. Where this is. That is why it's a crux. That is important to remember.
Yes.
My Lord has rightly used the word crux because you have to show that I as a minister, I as a public servant, I as the chairman of a department, I as the file signer, I as the file mover, I as the recommendee, I as the statutory compulsory persona designata, something. Nothing. But your discharge of official duties is because you're a public servant. So the discharge is as big as the universe, the entire universe. Now, let's kindly see. Come to 29.2. The official capacity of the petitioner at various junctures enabled him to assist in fabricating record. Now, is this possible? Just kindly see this. This is being told to your Lordship's brothers. In pleadings, is this the way to get sanction? And of course, none of this is dealt with. I would have liked the governor to say, I grant sanction of 1 and 2, but I call this bunkum. I reject it. He can still grant against me. See this, fellows. Various junctures assist in fabricating records. Your lordship will not work on adjectives like this. Next, recommendation or decision is made by a public servant not directly or reasonably connected with the official. He is not entitled to protection. Third, it is not the official duty to facilitate the fabrication of fake record. Well, some comma, full stop, some sign. Some collusion, some meeting in a smoke-filled, dark-filled room, doing something, well, your lordship doesn't. And this is very easy to destabilize. Anybody will take a pot shot. The petitioner cannot seek or obtain shelter under the aforesaid statutory provision as the offences alleged are not in the. This is, I'm reading his reply.
Yes.
Consequently, contends the prior approval does not apply at all. Then take your chance. Take your chance. You are the one who went to the governor. You are the one who's got all this thing going. And now you are pleading this also. And you are pleading this on one of those amazing facts of fabrication of records. Not a word, not a single comma, full stop, remotely. Then, page 44. It is pertinent to note that since the allegation against the named accused are not in relation to any action taken or recommendation made or other name, there is no requirement of prior permission or approval. This is amazing. It's extraordinary. Now, there's no answer to say that if this is so, Mr. Singh, you can be prosecuted without sanction. It is for him to take his chance, not for me. I'm only coming against what he did. I have started nothing myself. This categorical statement is not a concession. Mark 29.4 is my conclusion. And if this is true, then it's also apart from anything else, a wastage of public money and public time. If this is so, in addition, I don't know whether there's an offense of public wastage of public time. There's no offense like that. But this categorical statement is not a concession granted by the respondent, but an admission that the fundamental requirements of 17A with regard to recommendation made or decisions taken is not made out in the present case. Therefore, expatiate the impugn order. In that case, the sanction goes on this ground. 17A explicit, and I'm sorry to repeat, this para 29.2 is verbatim reproduction of his pleadings.
Yes.
No note, nothing, pleadings. So your lordship is obliged to rely upon it. I am obliged to rely upon it. The court is obliged to rely upon it. It's a pain of perjury. It's on pain of perjury. Section 17A explicitly grants protection concerning inquiries that are to be conducted solely by a police officer. The clear implication or necessary corollary is that only a police officer has the authority to seek prior approval to lift the bar. This process, much like registering an FIR under 154, 156 or 173, requires the police officer to exercise independent application of mind. This application of mind leading to a further action is the sole and exclusive jurisdiction of the police officer, and no one else can replace him. Criminal jurisprudence has deliberately limited the involvement of private parties, ensuring minimal interference of complainant in order to protect the accused's right to a fair prosecution. It is only through recent judgments by the court that the complainants have been given a limited role. This is important, Malas. Complainants have no role except to the extent your lordship permits them in ABCD cases. This limited role is designed to uphold the integrity of the criminal. Why do your lordship not give this, Malas? Because you just can't say that you can kickstart the whole thing in motion. Allowing private individuals, 45, to move the competent authority for prior approval would create an untenable situation where the police officer's authority to apply his mind and determine whether a case merits such approval would be undermined. This is, Malas, the core larger legal question lordship should, Malas. In this case, these dates I have done, but 29.6 I have done, Malas.
Yes.
18th, 25th, and Malas, 18th, 25th, and 26th. These are the three dates in 29.6. Then, Malas, the SOP.
When was the approvals, before the private complaint, when was the private complaint registered?
13.8 is the private complaint.
Private complaint.
13th of August.
Right. 18.7. No, 18.7 is the first complaint.
It's the first complaint. 25.7 is the supplement.
18.7 first complaint.
25.7 supplementary information.
Yes.
26.7 approaches the governor directly. Can you note one moment? Same day he issues show cause. 26.7.
That is argued. Yes.
And then Malas goes on. 13.8. 13.8 is the register.
That is because Lalit Kumari says when a cognizable offense is brought before the court, brought before the police, crime should be registered with, everything should be over in 1 week and crime should be registered. If it's not registered in 1 week, next rung. There, if it is not registered in 1 week, next rung, that is 200 before the magistrate.
Well, then what?
That's what, no, that is the purport of Lalit Kumari.
My lord is absolutely right. What happened to Lalit Kumari when Sashikala Jolie was pending for 24 years? 24 months?
That is approval, not
Something.
Lalit Kumar.
No, but I mean, it's the same.
No, that parity we'll see what has happened later.
No.
Because that is something that has happened now during the pendency of this petition.
Yes. No, that is the judgment has come. I mean, the order has come.
Order has come now. It was pending 21 years.
Then, Wallace,
I'm surprised that is approval or sanction is not.
the
even
Lordship said, so
clear.
we checked up. We were also
Yes,
surprised.
it is approval.
17,
Yes.
Now, Wallace, last, I'm just ending, Wallace. I want to just cover some facts and then I'll
Yes.
try and end. Lordship, give me a few extra minutes, Wallace. I want to.
No, take your time.
Wallace, 218 is page 46. I say it is virtually.
218 stage, I think, has not
virtually
yet come.
conceded. No, just read this one para only. It is virtually conceded. The Honorable Governor has, apart from granting prior approval, also proceeded to grant sanction. Your Lordship is right, but that's not what the Governor thinks. The Governor says, I'm granting sanction. It's written there, Your Lordship has seen that. During the course of the submission.
218 is what is 197 under the CRPC.
Correct, 197. During the course of submissions, the learned senior counsel of R2 made a categorical statement that the impugned order is not a sanction order of 218 and must be read only as an order of prior approval. Your Lordship, record
So
this
you
because
need
that
not
takes,
you need not labor on that.
provided it is recorded. What happens is ambush points are taken. Either side appeals and we say, no, this is not decided by the judge.
No,
But why will the judge decide this? You have conceded it.
No, that is in the written submission also.
Yes, also. Yes. Therefore, Your Lordship, just take that note. I am not arguing for that reason only.
Yes.
Otherwise, I am demonstrating completely that this is wrong. But anyway, he's saying that it is to be treated, this itself is non-application of mind value. To start treating 218s or 197s as 17A is itself non-application of mind.
No,
But
it's
leave that aside.
they operate in a
Leave
different
that aside. Now,
because 197 is after investigation.
yes. Now, no, he's saying treat it now as a 17A order, prior approval order. That's all. Now, page 47 is very important. Well, 3 or 2 very serious errors of law were made and then the facts. Natural justice was brushed aside on the simple point. Notice was given to me, and so what, I didn't send you the other 2 complaints. I was not required to give notice at all. That's the very, very far-reaching. So first argument, I gave you notice, but I was not required to give you notice. But since I'm not required to give you notice, I'm not required to send you the other 2 complaints. So my own definition of natural justice applies. And third, so what does it matter, Mr. Singhvi? There is no prejudice to you. Let's get on with the matter. All these 3 things are answered by the Supreme Court evocatively, and my learned friends have completely misrepresented the law on this point. The law is totally different. Just come on prejudice first. Dharampal, page 48. From the above discussion, it becomes clear the opportunity to provide hearing before making any decision was considered to be a basic requirement in the court proceeding. Later on, this is all very common, so we ignore it. The more common, the more important is to underline it. Later on, this principle applied to other quasi-judicial authorities, even in administrative, before taking a decision, hearing is necessary. Boldface, Krepak, etc. Now just see what he says, Wallace. So far, so good. However, an important question posed by Saurabhji is as to whether it is open to the authority, which is to take a decision, to dispense with the requirement of principle of natural justice on the ground that affording an opportunity will not make any difference.
No, that's not.
To put it differently, can the administrative authority...
No, it can't be said. Or even if I give you notice, what will you say? That cannot be the reason.
I was not required
That
to
can't
give
be.
you. Even if I gave you, I'd have the same result. No prejudice would happen. These are the angles of the same argument.
But here, he only extracts one paragraph in the order saying that there are 2 other complaints. No contents of that complaint is noticed.
That's my grievance. That's my grievance. Because he has already sent me notice. So now I'm dealing with 3 points. Well, 1, if you elect to send me notice, you are stopped from arguing that no notice is required. That's proposition 1. You're in administrative law.
Yes.
If you elect, I did not elect, you elected. You elected to send me, then you cannot say that now notice is not necessary. Second, if you elect to send me and do not send anything else, then you cannot take the plea that even if I had heard you, nothing else would have happened. They are the 2 main propositions.
Right.
Now we'll just come to 31.3.1 at page 49 bottom.
Yes.
49 bottom. The request for prior approval or receipt by the governor on the same, and third, I'm very sorry, third is the most important. He gave a detailed half-day hearing to the complainant. It can't be brushed aside by saying criminal law. I can hear whom I like. He heard the criminal law complainant. He gave me notice. Then he did not give me the notice for the other two and then said no prejudice. That's the fourth. Let's put them all together and whatever the conclusion is. The request for prior approval received by the governor on the same day a detailed hearing is granted to the person seeking. Same day, the governor further finds a prima facie view on this meeting alone and proceeds to issue show cause. Such view was formed despite the fact that documentation was mostly in Kannada. The detailed set of the governor is obviously not Kannada. So very detailed. 200 pages. I have seen, my learned friend has seen is all Kannada. Obviously, he didn't learn Kannada overnight. Prima facie case. No, these are important. If you are doing this application of mind, what if mind can't apply in a language you don't understand? What application of mind in a language you don't understand? The detailed set of documents provided by the third is in Kannada, application by fourth is in Kannada, fifth respondent is not even on file. The Honorable Governor, as can be seen from the response to the RTI, admits that he needed an English translation. He writes the file to proceed with the other application for prior approval.
Aid and advice of other officers.
Yes, for the others. But in the present case, Kannada seems to be the chosen language. This is in the other cases. Here, on the same day, on 26th July, he proceeds.
Yes.
In the present case, English translations were done by the governor's office is not borne out from the records. Whereas in the other cases, investigating agencies are directed to file translations. There's an order noting. So this is the direct proof. Well, this matter, this particular order must be set aside. Whatever order he has to pass, etc., is a different matter. The Honorable Governor, on the basis of a petition accompanied by more than 100 pages in Kannada, come to the conclusion that the allegation is serious nature and prima facie need action. Also notices that complaint is filed to the local police. It is rather surprising and ironical that the Honorable Governor, unable to read and decipher Kannada, is also able to digest documents of hundreds of pages, etc., etc., and issues notice immediately. There is undue and inexplicable haste. This is not a facetious thing. It all adds up in the overall. It's not just a light game that I'm saying he doesn't know Kannada. That's not the point. He's not expected to know Kannada. I'm not suggesting a lordship. In fact, in the old days, there used to be a bar that you're not from. Even today is a bar. You can't be from the same state if you're a governor. The application of a prior approval.
It's all right. How can you interfere? Yes, I am aware of that.
The application for prior approval sanction is received by the Honorable Governor. Addendum is on 26th. Addendum is also received same day. Let us kindly see page 51. Opportunity of detailed hearing of 3 hours is provided. And by 10:30 on the same day in the night, 10:30 p.m., a show causes notice issued. A process in such a manner by one of the highest constitutional authority against another highest constitutional functionary is unheard of. I'm saying this with a sense of response. Such application, the Raj Bhavan would on the same day reach the governor, and then hearing to a private party takes place on the same day, a show cause. This is all Article 14, etc., etc. And your lordship will see the totality of the earlier arguments also. Then, Malads, 31.3.4.1 is page 52. Sashikala Jole, all the dates are given to your lordships. In one place, at page 52. Murugesh Nirani is the other case.
That is also pending?
Returned. On 28/8. All is happening after this case has started. He's either returning or rejecting. Approval is only my case. Well, now you have to explain the delay. Well, it happens even in the judiciary. Sometimes after 2 years, the matter is put again for clarification. So here, after 2 years, in Nirani's case, he sends it for clarification on 28th of August. Then, same thing about H.D. Kumaraswamy, returned to the requesting authority. Then, it is very clear the dates are all after the hearing of this matter has started or after this matter has become a dispute. Not hearing started, but dispute. Then, application of 13th of May submitted for sanction was returned by the governor in June 2024. On 21/8, investigation replied. On 28/8, the application was returned for English translation. Well, by the way, each of these, that is page 52, all the cases except Sashikala, page 53, all the cases are returned after they come back from the clarification, further returned for translation. Well, I hope I'm clear. Take, for example, 53. My case, the same day, the night. Same thing. Now, let us see this ground. This is very, very important, 53. In Shashikala, he does exactly what I've been laboring the whole day today. He did not do in my case. That is quoted. It is quoted once. He has given, I'm not saying it's right. I'm not saying who will challenge, not challenge, what your lordship will decide. But is there anything your lordship found? Just glance at it, brothers. Any word similar in my review, judicial, this is judicial review. We don't need.
Wait, sir. I'll get back to you. Wait. Yes.
In order to attract the provision of 730, there must be a receipt for the bribe amount. The mere statement one was paid 25 lakhs paid, whether he received the amount is not clearly disclosed. For sanction on inquiry necessary to prove the demand of illegal gratification. So while he's doing the ingredients of POCA, he's writing, and then while he says, hence I find now. 20. Then while para 20 is read, it's already read. Then while 55, I will skip till 59 because I want to take a lordship's 10 minutes on that dates. 55 to 59 are largely dates, fellows. So lordship may just give me, and then I'll come back to it because the matter ends at 62, but just come to 63. Just come to 63.
List
now,
of dates.
Yeah, they just note on the side.
Yes.
All these documents are in the writ or filed by them. Number two, I have not going into it. My learned friends have gone into it meticulously in the arguments. Half the argument, 3/4 of the argument, Mr. Maninder Singh was on these facts. 3/4 and others. But I want to now show the true facts. And what I've done in the table is document 1, document 2 I put on the left side. What she's got? 63.
Yes, yes.
I made one compilation of all. They're already there in the writ or elsewhere. There are 4 new documents. One is Shashikala Jole, which is not a new document, subsequent development. One is the plan, which is all are mentioned. Apart from Jole, each and every one is mentioned both in my petition and in the cabinet sanction or denial of sanction.
All right.
All mentioned. Now just see the startling consequences very quickly. Well, 92, your lordship has a notification. Then the old fellow, the earlier owner is Devaraju in item 4. When I say 4, I mean document 4.
So, Devaraju is the owner?
Then owner.
Was not there a relinquishment in favor of one Cheluraya or something? Mailaraya. How did Devaraj become the owner?
No. That is much old. Subsequent to that, a release deed in favor of Devaraju.
Where is the release deed in favor of Devaraj?
Yes, give me the page. Is it on record? Where is the and the averment in the writ? And the averment in the writ.
No, since you are replying on facts.
No, it's very important.
Should be clear.
Very important. Very important.
It's 10th of April, 1993.
Yes, Rangnath.
10/4/93.
There is one relinquishment deed in favor of one Mailaraya or something. Yes.
1935. It was 1935.
No, let us see. The date of the one thing says one thing.
Mailaraya was 1935 from the same family.
What's the date?
10/4/93.
10/4/93 is in the documents file. Give the file to my lord. Page 11.
We gave it in the morning.
Page 11.
Oh, it is release the land in favor of Devaraju, is it?
Yes. Yeah. We are talking of 93.
Which is that I have not seen this document at all.
It is.
Yes, Rangnath, you have not produced this? No, which is this 10/4/93 document?
No, this is produced now.
Now it's not a part of the record. No, nim record allu hakilva adu.
It is recorded in the writ. It is recorded in the cabinet thing, but document is this.
Where is that document?
This one, page 11.
It is given in the morning.
That bunch we given once.
In the morning.
All of it is in the writ or the cabinet decision. This bunch. Kindly give the bunch. No?
All right.
No, morning. Just show the bunch.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
It is mentioned in both my reply to the governor and in the cabinet decision.
Yes.
Now, kindly come to. I obviously can't read it.
No, that
and
document number 3.
4, I think.
4 is it?
4.
No, in this you say document number 3, 10/4/1993.
Document 3.
Bhautikata.
Well, just for fun, we have made serial number 4. Foolish, why did you make
It's all right. ಭೌತಿಕಾತ ಒಬ್ರಿಗೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ?
is no more.
ಲಿಂಗ ಇಸ್ ನೋ ಮೋರ್ ನಿಜ. 3 ಮಕ್ಕಳು. ಭೌತಿಕಾತ ಆದ್ರೆ ಅದು ಒಬ್ರಿಗೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ?
Surviving 3 brothers.
Let's see. Yes.
Right, fellas? Now, kindly go ahead. Then, Malas, this Devaraju makes an application in document number 4 for Malas deletion.
Yes.
Then, Malas, a resolution is passed in. Well, look at this person who is trying to grab all this and is so corrupt. We're talking of 93, 97. That itself, Malas, and a person comes today, I'll read that para about the antecedents of those who have come now. Keep that para ready. Keep it out. Document 5 passes a resolution that they can be excluded in 97. Then, Malas, notification is issued. Now the Commissioner Muda recommends for release.
Yes.
General award is passed in document 8. Denotification is again recommended to 9. It was made to sound like a huge conspiracy that there is no denotification at all. These are all balance.
No, denotification is there.
No, it is wrong. This is a government process going on. It is not something which I am the minister in charge or is done for me or not for others. Then balance 10. Denotification is issued under 48. The Roshima specifically told, where is 48? This is no 48. This is all false 48. I was there, Malas. It was 48 was just brushed aside as some kind of thing. What is this document, Malas? Item 10, page 47 to 51 in the writ. Then, Malas, approved layout plan is important. This is mentioned again in my and Malas the cabinet, but I produced it at page 52. How do you approve a plan, Malas, by saying denotified? Can a lordship have an approved plan of denotification without it actually happening? Somebody will go for forgery, Malas. And forgery would have happened, Malas, in 98. We are in 2024. Then Malas, very irresponsible and extremely rhetorical and hot-blooded accusations were made, making the whole thing look like a scam for 23 years. Ignoring all this, and people who knew so much to say also had all these documents. Those who argue with all this vehemence are deemed to have all these documents. You can't argue, so I did not know. If you did not know, you jolly well be responsible and don't raise it in so irresponsible a manner at such a high pitch. Then verse 12. Notification does not show the lands in question. Now this is because it's denotified. This is the reverse thing. I'm showing an omission in item 12. An omission. Now you can say that all the documents for 25 years have been forged. Thankfully, you have not said so yet.
No, that's not.
You're not thankfully till now said so. Then Malas, personal award is passed in 13. Now it is possible, Malas, that despite this, I'm such a superhuman human being. But this is not a ground automatically without adverting to a single fact to grant a sanction. This is not the kind of case a Lordship Malas has cases where Lordship has. What has happened in Malas, the precedents have muddied the field because you have corrupt people. You have people with the same day, same this thing and all. Past. This is not that kind of case. This is proceeding at, if at all, a inordinately slow pace in my view. In my view, a very slow pace. 13, personal award. 14, illegal allotment of sites on paper. This is a reality. Please check up. And Maharaj, at 61 to 71, it is found Mr. Abraham's application. Mr. Abraham's application. And they have argued and he has argued such vehemence.
No, allotment of sites is not on paper. It has actually happened. To the allottees of the layout, it has actually happened. Yes, Ragnath. It has actually happened.
Paper.
Yes.
May I say, de facto 100%. 100% de facto. Muda is dealing with it. Nothing on the paper will happen. Nothing on the ground will happen without the paper, Malas.
True.
It can't be that in the air. This is a Muda authority. Document 14 is found, Malas, 61 to 71. Lordship may see. I put the page. What else can I do, Malas?
All right.
But this is not a figment of imagination. And none of this is dealt with by the governor. First time a sale deed happens is 2004. So Lordship will draw a line here.
First sale deed is 2004.
I mean, sale deed relevant to not him, but his brother-in-law. I mean, not him, but his brother-in-law. I'm drawing a line still. This is, Malas, from 92, 93, and Lordship is stopping at 2004. This is a whole decade. Then, Malas, conversion of lands is applied. This is applied in 2005. And let us just see the next date between 16 and 17.
5 years.
Such a mad rush because he's been in politics all along, Manas. He's been either an MLA or he's been a deputy chief minister or a minister. He became a minister in the 80s. Such a mad rush, man. He must be madman, Manas, that he's taken 5 years to have a gift deed to his wife. These are lordships reach the totality, the holistic. This is not some kind of a scam, Manas, where the man is desperately trying to grab something. He's taking 5 years from 16 to 17. Then Manas, 18. This lady Malas requests to allot alternate land. Now, it is not the only lady who gets it. It is not the only case of encroachment. It is not the only time it has happened. It just happened that I am the chief minister's wife also. Then Malas, 19. Proceedings of the meeting where the application is discussed and decided as follows. This is Malas, 90 to 94. This, Lordship, just note that. That thing your Lordship asked me. Just note on the side.
Yes.
My son is officially ex officio, all MLAs. I've checked.
Yes, all not only. I'm not saying that it's only.
My Lord asked a neutral question. I'm giving the facts only. I'm also giving a neutral.
As an ex officio member of Muda, being an MLA of the constituency, you had participated in those deliberations which decided to allot alternate sites.
Number two, no, but there's something more interesting. The minutes of the resolution of that meeting are fascinating. They are in the relevant, the same volume, page 96. All the people, including MLAs who participated, contributed.
Yes.
This man did not say a word. No, I'm just saying there's no participation. He's sitting, he's attending. There's no participation in decision making. None. None. And this complaint is against me.
No, the complaint is against you.
Yes.
That's all right.
And fourthly, that person, my son, is not made a accused. Now, Malas, if it is private,
Yes, sir.
now, Malas, very well. Now, Malas, today, if Malas, I am to be culpable because of this one incident of 19, which is happening in 17, when Malas, this event happens, then Malas, your Lordship will see the totality also. That's the point.
No, their allegation is the beneficiary is the roof.
I understand, Malas. This is the allegation is much
The
more.
roof of the chief minister.
This son came now, Malas. The allegation is that this is happening from last, all the decisions, this denotification is the allegation. The encroachment is the allegation. No son, no father, nothing but it's the allegation. This is only the Malas consequential decision which is coming up now. That act has happened.
It's an allegation, not a conclusion. It's an allegation.
Now, Malas, my first point is, have you dealt with it anywhere in your order, Mr. Governor?
That will, yes.
Have you then shown that is there any connection with me in a manner which can be credible? Have you addressed it? There is a whole para which addresses it in the cabinet decision.
Yes.
Have you then dealt with that para and said this is wrong because of 1, 2, 3, 4?
That I will answer.
This is the. And then, Malas, then of course, willingness given. Now come to Malas, document number 23. No, sorry, before that. No. 20 onwards, Malas. 20 onwards is very important. Just draw second line at 20. That is 14, 11, 19. I am in the opposition. But should I put that line there? Item 20.
Oh, yes.
Now, then, Malas, the principal government department writes to Muda to take a decision at their level. Proceedings of the meeting of Muda where it decided to give 50% of developed area as compensation. Willingness given by not me, but by Malas, 14 or 15 other people across the state, or where not across the state, in the relevant areas. Then Malas, relinquishment deed, etc., the last 4 days. Now, Malas, the last part is come to Malas, the submissions at page 55. Come to 55, the submission, I am done, Malas. So, Malas, there has to be a proportionality for this one meeting and most of the time outside of the power. If you are going to go that far, then Malas, totality doesn't justify, you have not dealt with the administrative law aspects.
You told me you made about these antecedents.
Then Malas, come to para 32 of my note, page 55.
55?
Yes. So 32 and 33 gives the same list of dates. All the way, Malas, to the end of 56. Come to 57 top, the denotification is not specific to the subject lands, extended to other lands.
No, it is Denotification is not only this land, it is something else. A denotification happens to the adjacent land. That is also there on record.
19 is what I've said, Malos, at page 57, 19
What is
examples.
this survey number denotified?
462.
462 now.
462. One person.
462 or 464?
462 and 464.
462.
Now 19 other is important, Malos, at page 57.
No, all that is there.
Yes. Then, Malas, just note that these are impressions given to your lordship in the prejudice part of the argument. If I'm just very quickly clearing them. Now, Malas, 33.3.1. The notification does not, under 16.2, does not cover the lands in question, and the lands were therefore excluded. This notification is 33.3.1, Malas, find me. No Panchnama, no inquest report, no memorandum, no sufficient documentation as required under Indore Development Authority regarding taking over of possession. Your lordship is told taking over of possession. Then, Malas, now, this para 33.5 I have put in boldface. I need a seat for a minute. Allegations questioning title are based on suppression of the crucial family settlement. Now, Malas, you are questioning my title. Inside my family, there is no dispute. It's a family settlement at para 33.5. Number is given. Register is given. There is no jhagda, but Malas, somebody else is questioning.
No, that's not the submission also.
Then, Malas, that other writ, Malas, is identical for this reason. That's very important, Malas, to remove that impression. Where, Malas, the matter was not proceeded with and the man was released, the land was released.
Which one, sir?
Other writ was said that we have suppressed the writ number and all that. Sundarama's case. Sundarama's case is only cited for the point that another case where actually acquisition was not continued.
Oh, that Justice Bhajantri's order.
Yes.
Yes.
It is not continued. So also in my case, acquisition is not continued. Just 5 minutes more.
Just one.
61 is very important. 50-50 benefit taken by hundreds of people. It is not just me who's got it. 61, we have made a chart.
Yes, sir.
Now, Malas, that other matter, just see 61 and I'm done in 2 minutes, Malas. 61 is a list. This is important. I put a chart.
Yes.
This Muda, look at what it did for an overall policy, Malas. Look at the number of sites, Malas. 50-50 ratio. This can't be, Malas, any kind of an individual case, Malas. Then sanctioned without land acquisition, 570. First one is without compensation, 358. Without acquisition, 570.
Yes.
Then prior to the date, 99. After the date of 5/1/22, 835. This is completely, well, to particularize it as if some kind of conspiracy by an interested party is wrong. This is an all Karnataka thing. Then, well, Sundarama is important because, just note one thing, 33.8.3, which is at page 61.
There is no distinction between the case.
That was what was thought to be said. There is a vital distinction. There is none. Where land acquisition is not initiated, and a case where land acquisition is initiated, but the land is later denotified. That was the example being given. We have given an analogy. We are not saying we are that case. We were saying that land acquisition was in the process, was not initiated then. Mine was the case initiated but withdrawn. So the result is the same. There is no distinction. Lastly, just note my writ, para, page 31. Page 31. This also
of the writ petition?
No, this 31, yes, in the main writ petition.
Yes, it's main writ petition.
Main writ petition. 1, 2, 3, 5, 6.
Krishna, you said limited the bond.
Yes. Page?
Well, it is also important for such matters. It is not that it's a rule of law, but the sanctioning authority gets a feel of the case. It is not that everybody on Malas will come and start doing this. Frivolous, vexatious, or dubious antecedent people should never be encouraged because this is a much larger repercussion. You are protecting public servant anyway. Here you are protecting a public servant against dubious people or dubious antecedents with frivolous, vexatious objectives.
What's dubious?
Yeah, come. 31. 31.
No, who's dubious here?
This particular person was 631.
Page 31.
Reading the paragraphs. The credit, no.
Oh, antecedents of respondent number 3.
This is one example. Mr. Abraham is a crucial factor. He is a habitual litigant, well-documented history of engaging in blackmail, extortion, and the misuse of legal processes.
No, I would put it this way. Yes, it may be. A whistleblower will always face these problems.
Provided he doesn't have, a whistleblower need not have an antecedent thing. This is not
Any
25
any whistleblower will always face this problem.
Correct. Will the Supreme Court impose 25 lakhs cost on a there can be whistleblowers without this? Next sentence, please read,
Right.
Manoj.
Yes.
It's not a,
Yes.
he is a habitual, I have put words here, Manoj, advisedly. He is habitual litigant with a well-documented history of engaging in blackmail, extortion, and misuse. His conduct has been repeatedly condemned by various courts. Supreme Court imposed a cost of 25 lakhs in SLP. 25 lakhs is not given in 2017 in even 1 or 2 cases for abusing PIL. In addition to the history of vexatious, respondent has been involved in criminal activity. But a lordship is a judge who takes a holistic view. Ultimately, judges have to take holistic view. FIR registered in 2023 for offences including, can't you have whistleblower without all this, police? Extortion, outraging the modesty of a woman, criminal intimidation under sections 384, 506, complaint filed by Sudha, a government official, alleges that Abraham attempted to blackmail.
384 is not outraging modesty of a woman.
What is the
Oh, that matter. 384 is extortion.
384 is extortion.
All right, yes.
The complaint filed by Sudha, a government official, attempted to blackmail these serious
Sir,
criminal antecedents evident that
sir,
it lacks.
If we can do this, give me 5 minutes, I'll resume. Whatever it is, I'm going to complete this today.
I have in fact finished. Police.
Yes, sir. I'll get back in 5 minutes.
Certainly,
Yes.
certainly.
Good.
Sorry? He's going to conclude today. If you want to argue, you can argue with me.
Yeah. You have practically covered I just want to take him through. Yeah, I will take him through those.
What I'm saying is, anything else? note the three dates. Well, it's the post-coalition true opposition government came on 26 July 19. Just note the three dates. Whereas there was in between small coalition period. Then whereas the government of the current central government ruling party came on 26 July 2019. Well, it's the official principal secretary level decision to say that Muda will take a decision at their level, entirely delegating to Muda, is published on 14/11/19. That is 5 months after the BJP government had come.
All right.
14/11/19. And finally, the Muda, acting under that government mandate of a different government, on 20th November 2020, decided to give 50% of the developed area as compensation, wherever Muda has not acquired land or not proceeded to acquire fully.
Not acquired, but utilized.
So therefore, Maharaj, these are the three crucial dates. Of course, one of my learned friends here on the other side have gone to the extent of saying, and I have no illusions about myself, but she certainly has illusions about me, that I was so powerful even as the opposition that I engineered this. I am very happy for the compliment, Wallace, but I'd rather live without such left-handed compliment because I have no illusion about my own power. But Wallace, anyway, these three dates are crucial because the operative thing is happening 5 months after the new government and 7 months Wallace, at the end of 2020. 1 year after that first. So decisions are 14/11 and 2011-2020 next year.
Yes.
So Wallace, this is when all this has happened. And without that consummation, there would be no such complaint. That entire consummation, the actual so-called, if I may say, Wallace, the fruits of crime, I mean, I'm not saying crime, but have happened entirely during a BJP government.
While you were in the opposition.
Very, very deeply obliged for a very patient hearing.
Yes, yes.
Good, my lords, excuse my absence. My lord,
Yes, yes, no problem. Yes.
Very deeply obliged.
Yes.
After the argument started, a sheaf of papers are given before the court, saying that they are the proceedings of the government.
What papers?
Records of the government.
ಈಗ
ಅಲ್ಲಿ ಕೊಟ್ಟರಲ್ಲ ಆಗ್ಲೇ.
The other day. Yes, yes. All right.
May I request the court to kindly take those
Yes.
for a minute.
ಗವರ್ನರ್ ಅವ್ರ ಇದ್ರಲ್ಲಿದೆ 6-2 ಏನೇನಿದೆ ಎಲ್ಲ ಕೊಡಿ. Take this. ಇದಲ್ಲ ಸರ್ ಯಾವ್ದು ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮೆಮೋನಾ?
No, governor's file.
ಗವರ್ನರ್ಸ್ ಫೈಲ್ ಇದು ಬಿಟ್ಟು ಇಲ್ಲ ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ನೀವು ಓದಿ ಇದರಲ್ಲಿದೆ. ಎಸ್ ಸರ್. ಇಲ್ಲೇ ಇದೆ. ಎಸ್.
Sir, kindly come to page 3.
Yes.
Paragraph 8.
Yes. Yes, sir.
This is the first order passed by His Excellency, the Governor. I have heard Sri T.J. Abraham.
Yes.
In person. Gone through the petition and supporting documents submitted by him. Prima facie, I am of the view, there might be irregularities and misuse of power. Kindly mark the words.
Yes, there may be.
There may be irregularities and misuse of power. Hence, issue show cause notice to Sri Siddaramaiah. I'll refer to the show cause notice, what it is. So
Yes.
this is the first signature in the file
Yes.
on 26/7.
Yes.
Now kindly come to the next signature. Page 5. Same day. This is to send the notice.
Yes.
Draft copy was approved. It is being sent. Then, as per the orders of the Honorable Governor, draft copy of the letter again same it repeated. Page 7. So
Yes.
this is the first sign of application of mine, put up along with comparative statements of petitions.
Yes, because there were other complaints.
Comparative statements of petitions, Chief Minister's reply, and Cabinet decision.
Yes.
So this is the first direction.
Yes.
Now thereafterwards, His Excellency passes another order on 14/8.
Yes.
Peruse the file,
Yes.
discuss the issues, hence resubmit the file along with notes, analysis, points as dictated based on the comparative statement and available documents and petition. So this is on 14/8. Now thereafterwards, the final order comes. So these are the only deliberations of His Excellency. Now what I want to show is, kindly come to para 25. Now this is a file built up on the representation of or the application of Mr. T.J. Abraham,
Yes, Abraham.
which was filed on 26/7.
Yes.
Kindly come to page 9.
All right.
There is a reference to 3 petitions.
Yes.
Item number 3 is a petition from Snehamayi Krishna.
Is the fourth respondent.
Dated 5/7. I want to know where is that file? Why it is not placed before the court?
So it is in the original file.
No, it has.
In the original file. All right. Yes.
Anyway, it is not given to us.
No, original file is not given. Only the.
ಅಲ್ಲ ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. No, what I want to tell the court is, ಅಷ್ಟು ಪ್ರೀತಿಯಿಂದ ಅಬ್ರಹಾಂ ಕರೆದು ಕುಂಡ್ರಿಸ್ಕೊಂಡು 90 ನಿಮಿಷ ಮಾತಾಡಿದ್ದಾರೆ. ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣನ್ ಪಾಡೇನಪ್ಪ ಅಂತ. ಅವ್ರನ್ನೇನಾದ್ರು ಕರೆದಿದ್ರ, ಅವ್ರನ್ನ ಮಾತಾಡಿದ್ರ, I think my learned she will not interfere with my submission.
All right. Wait.
5/7/2024. That is the first application given. What is the deliberation of His Excellency on that petition? Is a file opened at all? If so, what are the orders passed? Why notice was not issued in that first petition that was filed before? So is the case with Pradeep Kumar,
The fifth respondent.
fifth respondent. So this is one issue which needs to be addressed. Now, be that as it may, kindly come to the order that was dictated
By the governor.
by the governor.
Yes.
That is what
Yes.
the
that is
note
what-
says.
Yes.
Governor doesn't say this is the order. No, notes. We have to infer that this must be the order.
Dictated.
Dictated. Now, para 27 onwards
Is the dictation.
is the supposed dictation. Kindly come to. So the first one are all in the nature of preamble. What happened? Para 30 deals with Council of Ministers and the contents of the cabinet
Yes.
advice. I'll not trouble the court with the text of it because it only extracts what the cabinet has advised. Kindly come to para 31. In view of the averments made in the aforementioned petitions, seeking grant of sanction for prosecution and the materials in support of the same, the subsequent issuance of show cause notice dated 26/7/2024, reply to the show cause notice by Sri Siddaramaiah, Honorable Chief Minister, legal opinion of the learned Advocate General, and the decision of the Council of Ministers dated 1/8, I am of the opinion that in exercise of my powers under Article 163(1) of the Constitution of India, considering the aforesaid materials placed before me, and the facts and circumstances present of the present matter. As a matter of propriety, I shall exercise my discretion. So this is where His Excellency comes to the conclusion that he will exercise his own independent.
That is because he concludes that the decision of the cabinet, decision of the Council of Ministers is irrational.
No. Previous paragraph, there is no such thing. Court,
order.
Allah, I go down to Allah. We can't disjoint the order from the note.
Right.
Order is a product of this. I will also demonstrate how it is a product of this very note.
Yes.
Because the order by itself does not contain any.
No, order does not contain, but the order does contain the words. I decided to exercise discretion on the score that the Council of Ministers' decision is irrational.
If I may say so, the order is a very interesting order.
No, page 44 of the petition, the order says.
I'll deal with it. ನನಗೊಂದು ಕತೆ ಜ್ಞಾಪಕ ಬರುತ್ತೆ. ಒಬ್ಬ ಭಕ್ತ ಅವನು ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ಬೇಕು ಕೈಲಾಸಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂತ ಡಿಸೈಡ್ ಮಾಡ. ಈ ಡಿಸೈಡ್ಸ್ ಟು ಗೋ ಟು ಕೈಲಾಸ, ಶಿವನ ಹತ್ರ ಹೋಗ್ಬೇಕು ಅಂತ. ಹರಿಗೆ ನಾನು ಪೂಜೆ ಮಾಡಿದ್ರೆ ನಾನು ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ಬಿಡ್ತೇನೆ ಅಂತ 2 ಲೋಲಾಕ್ ಕಟ್ಕೋತಾನೆ. ಕಟ್ಕೊಂಡಾಗ ಏನಾಗುತ್ತೆ, ಹರಿಗೆ ನಾನು ಯಾವ ಕಾರಣಕ್ಕೂ ಪೂಜೆ ಮಾಡಬಾರ್ದು, ಕೈಲಾಸಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂತ. ಬಟ್ ಅವ್ನು ಎಡಗಡೆಗೆ ತಿರ್ಗಿದ್ರು ಹರಿಗೆ ಜ್ಞಾಪಕ ಬರ್ತಾನೆ, ಬಲ್ಗಡೆಗೆ ತಿರ್ಗಿದ್ರು ಹರಿಗೆ ಜ್ಞಾಪಕ ಬರ್ತಾನೆ. ಸತ್ತಾಗ ನೇರ ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ತಾನೆ. ನನ್ನನ್ನು ಯಾಕಪ್ಪ ಕರೆಸ್ಕೊಂಡೆ, ನಾನು ನಿನ್ ಭಕ್ತ ಅಲ್ಲ ಶಿವ ಭಕ್ತ ಅಂತಾನೆ. ನೀನ್ ಮಾಡಿದ್ದಿದೆ ತಪ್ಪು. ನೀನ್ ಪ್ರತಿ ಸಲ ಲೋಲಾಕ್ ತಾಕ್ತಾಗ್ಲು ನನ್ ಜ್ಞಾಪಿಸ್ಕೋತಿದ್ದೆ, ಶಿವನ್ ಜ್ಞಾಪಿಸ್ಕೊಳ್ಳಿಲ್ಲ. ದಟ್ ಈಸ್ ವಾಟ್ ದಿ ಗವರ್ನರ್ ಹ್ಯಾಸ್ ಡನ್. He is obsessed with the cabinet note. All right, he rejects the cabinet advice. After that, what has he done?
So that was the material before him in reply. So he has to look into it.
That he has not done. For example,
the order
Chief Minister's reply is there. I will point out that also. Not a whisper in the entire order. Not a whisper in the order sheet.
No, the defense was that Chief Minister's reply, the cabinet note, are verbatim similar. So one is taken into consideration.
We can reject.
Wait, Rangnath. Yes. Adalle irli. Yes.
No, cabinet.
No, that is the argument.
No, cabinet advice may be refused to be looked into. That he has said so. But he can't refuse to look into my reply.
No, the argument was there verbatim similar.
That order should say so. Your argument too. Now argument ಹೇಳಿದ್ದಕ್ಕೆ may I request the court to kindly just one paragraph I'll show. Mohinder Singh.
All that para 8, 851, 78, 851, para 8. Yes.
May I just read that? And the second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise.
Of objections or otherwise.
Otherwise, an order bad in the beginning
will get validated
by the time it comes to the court on account of a challenge, get validated by additional grounds.
The orders are not like old wine getting better by the day. Yes.
Govardhan Das Danji, quote, public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer, not even by the contesting. Even if the officer gives it, it can't be accepted. Making the order of what he meant, or of what was in his mind, or what he intended to do. Public orders publicly made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Unquote. Orders are not like old wine becoming better as they grow older. So that is what, so it has to be summarily rejected, whatever arguments or justifications are given. I'll come to the order later. Now kindly see, Now that the court says there is a reference to it, may I take the court to the impugned order, volume 1 of the petition. ಅಲ್ಲ ಈಗ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
Same. Volume 1 of the petition.
Volume 1 ಅಲ್ಲಿ ಇದೆ.
Yes, sir.
Paragraph, page 41.
Yes.
Para 1 quotes the order.
Yes.
Para 2 quotes the two petitions given.
Para 3 show cause notice.
Para 3 show cause notice. Para 4
Committee.
council about the committee.
Yes.
Then para 5 the resolution of the
decision.
cabinet
Yes.
resolution. I have considered the decision of the cabinet dated 1/8. That is para 6. And file in relation to the issue at hand. It is noticed from the said file that Sri so-and-so had asked the Chief Secretary to convene a meeting of the Cabinet and to place the show cause notice dated 26/7 and all other materials before the Cabinet. Accordingly, the Cabinet meeting was convened on 1/8/1918, wherein show cause notice dated 26/7 and other materials were discussed, and the aforesaid resolution dated 1/8/2024 came to be passed. I have also taken note of the fact that the said cabinet meeting was not presided over by Sri Siddaramaiah, the Chief Minister. So it only narrates what the cabinet has done. In the present case, the petitions have been filed seeking grant of sanction against Sri Siddaramaiah. The resolution dated 1/8 of the cabinet has been passed by the cabinet colleagues of Sri Siddaramaiah, who have been appointed on his advice. In view of the above, and considering the fact that the petitions have been filed seeking sanction for investigation and prosecution against Sri Siddaramaiah, Chief Minister, I have also independently examined the petitions and documents submitted in support of the same, not the representation of the same.
Yes.
Now, since the sanction is sought against Chief Minister himself, the surrounding circumstances of placing the show cause notice and the decision of the cabinet would not inspire confidence to act on such advice. So it is about cabinet advice. Para 9. Subject of binding of the advice, again it quotes the cabinet this thing and quotes Madhya Pradesh police establishment case. That is it. Then para 10, this is where a decision is taken.
Upon perusal of the material.
Upon perusal of the petition, sir, not material.
Petition along with the material.
Along with materials in support of the allegations. In the petition and subsequent reply of Siddaramaiah and advice of the state cabinet, along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. It doesn't spell out what are those two versions. It is very necessary that a neutral, objective, and non-partisan investigation should be conducted. I am prima facie satisfied that the allegations and the supporting materials disclose commission of offences. Nearly 25 offences are cited. Which of those offences? For example, forgery is alleged. Is it the case that the governor is satisfied that Chief Minister has forged?
This is the first question I asked him the other day.
Yes.
He will answer.
Yeah. So, my very respectful submission is this is not consideration of the representation. And very interestingly, the note is important. That's why I was reading para 31 in the note. So this is all what the order says.
Order says. The governor's note is there.
Governor's note alle. Para 31 alle.
Yes. You can read, yes, sir.
Yes. In view of the averments made in the aforesaid petitions, seeking grant of sanction for prosecution and the materials in support of the same. Subsequent issues of show cause notice dated 26. Reply to the show cause notice of by Siddaramaiah dated 3/8. Legal opinion of the learned Advocate General and the decision of the Council of Ministers. I am of the opinion. So considering all this, what is the opinion formed? I am of the opinion that in exercise of my powers under Article 163(1), considering the aforesaid material placed before me and the facts and circumstances of the present matter, as a matter of propriety, I shall exercise my discretion by independently examining the aforesaid material. So he now proceeds to examine. What does he examine? 31.1. It is seen from the resolution of the Council of Ministers. The conclusion has been arrived at by the Council of Ministers by non-consideration of relevant material facts. For instance, the Council of Ministers has taken into consideration that absence of possession notification or a measure taking possession was mandatory.
Yes.
However, the revenue transfer certificate as provided under Annexure A5 of the petition by T.J. Abraham clearly stated possession of the alleged land was with Muda. Further, the fact that the alleged land was developed, etc., I'll come to it later. So, Governor is satisfied, possession is with Muda. Because Abraham says so, and Cabinet advice to the contrary is rejected for that reason.
So documents are there.
I'm obliged.
Muda's name is there everywhere.
That
is what is said.
I'm deeply obliged for that. Kindly come to documents of Abraham.
R3 ಕೊಡಿ.
90 minutes governor has heard. I think this was the only pertinent question he should have asked. Kindly come to para 51.
Para 51.
Sorry, page 51. This is Abraham's petition.
Objections.
No, Abraham's application, sorry.
Complaint.
Complaint, which starts at page Annexure B, page 48.
Sorry.
I'm sorry. Garbudi aitu.
ಇಲ್ಲಿ file with. Page?
Page 48.
Yes.
Annexure B.
No, you're referring to the complaint of T.J. Abraham.
Yes, R3.
That is found in which?
This is what the learned,
No, you're reading the governor's note or the?
No, governor's note refers to Abraham's content.
Complaint. That is page 50?
Page 48, Annexure
48 it starts, Annexure B. Yes, sir.
Yes. Now kindly come to page 51.
Yes.
Award declared. Page 51. On 30th March 1998, subsequent to the notification dated 20th August 1997, the preliminary award notice dated 20th August 1997, the award decision notice dated 12/3, and the final award notice indicating award of 3,24,000 was issued on 30/3 to Ninga, son of Javra. Sir, Ninga is dead. 28 years ago.
But the award notice refers to Ninga.
It is issued in his name.
Yes.
It is issued in name. A copy of the preliminary award notice, the award decision, etc., are produced. Then immediately, next sentence, he stumbles on this conclusion. Possession with Muda. As a consequence of the notification, the entries for the year 98-99 in the RTC indicates that the said lands were in the ownership and possession of Muda, effectuated by so and so. Now the question is, when was the possession taken over by Muda? He doesn't say so. Why he doesn't say so, I will refer to it. Kindly come to Annexure B1.
No, possession was taken over by Muda. No, he may say or is not said. But does the fact remain that possession was taken by Muda after the preliminary notification, final notification, award notice, then Muda is in possession. Everywhere it is said Muda is in possession.
I'm obliged.
Symbolic
Kindly
or
come.
physical?
I'm obliged for that also.
Yes.
Kindly come to Annexure B1.
That's the annexures that were read out earlier.
Sir, this has been suppressed. I'll point out.
What has been suppressed?
The fact that possession was not taken.
Where is the document?
I'll show that. Kindly come to Annexure B3.
D3.
B3.
B3.
Page 105. This is the crucial document. I request the court to kindly permit me to read.
Yes,
It's a very short document.
Yes, yes. Award notice.
This is award notice.
Yes.
Under section 12(2
Yes.
of the Land Acquisition Act.
Yes.
So everything is addressed. Ninga,
Ninga.
as court observed, it is Ninga Uruf Javra. Property name is correctly described. No problem. Kindly come to the narrative at the bottom of the page. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿಗೆ ಅವಾರ್ಡ್ ಆಗಿರುವ 3,24,700 ರೂಪಾಯಿ ನೀವು ಈ ಆಫೀಸಿಗೆ 15/4/98 ಬೆಳಗ್ಗೆ 11 ಗಂಟೆಗೆ ಈ ಜಮೀನಿನ ದಾಖಲಾತಿಗಳ ಸ್ವತ್ತಿನ ಮೇಲಿನ ಕಂದಾಯ ವಗೈರೆ ಪಾವತಿ ಮಾಡಿರತಕ್ಕ ದಾಖಲಾತಿಗಳು ಹಾಗೂ ಈ ಸ್ವತ್ತಿನ ತಹಲ್ವರೆಗಿನ 13 ವರ್ಷದ ಬಾಬ್ತು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಮೇತ ಹಾಜರಾಗಿ ಮೊಬಲಗು ಪಡೆಯತಕ್ಕದ್ದು. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತು ಪ್ರಾಧಿಕಾರದ ಕೆಲಸಗಳಿಗೆ ಬೇಕಾಗಿರುವುದರಿಂದ ಅದನ್ನು ಈ ನೋಟಿಸು ತಲುಪಿದ ಡ್ಯಾಶ್ ದಿನದೊಳಗಾಗಿ ಅದು ಕೂಡಲೇ ಇರಬೇಕು. ಐ ಡೋಂಟ್ ಗೆಟ್ ದಿ ಇಟ್ ಇಸ್
ತಲುಪಿದ
ಕೂಡಲೇ ಇರಬೇಕು.
ಎಸ್,
ಕೂಡಲೇ ದಿನದೊಳಗಾಗಿ ಖುಲಾಸು ಮಾಡಿ ಇಲಾಖೆ ಮಜುಕೂರಿಗೆ ಒಪ್ಪಿಸಿಕೊಡತಕ್ಕದ್ದು. ವೆಕೇಟ್ ಮಾಡಿ ಪೊಸೆಷನ್ ಸರೆಂಡರ್ ಮಾಡಿ ಅಂತ. ತಪ್ಪಿದಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಕಾಯ್ದೆ 16ನೇ ಸೆಕ್ಷನ್ ಮೇಲೆ ಸ್ವತ್ತು ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ಇಟ್. ಸೊ ದಿಸ್ ಈಸ್ ದಿ ನೋಟಿಸ್ ಡೈರೆಕ್ಟಿಂಗ್ ಹಿಮ್ ಟು ಸರೆಂಡರ್ ಪೊಸೆಷನ್. ಅಲ್ಲದೆ ಇತ್ತೀಚಿನ 3 ವರ್ಷಗಳ ಎಟ್ಸೆಟ್ರಾ ಅದೇನು ಬೇಡ. ಸೊ you surrender possession immediately. When was this served and on whom it was served? It was served on one son, Mallayya. It was served on 18/4/1998. 15/4 ಬಂದು ದುಡ್ಡು ತಗೊಂಡೋಗಿ ಅಂತ ಕೊಡೋ ನೋಟಿಸು 18/4 ತಲುಪುತ್ತೆ.
4 days ಅಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಅದೇ ಆ ಇವೆಂಟ್ ಆಗೋದ್ಮೇಲೆ, ಆ ಡೇಟ್ ಆಗೋದ್ಮೇಲೆ ತಲುಪುತ್ತೆ.
ಹಾಗೆ.
ಸೊ ಅವ್ನು ದುಡ್ಡು ತಕೊಳ್ಳೋದು ಸ್ಕೋಪ್ ಇರ್ಲಿಲ್ಲ 18/4. ಸೊ ಅವನು ಅದರಲ್ಲಿ ಹೇಳ್ತಾನೆ ನಿಂಗ ಪಾವತಿ ಆಗಿರೋದ್ರಿಂದ ನಾ ತಗೊಳ್ತೇನೆ ಅಂತ. ಬಿ ದಟ್ ಆಸ್ ಇಟ್ ಮೇ, ಅದು ಬಿಫೋರ್ he was dispossessed, either he should have surrendered thereafter and there should have been a measure. Not a scrap of paper is produced by them to say that any such measure was conducted or possession was taken. Much less any details are given as to when and where by whom possession was taken over. Now, after the award notice, immediately within a month thereafter, denotification happens. That is at page 110.
Yes.
18/5.
18/5/1998.
Yes. It is gested on 4/6. Page 110, Annexure C. ಇವತ್ತು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲೂ ಇದೆ ಅದು. ಅಲ್ಲ, ಇವತ್ತು ಫ್ರೆಶ್ ಆಗಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲೂ
ಇದೆ. Those documents have the compilation of all.
Anyway, ಇದು this is denotified 464 ಕನ್ನಡದಲ್ಲಿದೆ. ಕನ್ನಡ ಅಂಕಿಗಳು page 111.
The government takes a decision to denotify?
Yes.
Yes. All right. Government order. Notification.
Yes, government notification. And it's a gazette notification. And it is pursuant to the deliberations of the committee, which my learned friend Dr. Singhvi has already highlighted. Now, very important to take note here is that after the denotification, no further development has taken place. Possession was either asked or pursued after the denotification. Obviously.
But layout is formed, everything is done.
ಹೇಳ್ತೇನೆ ಒಂದು ನಿಮಿಷ.
ಅಲ್ಲ, no development has taken place.
ಅಲ್ಲಲ್ಲ, ಒಂದು ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಆಕ್ಟ್ ಒಂದು ನಿಮಿಷ ತಾವು ನೋಡಿದ್ರೆ ಸೆಕ್ಷನ್ 48.
Yes, denotification.
Yes.
Yes.
Old Act.
48 was, yes. ಅದು ಇದು ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ವಾ, ಅದಿರಲ್ಲ. ಅದಕ್ಕೆ ಓದಿ ಅಂತ ಹೇಳಿದ್ದು ಅದಕ್ಕೆ. 482 ಕೋರ್ಟ್ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಇಲ್ಲ ಅಂತಾನೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, ಅದಕ್ಕೆ ಓದಿ ಅಂತ ಹೇಳಿದ್ದು.
On section 48,
Yes.
1. Except in the case provided for in section 36, this does not come under that. The government shall be at liberty to withdraw from the acquisition of any land. Kindly mark the next phrase, very important. That's a condition precedent of which possession has not been taken.
Yes, at that time aware.
Sir, this is condition precedent. When there is a notification and I have shown that no possession was taken, how can the governor come to the conclusion there is a possession with the Muda? How can the complainant misrepresent to the governor?
Is it not that once final notification is issued and award notice is award is passed, determined, it vests with the government?
Sir, vesting is different from possession.
All right.
With great respect.
Yes.
Otherwise, why would notice be given? More importantly, kindly permit me to show that under section 16, they are entitled to take possession.
Yes. Land Acquisition Act. ಅದೇ ಸರ್ಗೆ ಕೊಟ್ಬಿಡಿ.
ಬಂತಾ? 16
ಬರಲ್ಲ, 5
16(1). ತಾವು ಒಂದು ನಿಮಿಷ ನೋಡ್ಬಿಟ್ರೆ. Possession has to be taken under section 16(1).
Yes, sir.
And it is very well established that possession has to be taken by drawing a measure.
Yes, that is.
No such measure has
There
been.
is no measure drawn.
No measure drawn whatsoever.
Yes.
So 16(1) possession is not taken.
So the submission is, it still vested, still the land was in possession of the legal heirs of Ninga.
It continued to be a private land.
Continued to be a private
land.
Therefore, it was not a subject.
And this was conclusively established when a 16(2) notice, 16(2) ತಾವು ಒಂದು ನಿಮಿಷ.
Yes.
16(2) notification was issued.
Yes.
That notification we have placed before the court today, which is a gazette notification. So if possession is taken, it will be notified in the gazette under subsection 2 of section 16.
Yes.
Sir, ತಾವು ಇವತ್ತು page 53.
ಇವತ್ತು ಕೊಟ್ಟಿರೋದ?
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಡಾಕ್ಟರ್ ಸಿಂಘ್ವಿ.
Yes.
Document number 12, page 53.
All right.
So ಇದರಲ್ಲಿ ಕೆಸರೆ ಗ್ರಾಮ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಬರುತ್ತೆ. ಕೆಸರೆ ಗ್ರಾಮದ ಅಕ್ವೈರ್ಡ್ ಲ್ಯಾಂಡ್ಸ್ ಎಲ್ಲ ಎನ್ಯೂಮರೇಟೆಡ್ ಆಗುತ್ತೆ 1 to 24. ಇದರಲ್ಲಿ 464 ಬರಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ in seriatim the survey numbers are mentioned. Kindly come to item 34, which is 455. 455 ಆದ್ಮೇಲೆ 464 ಬರ್ಬೇಕಿತ್ತು. 466 ಕೊಟ್ಟು ಹೋಗ್ತಾರೆ. ಯಾಕೆಂದ್ರೆ 464 ತಗೊಂಡಿಲ್ಲ.
ಅದಾದ್ಮೇಲೆ ಎಲ್ಲೂ 464 ಬಂದಿಲ್ಲ.
What is document 13?
13.
ವೈಯಕ್ತಿಕ award determination.
ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೊಸೆಷನ್ ಅಲ್ಲ.
ಅಲ್ಲ, award notice ಕೊಟ್ಟಿದ್ದಾರೆ.
I don't dispute award notice.
ಅಲ್ಲ, after denotification. 15/2/1999.
I request the court to kindly mark one thing.
That's what, yes.
What happened was, now this notice was taken out on the basis of the common award that was made. I think common award is also produced.
ಅದೇ common award ಓದಿದ್ದೆ ಅವಾಗಲೇ. Yes.
Common award. Page 29 alliде. Yes. Page 29 alli, it is dated 31/10/97.
Yes. After the final notification.
464 is specifically mentioned in line number 4.
Yes.
ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ಗಳು.
ಆಮೇಲೆ ಅದಿರಲ್ಲ.
ಸೊ ಇದಕ್ಕೆ ಅವಾರ್ಡ್ ಆಗಿದೆ, ಕಾಮನ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ, ಇದು ಜನರಲ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಆಗಿದೆ.
ಅದಕ್ಕೆ
ಹಾಗೆ
ಡೆಪಾಸಿಟ್ ಮಾಡಿ
1,52,00,000 ಟೋಟಲ್ ಅವಾರ್ಡ್ ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ,
ಕಾಮನ್ ಅವಾರ್ಡ್
ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ. ಈ ಅಮೌಂಟ್ ನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ. ಅಂಡ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಏನ್ ಮಾಡಿದೆ, ನೀವು ಈ ತರ ಲಂಸಮ್ ಕೊಟ್ರೆ ಆಗೋದಿಲ್ಲ, ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಪ್ರತಿ ಲ್ಯಾಂಡ್ಗೂ ಕೊಡಬೇಕು ಅಂತ. ಇನ್ ದಿ ಇಂಟ್ರೆಗ್ನಮ್ ತಾವು ತೋರಿಸಿದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 13 ಬಂದಿತ್ತು. ದಿಸ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಕಾಮನ್ ಅವಾರ್ಡ್, ಬಟ್ ದಿಸ್ ಇಸ್ ನಾಟ್ an independent award. Be that as it may, he has not drawn that amount, no compensation was paid. It is nobody's case that compensation was received.
Was not claimed.
Not claimed, not paid.
Deposited in civil court, not
returned. No. What was deposited has been returned.
All right.
And that has lapsed.
That is 3,24,000.
No, entire amount was deposited for the.
ಅಲ್ಲ, page 60 ಪರಿಹಾರ ವಿವರ
ಅವರು
ಅದು ನಿಮ್ದು.
ಹೌದು, ಅದು ಕೋರ್ಟಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಲ್ಲ. ಎಂಟೈರ್ ಅಮೌಂಟ್ ನ ಒಟ್ಟಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ. ಅದು ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇಲ್ಲ, ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ನಿರ್ಣಯ ನಿಮ್ದೇ. ಅದು
ಅವಾರ್ಡ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ
ಕಾಮನ್ ಅವಾರ್ಡ್,
ಜನರಲ್ ಅವಾರ್ಡ್. ಎವ್ರಿ ಒನ್ ವಾಸ್ ಈ ತರ ನಿಮಗೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಂಡೋಗಿಲ್ಲ. ಸೊ ದೇ ಡಿಪಾಸಿಟೆಡ್ ಇಟ್ ಅಂಡರ್ section 31.
No, these are all events that have happened earlier. You come into the picture in 2004, or the family comes into the picture in 2004.
No, with great respect, court heard them for over a day. That where is the land?
Over a day.
Allala, where is the land? Where is the village? I am answering that question.
All right, yes.
Where is the land? Sir, land is with me, my predecessor in title. It has never left my hand. It is still with me. I am the owner. I am the man in possession.
Then how did Muda form layout in that?
Yes, that is the $1 million
If
question.
you knew that you were in possession of the land and it was conspicuous,
Yes.
then how did you permit Muda to form a layout there?
My permission is needed.
No, ಆಗಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ತಾವು
You should have
ಹೇಳೋದು ನೋಡಿದ್ರೆ
objected
ನಾನು
to it.
ಪರ್ಮಿಷನ್ ತಗೊಂಡ್ ಮಾಡ್ತಾರೆ.
You have not objected to it any time.
No,
but
no,
this
with
is
great
land.
respect.
How are you
No,
forming a layout?
why should I object
Need not object.
when the layout plan excluded this particular land?
But even then, land layout is formed in your land.
May you plans yellow.
So anyway, the family comes into picture in 2004. Let's
Sir,
fast let's
kindly come
fast
to page
forward
52.
there.
Kindly come to page 52.
50?
52. ಇದು ಬೇರೆ ಫೈಲ್ ತಂದಿಲ್ವಾ? ಇದೆ ನೋಡಿ, ತೆಗಿರಿ. ಎಲ್ಲೋ ಫೈಲ್ ಒಂದಿದೆ. Page 52. The marked portion in page 52 the layout plan expressly declares that this is a denotified land.
Yes.
So this was not included in the layout. It was left out. And I have the copy of the approved plan. I'll give it. There also, the survey numbers which are being subjected to the development are also specified. 464 is left out. So this was not part of the layout.
Yes.
So in these circumstances, the land has never left the
hands of
Devraj. It remained with him. He sold it in favor of my brother-in-law.
Then comes the family interpretation.
That learned senior counsel has already covered. I'll not trouble the court.
So, ಈಗ layout form, what is that?
The need of suspicion. The reason why now the governor proceeds. The governor proceeds on the footing that possession is taken over. And my learned friend, Mr. K.G. Raghavan, eloquently argued the need of suspicion. ತಾವು ರಿಪೀಟೆಡ್ಲಿ ಕೇಳಿದ್ರಿ ಏನು ಇವ್ರ ರೋಲ್ ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಯಾರು ಉತ್ತರ ಕೊಡ್ಲಿಲ್ಲ. ದಿ ನೀಡ್ ಆಫ್ ಸಸ್ಪಿಷನ್ ಇರೋದ್ರಿಂದ ತಾವು ಅದಕ್ಕೂ ಹೇಳಿದ್ರಿ ಹೇರ್ ಸ್ಟ್ಯಾಕ್ ಅಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ಸೊ ದಿ ನೀಡ್ ಆಫ್ ವೇರ್ ಇಸ್ ಸಸ್ಪಿಷನ್ ಸರ್? ವೇರ್ ಇಸ್ ಪೊಸೆಷನ್? ಇಟ್ ಈಸ್ ವಿತ್ ಮೀ. A false statement is being made in the complaint that possession is with Muda. Governor records a perverse finding that the possession is Muda, and the entire case is built up on that foundation. The possession has never been handed over. The taking over of the possession is not even notified under section 16(2). And the layout plan, I'll place the certified copy. Idರಲ್ಲಿ clear ಆಗಿಲ್ಲ.
All right.
So the land is very much there. It remained an agriculture land till it was converted.
Till it was converted.
Yes.
Which is this layout scheme that Muda formed?
That is what I want to place it. ಇದನ್ನೇ ತಾವು ನೋಡಿದ್ದು.
Layout scheme was formed even in 464.
No. No.
All right.
I'm going to place the official plan, approved plan.
So according to you, in 464, no layout.
It was not part of the layout. It was specifically excluded as a denotified land, and the number of the survey numbers were specifically enumerated. This was not included in the survey numbers that formed the project layout. I'll place it before the court.
All right, no problem. Yes, we'll take your statement.
So the entire case is built on this. Muda has taken over possession. Muda has developed the land. And that is the finding recorded by the His Excellency, the Governor. So this is the foundation for the Governor's order. Kindly permit me to resume the reading of it.
Back to the.
It makes further interesting.
Bring back to the Governor's order.
Back to the Governor.
Yes.
ಅದನ್ನೆಲ್ಲ ಯಾತಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇನ್ 31.1 ಅಂದ್ರೆ ಪೊಸೆಷನ್ ತಗೊಂಡಿರೋದು the aforesaid aspect have not been examined and considered by the Council of Ministers.
That is why he terms it to be irrational.
Possession. So it is a comment on the Council of Ministers advice. Now kindly come to para 31.4. In the present matter, page 18.
Yes.
In the present matter, the allegations and the material in support of the allegations would prima facie indicate that the said land was given to a SC person due course of law.
Yes.
The records of the said land was transferred from the father to the children. And again from children to father. So this is a fantastic story of the Governor. Where is it?
Children to father.
This is what Governor has written. Kindly.
Father was not there.
Kindly see the ಅಲ್ಲ ಇದು ಬುರುಡೆ ಬಿಡ್ತಾ ಹೋದ್ರೆ ಅದಕ್ಕೆ ರೈಲ್ ಇರೋದಿಲ್ಲ, ಹಳೆ ಇರೋದಿಲ್ಲ, ಹಿಂಗೆ ಹೋಗ್ತಾ ಇರುತ್ತೆ. Kindly see para 31.
That I have seen.
Yes. So the records of the land was transferred from father to children, again from children to father, and this mystery was considered by the state cabinet, was not considered by the state cabinet. How should they imagine that this kind of a story would be written in the governor's order? They would have considered it. So this is the first reason. When the notification for land acquisition issued and the notification order was issued, Siddaramaiah was the MLA, etc., etc.
Is on the
Yes. Now all this, why is he saying all this?
power timeline of the chief minister.
No, all this, why is he stating? Kindly come to the bottom of that paragraph. Due to the apparent bias, the present matter requires my independent application. Now, Shivbhaktan kate heladnalla. Cabinet advice, cabinet advice baggene he is obsessed. So, it is biased. Next also, 31.5. Again, he is on the cabinet advice. Cabinet Council of Ministers, the Council of Ministers do not consider the entire material in support of the allegation. 31.6.
Yes.
He quotes the Madhya Pradesh case. I request the court to kindly permit me to read 31.8. Dr. Singhvi has elaborately argued.
Yes.
But only one aspect I would like to. Very, very disturbing finding has been recorded by the governor in para 31.8. In view of the aforesaid, it emerges that the present situation amounts to peril to democratic principles. Sir, in the last 50 years, kindly take judicial notice of this fact. Siddaramaiah is the only man who has served full term of 5 years. And he is now re-elected. And the governor has this thing to say that democracy is in peril. He is a nominated governor, an elected man with such an overwhelming mandate, a man who has ruled the state without any blemish. I request the court to kindly take it. Is it not a disturbing finding that the governor has indulged in? Kindly look at the predecessors who ruled the state. What has happened to them? What kind of situation they have faced? And a man who has been in power for such a long time, ಒಂದು ಜುಜ್ಬಿ ಸೈಟ್ಗೆ ಇಷ್ಟು ಇದನ್ನ ಮಾಡ್ಬೇಕಿತ್ತು. 23
ನಿಮಿಷ. ಜುಜ್ಬಿ ಸೈಟ್ ಅಂದ್ರೆ
ಅಲ್ಲ, ಜುಜ್ಬಿ ಸೈಟ್ ಯಾಕೆ ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ ಅಲ್ಲಲ್ಲ, ಜುಜ್ಬಿ ಸೈಟ್
ಅದು ಹಾಗೆ ಆಗಿದ್ರೆ ಇವ್ರು ಏನು ಮಾಡ್ತಿರ್ಲಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
55 crore ಇದೆ ಅಂದ್ಬಿಟ್ಟು ಅಷ್ಟೇ.
ಇಲ್ಲ ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ ಕೇಳಿ. ಜುಜ್ಬಿ ಸೈಟ್ ಯಾಕೆ, ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಕೂತ್ಕೊಳ್ತೀರಾ? ಕೂತ್ಕೊಳ್ಳಿ.
ಎಸ್,
ಜುಜ್ಬಿ ಸೈಟ್ ಯಾಕೆ ಹೇಳ್ತೇವೆ ಅಂದ್ರೆ 60-40 ಅವ್ರ ತಕರಾರಿಲ್ಲ, 50-50 ತಕರಾರಿದೆ. ಅಂದ್ರೆ ಇನ್ 2 ಸೈಟ್ ಎಕ್ಸ್ಟ್ರಾ ಬಂದಿರಬಹುದು.
ರೇಷಿಯೋಗಲ್ಲ ತಕರಾರಿರೋದು. ದಿ ಅಲ್ಟಿಮೇಟ್ ಬೆನಿಫಿಷಿಯರಿ ಟು ಒನ್ ರೂಫ್ ದಟ್ ಹಸ್ ಗಾನ್, ದಟ್ ಇಸ್ 55 crores ಇಸ್ ದಿ ಪ್ರಾಬ್ಲಮ್ ಅಂತ. ದಟ್ ಇಸ್ ವಾಟ್ ದೇರ್.
No, with great respect, it is in respect of her land.
It is what their project.
No, 3 acres 16 ಗುಂಟಾಸ್ ವಾಪಸ್ ಕೊಡಿಸ್ಬಿಡಿ, ಮುಗಿದೋಯ್ತಲ್ಲ. Anyway, it is not a denotified land, admittedly.
Not a denotified land.
It is a denotified land. Denotified land. It ought not to have been subjected to layout formation. They have encroached and done it. ವಾಪಸ್ ಕೊಡಿಸ್ಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು. ಅವ್ರ ಲ್ಯಾಂಡ್ ಅವ್ರು ವಾಪಸ್ ಕೊಡಿ. ಅದಕ್ಕೀಗ ಇಷ್ಟು ಸೈಟ್ ಕಾಂಪನ್ಸೇಟರಿ ಸೈಟ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಕೊಟ್ಟಿರೋದು ಸಿದ್ದರಾಮಯ್ಯ ಅಲ್ಲ, ಅದು ಕೊಟ್ಟಿರೋದು ಮೂಡ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಅದರದೇ ಆದಂತ ಒಂದು ಪ್ರೊಸೀಜರ್ ಇದೆ. ದೇ ಹ್ಯಾವ್ ಫಾಲೋಡ್ ಇಟ್. Sir, kindly take judicial notice of this fact. When one man is in power, so many things may be happening. Somewhere, some of his relatives may be benefited. There may be officers who are overzealous. ಮಾಡಿರ್ಬೋದು, ಮಾಡಿಲ್ದೇ ಇರ್ಬೋದು. ಬಟ್ ಅದಕ್ಕೆ can you hold a man who is at the helm of the affairs, who is ruling the state with such popularity, subject him to this kind of cavalier treatment?
What has happened?
Sir, sanction.
Approval.
He says sanction.
That is.
ತಾವು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ಅದನ್ನ ಅಪ್ರೂವಲ್, ಅವ್ರು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅದು ಅಪ್ರೂವಲ್ ಅಂತ. ಅವರು he says it is a sanction. So this 31 point
So
itself.
it is not that the edifice is now shaken. It's approval.
No, 31.8, the finding there, it betrays the mind of the government. The political.
We will answer.
The political vendetta he has got in taking this decision. We have attributed
Yes, that
political motives.
I have seen.
And he has not refuted them by any affidavit. My learned colleague instructs me. There is absolutely no scam against him. And therefore they have brought up this.
I saw Billy doing it. Yes.
So
Yes.
it is in this state of affair. I request the court to kindly. So this is the needle of suspicion my learned friend was harping upon.
Needle that is now
needle
that is now pricking.
There is no suspicion, there is no gray area. The possession is with me, and therefore they have to compensate for having encroached upon it.
Yes, sir.
And
You have any judgments to?
I have already given Article 20 this thing. Now
that is
yeah. Now
post
that
facto.
yeah.
Post facto with regard to
Yes.
provisions under the BNS.
Now that they have considered.
ಅದು sanction 17A ಮಾತ್ರ ಈಗ.
ಈಗ 17 year. So I'll not further trouble the court.
So that may not be required. Post facto finding need not be gone into.
ಓದಿಲ್ವಾ? 17A ಗೆ ಒಂದು ಜಡ್ಮೆಂಟ್
ಕೊಡಿ.
ಕೊಟ್ಟಿಲ್ವಾ? ನನಗೆ ಕೊಟ್ಟಿದ್ರಲ್ರಿ, ಕೊಡಿ. This is a case of Shankar Bhatt versus State of Kerala, 2021.
ಶಂಕರ್ ಭಟ್
ಇದು ಕೊಟ್ಟಿಲ್ವಾ
ಶ್ರವಣ್ ಕುಮಾರ್ ಅಂತೇನೋ ಇದೆ
ಸರ್? ಇದು ಕೊಟ್ಟಿದೆ, ಆಗ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕಂಪೈಲೇಷನ್ ಇದೆ. ಸಾರಿ,
ಕಂಪೈಲೇಷನ್. ಶಂಕರ್ ಭಟ್ ವರ್ಸಸ್
ಕೊಡಿ, ಕಾಪಿ ಇದೆಯಲ್ಲ. ಕೊಟ್ಟಿಲ್ಲ, ಕಾಪಿ ಕೊಡ್ತೇನೆ ನಾನು. ಸಾರಿ,
ಓದ್ಬಿಟ್ಟೆ ಕೊಡಿ. ಇಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಫೈಂಡಿಂಗ್ ಇಟ್ ಹಿಯರ್.
ಕೊಡ್ತೇನೆ.
ಇದರಲ್ಲಿ
ಇಷ್ಟೇ ಅವ್ರು ಹೇಳೋದು ಸೆಕ್ಷನ್ 17A, ದಿ ಹಾರ್ಟ್ ಅಂಡ್ ಸೋಲ್ ಆಫ್ ಸೆಕ್ಷನ್ 17A is recommendation or a decision. That is
statute ಅಲ್ಲಿ
ಅದೇನೆ. So with these submissions I rest my case. Grateful. Yes.
ಅಷ್ಟೇನಾ? ನಿಮ್ದು ಇದೆಯಾ? Well, it should not go on. It can't go on like.
ಕೆಸರೆ ವಿಲೇಜ್ ಬಗ್ಗೆ ನಾನು ಒಂದು ಹೇಳ್ಬೇಕು.
ಅದೊಂದು ಹೇಳ್ಬೇಕು. Because he says ಕೆಸರೆ ವಿಲೇಜ್ is not there at all.
Sir, 2011 ಅಲ್ಲಿ ಸೆನ್ಸಸ್ ಮಾಡಿದ್ದಾರೆ. And according to the census, I'll place the census report also. But I can give the data, census data. According to the 2011 census.
Why all of you have got up? Sit down. Yes.
Nandu ideli list of dates. Not only Kesare village is intact, but Kesare village consists of several ಸ್ಕೂಲ್ಸ್ ಇದೆ, ಹಾಸ್ಪಿಟಲ್ಸ್ ಇದೆ, ಓವರ್ 2000 acres ಲ್ಯಾಂಡ್ ಇದೆ ಕೆಸರೆ ವಿಲೇಜ್ ಅಲ್ಲಿ. Now, of course, it forms part of the city corporation.
Now in the MCC.
Yeah.
Yes.
I'll place that data. That
Your Lordship, just a
Kesare village was subjected to census 2011 ಅಲ್ಲಿ. Full data is available, entire population data.
That's the last census.
And the lands particularly. ಕೆಸರೆ ವಿಲೇಜ್ ಕಳೆದೋಗ್ಬಿಟ್ಟಿದ್ರು, ಕಳೆದ್ಬಿಟ್ಟಿದ್ರು. I want to show.
Submission was made.
Yes. Therefore, I'll place it.
With your Lordship, can just a short note, my lord, on just with regard to prerequisite of prior to 17A, my lord. Just a short note. I'll just give the submission.
Prerequisite.
Your Lordship, make only 3 issues which I have dealt with, my lords. First one is with regard to preliminary inquiry to determine the commission of a cognizable offence is a prerequisite for seeking prior approval under 17A. So therefore, my lords, prior to filing an application under 17A, my lords, a preliminary inquiry as per Lalit Kumari lines of judgment. I was not speaking about preliminary inquiry under 17A. The second issue is Section 17A of the Prevention of Corruption Act does not provide for preliminary inquiry by the competent authority as provided under 173, my lords. Because what is required under 173?
According to you, preliminary inquiry is also by police officer.
Please, my lords.
That's right.
So therefore, it does not contemplate 173 inquiry by the competent authority. Because what is the nature, is only a prior approval of the material as per the SOP, my lords, which is to looked into while deciding, my lords.
Page 704.
Please, my lord. The last issue is when an investigation officer forms an opinion of a cognizable offence, the standing operating procedure dated 3rd September 21 requires submission of information or data in the form of the proposal to the competent authority in order to seek prior approval under Section 17A of the PC Act for conducting inquiry or investigation. So therefore, my lord, what is required is that report, my lords, for which prior approval is given as per the prerequisite. So therefore, my lord, if that is not there, my lord, it is premature in that sense, my lords.
It is premature.
The application to consider 17A.
ಯಾವಾಗ ಕೊಡಬೇಕಾಗಿತ್ತು ನಿಮ್ಮ ಪ್ರಕಾರ?
So it would have been, ought to have been given if there was a preliminary inquiry pre-17A, or in the event worst scenario, my lords, if the competent authority, assuming, my lords, in the case it was not a governor, otherwise every competent authority will become an investigating officer while giving sanction. Approval, prior, I stand corrected, prior approval. So therefore, my lords, he can't do the work of both preliminary inquiry of.
You told that.
So therefore, my lords,
both can't do the work of the IO and competent.
And competent. In support of that, my lords, only under 17A, my lords, and Lalit committed series of judgments, I put judgments which speaks about this situation.
So one factor we must consider is when Lalita Kumari was rendered, statutory 17A irlilla.
Please.
17A banded 2018 only.
Correct.
So whatever is Lalita Kumari, we immediately apply, or who should conduct, these are all, it's a gray area.
See, that's why my daughter Ashok's your lordship judgment, my lord. That's the only case which deals with private person.
Yes, private complaint, that's the only.
That's the only case, and this is the next case which your lordships are dealing with 17A application. All that is prior to that. So the point is this, my lord, if preliminary inquiry is mandatory under 173(3) as well as per Lalit Kumari, if a cognizable offence is made out, my lords, by the IO, then 17A is an additional protection. It's an additional protection.
After cognizable offence is made out.
Please, my lord, that is what 17A says. 17A says no police officer, my lord,
of a cognizable offence.
Of a cognizable offence. So therefore, reading Lalit Kumari and 173(3), my lords. So therefore, my lord, the whole purpose of those line of judgments will be rendered odious, and again giving the power back to the competent authority. To the lordship may kindly forgive this case. Tomorrow, anybody, the minister or chief minister, that apart, any competent authority, any person can go give a complaint. He can.
Anybody can set the criminal law into motion.
Without, in case of protection under either.
Adikke I have written 17A approval, no man can set the criminal law into motion. PC Act offences.
Correct. So therefore, 17A becomes premature. Because the same, like, if your lordship take it to its logical and malod, in that sense, 17A becomes premature unless that is done. So we will.
We'll consider.
That's all. I just.
But,
ಅಲ್ಲ 5 ನಿಮಿಷ ಅಷ್ಟೇ.
please, please.
Yes.
Since learned senior friend concluded with.
No new facts.
No.
Only answering. Yes.
Please.
5 minutes also, Your Lordship, closing.
ಎಲ್ಲರಿಗೂ.
In connection to the private complaint, my lord. Since it was concluded with how the court must deal, my lord, when a private complaint is.
17A ಹೇಳಿದಾರಾ
How
ಇದರಲ್ಲಿ?
the special.
17A ಹೇಳಿದಾರಾ?
17A, please, very much.
Is after my judgment or before?
Division bench of the.
Madhya Pradesh.
Madhya Pradesh.
Yes.
Please. But I invite my lordship's kind attention to page 16, 10.4, paragraph 10.4. Thirdly, section 17A does not bar the special court from conducting inquiry or inquiry as defined in section 2G of the Code of Criminal
CRPs, yes.
Please. Argument may be raised that though the special court is not statutorily barred from conducting inquiry, but occasions may arise where the special court for aid and assistance may direct police to conduct inquiry, leading to an impasse in the face of statutory bar under section 17A, prohibiting police officer from proceeding ahead. True, it is that the police officer alone has been restrained from conducting inquiry or investigation, but the said argument can be put to rest by the well-established principle of law that what cannot be done directly in law also cannot be done indirectly.
As simple. Yes.
Therefore, please.
As simple as that.
Please, my lord.
Yes.
So, my lord, I would, my lord, straight away draw my lord's kind attention to the operative portion, please.
This is exactly what is written.
Please, our para 10.7. Not so the special court, my lord.
See, this is what others were doing. What could not be done directly by taking an approval under 17A?
Please.
Go before the magistrate. Get the matter referred. FIR registered. No 17A. That was being done indirectly.
Please.
That is why Ashok was
This is
written.
in conformity with Dr. Ashok.
Yes. ಆಮೇಲೆ
No, my lord, my learned senior friend, my lord, made an assertion that the land, my lord, the possession was never taken. And so it stood vested with the erstwhile owners. But that is in fact self-contradictory to the claim made by the petitioners. Because she in her application, the two applications, my lord, dated 2014, another application dated 2021. She makes a claim that in the year 2001 itself, Muda has utilized survey number 464. Although, my lord, she or her family members were nobody at the relevant juncture, as observed by my lords earlier. Lord, then the claim itself becomes fraudulent, my lord. Now they say possession has never been taken. Now you come back to 2014 and say possession has been, the land has been encroached, possession has been taken.
That is in answer to your submission that possession is not taken at all. ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಆನ್ಸರ್ ಕೊಡ್ತಾನೆ ಇರಲಿ.
Certainly, my lord. Now the claim becomes fraudulent because in the year 2001 itself, now they claim that the Muda had formed sites, parks, layouts, and other civic communities in the year 2001 itself. My lord, they cannot, my lord, make a claim contrary to their application, seeking. And interestingly, my lord, after a while, my learned senior friend makes a submission that encroach ಮಾಡಬಾರ್ದಿತ್ತು. Encroach ಮಾಡಿರೋ ಜಾಗಕ್ಕೆ why did your brother-in-law go and seek for conversion? My lord, they cannot have a double standard approach, my lord. In fact, this is triple standard. Encroach ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಪುನಃ ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ. Why did you go and seek conversion?
All right.
And they expect this honorable court to believe that by pursuance of a common man, Mallikarjunaya, that both Tahsildar and Deputy Commissioner of the concerned jurisdiction, they come to this spot, inspect and form an opinion that they have found and identified an agricultural land. When now, my lord, they say that the land was encroached. But kindly, my lord, this can be taken note
Land
of.
was encroached ಅಂತ ಹೇಳಿದ್ರು.
That is what they claim in the application.
Argument submission ಏನ್ ಮಾಡಿ?
No, ಮಾಡಿದ್ರು.
All right.
That submission was made. Encroach ಮಾಡಬಾರ್ದಿತ್ತು, ಮಾಡಿದ್ದಾರೆ. That was made, my lord, in the open court.
No, that is the reason for asking compensation.
Please, my lord. So that being the case, my lord, now they cannot now, my lord, have multiple, my lord, approaches. Whether it was encroached or not, whether conversion was sought or not. That's the question, my lord.
ನಾವು ಕೊಡ್ಬೇಕು.
Please.
ಸಾಕು.
ಪ್ರಶ್ನೆ ಯಾರು ಕೇಳ್ತಿದ್ದಾರೆ ಅಂತ.
Lord, now I have filed a written synopsis.
ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ?
Please.
ಕೊಟ್ಟಿದ್ದೀರಾ ರಂಗನಾಥ್?
I have given. In fact, my lord said sought for the same, the earlier occasion.
Yes, sir.
Lord, in the year 1999, my lord, as observed by my lords, individual award came to be passed.
Sir, that is the document.
It's not as claimed as though a universal award was.
Common award was first passed.
Subsequently, it was.
ಆಮೇಲೆ
Please.
ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ವಿವರ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಕೊಟ್ಟು ಅವಾರ್ಡ್ ಅಮೌಂಟ್ ಡಿಟರ್ಮಿನ್ ಮಾಡಿ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ ಅಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೆ.
My lord, when, my lord, the land was denotified, Lord, how could, my lord,
1998.
After a year, my lord, the amount is deposited, the award amount. How could it be possible, my
No,
lord?
that is perhaps because of the common award.
Whether such a denotification document is an afterthought and whether it is planted.
Sir, government notification afterthought, gazette notification afterthought ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
But there are.
Amount has been returned by check. The amount.
Afterthought ಆಗಕ್ಕೆ ಅದು ರಿಟರ್ನ್ ಆಗಿದೆಯೋ ಅಲ್ಲ ಬೇರೆ ಮಾತು. ಗಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ afterthought ಇದೆ. 99 ಆದ್ಮೇಲೆ 98 cannot come afterthought.
ಮೂಡಾದವ್ರು ಕೊಟ್ಟ ಇದು ಕಾಂಪನ್ಸೇಷನ್ ಇಟ್ ಹಸ್ ಬೀನ್ ರಿಟರ್ನ್ ಬೈ ಚೆಕ್.
The root of the matter.
ಕೊಡ್ತೇನೆ ಅದನ್ನ ಡೀಟೇಲ್ಸ್.
The AG always gets into the root of the matter.
My humble submission is that without, my lord, scrutiny, amount can never be deposited, my lord, in the jurisdictional court. That has been done. Now subsequently, my lord, initially in the year 2014, my lord, after the application is made, the decision is taken, my lord, to, my lord, compensate the petitioner's wife in the ratio of 50-50, my lord, in a similar layout. Subsequently, another decision is taken after another 3 years, my lord, wherein decision has been taken to compensate her with a land which is undeveloped and in possession of Muda. Now, out of nowhere, my lord, the compensatory sites are allotted in upmarket Vijayanagar area, which is a posh locality, which is an upmarket area. Devanuru Badavane, my lord, can't be equated to Vijayanagara, just like Sadashiv Nagar of Bangalore.
In Vijayanagara?
Yes.
Oh.
In Mysore, that is the stature of.
I thought Jayalakshmipuram.
Not at all. Not at all.
All right.
Devanuru Badavane is like Chintamani.
Oh, all right.
So such is the.
I always knew that Jailpuram was equated to Sadashiv Nagar.
Such is the difference, my lord. Such is the difference between Devanuru Badavane and Vijayanagar. That apart, my lord, the special land acquisition officer, when he directs the petitioner's wife, my lord, he refers to certain meetings, my lord, of the year 2017 and of the year 2021. But when the allotment is made, out of nowhere, my lord, a meeting of the year 2020 is referred to.
That nothing happened in that. 2021 meeting supersedes that 2020 meeting.
Please,
A document illa 2020.
he claims that in the year 2020 a decision has been taken and pursuant to that decision allotment has been made.
I don't, resolution is not even there of 2020. I don't know what is that.
But it is there.
19/9/2020 ಅಂತೇನೋ ಇದೆ ಅದು.
ನಾವು ತಿರುಗಿ ರಿಪ್ಲೈ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಇದು.
ಬೇಡ ಸುಮ್ಮನೆ ಇರಿ.
ನಾವು
Yes, ರಂಗನಾಥ್ ಅದೆಲ್ಲ ಹೇಳಿದೀರಾ, ಸಿನಾಪ್ಸಿಸ್ ಹೇಳಿದೀರಾ, I will go through it. ಮತ್ತೆ ಇದಕ್ಕೆ ರಿಪ್ಲೈ ಅದೆಲ್ಲ ಆಗಲ್ಲ.
Page 178 to 194, my lord, the allotment letters are placed.
Allotment letters are placed, yes.
If at all, my lord, in the year 2020 itself, decision was taken to compensate the petitioner. Right? Why would, my lord, she once again, my lord, approach the Muda with a letter dated 2021, my lord? Once again, another letter is written claiming compensation. My lord, these facts, my lord, would certainly, my lord, warrant investigation as to how. Please. Lord, lastly, my lord, coming to the antecedents, my lord, because there are some serious.
That you may have to reply.
Please.
ಅದನ್ನ ಮಾಡೋದ್ ಬಿಟ್ಟು ಇದೆಲ್ಲ ಬೇಕಾಗಿದೆ. ಇದೆಲ್ಲ ಹೇಳಿದ್ರಿ ಆಲ್ರೆಡಿ. What is the 25 lakhs? Because the submission is made, I have to answer that all.
Please. Sorry. The fine, my lord, was levied in connection to a PAL, my lord, preferred by the respondent number 3. Please. Lord, on the relevant day, he was, my lord, represented by his counsel, my lord. And at page 130, my lord, the operative portion, my lord, therefore, while discussing the SLP, we impose 25 lakhs. Now, thereafter, what happens is that, my lord, the petitioner, once again, my lord, he approaches the court and, my lord, explains as to, Lord, actually what transpired is that, if my lord,
Reduce costs, amend the application.
So happens, my lord, that the petitioner, my lord, he had interested his counsel.
ಅದನ್ನ 1 lakh reduce ಮಾಡಿದ್ರ?
Reduce ಮಾಡಿದ್ರು. In fact, they insisted on reduction. No, that, my lord, is nowhere told, my lord. We asked for extension.
No, that's why I said sometimes whistleblowers face all this. It's not that. Yes.
Now, what happens is that, my lord, in fact, the brief, my lord, with the counsel on record at that relevant point of time, Ali, the file, my lord, would be of some other case.
No, that's all right.
Please.
It is reduced to 1 lakh.
Bona fide error was, my lord,
that is not a problem. Then what is that outraging the modesty allegation?
Please, my lord. Now, page 77, my lord, kindly be of the writ petition, of the statement of objections, my lord.
ಏನು ಹೇಳಿ ಅದು?
Please.
Which is that complaint?
Lord, in fact,
that PC Act complaint.
Please, based on the complaint, my lord, of the respondent number 3, Lord, there were certain raids, my lord, which had taken place. Now, my lord, as a counter blast, there was a complaint, my lord, lodged against the respondent number 3. That, my lord, they are projecting as though the respondent number 3 is a convict. That is how, in fact, there are 2 cases, my lord, registered against the concerned complainant by the respondent number 3. And in fact, my lords is looking.
The other one, which was the other day.
Please. But paragraph E, my lord, page 77, my lord, of my statement of objection.
ಹೇಳಿ ಓದಿ.
But page 82, my lord. Lord, these are, my lord, the list of cases, my lord.
You have rebutted everything that is said in the petition.
Please.
Quay the antecedents.
Please.
All right.
There's a separate paragraph, my lord, paragraph E.
All right.
Coming forth at page
regarding
77.
paragraph AE.
E, my lord. Page 77, my lord.
77.
77, my lord.
Yes. Regarding antecedents.
Please. Now, every allegation, my lord, is answered. Now, my lord, page 81 may kindly be perused. The mining case, my lord, which the respondent number 3 had uprooted, it is still now, my lord, being directly, my lord, monitored by the Honorable Apex Court.
I know.
Please. And there are so many other cases which are.
That is why that statement was made.
Please. Lord, in fact, at the risk of sounding political, my lord.
Don't sound political.
No, kindly, my lord. Lord, in the last 2 decades, my lord, if the history of the state of Karnataka is seen, Lord, no political party, either be it the ruling party or the opposition party, they have uprooted either each other's scams or scandals.
Don't.
It is only these respondents, my lord,
these are
their life and limbs, my lord. They have, my lord.
We are in a court of law.
Please.
The argument should be apolitical.
My humble submission is
yes.
It is these private complainants. If the history is seen.
I told you again.
Please.
I have made a statement that whistleblowers do suffer such things. It is not in the air made. Yes.
No, Lord, because serious allegations were made.
All right. You have countered that, I will consider. Yes. Yes.
I'll submit that plan so that they may also. ಎಷ್ಟೊತ್ತಿಗೆ
ಮತ್ತೆ ಇನ್ನೊಂದು ಪ್ಲಾನ್
ಇಲ್ಲ no. I've already made my submission.
Yes.
That material I'll place before the court, the sanction plan and the census data.
Yes, madam.
ನಾಳೆ ಎಷ್ಟೊತ್ತಿಗೆ ಅವ್ರು so that
ನಾಳೆ ಇಲ್ಲ ಮುಗೀತು ಇವತ್ತೇ.
ಅಲ್ಲ ಅವ್ರು ನಾಟ್ ಬಿಹೈಂಡ್ ದೇರ್ ಬ್ಯಾಕ್.
ಆತರ ಅವರು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟು
ವೆರಿ ವೆಲ್
ಫೈಲ್ ಇಟ್ ಬಿಫೋರ್. ಐ ಆಮ್ ನಾಟ್ ಲಿಸ್ಟಿಂಗ್ ದಿಸ್ ಮ್ಯಾಟರ್.
ಇಲ್ಲ ಬೇಕಾಗಿಲ್ಲ. ನೋ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
ಎಸ್
ಐ ಥಾಟ್ ಐ
ನಾಟ್ ಫಾರ್ ಎನಿಥಿಂಗ್ ಲಿಸ್ಟಿಂಗ್ ಇಲ್ಲ.
ಓಕೆ.
Yes.
Very well.
Page 33 may kindly be.
Of what, sir?
My written synopsis.
Synopsis, sir.
Yes.
ಹೇಳಾಯ್ತಲ್ಲ ರಂಗನಾಥ್ ಮತ್ತೇನು?
Only couple of minutes, please.
ಹೇಳಿ. Couple of things.
Couple of minutes.
Minutes.
Lord, regarding Lalita Kumari's case, my lord, what that court, in fact, the learned AG had addressed this honorable court. That
ಅಲ್ಲ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ರೆಡಿ ಆಗ್ತಿರೋದು ನೋಡ್ರಿ 10:30 ಅಲ್ಲ ಈಗ 6:30 ಆಗ್ತಾ ಇದೆ.
couple of
ಎಸ್ ಸರ್.
preliminary inquiry, my lord, not exceeding 7 days. There is clear, my lord, gap of 7 days, my lord, before.
I told that right. ಲಲಿತ್ ಕುಮಾರಿ ಸೇಸ್ ಒಂದು ವಾರದಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೈಯರ್ ಆಫೀಸರ್.
Lord, all that, my lord, I want to say is that when Lalita Kumari was rendered, section 17A, my lord, was not in.
ಅದನ್ನು ಹೇಳಿದ್ನಲ್ಲ.
Lord, because there are multiple, my lord, assertions made in connection to this.
We will answer.
As well as Priyanka Srivatsa's. So both, my lord, while complying with section 154 subclass 1 and 154(3), my lord, there is clear gap of 7 days, my lord, before I take the next step. So therefore, that has been completely complied with.
I will look into it and ask. Yes.
Lalit Kumar has been modified to 15 days to 6 weeks, my lord, not 7 days. ಇಲ್ಲ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ.
Yes. ರಂಗನಾಥ್
please.
Closing, Your Lordship.
ನಿಮಗೆ 5 minutes ಸಾಕು ಹೇಳಿ.
That's it. 12 points, Your Lordship.
12 points.
5 minutes will be done.
Yes.
They had mentioned that it was 23 years is what they had mentioned. That it took that long. Could have been done within one period of 5 years. The difficulty for them was there was a huge blunder. The blunder committed took 15 years now to undo.
Madam,
reboot.
1 minute. Blunder committed 15 years. Where were they in the picture in 15 years? Everything has happened on its own. They come into. You mean to say that? Are you saying that the chief minister was of the idea, or the family of the chief minister, or idea of buying this land in 1997?
No, not at all. A4.
2004. The story commences from this family.
It doesn't commence from the date that the brother-in-law buys it.
Yes.
It commences from the date A4 applies, asking for denotification.
That is Devraj.
Yes. Devraj
is an accused?
He's an accused. Now, what he does is, he works in the education department. He suppresses it. The whole scheme of all of this starts with a misrepresentation. He states, this is my only source of income. This is my agricultural income. And therefore, please denotify. Whereas he works here in the education department. It starts with that. And as I had taken your lordship through the periods when this was involved, it started from there. So from the period when Devraj had applied, it started. So what I'm trying to say is that 23 years is a fault of theirs, not ours, that they made a big blunder in the way they went about it. After finishing with denotification and then conversion, and then, oops, we've gone the wrong way. Maybe we need to take another route. And then applications start for compensatory sites. Now, the other issue that they seem to mention is that 50-50. It is not 50-50, reason being, in the Muda sale deeds to the wife of the petitioner, it states clearly that it's under the 1991 scheme. Now, the reason this is extremely important, Your Lordship, is that 60-40 allotment. If it is 60-40, say about in an acre, development 45% goes, 55% is only left. In 45 allotment, the parks, the roads, the amenities, all of that. 55% is left. In 55%, 40% of that is what a landowner is entitled to, which is be about 22%, which is about 9,500 square feet in 1 acre. 3 acres, let's assume for a minute that they have a flow of title, which they don't. 3 acres, they would have to get at best 28,000 square feet. What is given is on the 50-50 scheme, 38,000 square feet.
Government had changed the scheme by then, 50-50 had come in.
The sale deed itself talks of what scheme would be applicable to them. So the question of changing that would not arise. Your Lordship, as he had mentioned, I have to just make it very clear where Devanuru comes. That is this village that they're talking about. It's precisely 2 hours from Mysore, if we do it on the map. Now, if I have to draw a parallel, if a layout is being made, that is exactly the reason why I'm trying to state is that we need to say where Devanuru is. Devanuru is 2 hours distance from Mysore, if we take, say, Palace as the center point. If your lordship, there is a layout being developed, say, beyond Jigni, am I entitled to compensatory sites in Indranagar and choicest of ones and a sprinkling of all of them and 14 of them in Indranagar, I would not be entitled to. One of the defense taken earlier was that these are not incentive sites which have to be given in the very layout. They can be given anywhere, your lordship, because they're not incentive, they're compensatory. Compensation sites are always site for site. For example, if there's a flyover being made in the heart of town and they take my site, then they have to give it to me in the urban area and they can't compensate me with that. So if my area is being taken in Jayanagar, I can be given in Baswangudi or BTM equivalent value. I cannot be given something where I have own in Jigni and then I get in Indranagar. That is not possible. Your lordship, next. The allegation is that, Your lordship, that there are a lot of sanctions that are languishing, not met the light of the day, and this has been done in a tearing hurry. Your lordship, all our brothers and sisters in the bar keep cursing us that we've taken up so much of your lordship's time over here for this matter. They can all say, where is the tearing hurry in this matter? This matter is not of any great importance. This matter could have waited. But your lordship, the point is ultimately...
I have granted an interim order. So that is the reason.
I'm just trying to say...
Are you saying I should not take this?
No, I'm exactly what, the contrary. I'm trying to state that they cannot say, governor took this matter up while others are languishing.
You're drawing
so,
paraphrase.
drawing a parallel with what all my brothers and sisters have been cursing us with, but that cannot be done.
Oh, are they so doing?
I'm sure they are, your lordship. So ultimately, it's the discretion of the governor. There could be other reasons for other matters, but that cannot be taken up now, right now to say that there are malifides in this and therefore it was taken up earlier. Your lordship, the rights of the...
Very illustration.
This is, yes. The pressure is on by all of the others, your lordship. The CM's wife, they're stating that others were also allotted. Your lordship, there is not one other case where allotment took place
in
Vijayanagar area or any other well-developed area which is not in the heart of Mysore as opposed to being 2 hours away. Now, your lordship, even let's assume they're saying, okay, give us back our lands. 3 acres of lands worth 4 lakhs when it was sold. At best, it becomes 40 lakhs. Worst case, best case scenario, 3 crores. It does not go to up to 60 crores. That doesn't even happen in prime Bangalore area. And that could be the root of the ultimate problem. Your lordship, then also going into the aspect of many others, denotification. Your lordship, denotification can happen. There's land mafia everywhere. All of that denotification happens with whatever reasons. Can that be a reason that this, in terms of parity with other frauds, this cannot be excluded? It's ultimately a public servant. Your lordship, also with respect to the 262 and 264, your lordship, stating that 262, both in fact were owned by Ninga only. What happened was...
262?
462 and 464.
Survey number 1. Yes.
462 was also owned by the very same person, but he sold it to someone else. And this was what remaining for the 3 brothers ultimately. And flow of title doesn't happen. That's all.
Done?
Done, your lordship.
Yes.
Got the copy of the
plan.
Sanction plan. Cabinet colleague will show me.
Sanction plan of that scheme.
The layout.
The layout.
This is the scheme
So,
that was
but where is this layout from? How far is this from Mysore? What Senior Counsel Lakshmi Iyengar said is correct? That it is 2 hours away from Mysore.
I don't know the details.
So yes.
Must be from
Then we'll
Bangalore.
get to know.
Must be from Bangalore.
I shall put it on the Google map right away and show, and then Shashi would have to buy us all sites.
Must be from Bangalore.
There are 2 aspects to be noted from the plan. One is this survey number along with 462. Both are marked as denotified lands.
In the plan.
In the plan.
And when the survey numbers are mentioned as to the details of the project, these two survey numbers are not in.
ಅದು ಮಾರ್ಕ್ ಮಾಡಿ
ತೋರಿಸ್ಬಿಡಿ.
ಅಲ್ಲ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ ಸರ್, ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ. Doesn't find a mention. Both 462 and 464.
462 and 464 is denotified.
Denotified ಅಂತಲೇ ತೋರಿಸಿದ್ದಾರೆ ಲೇಔಟ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ.
ಆಯ್ತು ಕೊಡಿ.
So this is the layout plan that is executed and developed as.
On that basis, they want 50-50. Everything is there.
ಹೇಳಿ ಮೇಡಮ್.
I'm now
2
instructed.
hours ಸ್ವಲ್ಪ.
ಅಲ್ಲ, I'm now instructed to submit. Kesare is behind Columbia Asia in Mysore.
ಕೆಸರೆ ಗ್ರಾಮ. Then how can it be Devanur Badamane 2 hours from Mysore?
We checked both cases. We
Bangalore.
checked.
Bangalore ನಿಂದ ಅಂತ.
We'll see. We'll see. Yes.
Hale Kesare is different. 40 kilometers. Yes. What they are trying to put in is an Hale Kesaru, which is near Columbia Asia. That's not the one. This is acquisition to us.
Anyway, Google will tell.
In the birds are creeping, chirping down.
ಯಾಕೆ ಹೋಗ್ಬೇಕು ಅಂತ.
Then I'll be the bellwether, your lordship will all.
Yes. Anybody else, sir?
The painstaking hearing.
No. Don't worry about that. I should determine that. That's all right. If anybody have to say something, please tell. Because I'm not going to list this again. Yes. ಯಾರ್ದು? ಕೊಡಿ. ನಿಮ್ದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
By tomorrow, your lordship.
By tomorrow it should be there. Yes. ನಿಮ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲ? ನಿಮ್ದು ಹಾಕಿದ್ದೀರಾ? ಅದು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಷ್ಟೇ ಅಲ್ವಾ? ಎಸ್ ಸರ್, ನಿಮ್ದು ಆಯ್ತಲ್ಲ? Everybody done?
Please.
I am also done.
We are deeply obliged.
Yes.
Such a patient.
No. For today. I say DD done for the day.
Survey number is here.
Yes, thank you all.
My lords, if I can just make one mention, my lords. Date was given for. I'm sorry, my lords. Date was given for tomorrow, my lords, but the office is not moving the matter, my lords. So instructions may kindly be given, my lords.
Madam.
This is WP number 250.
Tomorrow, sir. 10:30 move ಮಾಡಿ. I'll take it at 2:30. List close ಆಗಿರುತ್ತೆ. How will you take it? Move it at 10:30 tomorrow.
Please, my lords. Please, it is already listed for today.
ಎಲ್ಲ ಇವತ್ತು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದ ಕೇಸ್ ಎಲ್ಲ ನಾಳೆಗೆ ರಿಪೀಟ್ ಆಗಿದೆ.
Bill number 61 is 2, my lord. Settlement. The time may be fixed, my lord. The respondent.
Parties are there?
Yes, no, they're here right now. It was listed today.
ನಾಳೆ ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ.
My lord, the urgency that I cited yesterday was, my lord, the respondents don't already reside in.
What's the offense?
Lord, motor vehicles accident case was 338 and 220.
Where the parties get them? Yes, I'll finish that and leave. All of you can leave.
Great.
Yes. Parties are here?
Yes.
Still waiting. Respondent yaru?
Respondents are the complainant and the victim, my lord. The petitioner is the accused.
But true, sir. Respondents counsel idara?
Sorry to.
Sir.
Interim order continue.
That will. That you need not mention, sir. Adralli heard reserved interim order subsisting will continue till the disposal of the petition.
For respondent number 2 and 3. For 2 and 3, my lords. May permit me to file.
What's the offense, sir?
My lords, the offense
is 279 and 338 of IPC, my lords.
229 and?
279 and
338. Kodi.
Lordship,
Madam,
permit me to file wakala
give it.
for-
Give it. Give the settlement.
Yes, my lords.
Madam. Parties sign ಮಾಡಿಸ್ಕೊಂಡಿ sir.
Great.
Where are they from?
My lord, the accused victim is from West Bengal, my lord.
Oh, ask him to go. No problem. You sign the order sheet and go.
Please.
Settled, closed.
Grateful.
But you'll get the order only after a week.
Grateful.
Grateful.
Because they were waiting, I took it.
Grateful.
Grateful.
Obliged.
Emberilla.
Madam. Madam, list number 2, serial. Thank you.
ಹಸ್ಬೆಂಡಾ? ಎಂಟೈರ್ ಫ್ಯಾಮಿಲಿಗೆ ಸ್ಟೇ ಇಲ್ವಾ? ಆಯ್ತು, ಮಂಡೇ ಕೊಡಿ ಅದು. ಇವತ್ತು 2022 nobody has moved. I have got all the matters listed. Nobody is interested. 2 years ಇಂದ ಹಂಗೆ ಇರುತ್ತೆ, ಸಡನ್ ಆಗಿ ಅರ್ಜೆನ್ಸಿ. What application is this? When did you file it? Judgment post ಆದ್ಮೇಲೆ? Then? When did you file it, sir? That's all right. At what stage did you file it? ಏನ್ ಪೇಪರ್ ನೋಡಿಲ್ಲ, ಏನಿಲ್ಲ, ಸುಮ್ನೆ ಒಂದ್ ಮೂವ್ ಮಾಡೋದು. ಕೊಡಿ 12th ಕೊಡಿ. Vacating interim orders, ಯಾವ್ಯಾವ applications, give all those applications. Give all the applications where vacating stay is filed. Vacating stay. Wait. Vacating stay applications kodi alla. I will assign dates for that. Yes. Vacating. Fresh matter alla Monday kodi, matte move madbidi. Yes. Yes, Ravi Shankar. Kodi. Vehicle release naale tagoli. Give it. Yes.
DA case, my request for tomorrow, since all the matters coming tomorrow.
We'll see. Give it. Yes. All the matters ಮುಂಚೆ ಇದ್ದಿದ್ದು, ನೀವು ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ನಾಳೆ ಬರ್ಬೇಕು ಅಂತಿಲ್ಲ.
No, it is all.
Give it. We'll see. Yes, sir. New DA cases, whatever is filed, madam.
My lords,
New DA cases, whatever is filed, don't post them tomorrow. We'll post it next week. Give it. Yes.
498 matter, husband and family members who are residing in Coimbatore.
Pending, sir.
It's like we have filed an IA number 20.
Fresh or pending?
Pending, sir.
Pending. Right? It has come once already?
Yeah, on 2nd of this month it just came. We have filed an amendment application.
It has come, not came. Yes, give it.
May proceed on Wednesday, my lords.
Give it next week haki alla.
Sir, it's urgency, sir.
Oh, urgency. Why day after tomorrow? ನೀವೇ ಡಿಸೈಡ್ ಮಾಡ್ತಾ ಇದೀರಾ ಡೇಟ್ ಇಲ್ಲಿ? ಯಾರಿಗೆ ಅವ್ರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದೀರಾ? Give it on Monday. Yes.
Well, a small submission, please. I was
MMRD Act covered by judgment.
Maybe, sir. Give it fresher. If it is fresh matter, please don't wait. Give the memos. No, this week, all on Monday.
Particular case now will be listed tomorrow.
Maybe, sir. Tomorrow you move the matter when the matter is listed.
blood.
Yes. Give all the memos. Fresh matters, please give all the memos. I'm not going to take anything for this week. Give it. Yes. If it's pending, wait.
This one submission, please.
Give it. No problem, sir. So what, sir? Can't help. What were you doing till 17th August? Yes.
One submission, please, my lord.
Give it. Monday, all Monday, give it.
Can I submit, please, my lord?
Ella Monday ge kodi. Fresh matters, I'm not taking anything, sir. All on Monday. Everything on Monday, give it. No, sir, Monday. Can't help. Yes. Next.
Small submission, please, my lord.
ಎಲ್ಲರೂ ಹೇಳಿದ್ರಾಗಲ್ಲ. ಮೆಮೊ ಹೇಳಿದೀನಿ. Whichever is fresh matters, please give it.
My lord, this is.
Please give all the fresh memos.
Matter settled in the family court. That's the.
Give that. Yes. At 2:30 ತಗೊಳ್ಳಿ. 2:30.
Your lordship permits. My lord, I have been tried and convicted already under the Provident Fund Act. My lord, on that appeal is pending now. My lord, on the same facts, my lord, I have been charge sheeted for an offence under 406. That is the problem, my lord. Your lordship may assign any date, my lord.
Pending matter.
Not pending, my lord. Fresh matter.
Monday, sir.
Monday, please.
All Monday, I've told you, ಮತ್ತೆ an assignment of dates there.
Grateful.
Yes, give it.
One submission, withdrawal of the amount, my lord, under petition and section.
Take that tomorrow. Withdrawal of the amount tomorrow. Yes. Respondent tomorrow. Yes.
Who has been arraigned as an accused, stay order has been granted.
No problem.
The verge of retirement. The date may be.
Next week. Yes.
One submission, my lordship. 2023 fresh matter, my lordship.
Monday.
9 memos, my lordship, not being listed so far.
This is the 10th. Give it. Monday.
My lords, may I make a mention?
Give withdrawal, sir.
My lords.
ಯಾವ ಬೌನ್ಸ್ ಆದ್ರೆ ಏನಂತ ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ರೆ
ತಾಲೂಕಲ್ಲಿ ಇದಾರೆ ಅಂತ ಓಲ್ಡ್ ಪೇಟೇಷನ್ ಕೊಟ್ಟು ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡುತ್ತಾರೆ.
ಕೊಡಿ, ಅದು ಯಾವ ವರ್ಷದ ನೋಡಿ ಅದು ಹಾಕಿ.
Fresh matter, my lord, to be listed today.
Monday.
I request.
Why?
Monday ಬರ್ಲಿ.
Why today?
Like today it was scheduled. It was
Monday it will come, sir. Give it.
One
Monday alla. Monday is a holiday. Tuesday. Yes.
One pending
My
matter.
lords, in this.
It is both.
Cryptocurrency exchange, my lords. FIR was filed in 2021, my lords. Now, my lords, my bank account has been attached, my lords. My name is not disclosed in the FIR itself, my lords.
Monday.
My lords, bank account, salary account.
ಯಾವಾಗ ಆಯ್ತು?
23/8 ಆಗಿದೆ ನಂದು.
23/8 ಪ್ಲೀಸ್ ಸ್ಯಾಲರಿ ಡೇಟ್ ಆಗೋಯ್ತು. ಇನ್ನ ನೆಕ್ಸ್ಟ್ ಏನಿದ್ರು ಅಕ್ಟೋಬರ್ಗೆ. ಸೊ ಗಿವ್ ಇಟ್
Difficult. Tomorrow at least.
Monday.
Tomorrow if it's possible, my lords.
Give it on Monday. They'll come on Monday, madam. ಯಾವ್ದು Tuesday, no memo should be held. Post everything.
Lords, matter for being spoken to, my lords at court.
Tomorrow.
My lord, this
Being spoken to, my lord. Tomorrow. In being spoken to na. 2:30 ಯಾಕೆ sir? Yes.
Respond number 2 has filed a complaint.
So what? So what? ತಾನೆ ಮಂಡೇ. ಎಸ್
my lord.
ಥರ್ಸ್ಡೇದೆಲ್ಲ ಇವತ್ತು ಡೈರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿದೆ, ಯಾವ್ದು ನಿಲ್ಸಿಲ್ಲ. ಸೊ ಮಂಡೇ ಥರ್ಸ್ಡೇ ಏನ್ ಬಂದಿಲ್ಲ.
My lord, this is lordship
ಮಂಡೇ
lordship in this matter. Is pending matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಸರ್.
It is
ನಾ ಈ ವಾರದಲ್ಲಿ ಏನ್ ತಗೊಳಲ್ಲ, ಕೊಟ್ಬಿಡಿ.
lordship in
10ನೇ ಮೆಮೋ ಆದ್ರೆ ಈ ವಾರದಲ್ಲಿ ತಗೊಳಲ್ಲ, ಕೊಡಿ.
lordship in pending matter. It is notice is ordered. On 19/7 it is posted. On that day, since notice is not served, await is ordered. Thereafter it is not posted. I have moved to 3 memos.
So what?
Lordship, there is urgent.
No, give it, yes. Birth code, when do you want?
My lord, this is the please. This is the fresh matter.
Monday.
I moved 3 memos, my lord.
10th ಆದ್ರೂ ಮಂಡೇ.
Monday.
Sir, no precedents like that. Give it. Yes.
My lord,
ನಿಮ್ಗಿಂತ ಮುಂಚೆ ಮುಂಚೆ ಬರುತ್ತೆ.
My lord, one FIR was stayed, my lord. Another FIR has been registered against the same petition.
Monday, sir.
For the same fact, my lord. My lord. Government servants are suspended for the by registering non-cognizable.
Government servants are suspended. Why are you moving this court?
FIR is registered for non-cognizable offense, my lord. And we have approached the KIT. KIT has refused to stay, granting stay.
So
that FIR is registered for non-cognizable offense.
You are inside for 48 hours.
No.
Were you arrested for beyond 48 hours?
No more.
ಮತ್ತೆ ಯಾಕೆ why were you in suspension? Mere registration of the crime will not put you under suspension. No. Challenge it, service ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ, ಇದಕ್ಕೆಲ್ಲ ಬರಲ್ಲ, ಕೊಡಿ. ಮಂಡೇ
Day after tomorrow, KIT is
Monday, sir.
Tomorrow, my lord.
ಏನ್ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ಸ್ ಅಂದ್ರೆ suspension is not dismissal. Give it. Yes.
Your lordship.
Fresh matters, my lordships.
Monday.
Petitioner is student, my lordships.
Monday.
Your lordships.
All for Monday.
Lordship.
Give it. Which year? Give all the memos.
Pending, my lord, 2023 matter.
Thank you. Give it. Yes.
Entry order granted, subsequent entry order is not extended, my lord. Now
That's all right. We'll see. Give it. Yes.
charge sheet ಹಾಕ್ಲಿಕ್ಕೆ ಅವ್ರು ಕರೀತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ.
ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಯಾವ್ದು ನಾಳೆಗೆ ಹಾಕಿ ಅದು.
Your lordship, there's an MC case.
Where charge, where entry order is not extended, please take that.
Connected.
Give all the memos. Other memos, please kodi. Yes.
Your lordship, there's an
If you want
MC
to
case.
give, call the cases, madam.
Lords, may I make one?
Lordship, please.
1 minute, sir.
There's an MC case, your
If
lordship.
you want to give the memo, give the memo. Yes.
My lord, petitioner has to go to abroad day after tomorrow, my lord.
Day after tomorrow. Why have you fixed without taking the leave of the court? ನಿಮ್ ಪ್ರೋಗ್ರಾಮ್ ಹೆಂಗ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡ್ರಿ?
No, my lord. As per, I mean, like he has to go, or else, my lord, he can't able to continue his education, my lord.
It's good.
My lord,
Tomorrow.
My lord, basically, my lord, as per previous memo, Thursday was scheduled, my lord. So
Tomorrow you come give it, sir. ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಸ್ಟೂಡೆಂಟ್ ಯಾವ ತಗೊಳ್ಳಿ. Tomorrow. Pending body, sir. Yes. How many extensions? Already I've granted everything. Please give it.
Your
Yes.
lordship, one submission, your lordship. It was already posted for 12th. This is a DV case. The respondents are really old, your lordship.
DV case or DA case?
Sorry, domestic violence case.
Domestic violence. All
Yes, your
right.
lordship. Please, if you could post it maybe just before 12th.
No. Yes. Monday.
Much
It's
obliged.
a fresh matter or pending, madam?
Fresh matter, your lordship.
What's there? When is the next date there?
12th.
You are the husband?
Yes, your lordship.
No problem. Monday. Yes.
These two matters are 2:30 minutes.
Why, sir?
My bank accounts have been freeze minutes.
Tomorrow.
Tomorrow minutes.
ಅದೇ 2:30 ಕೇಳಿದ್ರೆ tomorrow ಕೊಡ್ತೀನಿ. Day after tomorrow. Yes.
2:30 only minutes.
Tomorrow ಕೊಡಿ. FR ಅದು ತಗೊಂಡ್ಬಿಡಿ ವಾಪಸ್.
It is complied, my lord.
ಸುಮ್ನೆ ನೀವು ಆಫೀಸಿಗೆ ಬಂದ ತಕ್ಷಣ ಕ್ಲೈಂಟ್ ಇಲ್ಲಿ ಬಂದು ಒಂದು ಫೈಲ್ ಮಾಡಿ, ಡೋಂಟ್ ಡೂ ದಟ್.
I've complied with the office of
ಕಂಪ್ಲೇಂಟ್ ಇದ್ರೆ ಮಾತ್ರ.
Tomorrow minutes.
Tomorrow.
My bank accounts have been.
Your bank accounts won't be defrozen tomorrow. No worries. Let it come.
One matter we had moved, my lords, your lordships. That's a Poxco case by the wife against the husband. By the time it came before my lords, your lordships were inclined to grant an interim stay. Charge sheet was filed. I brought it.
You have withdrawn.
Tomorrow it is posted.
Tomorrow, give it to us. You want it 2:30?
2:30 because tomorrow it's posted for framing of charges.
I'm taking it because you withdrawn.
Withdrawn.
The
I
insistence of the
withdrew.
court, so I'm taking it. Yes.
Next one.
A4 stay is pending.
IFR stay will always be pending if it is not granted, sir.
Last time, Kalburgi got the date was not given, my lord.
No problem, sir. Give it Monday or Tuesday. Yes. No adjournments. Yes.
It's number 2, my lord.
No adjournments in any list. Yes.
Fresh matters, list 1, still number 1.
Lord, I appear for the petitioner in this case.
ಏನ್ 2 ವರ್ಷದಿಂದ ಏನಾಗಿದೆ? CC of 2014, sir.
My lord, there is an absconding. It's a split up charge sheet. But insofar as the accused numbers 1, 3, and 4 have already been acquitted.
Where is that? Orders elli?
Ada enclosed ಮಾಡಿಲ್ಲ. Yes, not enclosed.
What is the orders? The learned counsel, the petitioner submits that the case against the petitioner has been split up, notwithstanding the fact that other accused are acquitted. Petitioner shall produce those orders of acquittal by the next date of hearing, next Tuesday in the next Wednesday, fresh matters list.
Grateful.
That is on 18th. Next.
Number 2.
2021 crime ಏನಾಗಿದೆ?
My lord, B report is filed in this.
Learned counsel, learned CGP on instructions would submit that police after investigation have filed a B report. In that light, the petition in the form that it is present is rendered infructuous, disposed as having become infructuous, deserving liberty. Yes. Next.
For the petitioner, Your Lordship. Your Lordship, the allegations are that the petitioners have granted an illegal permission to run educational activities to one Shreyas public school.
Yes, government. 2017 incident, crime in 2021, today we are in 2024. What has happened?
ACB is the respondent. ACB is the respondent.
ACB alla, implicit lokayukta.
Please, Your Lordship.
Who are you?
My lord, for the response. Previously, Manmohan sir was appearing for the ACB.
Who was appearing? Manmohan. We'll delete his name.
Yes, my lord.
Registry to delete the name of PN Manmohan as appearing for the first respondent and print the name of B Latif as appearing for the respondent. Petitioner to serve set of papers upon counsel to B Latif. For an incident of 2017, the crime itself comes to be registered for offence punishable under section 13(1)(c) in the year 2021. Till today, no charge sheet is filed against these petitioners. Is the submission of the learned counsel appearing for the petitioner. Therefore, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. List the matter on 24th in the fresh matters list. Serve on Latif now. Yes.
14.
For the petitioner.
Elli avaru? Who is Parmeshwar Hegde? Implicit lokayukta. Yes, sir.
Sir, I am for the petitioner, my lord.
A3 and A4.
No, I am for A4, my lord.
A4 matra, na?
A4 matra. There is no role of the A4 as per the complaint and as per Annex B.
2015 CC.
My
What
lord,
has happened?
in this 2823 charges framed, my lord. Now 2823.
But this is filed on 30th March 22,
Yes,
sir.
my lord. Now evidence is commenced, my lord. Almost witness.
But there's nothing against him.
As per
They heard the learned counsel appearing for the petitioner. The learned HCGP on instructions and verification of the records would submit charges have been framed on 2/8/2023. It is long after the filing of the present petition. Merely because the matter was not listed before the court, the petitioner should not be put to prejudice. This is in the light of the fact that petitioner accused number 4 is accused number 4 and there is nothing that would pin him down for the offences laid in the charge sheet or the charges framed for forgery. Therefore, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. 1 HCGP 2 emergent notice. 138 CC 2019.
138.
5 A2 and A3 Kashkan. Next.
My lord, in this matter, my lord, serial number 5, only FIR is challenged, my lord, but
Charge sheet
agide CC 88 of 22. That then
Adru stay madbekadde adu. First. Yes.
withdraw my lord's permission.
That is always there.
Please.
Next.
6.
No representation list after 2 weeks. Registry is directed not to list the matter prior to the expiry of 2 weeks. Next.
7.
Same order.
8.
IO existing. Yak move madidri?
I am not moved, my lord.
List the matter, post the matter for admission. Interim order subsisting shall continue to the next date of hearing. You have the respondent?
I am the second.
Okay. Any urgency?
No urgency.
Yes. Yes.
9.
2022 crime charge sheet ಆಗಿದೆಯಾ?
Please, my lord, charge sheet is filed.
What happened ಇದಕ್ಕೆ? Charge sheet ಆಗಿದೆಯಾ?
Charge sheet agide.
Same order. HJK. 9, serial number 9.
10.
Charge sheet.
Lord, I appear for the petitioner in this matter.
Yes, sir. I have stated the warrant. What is the arrears?
Lord, I'll ascertain, Lord, and
Learned counsel for the petitioner to ascertain the arrears and make submissions on the next date. Kapil Dikshit,
And for the first
come this
respondent.
side. What is the arrears ಎಷ್ಟಿದೆ? Arrears.
I'll check with, I'll
You
get the
you also have to ascertain. Both the learned counsel appearing for the petitioner and the respondent are not aware of the arrears that are to be paid to the wife. Therefore, list this matter on next Thursday. In the fresh matters list. Next.
11.
CC of 2019.
My lord,
Stage.
it is for
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? Number ಕೊಡಿ. Learned counsel, sorry, your name? Learned counsel B. Vijay Shetty submits that he would, undertakes to enter appearance for the second respondent, registry to print the name of so-and-so, tag this petition along with so-and-so. Yes, Devraj? Adhe. Admission. We'll post it for admission. CC of 2019.
And I handed over the file back.
You're not Gopal Singh error. Registry to delete the name of Devraj G as appearing for the petitioner. List the matter after 2 weeks. Why, sir? Interim order illa. One ನಿಮಿಷ. List the matter after there is no representation on behalf of the petitioner Gopal Singh. ಮಾಡಿ. List the matter after 2 weeks. Pendency of this petition will not come in the way of any proceeding before any fora.
These are the order which is done. But subsequently, we are challenging the order. But in spite of the order, in spite of the most, they are not releasing it in my favor.
ಬರ್ಕೊಳ್ಳಿ ಆಮೇಲೆ the pendency of this petition will not come in the way of any consideration of any application filed by the respondent before the concerned court. Yes. Because in his absence, I can't dismiss it. More than this, I can't do. Put. Yes, next. Memo ಕೊಡ್ತಾರೆ. Memo in terms of the memo. Next.
14.
13 also B report is filed.
13 ಈಗ ಹೇಳಿದ್ದು.
Sorry, my lord. 13 B report is filed, my lord.
14 ಏನಾಗಿದೆ?
14 acquittal ಆಗಿದೆ before the trial court.
Acquittal order. Yes. Next.
15.
Mohan Chandra. No representation list after 2 weeks.
16.
ಇದೇನಾಗಿದೆ?
My lord, in this charges framed on 7/12.
Even otherwise it is husband.
Lords, and 2020 itself, there's a decree, judgment passed by the family court.
For what?
On the ground of cruelty and desertion, I had filed a divorce petition against the respondent complainant.
What happened to that?
There are findings that there is a judgment and decree in my favor. Marriage is dissolved and the petitioner is also remarried, my lords, after the appeal.
All right, then wait.
There are findings that
Take out notice. The petitioner submits that he had instituted a suit, instituted proceedings for annulment of marriage and has a decree in his favor which has resulted in dissolution of marriage. It is a submission that the correspondent complainant is already married and
no, my lords, the petitioner accused.
You are married.
Yes, after the appeal period, my lords, he got remarried.
After that, so and the petition, in that light, emergent notice to the second respondent returnable by the 26th of September, one HCGP mail hackpudi. So and so list on 26th of September, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. Next.
17.
My lords, I appear for the petitioner. In this case, the B report has been filed.
B report, all right. Even otherwise, it's a matter to be stayed.
17 B report is filed.
17 B report, yes.
18.
Next.
For the petitioner.
My lord, the matter is still in the stage of hearing before discharge application is filed. However, my lord, they've suppressed the fact that there was another complaint which was filed wherein the victim was being threatened with her obscene photographs. Charge sheet was also filed in that. And they claim that dowry harassment was done. However, repeatedly, the victim has transferred money to the complainant, my lord. Her father, bank statements are also produced. Further, my lord, we have also produced the charge sheet of the Andhra Pradesh police, which indicates that she was being harassed with her obscene photographs. Nevertheless, here they also claim that a site was registered in the name of the petitioner. However, my lords, that site was registered in the name of the victim even prior to marriage in 2015 itself. More so, my lords, if the Andhra Pradesh police charge sheet is perused, it indicates he's an auto driver, my lord, while she was working here as an engineer along with the petitioner. And such being the case, he claims that 30 lakhs cash dowry is paid and 500 grams gold. Hence, before this honorable court, man. Notice was issued.
304B, 498A.
Please, my lord, how
Death
documents. My lord, the document.
All these material that you're now trying to project are a matter of evidence.
Please, my lord.
In 482 will not consider all this, particularly when it is 304B read with 498.
Please, my lord, however, previously notice was issued to the respondent number 2.
So far as the charge sheet that is filed by Andhra Pradesh police is concerned, that was about 7 months
Whatever,
prior to that.
take advantage of all that in a trial. In a 482, I will not. Prima facie offences are glaringly found. Your A1, 2, and 3. Right?
My lord, prima facie offense is not made out, my lord. If your lordships may kindly page 201. Page 225 would explain, my
Page
lord.
54. Want me to go
Please,
through the
that's charge
statements
sheet,
also?
please, my lord.
Yes.
My lord, however, the documents speak contrary.
That is a matter of trial, madam.
Please, my lord, please. I leave it to your lordship.
Yes. You want to avail remedy of discharge, you
May I
can avail.
Please,
Yes.
please.
That
my lord.
application is already filed, is pending.
Filed, pending.
It's
pending.
Let the
pending, my
court
lord.
consider. We'll dispose on that ground.
Please.
The petitioner is before this, petitioners accused 1, 2, and 3 are before this court calling in question proceedings in SC 1938 of 2019 registered for offense punishable under section 304B read with and 498A inter alia. The learned counsel appearing for the respondent complainant submits that the petitioners have also filed application seeking their discharge from the array of accused in SC 1938 of 2019 and the same is pending consideration. In that light, I decline to entertain the petition, leaving open the petitioner to pursue the remedy of discharge that the petitioners have availed of as on today. With the aforesaid observation, petition stands disposed. All contentions left open.
May I make a request for expeditious
Dispose. That we will see. Aವಾಗ ಹಾಕಿರೋ discharge. ಅಲ್ಲಿ 4-5 ವರ್ಷ ತೀರ್ಮಾನನೇ ಮಾಡಲ್ಲ.
2019 is the.
Yes, the application seeking discharge, if pending as on today, shall be expeditiously disposed at any rate within 4-5 weeks, 6 weeks from the date of receipt of the copy of this order. Yes.
Rating?
ಅದೊಂದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಆರ್ಡರ್ ಡೆಕೋರೇಟ್. In the meantime, next.
20.
Correct. In terms of the memo, withdrawn.
21.
ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಕ್ರಾಶ್ ಆಗಿದೆ ಮೆಂಬರ್ಶಿಪ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಡೇಟ್ ಒಳಗಡೆನೆ
ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ವಲ್ಲ ಕೊಡಿ ಅದು ಯಾವ್ದು ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ
ಕೊಟ್ಟಿದ್ದೀನಿ ಡೇಟ್
ಯಾವ್ದು ದೇಶ್
ಡೇಟ್
ಅಂದೆ ಸೇಮ್ ಕ್ರೈಮ್
ಸೇಮ್ ಪಾರ್ಟಿ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್
you can't draw similarity if it's same accused then the co-accused of the same crime. Yes, no, look at it. Please. List on Wednesday in the fresh matters list. Next.
22.
20. Petition is weeks time.
You want to
Charge
withdraw?
sheet is filed, my lord.
File. If you want to challenge the charge sheet. Learned HCGP on instructions would submit that the police after investigation have filed a charge sheet. The Learned counsel of the petitioner seeks leave of this court to withdraw the petition. So and so, same charge sheet, man. Challenge the charge sheet. Yes.
23.
In the meantime, list after 2 weeks. Yes.
24.
Pay report is filed, my lord.
Pay report.
25.
Please, petitioner. Lord, the alleged incident has been taken place on 4/11/2019, my lord. The complaint has been lodged on 1/12/2021.
Parallel.
No, my lord.
That is not the issue. Why did you blackmail her?
My lord,
why did you blackmail her? See page 27. ನೀವೇನು ಓದಿಲ್ವಾ? ಓದಿಲ್ವಾ? 2 ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks. Yes.
26.
Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
26.
Appeal for petitioner.
2, 3 and 4, Kashkan. Next.
Same parties, accused number 1 already crash agide my lords. Adragade na accused number 3 idivi idragade. Already judgment copy kotti.
Kodi edellide. Even otherwise ಏನು ಇಲ್ಲ ಇವ್ರ ಮೇಲೆ. MPML ಇದೆ ಇದು. What are you saying, madam? Which matter is this? ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ನಿಮ್ದು?
26.
26 offense punishable 498 ಇದೆ I think.
498 ಹೇಗೂ MPML ಅದಕ್ಕೆ ಏನು ಸಂಬಂಧ?
ಅವ್ರು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೇಡಮ್ ಎಸ್ ಕಾಶ್ಖಾನ್ 2, 3 and ನಾನೇ ತಪ್ಪು ಓದ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅನ್ಕೊಂಬಿಟ್ಟು. ಎಸ್
27.
2, 3 and 4. Will stay only 341. Stage.
HBC ಇದೆ stage.
The petitioners are before this court calling in question so and so. A perusal at the summary of the charge sheet would indicate that there is no foundation or facts that would become an offence under section 341 of the IPC. Therefore, there shall be an interim order of stay only insofar as the offence under section 341 is concerned. The further proceedings qua the other offences shall continue. 1 HCGP, 2 emergent notice. Yes. Madam? ಯಾರು ಇರ್ಲಿಲ್ವಾ? ಅವ್ರು ಯಾರು ಮತ್ತೆ? ಹಂಗಾರೆ ಬೇಡ. List after 2 weeks. 28.
28, my lord, 15/4/23, my lord, charges framed and 5 witnesses already been examined in.
But 2022 matter. Even otherwise, no case A to owner of the spa. There is no representative of the petitioner. List after 2 weeks. Registry is directed not to list. Yes.
29.
And pendency of this petition will not come in the way of further proceedings before the concerned court.
My lords, in this matter, my lords, we issued NOC and some other learned counsel named Nagaraj SS filed his wakalat, my lord.
29 ಅಲ್ಲ.
Please, my lords.
ಅದಕ್ಕೆ ಫೈಲ್ ತಂದಿಲ್ವಾ?
We have returned it back, my lord. NOC.
29.
Please, my lords. KG Sadashivaya has issued NOC, my lord. No objection.
Where is the memo for retirement?
My lord, they have taken away the entire
file. Sir. Nobody has filed wakalat. List after 2 weeks. Yes.
30.
Interim order.
2017, sir. End stage alida?
Because there is one interim order in another matter.
What interim order? Kodil?
Accused number.
Criminal petition 299 of 2019.
Accused number 4 and 7. Now the matter is for evidence before charge. B report was challenged, madam.
Learned counsel for the petitioner submits that the coordinate bench, qua the other accused, has granted an interim order of stay in criminal petition 299 of 2019. Tag this petition along with so and so. There shall be an interim order of stay in the case at hand as well, in the light of the interim order subsisting in the companion petition. List after 4 weeks. 1 HCGP, 2 emergent note.
I have filed the petition on 30/11/22, my lord. Charge framed on 14/7/23, my lord.
That's all right. CC of 2014, sir.
Yes.
10 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನ್ ಸ್ಟೇ?
Name of the petitioner included after the charge sheet, my lord.
So what? ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿದೆ. FIR ಎಲ್ಲ ಹೆಸರು ಇರ್ಬೇಕು ಅಂತಿದ್ಯಾ? Rudimentary, don't make submission.
Accused number 2 also quashed by this honorable court, my lord.
Quashed?
Yes, kodi. Case number ಇದೆ ನಾನು print ತೆಗೆದು. Sorry.
Get the order. List the matter day after tomorrow in the fresh matters. Get the order.
32.
Petition. Senior is out of station.
A case also out of station. List after 4 weeks. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
33.
My lord, 21/1/23, my lord, charges framed and witness already been examined.
No representation. List after 4 weeks. Even otherwise, it's 306.
306.
No case.
34.
34, my lord, settled in Lokadalat, my lord.
Learned HCGP on instructions and verification of the records would submit that the matter has been settled between the parties in the Lokadalat. In that light, the petition stands disposed. as having rendered infructuous in the light of the aforesaid settlement. Yes, next.
55. I appear for petitioner, my lord. Now the stage is for summons only. Deficit stamp paid, so it is for the stage of summons only, my lord.
Yes,
This is
comment.
138
138.
section.
We will.
My lord, in this, the
Learned
relationship
counsel
between
for the petitioner is directed to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement, list the matter on 24th in the fresh matters till such time further proceedings before the concerned court shall remain
the
stayed.
order sheet, everything order sheet is here.
File ಮಾಡಿ ಕೊಡಿ. Learned counsel of the petitioner
The order sheet.
files the entire order sheet. The same is taken on record. Next.
36.
No representation. List after 2 weeks, not to list.
37.
Offenses under section
376, 420.
420.
The
incident took place in the year 2013. The complaint was came to be lodged on 2019. There is inordinate delay. And in the meanwhile, my lord, the petitioner...
Meanwhile, touch ಅಲ್ಲೇ ಇರ್ಲಿಲ್ವಾ ನೀವು ಅವ್ರ ಜೊತೆ?
He has filed the complaint against the petitioner, against the victim
For what?
on 7/1/2018 for the offense punishable under section 384.
Extortion.
Extortion.
Charges framed, 5 witnesses have examined.
But I have filed the discharge application.
ಯಾಕೆ ಮೂವ್ ಮಾಡಲ್ಲ?
Discharge application was filed.
ಅಲ್ಲ ಸರ್, ಫೈಲ್ ಮಾಡಿದ್ರೆ 2022 ಅಲ್ಲಿ.
Please.
ಇದನ್ನ ನಾನು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕಾಯ್ತು.
I have filed the memo.
ಏನ್ ಮೆಮೋ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ. ನನ್ ಅಪಿಯರ್ಸ್ ಫಾರ್ ದಿ ಪೆಟಿಷನರ್. You filed a memo. ಇಲ್ಲಿ ಬಂದ್ ಬೆಳಗ್ಗೆ ಅರ್ಜೆನ್ಸಿ. 2 years in the none of you would comply the office objections. What would happen to the clients? ಅವರು ಒಂದು ರಿಮೈಂಡರ್ ಫೋನ್ ಮಾಡಿದಾಗ ಇಲ್ಲಿಗೆ ಅರ್ಜೆಂಟ್.
Sorry.
Memo. I will not interfere now.
No, I have filed the discharge application. On that basis, discharge also I filed. It has came to be rejected.
When?
On 9th of November 2022. It's at page number 19.
That is what. Challenge ಮಾಡಿದ್ದೀರಾ page 19.
Please.
ಈಗ ಯಾವ ಸ್ಟೇಜ್ಗೆ ಹೋಗ್ಬೇಕು? ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿ 2 ವರ್ಷ ಆಯ್ತು. What should happen to a case that is good on merits, evidence is commenced, 5 witnesses are examined? Why should I interfere now? ಏನ್ ಮೆಮೋ ಹಾಕಿ? ಒಂದು ಮೆಮೋನು ಹಾಕಿಲ್ಲ, ಒಂದ್ ಸರಿನೂ ಬಂದಿಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ. ಒಂದೇ ಸರಿ ಬಂದಿರೋದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ.
Subsequently I have filed the memo.
Subsequently filed a memo. Subsequently 2 ವರ್ಷದಿಂದ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Don't tell me this. It's highly incorrect. 2 years in you keep the petition pending and now in urgency springs. Will not interfere in this case.
Even in the cross examination, she has accepted.
Acquit ಆಗ್ತೀರಾ ಬಿಡಿ. Acquit ಆಗ್ತೀರಾ.
In page number 223, my lord.
I know you have an excellent case on merits.
She has lodged the complaint, and in that complaint also she has not stated about the sexual intercourse.
It's all right.
Trial,
Yes.
my lord. Because 5 witnesses examined. Let the trial court take the decision because we don't know what
Direct
is the
conclusion of the trial. ಇವ್ರ ಮೇಲೆ ತೊಂದರೆ ಆಗುತ್ತೆ, ಸುಮ್ಮನೆ ಇರಿ. The party will go against the advocate then. ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನೀವು. ಕರೆಕ್ಟ್. 2 years ಇಂದ ಮೆಮೋ ಪೋಸ್ಟ್ ಮಾಡ್ಸಕ್ಕಾಗಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಬಂದೇ ಇಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ. ಮೆಮೋನೇ ಕೊಟ್ಟಿಲ್ಲ. Not one memo is in the file. Is it not a mistake on your part?
Please.
Then what? The petitioner is before this court calling in question proceedings in so and so. The learned HCGP would put up vehement opposition, contending that the charges have been framed after the filing of the petition and the matter is set at the stage of trial. A perusal of all the statements, the summary of the charge sheet or even the complaint even would indicate an incident, that too consensual, that took place in the year 2013 is projected to be a crime in crime number 15 of 2019 for it having been registered in the year 2019 for offense punishable under section 376 and 420 of the IPC. This comes about after the petitioner registers a crime against the complainant for extortion under section 384 of the IPC. Adil charge sheet ಆಗಿದೆಯಾ?
Adil be report ಆಗಿದೆ.
So and so. Notwithstanding, though the police have filed a B report on the charge of extortion against the complainant in the peculiar facts and the fact that the charges have been framed after the filing of the present petition I deem it appropriate to stall further proceedings before the concerned court, where the petitioner till the next date of hearing, 1 HCGP 2 emergent notice returnable by the 27th of September. Next.
38.
Here for R2 in this matter, my lords. Matter where on the last date, the
directed
Honorable Court had
payment of
directed
rupees-
them to make payment of 10 lakh.
10 lakhs
That payment has been received, my lords.
received, huh?
We have made the payment.
May I just point out, my lords, what offense is made out in this particular petition.
we are
Just
willing to
take a
settle
few
the
minutes,
matter.
that's all.
Only
10 lakhs ಬಂತಾನೆ
ಬಂದಿದೆ.
ನೀವು ಹೇಳಿದ್ರೆ ಏನು ಬರೋದೇ ಇಲ್ಲ ಬರೀ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂತ. ಎನಿವೇ ಈಗ ಬಂದಿದೆ. Next installment.
We have already paid another 3 lakhs in the past. my
That's
lord.
okay.
That's
If
2
the
minutes,
matter
that's
is-
not 3.
Very well. Okay. We will negotiate. Matter may be referred to mediation, my lord. We will sit
Well,
across the table and we will.
There is no, my lords, if at all any payment has been made, it's only before this, my lords.
I
that
will
this
stay
is
for the
happening.
proceedings.
My lords, may I point out, my lords, what is the conduct and how the offense is made out?
Conduct may be anything. You want money, right? 35 lakhs ಎಷ್ಟದು?
ಅಷ್ಟು 35 lakhs was the due amount.
principal.
Now with the
Principal, interest ಆಮೇಲೆ ಬರುತ್ತೆ. That I will order. You take 35 first. Next.
Lords, I have instructions to state that there is a new apartment under construction. I'm willing to give him.
They will not receive it.
The
my lords.
the
They will
concerned
not
apartment.
receive it, my lords, because they don't trust him. Our flat itself, they have sold to someone else. If it's any monetary payment of the
The merits of
35
it, my
lakh.
lord, I have not sold.
12
it.
lakh is
Landowner
paid.
sold it, saying it is coming out of his
ಈಗ
share.
ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ first.
Out of 35, 12 is received, my lords. If at all, my lords, they are willing to.
Another next installment ಯಾವುದು?
Month's time because he's in custody.
ಆಯ್ತು.
That's why. This is
You
14
want
years.
money, right? Yes. If you want pass orders on merits, I will pass. You go the execution way and do anything you want.
It's only pursuant to my lord's orders.
If that is going to get over by 4 weeks, let's see.
This is the largest payment they've made in 14 years.
ಆಯ್ತು ಬಂದಿದೆಯಲ್ಲ ಈಗ. So you're seeing some money. Yes.
Indeed, my lords, indeed.
Some oasis in the desert, sir. Just
Indeed, my lords, indeed.
try to
Indeed.
relish that first.
Indeed.
Yes. Now, I'll list it on 27th.
Very well.
By then, another 10 lakhs.
We make efforts to make payments in installments, my lord. Let there not be a.
ಅದೇ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್
My lord, the only
ನಾಟ್
issue
EMI, sir.
ಇಲ್ಲ, the only issue is, my lord,
Could I pray for
that-
shorter date, my lords? It's 10 lakh rupees and that
Wait,
could.
sir.
Lords, this previous installment only because of.
Wait, sir. List the matter on 27th. The petition, it is made clear that the petition would stand dismissed in the event the petitioner would not pay to the respondent another 10 lakhs by the said date. This direction would not come in the way of the parties sitting across and arriving at a settlement, comma, if any. List on 27th is the fresh.
If I may request, my lord, 30th, my lord, 27th.
30th, but at 27th.
Then, my lords, 15 lakh.
My lord, in the interim, my lord, my bail application is pending
I'll
consideration.
then submit, my lords. If some interim protection is being sought, then I will also request my lord.
My only
kindly
interim
see
protection
some.
is that my lords may kindly direct my
The
bail
trial
application.
court has
to be
not been
heard
able
at
to
this
secure his
court.
presence. He's hoodwinking
here.
everyone.
Where are you?
In the custody as.
You're in custody, ಈಗ.
My lords, senior APP impresses upon the court that police agency is not properly executing warrants in the above case. Police ke actually execute madake. If he is let out, my lords, he is.
I am not letting you. Where? Friday, 27th will pass some order.
My lords may kindly.
27th, 35 ಕೊಟ್ಬಿಟ್ರೆ, I will pass some order and interest we will drag this.
He's in custody for last 1 month. Kindly, please, my lord, because we are making.
Money is
payments
also in their
installments.
custody. He may also be in custody.
No
Small amount. For a small amount of 35 lakh rupees, my lord, we are.
How small is this one?
1 minute, sir. ನೀವು ಸುಮ್ಮನೆ ಇದ್ರೆ.
I'm sorry. I'm sorry.
Yes.
Lords may kindly pass directions to consider the bail application. That's all.
No,
On the
that
merit,
I will pass on the next date.
please, my lord, only on the
Rightly in
merits.
custody.
Only on the merits of the case, my lord. Nothing.
Definitely, I will consider it. Another 10 lakhs you pay. List on 27th.
Great.
Avath will direct. Anyway, you're in custody. Next.
39.
A2 and
Is 498.
yes, sir. A2 and A3.
498 matter has been settled.
Settled.
Settled and divorce has also granted.
So we'll close this.
No, my lord. The respondent number 2 has to.
Lashkan, 1 HCGP 2 emergent notice returnable by 27th. Yes. Stayed. Next. Madam. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ. List on 27th ಅಷ್ಟೇ. Application ಇಲ್ಲ ಅಂದ್ರೆ 27th.
In this, in the inordinate delay of 4 months, my lord.
No problem, sir. ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿದೆ ಥೆಫ್ಟ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಾಗಿದೆ 4 ತಿಂಗಳ.
they got to know that on 24/10/2016, my lord. Thereafter, after we filed an NI Act against the informant, this complaint.
No
has
problem,
been
you
filed.
serve on the respondent. The one,
But it is for framing of charges.
maybe sir, one HCGP to emergent notice, next Wednesday in the fresh matters list. Al counsel idaralva, petitioner to serve on the counsel who represents the respondent in the trial proceedings.
Prosecution case.
Complainant ಇಲ್ವಾ?
Complaint ಅಲ್ಲಿ
ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ ಇಲ್ಲಿ?
ಇದ್ರ ಮಾಡಿದ್ವಿ.
ಹಾ ಸರಿ, ಅಲ್ಲಿ ಯಾರು ಇಲ್ವಾ?
ಅಲ್ಲಿ ಯಾರು?
ಸರಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಗೆ ಸರ್ವ್ ಮಾಡಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್
41.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file next date ಏನು?
ಲಕ್ಷದ 1:10
ಒಂದು list on 21st in the fresh matters list.
ಸ್ಟೇ
ಅವತ್ತು ಸಾರಿ 24th in the fresh matters list. Meanwhile ಬೇಡ, meanwhile adjournment.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಏನೂ ಆಗಿಲ್ಲ, ಏನ್ ಕೇಸೇ ಇಲ್ಲ, ಒಂದು ನೋಟಿಸ್ ಅಷ್ಟೇ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಇನ್ವ್ಯಾಲಿಡ್ ಚೆಕ್ ದಟ್ ಈಸ್ so
let it come
after the merging of our bank.
Non-CTS check, that is not a ground in under 138 at all. I will give you the judgment now.
One Allahabad judgment is there.
No sir, Allahabad ನನ್ನ judgment ಇದೆ. Should I follow Allahabad or mine? ಅದಕ್ಕೆ ಬರೀ notice. Yes, non-CTS check is not a ground sir. RBI has issued circular the moment merger happened in 2016.
After the merging happened, more than 5 years the check.
We'll see, ಅದಕ್ಕೆ notice. Yes.
Appearing for petitioner, Your Honor. My lord, the petitioner.
1,50,00,000.
Alla.
Recovery.
Illa, 3-1 application. There is only 1 lakh is recovery, my lord.
1,50,000.
1,50,000. But we have paid already 7.5 lakh. In this case, my participation is not at all involved, my lord. I have been implemented by way of 319 application. My lord, FIR came to be filed. Accused 1 and 2 were
Government.
Lord, in this 3 witnesses examined, my
No,
lord.
that's all right. 319, he is newly brought in. We'll see. Get the where is the order?
My lord,
Order notice ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
order I have challenged, my lord.
We'll see.
Please,
Learned
my lord, page number
HCGP is
25. Your
directed to
Honor.
accept notice for the respondent. Emergent notice to the second respondent returnable by 27th fresh matters. Till such time, the order that brings in the petitioner back to the web of the proceedings shall remain stayed.
Much of it.
43.
I pay for the petitioner's counsel. I run a platform. I have nothing else to do with anything. What happens is that the person who actually runs the cryptocurrencies gives me an intimation, page 166, saying, please, I want to delist these. I send an intimation to him, to the complainant. What he would do, page 168, I send the intimation. The following day, he sells. It's not, ultimately, he suffered some loss in the sale, apparently. But the complaint would come almost 10 months later.
We'll see. We'll hear the complaint. The learned senior counsel Zee Kannada appearing for the petitioner. 1 HCGP, 2 emergent notice, 26th in the fresh matters list, returnable by
Criminal protection till then.
No, not a case for that.
But the reason is this. He is, if your lordships are kind enough to look at the complaint, all he says is, and of course your lordships would have seen, all he says is, I want to know who the owners are. And please be kind enough to see one other. I'll just show your lordships one document if your lordships permit.
Let the government also get the papers.
I'm told they've been served, my lord. I'll verify.
Yes.
There is a transcript of a conversation between us, page 189,
Exactly.
where he says, I want to contest for elections. That is, this seems to be his motivation. There is something else, which
Any of the grounds that you have taken are a matter of trial.
I bow down to that. I'm not saying.
Let him get the papers.
Please, I bow.
Yes. PCR of Gopal Krishna. No representation, 2 weeks, not to list, prior to the expiry of 2 weeks.
55.
In the meantime, independence, pendants, pendants. In the meantime, next.
46.
State, madam. Yes, next.
46.
ಏನ್ ಗ್ರೌಂಡ್ ಇಲ್ಲ ವಿಷ್ಣುಮೂರ್ತಿ.
Based on Supreme Court, Honorable Supreme Court judgment, your lordship, that regarding. The Mehal Court has jurisdiction, your lordship, that as per your lordship, that
Emergent notice to the respondent. Yes, next. Stay. Application ಅಲ್ಲಿ.
ಸ್ಟೇ ಇಲ್ಲ ಅಲ್ಲ ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅದಕ್ಕೋಸ್ಕರ ರೆಸ್ಪಾಂಡ್ ನೋಟಿಸ್
ರೆಸ್ಪಾಂಡ್ ನೆಕ್ಸ್ಟ್ ಸೊ
For the petition, my lord.
ಇದೇನಾ
Notice.
Jagdish will pass it over. All matters are there. We'll see if possible. We'll take it to. Yes. Pass over.
48.
MDR.
ನಾಳೆ most of the matters are taken up tomorrow.
More charge ಇದೆ ನಾಳೆ.
Tomorrow, sir. Please.
49.
Please. Judicial custody, petitioner 9.
Judicial custody.
Is last time.
ಗೊತ್ತು ಮದುವೆ ಆಗಿದ್ದೀರಲ್ಲ
15 days time was
20.
granted.
ಅಲ್ಲ interim bail was granted for marriage.
21 years ಆಗ್ಬೇಕು ಅಂತ
ಆಯ್ತು ಗೊತ್ತು ತಗೊಂಡೆ. Recorded everything in the audit. This we will dispose.
Please.
Is in custody also. ಇದು ಡಿಸ್ಪೋಸ್ ಅಂತ ತಗೊಳ್ಳಿ, ನಾಡಿದ್ದು ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ.
Please.
We will give a direction to the jail authorities to release you.
Please.
Jagdish ಹೇಳ್ಬಿಡಿ, this case where
Yes.
I will record everything and do it.
Marriage certificate ಕೊಡಿ.
ನಂಜುಂಡೇಗೌಡ್ರೆ, ನಂಜುಂಡೇಗೌಡ.
Please.
I'll release it day after tomorrow. Till then, don't be in a hurry. Yes.
Please.
Yeah. Disposed.
Please. They were supposed to provide the marriage certificate. 15 days bail was granted.
20 years
ಎಲ್ಲಿ?
ಅಲ್ಲ 21 years ಆಗ್ಬೇಕು ಅಂತ ಸಿಸ್ಟಮ್ ತಗೊಂತ ಇಲ್ಲ ಅಂತ ಆಲ್ರೆಡಿ ಮ್ಯಾರಿಡ್ ಆಗಿದ್ದಾರೆ. ಮ್ಯಾರಿಡ್ ಆಲ್ಸ್.
Child is also there. Be wearing. Yes. Objection ಇದೆಯಾ? Next.
50.
A234 Kashkan. Next. State, sir. Next. The 7C and 12 list on 16th. Next 13th, 16th. Next Friday, madam. 18th. No. Next Friday, what's the date? 20th, sorry. List on 20th.
52.
A234 Kashkan. Next.
53.
The petition, no. We withdrawn one.
A withdrawal, we'll do it fast. Yes.
Lord, allegation offenses are 306 and
498A and 306.
Please, my lord. Lord, there are no specific allegations with respect to 306 of IPC, my lord. Lord, initially what had happened, the complainant has filed a complaint, my lord, on 23/8.
Sir. ಯಾವತ್ತು ಸರ್ವಾಗಿದೆ ನೋಡಿ.
13/7/20.
I will give one more chance.
Lord, last
List
two
matter on
occasions.
24th in the fresh matters list. ಅದು withdrawn, no?
Connected.
ಇದು adjourned.
53.1 withdraw. 53.1.
53.1 is withdrawn. Memo ಇದೆ. Yes. Next.
54.
What betting?
54, my lord.
ಬೆಟ್ಟಿಂಗ್ ಅಲ್ಲಿ ಬೆಟ್ಟಿಂಗ್ ಆಗಿ ಸಾಲ ತಗೊಂಡಿತ್ತು ಅಂತ ಅದಕ್ಕಾಗಿ ಎಲ್ಲ ಲೆಂಡರ್ಸ್ ಎಲ್ಲ ದೇ ಆರ್ ಥ್ರೆಟನಿಂಗ್ ಹಿಮ್, ಕಾಲಿಂಗ್ ಹಿಮ್ ಸೇಯಿಂಗ್ ದಟ್
Lord, in this charge sheet is filed, my lord.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಇಟ್ ರಿಕಾಲ್ಡ್ ಅಗೇನ್ಸ್ಟ್
ಆಗುಂಟು ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ.
19/8, my lord, 24 charge sheet is filed. We are awaiting the C number, my lord.
But you then keep it with you.
ಇನ್ನು ಆಗಿಲ್ಲ.
The petitioner is accused number
6, man.
Accused number 6. He is drawn in crime number 90 of 2024 for the offence punishable under section 306 of the IPC. The allegation against the petitioner is that the deceased, that the
husband of the
complainant,
ಅಲ್ಲ deceased, husband of the deceased was working in irrigation department and he had borrowed loans for cricket betting.
Husband of the
complainant
yaru sir?
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಅಪ್ಪ, deceased in ಅಪ್ಪ.
That the son of the complainant who was an employee son-in-law of the complainant who was an employee in the agriculture department had borrowed certain loan and had indulged himself in cricket betting. IPL. In cricket betting. And due to certain losses, the amount of loan that was raised was sought to be returned by the petitioner and several others. The son-in-law of the complainant commits suicide. Abetment charge is laid against these petitioners.
son-in-law ಅಲ್ಲ, ಅದೇ daughter has committed suicide.
ಆಯ್ತು, ಡಾಟರ್ ಯಾರ್ ರಿಲೇಷನ್ ಕರೆಕ್ಟ್ ಆಗಿ ನಾನು ಕೇಳ್ತಾ commit suicide.
ಅಲ್ಲಲ್ಲ,
And then I'll adjourn the matter by 2 weeks.
Son-in-law was employed.
1 minute. Who commits suicide?
Complainant's daughter.
Complainant's daughter. Son-in-law was employed in agriculture.
He had borrowed.
Why did the daughter commit suicide?
That is the question.
ಅದೇ ಹಂಗ ಟ್ರಯಲ್ ಆಗ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ. That is the problem. ಅವನು suicide ಮಾಡ್ಬೇಕಿದೆ. ಅವನಿಗೆ ಫೋನ್ ಮಾಡಿದಾಗ she has committed suicide. That is the allegation.
How are you involved in this?
Kindly come to page 60.
How are you involved in this?
ಅಲ್ಲ. They say that one of the lenders ಅಂತ. One of the lenders. My lord, kindly come to page 16 ಅಲ್ಲಿ ಕೆಳಗಿದೆ. Last four.
This is not the way. Give it. Yes. You should be fast. List day after tomorrow in the fresh matters. Records ಕೊಡಿ. Next.
55.
In the meantime.
56.
55 ಇದರಾ ಇಲ್ವಾ? Yes. Next.
56.
Entry ಮಾಡಿ. ಆಯ್ತು ಸರ್ ಕೊಟ್ಟಾಯ್ತು. Next. 143A.
The relevant magistrate has rejected the application and the.
I know. Emergent notice to the respondent.
Another petition your lordship granted after service of notice.
Correct.
Same petitioner.
ಅವ್ರು ಬರ್ದೇನೆ ಕೊಟ್ಟಿದ್ದೀನಾ?
ಇಲ್ಲ ಬಂದೆ ಅವ್ರು appear ಆಗಿ
ಬರ್ಬೇಕಲ್ವಾ ಈಗ? ಬರ್ಲಿ. Yes.
May be permitted to serve the copy on the advocate.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Yes.
Date ma'am.
All right. List on 24th in the fresh matters.
Please.
Yes.
57.
Same order. Same order. 58 to same. No representation list after 2 weeks. 2010 CC. ಈಗೇನ್ ಮಾಡ್ತಾ ಇದೀರಾ?
It's a PCR, my lordship.
So what? 2010
It's
PCR.
a matter settled, my
ಎಲ್ಲಿದೆ? Where is the settlement?
The endorsement is there, my lordship.
Settlement memorandum. Where is the conditions of settlement? Where is the settlement?
There is only endorsement there issued
Give
by
the settlement copy. Get complete records. I'll take it.
So that is
No, I'm not saying the endorsement. You should give me the settlement.
That is only settlement letter is there, my lordship. I produced.
Where is the memorandum of settlement? Before whom did you settle? Which court did you settle?
Before not court, that is before the parties, the matter was settled. Prior to this complaint.
Where did you settle? Where are the conditions, terms of settlement? 2010, the sarido.
House.
Yes. List the matter.
There is Annexure A, my lordship. There is a page number 14.
Get the complainant. Get the complainant. We will hear and then see if settlement is there. We'll close it. Petitioner shall serve on the complainant.
There is a page number 14, my lordship.
No, sir. ನೀವು ಇದೀರಾ? Respondent.
No.
The next matter.
ನೀವು ಪಾಸ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಆಯ್ತು ಸರಿ.
The fresh matter, my lordship.
Fresh matter, correct. Emergent notice to the respondent. Next.
Obliged.
Time for petition.
I am per respondent number 2.
Keep it to emergent notice, sir.
There is an entry matter subsisting in this matter.
Why did it get posted then?
I am per respondent number 2.
Vacating stay ಹಾಕಿದ್ದೀರಾ sir?
They have not filed, they are yet to file their response, my lords.
File your objections.
Investigation ಹೇಳಿದ್ರು ಸ್ವಾಮಿ ಗವರ್ಮೆಂಟ್ ಇವರಿಗೆ.
ಇರ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್, ನೀವು objections ಹಾಕಿ. List the matter on 24th September. Objections, if any, by the respondent by then. Interim order subsisting will continue till the next date of hearing.
Great.
61.
Yes, get the investigation papers.
So it is submitted, my lord, in this matter.
Is there ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ, sorry. Yes. No representation on behalf of the petitioners list after 2 weeks. Registry is directed not to list the matter prior to the expiry of 2 weeks. Next.
62.
Same order.
63.
Case number 1 and 2 before this honorable court, my lords.
Hello, what are the two crimes?
My lords, he has filed two other private complaints before this very same court.
This is PCR of 2013. Which are the other crimes?
Other crimes, my lords, at page number 176 and 182, my lords.
At what stage they are?
My lords, this honorable court stayed the further proceedings in this.
Number kodiyadalla.
My lords. 1352 of 2023 and.
Birth kodi, sir.
Please.
ಎರಡರಲ್ಲೂ stay ಇದೆಯಾ?
ಎರಡರಲ್ಲಿ ಇದೆ.
The learned counsel for the petitioner. The petitioner accused number 1 is before, petitioners accused 1 and 2 are before this court calling in question proceedings in CC 50 of 2015. Though the matter is of vintage today, what merits entertainment is the projection of the petitioner that the present crime is the third in line, two of which are registered before the very same court and both of which are stayed at the hands of this court in so and so. Tag this petition along with so and so. There shall be an interim order of stay of further proceedings for the proceedings in CC 50 of 2015 till the next date of hearing. Emergent notice to the respondent.
Notice servagide Swami. Yes, represented.
Idara?
Idar.
Illidare. Charan Kumar. Anyway, no representation. We have the respondent and Bardu. Ameli order ಮಾಡಿ. Next.
Oblige.
54.
ಎಲ್ಲಿದೆ ಕರ್ನಾಟಕ ರೇಸ್ ಬೆಟ್ಟಿಂಗ್ ಇಲ್ಲದೆ ಇರೋ ಸೆಕ್ಷನ್ ಎಲ್ಲ even charge sheet is filed. What do you file?
Yes,
Mysore race betting act is okay. Karnataka race betting ಎಲ್ಲಿದೆ? That is repealed.
Your stay is there, my lord, day after tomorrow.
List the matter on 24th in the fresh matters. This interim order subsisting shall continue to the next date of hearing.
65.
306 and 120 B, my lord. 306 and 120 B.
Correct.
The complaint allegations is, my lord, at page number 21.
506 part 2, sir. 306 and 506 part 2.
Yes.
The records have been submitted, my
You
lord.
have to file discharge. No question of interference.
That there is no allegation against the petitioner, my lord.
Anything else? We'll only adjourn it if you don't. Yes. No stay. Yes, sir.
Notice may be issued.
1 HCGP 2 emergent notice. Pendency of this petition will not come in the way of further investigation or proceeding. Return the papers. Next.
66.
Kindly pass over, Lord. Senior is on his legs in Court Hall 4. Kindly pass over.
Interim order in Kodala, sir. 7A.
But there is a prima facie material, Lord.
So, ಎಲ್ಲದರಲ್ಲೂ prima facie material ಇಲ್ವೇ ಇಲ್ಲ.
Kindly pass over.
Yes, list on 20th in the fresh matters list. Next.
67.
In this matter, I appeal for the petitioner. Not the respondent, not the executed a shielding.
Yes, sir.
For rupees 2 crores 10 lakhs. Not 90 lakhs has been not transferred to RTGS.
Yes, sir.
Not remaining 1,20,000 was remaining. Not he has issued, not the petitioner herein has issued being a equity, not he issued six checks, not which spread over to 6 months for not the payment.
All right.
2 payments were made, not
All right.
other not 4 checks, not so what happened, not when I went to the possession, not his wife and children came and locked the house, stating that they are having the right over the property.
Oh.
Immediately, my lord, she approached the High Court of Bombay, my lord, judicature, for my lord, the seeking for declaration and my lord, for my lord, removing the lock and up. My lord, he came from my lord, Bombay to my lord, the Coorg. My lord, filed a my lord, initiated my lord, the check bounce case against the my lord, the petitioner herein, stating that my lord, he had issued a check. My lord, since my lord, the matter is pending before the my lord, the Bombay High Court for my lord, the adjudication. Not here, not during the pendency of not the proceedings. He died, not his second wife, not continued with the proceedings. Not I have sought for not the stay.
Get the respondent.
Not here, not this is not clear case. May I take page number 21, not
counsel for the petitioner to serve on the counsel who represents the respondent. No stay, sir. Counsel for the petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect. List the matter on 20th in the fresh matters list.
There are 4 checks, not 4 petition numbers are there, not so I will give. All are not ready for only 2 today, not it is listed.
Move it, yes. ಇವತ್ತು ಒಂದೇ ಇರೋದು.
ಅಲ್ಲ 2 ಇದೆ ಸ್ವಾಮಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 73 ಇದೆ.
ಆಯ್ತು ನೋಡುವ.
And other 2 are.
Yes, next.
68.
The respondent wife in the aforesaid circumstances entertainment of the petition is not warranted, disposed, reserving liberty to the petitioner to urge all the contentions before the concerned court. Next.
69.
The matter has been stayed against accused number 193.
Recovery of money, give it. Yes. Tag this petition along with so and so. Counsel for the petitioner submits that this court has granted an interim order of stay. The co-accused. The order reads as follows. In that light, there shall be an interim order of stay with the present petitioner as well. 1 HCGP to emergent notice, tag the petition. Next. Obligement.
70.
The accused, please, my lord, coordinate bench has stayed against accused number 7, producing the order copy, please.
But you are what accused, sir?
My lord, I am accused number 2, please, my lord. Accused
Exactly.
number 1. Accused number 1 is my wife.
stay ಮಾಡಿರೋದು ಆ ಕಾರಣ.
Allah, accused number 1 is my wife, please, my lord.
Exactly.
Exactly, please. What happened? What has happened, please, my lord? Just because she is being my wife, my lord, she has access to my laptop and the internet connection, please, my lord, where the petitioner, this petitioner is being.
Get the complainant, sir.
Please, my lord. Complainant is the RTO, please, my lord, the investigation. And more so, please, my lord.
Direct record.
In the complaint, my lord, in the complaint, he would refer, there are 386 illegal transaction, please, my lord. But in the.
stay ಮಾಡಿರೋದು different ground.
Allah, in the computer, my lord, in the FSL report, they would only show 40 transaction, please, my lord. In the further statement of the complainant also, it reflects only 40 transactions. He would further state. My lord, the remaining, please, my lord, is something fishy, please, my lord. The complainant, in order to, please, my lord.
Will issue notice.
My lord, my submission, please, my lord. He is, my lord, he is on his wife, please, my lord, as the allegation in the charge sheet in column number 17 it would only reflect his wife role.
Correct.
My lord, just because, please, my lord, I am an husband.
Can you give up your wives?
My lord, Allah, that is it there, please, my lord. What has happened, please, my lord? She used.
Stay ಮಾಡ್ತು. Come to page 66 and 67. ನಿಮ್ಮ ಮೇಲೆ ಏನಿದೆ ಅಂತ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. ಎರಡನೇ ಆರೋಪಿ ಒಂದನೇ ಆರೋಪಿಯ ಗಂಡನಾಗಿದ್ದು ಸೋ ಅಂಡ್ ಸೋ.
Please, my lord.
Yes, sir.
Allah, that, my lord, what they would. My lord, ಅವನಿಗೆ ಪ್ರೋಸೆಸ್ ಸಹ ಬರೋದಿಲ್ಲ. ಅವನು is not a technician, qualified technician, my lord. In order to, my lord, that is the reason.
You don't know, sir. Yes. Learned HCGP is directed to accept notice for the respondent.
My lord, date, if I may request, please, my lord.
Just on 30th.
My lord, HCGP to take.
ಅದು ಹೇಳಿದ್ನಲ್ಲ. Yes.
71.
The petitioners. Applied under section 406, 506, 420, read with 10 of Immigration Act.
And Mohan has come this side. Yes. Stayed, yes.
Prepare for the petitioner, my lord.
52.
Prepare for the petitioner.
ಆಮೇಲೆ I am for petitioner ಕೇಳಿಸ್ತೀವಿ.
I am challenging the crime number 237
ಆಮೇಲೆ
ಇದರಲ್ಲಿ 13 days ಡಿಲೇ ಇದೆ. ಅಷ್ಟರಲ್ಲಿ ಇನ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ
petitioners are before this court calling in question proceedings in so and so. On an incident that happens on 17/6/2024, the petitioners register a crime against the complainant on 17/6/2024 itself in crime number 221 of 2024. Long thereafter, as a counterblast on the same incident, verbatim similar complaint is registered against these petitioners by the respondent, complainant and others, which becomes a crime in crime number 227 of 2024. For it having been registered on 29/6/2024 without a speck of explanation for the delay of 14 days. Generally, delay of 14 days would not be fatal since the present crime registered against these petitioners is a counterblast. I deem it appropriate to stay further proceedings with these petitioners till the next date of hearing. 1 HCGP to emergent notice.
73.
ಇದು ಸೇಮ್ ಯಾವತ್ತು ಹಾಕಿದೀವಿ ಅದನ್ನ 20th ಲಿಸ್ಟ್ ಆನ್
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್.
ಹ್ಞೂ ಸರ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್. ಮೇಡಮ್ ಯಾವ್ದು ಇವ್ರದ್ದು 6 ಇನ್ನೊಂದು ಯಾವ್ದು ಪ್ರಭೋದು 67 and 73. Tag them and list them. Yes, next.
24.
Jambu Bandari. Yes. We'll dispose it.
There are two other connected matters. 77.
Buy one get one free ತರ ಆಯ್ತು.
Allah, Milats have already granted stay in that matter.
Which is that?
7730 and 7733 of 2020.
Memory is not strong, sir. So right and give.
Yes,
yes. They tag this petition along with so and so. There shall be an interim order of stay of so on. We'll list them all and close them.
Certainly.
List on 20th.
75.
My lord, in this case.
Only if charge is not framed, I will grant stay on that condition.
My lord, kindly peruse the page number 109.
Charge frame agilla andre matra stay ಕೊಡ್ತೀನಿ.
charge framed, but she is living with another person with 2 children.
That's a matter of trial. ಅದು ಏನು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ 4 to 7 ಮಾತ್ರ ಕೊಡ್ತೀವಿ. Because 4 to 7, 69, 62, 68 years. ಅದಕ್ಕೆ.
Even though trial court is compelling to all the accused present.
No, compelling ಅಂದ್ರೆ all the accused persons ಹೋಗ್ಲಿ.
My lord, 1 year back, she itself filed a memo before the trial court in the.
ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Kindly,
If charges are framed, I will not interfere. But ಆದ್ರೂ 4 to 7, they are all 65 years. ಅವ್ರ ಮೇಲೆ ಏನೂ ಇಲ್ಲ. ಇವ್ರ ಟೈಮಿಗೆ ಬರಲ್ಲ.
My lord, in last 1 year, she appeared only 1 day.
No, I will direct the trial court to conclude the trial within a time frame.
My lord, kindly please 109, my lord, please, my lord. That memo filed before the trial court in 676 of 2018 at the DV Act matter, Your Honor. In that memo, she stated that Sadari Arjali ಆರೋಪಿಸಿರುವ ಆಪಾದನೆಗಳು ನಿರಾಧಾರವಾದವುಗಳು. Same complaint in this case also, Your Honor. In 498 case also in the same allegations, which have alleged in that.
We'll see, get the complainant. 1 HCGP2 emergent notice returnable by 26th.
Please.
26.
ಇದು ಅಷ್ಟೇ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ?
Allegation of 506.
Before filing of petition or after? 506 is not the problem. 509.
9.
Yes.
The only on the reason that my lords cursed anta heli. Cursed.
Whatever. 509 is the problem in this case. 506 is okay.
When we go through the complaint and charge sheet.
1222, my lord.
No, madam.
My lords, here, my lords, only the reason why the 509 has been included, my lords, allegation is that cursed that due to your attitude, your son is suffering. So that is the reason. Only this, my lords. If you go through,
why did you not approach the court? Now the matter is at trial. 506, yes.
It's like, my lords, the process itself, my lord.
Yeah, I've been closing petitions. I will direct the court to conclude the proceedings within 6 months.
This is first time it has come, my lords.
So, first time I dismiss it.
The complaint itself.
Otherwise, you want to settle with the complainant, you settle. If she is prepared to settle, because 6 ವರ್ಷ ಅಲಿಸಿದಾರೆ, ಅದಕ್ಕೆ ಏನಾದ್ರು ಸೆಟಲ್ ಮಾಡ್ಕೊಂತಾರೆ ಮಾಡ್ಕೊಂಡು.
ಅದು
ನೋಟಿಸ್ ಮಾಡ್ತೇನೆ ಅಷ್ಟೇ. Only for the purpose of settlement, otherwise will not come in the way. The 1 HCGP2 emergent notice returnable by 30th. If she comes forward for settlement, we'll see.
27.
OS number ಏನು?
995/2000.
The petitioners who has instituted complainant.
Petitioners here.
The petitioners have instituted OS
995/2017.
So and so. Immediately thereafter springs the impugned crime. In a matter that is purely civil in nature, criminal law cannot be permitted to be set into motion. Therefore, there shall be an interim order of stay. Next.
8.
CC 2018. ಏನಾಗಿದೆ ಈಗ? ಇಲ್ವಾ? ಗೊತ್ತಿಲ್ವಾ? CC of 2018, discharge rejected on November 2020. Petition filed on 10 July 24. Harish Pandari, ನಿಮ್ದೇ ತಾನೆ?
ಹೌದು.
ಅದೇ ಡೇಟ್ಸ್ ಹೇಳ್ತಾ ಇದೀನಿ ಅಷ್ಟು, ಬೇರೆ. So dismissed. Anything else? Not a case for stay at all.
Yes, Lordship, because A2, Your Lordship kindly referred to Your Lordship. He was only the representative, Your Lordship.
We'll see. 1 HCGP2 emergent notice.
Representative is the different than
next.
29.
Petitioners, my lords, husband's petition. Please, my lords.
File discharge.
My lords, there are no grounds made out, my lord.
Yes.
Kindly, my lords may kindly see on 16th.
Please, sir.
23, my lord.
Page 44 ಅಲ್ಲಿ second paragraph ನೋಡಿ sir, unnumbered. Yes.
My lords, to that my explanation is this, my lord.
Explanation trial.
Notice may kindly be issued, my lord, late.
But you have to better file discharge.
Notice may kindly be issued, my lord.
1 HCGP 2 emergent notice. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
80.
For the petitioner in this matter, my lords, petitioner is a coffee estate owner. Correct. In Kodagu.
RFO is the complainant.
Please, my lords.
Yes.
The course of action is that, my lords, on the date of incident, my lords, a herd of elephants enter the petitioner's property. They start vandalizing the property because one elephant, my lords, was carrying and it gave birth to its calf. My lords, naturally, it starts clearing a certain, the yield of the petitioner gets vandalized, my lords. My lords, he calls the forest officials, forest department. The respondent number 2 comes almost 8 hours after him calling.
As usual.
By then, my lords, please, that is the reason, my lords. The petitioner threatens him to file complaint.
Allegation is the
Allegation is the page 23.
Well, the allegation is there. The only material record, the only material record is a phone set.
Learned HCGP is directed to accept notice for the respondent. Ibru, respondents.
Yes.
Next.
My lords, framing of charges is on 310. My
No
lords.
problems. Yes.
51.
Same order earlier. Interim orders ಅಲ್ಲಿ ಕೊಡಿ. Tag this petition along with so and so. Same order.
Petition number 2 to 7 are the in-laws, my lord.
Correct. Accused number 1 and accused number 4, I will not grant. Others I will grant.
4 is the sister.
No. You look at the allegations against her.
Please.
Wherever I will grant. The petitioners are accused 1 to 7. Have knocked at the doors of this court calling in question proceedings in CC 16685 of 2024 registered for offence punishable under section 498A 504 506 149 of the IPC. A perusal at the complaint, the summary of the charge sheet would clearly indicate offences against the husband and certain offences against the accused number 4, the sister-in-law. Que other accused, there is not even a sprinkling reference to overt acts committed by them for it to become an offence as alleged. Therefore, except accused number 1 and 4, there shall be an interim order of stay que others. It is made clear further proceedings before the concerned court are not stayed. Que accused number 1 and 4 and the same shall continue. List 1 HCGP 2 emergent notice.
Public.
Next.
83.
The petitioners, man. It's accused number 4, man. 306. Accused number 8, 9, and 10, they granted stay by this law. Interim order 4, accused number 8, 9, and 10.
You are what, sir?
Accused number 4, my allegation that, my lord, 11 months before, my lord, he has completed work. My lord, I have asked for the bribe.
Page 44, sir.
44 is the interim order, man.
We'll tag with that, sir.
My lord, in the allegation,
Same order, sorry. Page 54 order.
2 petitions.
ಇನ್ನೊಂದು ಯಾವುದು?
Page 43.
43 and 44. Tag with those. Same order, interim order. Next.
84.
Charge sheet is filed, my lordship.
For petition.
Even otherwise 376 to not a case for interference at all.
The consent, my lord.
No, you consent? No, sir.
The contents of the complaint shows that, my lord,
not in
the
this
incident
case.
happened in the September 2023, my lord. Complaint has been filed, my lord, February, my lord.
No, it was not a consensual act at all. Yes.
Please, my lord.
No, sir.
Consensual, my lord, because, my lord.
Charge sheet file ಮಾಡಿದ್ದಾರೆ ಚಾಲೆಂಜ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಇಲ್ಲ I will give my finding, no problem. I'll post it now, not now. Tomorrow I'll post it and give my finding.
I'll
Charge sheet
the
challenge
charge.
ಮಾಡಕ್ liberty ಕೊಡು. Yes. Charge sheet format.
85.
Petitioner in this case. 504, 506 and 307.
ಏನು ಚಿಕ್ಕದು ಹೇಳಿ ಆಮೇಲೆ ದೊಡ್ಡದು.
Husband and wife.
7, sir.
The matter has been settled. Joint affidavit.
Husband and wife.
Is present. Parties are present.
Yes, government. Husband and wife 307. What did you do for 307?
ಮಗು ವಿಷಯದಲ್ಲಿ ಏನೋ ಗಲಾಟೆ ಆಗಿ
Where is the member? Where is the settlement?
Charges are framed, my lordship. Charges are framed.
So what? Settlement ಅವಾಗಲೇ ಆಗಕ್ಕೆ ಸರ್.
Page number 7, man.
Page number
7
of what?
Petition. Joint affidavit.
Joint petition.
Affidavit has been ಇಲ್ಲ. Joint affidavit has been.
Where are you from?
Devanadi's matter. They are from Nepal.
Nepal. They are from Devanhalli.
The matter is pertaining to them.
Yes. ಯಾವ್ದ್ರ ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಅದೇ ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಅಷ್ಟೇ. ಅದರಲ್ಲಿ
ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್
ಪೇಜ್ ನಂಬರ್ 7 ಮೇಲೆ ಆಫ್ ದ ಪಿಟಿಷನ್.
ಪಿಟಿಷನ್ ಹಾಕಿರೋದೇ ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಸರ್. The petitioner is the husband. The second respondent, his wife. The two had a squabble, and the squabble led to registration of a crime in crime number 47 of 2022 for offense punishable under section 307, 504 and 506 of the IPC. During the pendency of the petition, the parties to the list have resolved the dispute amongst themselves and have filed a joint affidavit through this petition, seeking compounding of the offense. Since though the offense is the one punishable under section 307 of the IPC, which cannot be quashed by way of by way of acceptance of a settlement, since the issue is between the husband and the wife, and the complaint not meeting the ingredients of section 307 of the IPC, I deem it appropriate to accept the joint affidavit, compound the offense, and give a quietus to the proceeding. In that light, for the aforesaid petition, the following order: disposed, quashed.
Great.
56.
Disaster management 51B in the meantime. Next.
87.
List the matter for admissions. Intermodal ideyala. ಮತ್ತೆ
R2 undertaking.
Learned counsel heard the learned
Grant 2 weeks time to file occur.
Heard the learned senior counsel G. Krishnamurthy appearing for the petitioner. The learned counsel so and so undertakes to enter appearance for the respondent and would seek 2 weeks time to file statement of objections. List the matter on 26th. Interim order subsisting shall continue to the next date of hearing. Yes, sir.
Section of application 456, my lord, were before the court. Lord, the
notice.
Emergent.
Emergent. All right.
3, my lords.
In the meantime, till the next date of hearing, list the matter on 24th in the fresh matters list. The learned HCGP to secure the investigation papers till date and place it before the court. Next.
90.
For petitioner.
90. In the meantime, next.
So, connected matter.
Could you tag the petition along with so and so in the meantime? Page 43.
My last, may kindly look into the wound certificate.
Simple in nature.
No, there are no external injuries. And
there is
also,
a wound.
Last, may kindly refer to page number 42, my lord.
In the meantime, yes.
Please.
Next.
92.
CC of 2019.
Yes, my lord. Petitioners accused number 4, my lord. Accused number 1, 2, 3 and 5 have been acquitted by the trial court.
Acquitted, huh?
Yes, my lord.
Split charge.
Yes, my lord.
Then we'll day after tomorrow in the fresh matters list.
Oh, bless.
Next.
Proclamation is issued against the accused.
Then go appear, sir.
And charges are
Lord.
paid on.
That's all right. Split charge will charge free. Proclamation.
Yes, my lord. Because my lord, complainant have not again have filed 2 more cases. My lord, are filing PCR
I will
again.
see on Wednesday.
Oh, bless.
Next.
93.
Notice only.
On my lords, earlier there's a stay, my lord, of the
In
FIR.
which? What is-
In the very same matter. Annexure M may kindly be seen. In
Page.
Annexure M, page 322. Lord, interim order at page 324. Further investigation was stayed.
1 minute. Sir. Even then they filed charge sheet. Huh?
Yes,
320.
324.
The counsel for the petitioner takes this court through an interim order granted by the coordinate bench dated 14/12/2023, eque the same petitioner. The contention is that in the teeth of the subsistence of the interim order, charge sheet is filed by the jurisdictional police. In the light of the aforesaid reason, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. 1 HCGP 2 emergent notice.
94.
For the petitioners, my lord. The petitioners are accused number 2 and 3, my lord. The first accused was working with working as a manager in the jewelry shop of R2.
Correct.
But these petitioners are nowhere concerned in there. The petition number 2 is residing in Bangalore. That is is working as a software engineer. It has nothing to do with the transaction in between accused number 1 and R2.
1 HCGP to emergent notice.
Date.
No.
Let the
Early, 26th.
Let them point out. Material.
Let the complainant come, he will point out. Yes.
ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ತಾವು
26th, sir. Yes. Emergent notice returnable by 26th, list on 26th and the fresh matters list. A2 and A ಇದರ 96 ಗುಹಾ. ಈ ಕಡೆ ನಿಮ್ದೆ ಬನ್ನಿ ಸರ್. Yes. A2 and A3 in the main, ಇದು ಕಾಶ್ಖಾನ್. Yes, next. 84 ಯಾವ ಕೇಸ್ ಒಂದು ನಿಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ.
948460.
94 94 Yes. 97 ನಡೀತಾ ಇದೆ. 96 ನಿಮ್ದು ಓದಿಲ್ವಾ? ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ರಾ? ಈ ಕೇಸ್ ಓದಿಲ್ವಾ? ಎಸ್, ಸ್ಟೇಡ್. ನೆಕ್ಸ್ಟ್
97. I am referring to the petitioner.
Maintenance ಎಷ್ಟು ಇದೆ arrears?
That maintenance was stayed by this court, that in connected matter.
ಆಯ್ತು.
8,000 was ordered.
What is the arrears today?
Arrears is that already that application.
Don't beg the question, sir. Direct answer. Arrears ಇದೆಯಾ ಇಲ್ವಾ?
There is no arrears.
No arrears.
Because of that, in the divorce petition was already granted.
Arrears ಇದೆಯಾ ಇಲ್ವಾ?
Arrears ಇದೆ sir. But that was stayed by this court in connected.
Arrears ಎಷ್ಟಿದೆ?
Yes, I will not calculate that.
1 lakh ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ? I will stay
at 50,000.
ಅದೇ ಬಾರ್ಗೇನ್ ಇಲ್ಲ.
Because of that, there is no marriage relations between the petitioner and
ನೋಡೋಣ, ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತೇನೆ.
that divorce petition, decree of divorce has been granted.
See sir, you deposit before this court. Because you are in huge arrears there. Yes, the
50,000.
Emergent notice to the respondent returnable by the 30th of October. List the matter on 30th of October in the fresh matters list. There shall be an interim order of stay as prayed for, subject to the condition that the petitioner would deposit 75,000 before this court by the next date of hearing. Yes.
50,000. Make it 50,000.
No sir, won't make it.
No work at all.
No making it. Yes.
It is heavy. 50,000.
Sir, in bargain.
No
1.5 lakhs then. I'll make it 1 lakh. Yes, next.
8 for the petitioner.
98
minutes.
CC of 2015, sir.
I'm challenging an order, my lords.
What order?
Witnesses were dropped, my lords. If my lords were to peruse order dated 13/9/2023, my lords. Ink page.
Yourda. Ade. No, that is different. That will stay the maintenance.
Ink page 58. Ink page 58, my lords. Even though issuance of notice and proclamation, my lords, CW 1 and 2 does not appear. CW 1 and 2 are dropped from this case. Issue summons to CW 3 and 5, my lords.
Why you did not appear?
No, I am for the accused number 2, my lords. CW 1 and
2 have not appeared.
Yes, my lords. Thereafter, on an oral request, my lords, without an application at a 311, my lords, court recalls them and examines, my lords. On 18/6/2024.
What's the prejudice cost to you, sir?
No, without an application, I have not been granted an opportunity, my lords.
311 application irrelevant.
Hakilla.
Those witnesses had been discharged?
Yes, dropped, my lords.
Dropped. Heard the learned counsel appearing for the petitioner. The petitioner calls in question an order dated 18/6/2024 passed by the concerned court, allowing an application under section 311 of the CRPC. Permitting CW
1 and 2, my lord.
1 and 2, who had been dropped on account of them not cooperating with the trial, to come back as witnesses without any application being filed. There appears to be a procedural aberration till the respondent, complainant error.
Complainant is de facto respondent number 2, my
lord. Till the state would go through the papers and make submissions, the order dated 18/6/2024 shall remain stayed. It's made clear for the further trial is not stayed at the hands of this court. List on 25th on the fresh matters list. Next.
99.
My lord, 406 and 420. Petitioner is accused number 4, my lord.
ಆಯ್ತು, ರಿಟರ್ನ್ ಮಾಡಿ 2.13 crore.
ನಾವು ಇಸ್ಕೊಂಡಿಲ್ಲ, ನಮ್ಗೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್
ಇಸ್ಕೊಂಡಿದ್ದಾರೆ.
ಅವರು 1 and 3
ಅವರೇ ಬಂದು ಹೇಳಿ ಯಾರು
ಅವ್ರು ಹೇಳಿದಾರೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿದೆ?
ಹೇಳಿ ಸರ್. Page number 14, my lord.
You are accused number 1, sir.
4, my lord. I'm 4. Sorry, my lord.
4. Nim cost title nodi.
Sorry, my lord. 4.
Hagadre will stay proceedings against accused number 1.
4, my lord.
In the meantime, proceedings shall remain state quay accused number 1. ನೀವ್ ಹೇಳಿರೋದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Sorry, accused number 1.
ಅದಕ್ಕೆ ರೆಕ್ಲೆಸ್ ಆಗಿ ಹಾಕ್ಬೇಡಿ.
Sorry.
Yes. Correct ಮಾಡಿ. Quay accused number 4. The petitioner. Next.
100.
For petitioner. That is offense is in 324, 332.
Case for settlement actually. Yes, anyway.
He is in advocate also, Your Honor. Petitioner, she is advocate.
One
Same thing.
emergent notice, one HCGP, 2 emergent notice. Returnable by 26th, there shall be an interim order of stay of further proceedings quay the petitioner till the next date of hearing. Yes, settle ಮಾಡ್ಕೊಳ್ಳಿ.
Definitely.
It's a case for settlement, yes. 1.
As for the
Yes.
petitioner in this case, my lord, 304A, my lord, accused.
A1 ಗೆ order ಮಾಡಿದ್ರಲ್ಲಿ.
A1 is already.
Where is the order?
My lord, I produced it in page number 94, my lord. Settlement was arrived, my lord, and this is accused number 3 and 4. They have only been made as parties only as the site manager and he was the manager and the other one was a
Page
site engineer.
93. Page 93. 93 ತಾನೆ?
94 ಅಲ್ಲಿ ಇದೆ.
93 ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
Apologies.
ಅದು ಯಾವ accused?
Accused number 1 was FIR was quashed against accused number 1.
Quay accused number 1. This court quashed the proceedings. Again, accused number this court quashed the proceedings on account of a settlement arrived at between the parties. In that light, the petitioner being accused number 2 and 3.
3 and 4.
3 and 4, who are site managers and who had nothing to do with the alleged site manager. Nothing to do ಹೆಂಗಾಯ್ತು?
Site engineer.
Accused number 1 ಯಾರು? What was accused number 1?
He was the CEO, my lord. He was the CEO of the company along with MD, managing director.
Yes, government.
The allegation is only with respect to A2, my lord. That
A2 ಯಾರು?
JCB operator ಅವರೇ ಮಣ್ಣು ತಗೊಂಡಾಗ ಹಾಕಿರೋದು ಅಂತ ಹೇಳ್ತಾರೆ. Only with respect.
ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸೈಟ್ ಮ್ಯಾನೇಜರ್ ಆಗಿ? You are responsible.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು A3 ಮತ್ತೆ A4 ಇರೋದ್ರಿಂದ ಅವರದ್ರಲ್ಲಿ ಅದು is not at all related as on that day.
Will not dispose it.
ಅಲ್ಲ
The emergent notice to the 1 HCGP 2 emergent notice returnable by the 30th of October, list on 30th of October in the fresh matters list. Till such time further proceedings quay the petitioner shall remain stayed.
102.
Yeah, for petitioner merge.
4 accused 2 to 6 Kashkan. Big. September 30. Not 3. Notice.
103.
ಇದು ಯಾರಿಲ್ಲ ಬಟ್ ನೋಟಿಸ್ ಟು ದ ರೆಸ್ಪಾಂಡ್ ವಿಕ್ಟಿಮ್. ಎಸ್ ಸೇಮ್ ಆರ್ಡರ್ ಕೊಡಿ.
Victim's petition.
ಅದಕ್ಕೆ ನೋಟಿಸ್ ಮಾಡಿದ್ವಿ. ನೋಟಿಸ್ ನೀವು ನೋಟಿಸ್ ಅಥವಾ ಬೇಕಾ ಯಾರಿಗಾರು ಬೇರೆ?
She has challenged the PW 19 ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ ನ ಮಾರ್ಕ್ಸ್ ಮಾಡಿ ಮಾರ್ಕ್
ಒಂದು
Certain documents were seized under a major.
All right.
Notice to second respondent. Second respondent in custody. I may be permitted to serve notice on the counsel representing the second respondent.
Counsel for the 103 ಅಲ್ಲಿ 1 HCGP 2 emergent notice. The second respondent is said to be in custody. Therefore, the learned counsel of the petitioner is permitted to serve on the counsel who represents the second respondent. Yes.
Please, ma'am. Great.
Next.
104.
78(3) dispose ಮಾಡಿದ್ವಲ್ಲ ಅವತ್ತು?
ಒಂದು ಮಾಡಿದೆ. ನಾನು 2/9/2024 in criminal petition 8196
ಬರ್ಕೊಡಿ.
ಬರ್ತೀನಿ.
Disposed. Next. Rajendra Reddy.
105.
Offense punishable under section
304. ಅಲ್ಲ negligence. Lineman. No. Yes, 1 HC.
There is
Complainant ಯಾರು?
some defect of complaint.
1 HCGP 2 emergent notice. Next.
6.
Non-signatory to the check. In the meantime, emergent notice to the respondent. Next.
107.
Already the connected.
192 year.
Connected but stay ಆಗಿದೆ.
Tag this petition along with so and so. The light of the interim order subsisting in the companion petition, there shall be an interim order of stay in the case at hand as well. Next.
Then 8.
The APA for the petition about dispute between family members. I filed a complaint my mother and brother file a counter complaint. That counter complaint, your lordship has stayed.
Yes, give it. Heard the learned senior counsel Pramod Nair appearing for the petitioner. The dispute is between the members of the family. It is a case and a complaint and a counter complaint. In the counter complaint, this court has granted an interim order of stay in terms of its order dated so and so. 24/6/24. The interim order reads as follows. In the light of the interim order granted, the counter complaint, there shall be an interim order of stay in the case at hand as well. There's a matter for settlement, settle it.
It is, my lord.
Yes. Tag the petition with so and so, list on 30th September. Yes.
109.
498A.
Charge sheet has, CC number has come, my lordship.
Even otherwise, only 4 to 8, 2 and 3 illa. Challenge ಮಾಡ್ಬಿಡಿ. Yes, charge sheet file ಆಗಿದೆ format. Yes, next.
110.
and 498.
Accused number 13.
Yes, my lordship.
ಏನು ಇಲ್ವಾ?
Before registering FIR, my lordship, I resigned the job, my lordship.
No, sir.
And pay the entire amount also, my lordship.
See page 28.
Yes, my lordship.
ಅದು ಪೂರ್ತಿ ನಿಮ್ದೇ ಗುಣಗಾನ ಇರೋದು.
Yes, my lordship. But entire amount also paid, my lordship.
Let's see. 1 HCGP2 emergent notice. Next.
111.
Girinagar, same order, madam. Where are those orders?
Please.
ಇನ್ನು ಉಳಿಸ್ಕೊಂಡಿದ್ದೀರಾ?
There are 3 petitions pending, ma'am.
ಕೊಟ್ಟಿಯಲ್ಲ, yes. Give that. Same order. ಅದು 2:30 post ಮಾಡಿಸಿ, ಅದು ಮುಗಿಸ್ಕೊಂಡು. Yes, next.
Much obliged.
112.
Hearing for petitioner, my lord.
A1 ಇಲ್ಲ. ಮಿಕ್ಕವರು ಕೊಡು.
One submission, my lord.
ಹೇಳಿ.
After separation, my lord, the petitioner number 1 filed a petition for divorce, my lord. And the respondent filed a petition for DV Act, my lord. That came to be rejected, my lord. Thereafter filed a PCR, my lord.
All right. List them. 1 HCGP2 emergent notice. There shall be an interim order of stay for the proceedings quay the petitioners. Investigation?
PCR.
So further proceedings before the concerned court quay these petitioners till the next date of hearing. 1 HCGP2 emergent notice. Next.
30.
HCGP ಇಲ್ಲ. ಇದರ? Emergent notice to the respondent. HCGP. 1.
I may be permitted to appear on behalf of the petitioner.
127A. Yes, sir. In the meantime, emergent note. Who appears for the respondent? 113. 113, right, sir?
113, yes.
1 HCGP2 emergent notice. In the meantime, yes, state.
Hello, madam.
114.
Yes, Nishit. Who is the tenant? Who is the landlord?
Brother, my lord. It is between the brother, my lord. 37 years, my lord, after private complaint was filed.
The petitioners are before this court calling in question proceedings, complaint so registered for offence punishable under section 406 and 420. You are the tenant?
No, I'm the brother and he's saying that I'm a tenant. It was written in my wife's name.
The dispute is between the brother, the dispute is between the siblings, and the complaint is registered after 36 years after the alleged incident. Therefore, there shall be an interim order of stay of further investigation. Quay these petitioners till the disposal of the petition. 1 and HCGP2 emergent.
Only one respondent. Private complaint.
Sorry, HCGP. Emergent notice to the respondent. Next.
115.
List on 20th. 13(1)B.
13(1)B of prevention of corruption.
20th. Yes.
116.
ಅದು ನೋಟಿಸ್ ತಗೊಂಡ್ಬಿಡಿ ಲೋಕಾಯುಕ್ತಾಗ. Learned counsel BB Patil is directed to accept ಇದರಲ್ಲಿ ಇದು ಮೇಡಮ್ 115 ಅಲ್ಲೇ. Learned counsel BB Patil is directed to accept notice for the respondent, registry to print the name of so and so is appearing for the respondent, petitioner to serve set of papers upon counsel to BB Patil. Yes, list on 20th.
Petitioners, my lord, please.
Who is in possession?
I am in possession of the property to
In the
establish.
meantime, next.
117.
For appear to petitioners.
Yeah, it's sir.
Please, my lord.
ಅದು YS case ಅವರು CW6 ಮೇಲೆ ಪೆಂಡ್.
117.
117.
Yes, sir.
CW6 ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮಾಡಿಬಿಟ್ಟು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
Page 28, sir.
ಫಸ್ಟ್ ಸ್ವಾಮಿ ಅದು ಆಸ್ ಪರ್ annexure ಡಿ ಸ್ಟೇ ಇತ್ತು ಸ್ವಾಮಿ. ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಕಟ್ತಾ ಇದ್ರು. CW6 ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮೇಲೆ SC/ST ಯಾರು ಅಂತಾನು ಗೊತ್ತಿರ್ಲಿಲ್ಲ ನಮ್ಗೆ. ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಕಟ್ತಾ ಆಸ್ ಪರ್ annexure ಡಿ. ಆಮೇಲೆ ಎಫ್ ಅಲ್ಲಿ ಸ್ಟೇನು ಕೂಡ ಆಗಿದೆ ಸ್ವಾಮಿ ಆಸ್ ಪರ್ CW6 ಮೇಲೆ. ಸ್ವಾಮಿ ಇದಿದೆ ಸ್ವಾಮಿ. ಅವರು ಪಕ್ಕದ ಮನೆಯವರು ಇವ್ರ ಜಾಗದಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಕಟ್ಟಿ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿ ಕಟ್ತಾ ಇದ್ರೆ ಬಂದ್ಬಿಟ್ಟು ಕೇಳಿದ್ದೆ ತಪ್ಪು ಅನ್ನೋ ಮಟ್ಟಕ್ಕೆ ಬಂದೋಯ್ತು.
ಆಯ್ತು ಸರ್. One HCGP to emergent notice. Next. ಬರ್ಲಿ. Yes.
Petitioner, my lord.
2, 3 and 4 in the event petitioners are accused. DV 118 ಅಲ್ವಾ?
118.
DV Act ಅಲ್ವಾ?
FIR already stay ಆಗಿದೆ.
ಆಯ್ತು ಕೊಡಿ. Tag the petition along with
54, my lord.
page 54 ಅಲ್ಲಿ tag the petition. Page 54 of the petition.
Accused number 1 is not in the party.
I know sir. 2, 3 and 4 ಮಾತ್ರ ಇರೋದು. Yes.
54 and 56.
5, 6, all right. There shall be an interim order of stay with these petitioners in the light of the interim order subsisting in the petition filed for an offence, challenging an offence under section 498A of the IPC. Yes. Tag the petition. So on page 53 alwa?
54, my lord.
54. Yes, next.
Then 19.
Representation list after 2 weeks.
20.
Petition number notes.
I may permit to take notice for respondent number 2 here in the.
Even otherwise, forgery is found. Yes.
Please permit.
Learned Counsel K. Chandrasekhar accepts notice for respondent number 2, the complainant. Registrate to print the name of so-and-so as appearing for the complainant. File your objections if you want.
Please, my
List the matter on 20.
Connected matter, my lord.
759
of 2020.
Adal stay idea.
Adal stay.
ಮಾಡಿದ್ದಾರೆ.
Tag this.
But suppressing the fact that, my lord, though there is a.
No, my order.
Yes, my lord.
List the matter on 19th in the fresh matters list. 18th, sorry. 18th in the fresh matters.
19.
No, sir. Why you're out of station?
Out of session. 19.
19th.
19th.
Yes.
Stay ಕೊಟ್ಟಿಲ್ಲ sir.
ಇಲ್ಲ.
121.
Lords appear for petitioners, please, lords.
NCR date in.
Please, lords.
NCR date.
14, please.
14?
14 of 14/2/2024, please, lords.
Third, Learned Counsel appearing for the petitioner. The first crime sought to be registered by the complainant is rendered with a non-cognizable report after consent. Sorry, we were called to the police station. After interaction with the complainant and the petitioners. The second crime comes about before the very same police station and which has become a crime, and second complaint comes up before the very same police station which has become the impugned crime. Therefore, there shall be an interim order of stay of further proceedings with the petitioners till the next date of hearing. 1, 2, returnable by 25th. List on 25th in the fresh matters list. Next.
22.
Civil suit number.
436 of 2023.
On the same cause of action between the parties, the parties are before the civil court in OS number
436 of 2023.
436 of 2023. During the teeth of the pendency of the proceedings, the criminal law is set into motion, which is clearly impermissible in law. Therefore, there shall be an interim order of stay with the petitioner till the next date of hearing.
23.
My lord, question the FIR registered for offence under 420. On the previous occasion, my lord had tendered the complaint. Just an endorsement, my lord.
We'll see. Yes, the papers kodi.
Sir.
We'll take it day after tomorrow in the fresh matters. Kodi, adu kodi. Yes, let's day after tomorrow in the fresh matters list. Next.
124.
Accused number 1 to 3, my lords.
307.
There is no complaints affidavit as 156 clause 3, my lords. And also,
Compliance affidavit. We will get the records. Yes.
no, and also, my lords, are in the
We'll get the records. Yes.
complaint
Learned,
is after 1 year, my lords.
HCGP to secure the investigation papers conducted till date. List on
And also,
Right, Friday, bada. List on 24th, sorry, 18th in the fresh matters list. 18th, madam. 18th, yes. No, nothing is there still.
498
Yes. We'll see, sir. Yes.
125.
For the
In the meantime, next.
Your Lordship, hand delivery may be permitted.
Why?
Your Lordship, the reason is that the second petitioner has gone abroad for studying. He's in the process of securing a job. So when they do a due diligence,
ಅದಕ್ಕೆ ಮಧ್ಯಾಹ್ನದೊಳಗೆ you'll secure a job, is it? By evening you'll get it, madam. Yes. ಎಲ್ಲದಕ್ಕೂ hand delivery ಕೇಳಿ.
we uploaded on the website.
That we'll see, yes.
126.
Lord, appear for petition, my lord. There is a dispute between my lord husband and wife. Lord, in the complaint governments, my lord, my name is my lord Tony.
You are not an accused.
I am not an accused, my lord.
Then why are you before the court? 35(3) notice is issued, summoning you. Appear, sir. Appear.
But there is no allegation, my lord.
All right, sir. You are not even an accused. Why are you before the court on a notice under 35(3) of the BNSS?
But as per the notice, there are ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಸಾಕಷ್ಟು ಪೂರಕ ಕಾರಣಗಳು ಕಂಡು ಬಂದ್ರೆ
ಅಪಿಯರ್ ಆಗಿ ಸರ್, ಪೂರಕ ಕಾರಣ ಕಂಡು ಆಮೇಲೆ ನೀವು ಅಕ್ಯೂಸ್ ಆದ್ರೂ ನೋಡೋಣ.
my request my lord, they are ready to my lord
you don't cooperate ಅಂದ್ರೆ they will arrest.
Blood sample ಕೊಡಿ ಅಂತ ಅವರು. My lord, only single line my lord in the complaint. Entire allegation are ex-husband. ಇವನ್ ಜೊತೆನೂ ಕೂಡ ಸಂಪರ್ಕ ಇದೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಒಂದು ಲೈನ್ ಹೇಳ್ತಾರೆ.
ಎಸ್, ಗವರ್ಮೆಂಟ್ ಬ್ಲಡ್ ಸ್ಯಾಂಪಲ್ ಕೊಡಲ್ವಾ?
ನನ್ಗೆ ನೋವೇ ಬ್ಲಡ್ is not blood.
Yes.
He has to cooperate with the investigation.
Let him cooperate. Cooperate with the investigation. You are not an accused still. I will not interfere.
But
whatever sample they are asking. Yes.
But there is no serious allegation. There is no such allegation against this petitioner. Entire allegation
The petitioner is before this court, even before he is declared to be an accused in a crime, apprehending that coercive steps will be taken against him by the police. The petitioner shall cooperate with the investigation as is directed, as is sought for in a notice issued under section 35(3) of the BNSS. In the garb of investigation, no coercive steps will be taken again till the next date of hearing. List the matter on 24th.
Please.
Yes.
27.
For the petitioner.
19(7)(24) is the crime.
No, there is no crime actually, my lord.
Actually, we'll see later.
Because as per the complaint itself, he doesn't state that we committed any crime.
Yen parayala, it can't be an encyclopedia.
Allah,
Yes.
they have said that even the other petitioners, petitioner number 2 to 6 ಮೇಲೆ ಏನು ಇಲ್ಲವೇ ಇಲ್ಲ sir.
1 HCGP, 2 emergent notice returnable by the 25th. The learned HCGP to secure the investigation papers of investigation conducted till the 24th of September.
Stay I have sought for. Lord, in so far as the respondent number, no, petitioner number 3, Allah, or ಎಲ್ಲಾನು officials, so they have been unnecessarily been dragged.
Yes.
Allah, ಇದರಲ್ಲಿ stay copy put up ಆಗಿಲ್ಲ. That is one thing that has also not come.
Application,
That we have filed it, mother. Reason
ಅವತ್ತೇ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ, ಇವತ್ತು ಇಲ್ಲ. Yes.
ಅಲ್ಲ, last time when it had come up, my lord,
Fourth. Yes. Next.
ಅಲ್ಲ, my lord, because their official work ಗೆ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ. They have been unnecessarily been called to police station.
No problem. Yes. Next.
128.
Petitioner. 13(1)(e).
ಯಾಕೆ ಇಷ್ಟು ಜಲ್ದಿ ಹಾಕಿದ್ದೀರಾ? 2008 proceedings.
They have filed charge sheet in the year 2020.
20? ನೀವು 4 ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ ಈಗ?
No, that's now my discharge application came to be released.
When?
On 18/7.
List on 20th. Learned Counsel B.V. Patil is directed to accept notice for the respondent. Next.
129.
This cashier have granted interim order in identical case where?
My lords,
In identical case of grant and interim order, where is that?
my lords, the principle of Lalit Chaturvedi applied to this. It's a civil dispute. The complainant is filed a civil suit.
192A. That's what I'm saying. Anyway, we should get the orders that I've granted. Yes. So in the meantime, next.
130.
The petitioner, my lords, offenses under 192A, 51 of the Disaster Management Act, 353, 427, 447 IPC, my lords.
In the meantime.
131.
My lords, the allegation is under section 207. I have not answered
the DSGI. You're already on record?
This will be. This
One
may be
ಇನ್ನೊಂದು
tagged
ಇದೆ.
along with 8655 of the
Same.
please.
The learned DSGI Shanti Bhushan is directed to accept notice for the respondent, petitioner to serve set of papers upon the learned DSGI registered the name of DSGI as appearing for the respondent. Tag the petition along with so and so. ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ ನಾಳೆ
ನಾಳೆ ಬರ್ತಾ ಇದೆ.
come up tomorrow.
ನಾಳೆ ತಗೊಳ್ಳಿ. Yes, next.
32.
For the petition, my lord. 132 and 133 is the same incident.
Correct.
Same incident. Only for NOC, they have gone and third person has assaulted, not the petitioner's hearing. Absolutely no allegations, not.
Absolutely no allegation.
So far as the,
But I'll see the investigation papers.
but so far as second petition, you also can consider second petition, my lord. ಅವ್ರು ಅಲ್ಲಿ ಹೆಸರು ಹೇಳದ್ ಬಿಟ್ರೆ ಏನೂ ಹೇಳಿಲ್ಲ. And is a respected senior person, my lord, senior lawyer.
We'll see. Yes.
Well, the only allegation is that, and moreover, my lord, in the second case, 174, my lord, because overall non-cognizable offense. Correct. That's also not complied with.
Yes. No, precisely because you have traveled United Nations Congress,
That,
then
my lord, that,
treatment of offenders in
I
Cuba. ಇದೆಲ್ಲ ನೀವು if I have to digress all this and
that
write,
I will not get into, my lord.
I'll have to hear the other side.
That I will not get into, my lord.
ನೀವು ಇಂಡಿಯಾದಲ್ಲಿ
The offense
ಇದ್ರೆ you have traveled to Cuba also. I know Cuba is
It's a bit excessive on the our part, but I will, you will also kindly ignore that part, my lord.
Okay.
But yeah, offense wise, my lord, no offense as against the petitioners here.
But why did you bring United Nations of offenders?
I will, I know it was, anyway, I have to own the responsibility, which I will do.
All right. Yes, madam, get the investigation papers. We'll take this on Friday.
Very well.
List on third. At the Learned Council, so and so. One learned will not issue notice to the complainant. We'll see the papers and then list the matter on 13th in the fresh matters list. The learned HCGP is directed to secure the investigation papers and place it before the court on the next date.
In both the matters. Same incident, two complaints.
Correct.
Of course, a different complaints, not a.
Yes, sir. Same incident to two different complaints.
Two different first complaints.
Yes.
Yes, members.
Other United Nations, huh?
Anyway, I will not get into the
List on 132 and 133 both. Sir, crime is registered on 21/8/24.
Yes, my lord.
I would see the papers only and then do it.
My lord, the allegation is that, my lord, we have hit the vehicle from behind.
307 and
307 ಹಾಕಿದ್ದಾರೆ. That is the allegation, my lord.
Toll
Page
plaza assault. Allegation.
Allegation is, my lord, page 17, saying that, my lord, the complainant was going in a two-wheeler. He came, my lord, from the behind, that is the accused, and hit him, my lord, in the vehicle. ಅದಕ್ಕೆ 307 ಹಾಕಿ.
Let's see. ಅದೇ ಹಿಂದ್ಗಡೆ ನೋಡಿದ್ರು ಅಷ್ಟೇನೆ.
ಅಲ್ಲ, my lord, maximum, my lord, it will be negligence, accident ಇದು ಬರ್ತದೆ.
We'll see. Yes. List on same 13th. Heard the learned counsel Bipin Hegde appearing for the petitioner. The crime was registered on 21/8/2024 and the offense alleged is section 307 of the IPC. Though 307 ಹೆಂಗ್ ಹಾಕಿದ್ರಿ 27 ಗೆ? BNS ತಾನೆ?
My lord, complaint is on 21/8/2023.
23 ನಾ?
23.
24 ಅಲ್ವಾ?
ಇಲ್ಲ 23.
ಏನಾಗಿದೆ ಇಲ್ಲಿವರೆಗೂ ಮತ್ತೆ?
ಏನೂ ಆಗಿಲ್ಲ ಇಷ್ಟ ತನಕ.
Yes. Government 24 ಅನ್ಕೊಂಡೆ, sorry. Yes.
Even we were not aware of, my lord, about the complaint being lodged. Now, my lord, the police.
ವರ್ಷದಿಂದ ಏನ್ ಮಾಡಿದೀರಾ?
I'll get the records.
Heard the learned counsel Bipin Hegde appearing for the petitioner. The complaint comes to be registered on 21/8/2023 alleging that the vehicle in which the petitioner was driving has hit the two-wheeler.
Yes, my lord.
Has hit the two-wheeler as the two-wheeler had applied sudden brakes at a toll plaza. The learned HCGP is directed to secure the investigation papers conducted for the last 1 year and place it before the court. Till such time further proceedings before the petitioner shall remain stayed.
Okay.
The 24 ಅನ್ಕೊಂಡ್ಬಿಟ್ಟೆ. Yes.
135.
35, my lords. Petition is a bona fide purchaser to the accused number 3.
A2 only.
Lords, A1 is the purchaser, bona fide purchaser.
A2 is the advocate.
Yes. A1 is the advocate. A2 is the advocate.
First ಅವ್ರನ್ನ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ ಮೇಲೆ. ಅದಕ್ಕೆ A2 ಮಾತ್ರ. Yes, 1 HCGP 2 emergent notice returnable by 30th. there shall be an interim order of stay only insofar as the first petitioner hyphen accused number 2 till the next date of hearing. Yes.
36.
Victim was 17 years, 11 months.
Who got them married?
They are not married. They have only agreed. That is what the understanding between the parents.
Agreed? Yeah, agreed.
They have agreed.
What agreed?
Since post now presently is in judicial custody.
Correct.
In fact, post is
So this
released.
is POCSO and
17 years, 11 months. The accused is 20 years.
17 years, 11 months.
at the time of the incident. This
DNA report matching.
ಎಲ್ಲ ಇದೆಯಾ? Well, he's in judicial custody.
Please.
Jagdish.
See, my lord.
Huh?
We'll have to see, my lord, because
Judicial custody ಇದೆ ಇಲ್ವಾ ಅಂತ? ಅಲ್ಲ 17 years 11 months verify ಮಾಡಿ. I'll take it day after tomorrow. If it is 17 years 11 months, then we'll see. Supreme Court judgment will come the way. Justice Oak judgment.
Please.
Let us get that judgment.
Please.
Yes. List on day after tomorrow in the fresh matters list. Yes, next.
37.
Let's appear for the petition.
We'll post it in admission and here.
My lords, there is an IA, my lords, for issuance of NOC for passport.
Passport?
Yes, my lord. Because of the pending
Have you
criminal...
impleaded the RPO?
My lords, they are only asking for a NOC from the court, my lords. If your lordships will see the IA, my
Implead the RPO, sir. ನಿಮಗೆ ಜಲ್ದಿ ಬೇಕು ಅಂದ್ರೆ you get Shanti Bhushan.
I'll do that.
The petitioner is directed to implead the regional passport officer as party respondent to these proceedings.
For initiating Surface Act, they have filed section 499.
Learned DSGI Shanti Bhushan is directed to accept notice for the second respondent, petitioner to serve set of papers upon the aforesaid council.
Yes.
List the matter on Monday ಹಾಕೋಣ. Tuesday 16th.
Much of
16th, 17th in the fresh matters. ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ.
much.
Yes. By then he will get all instructions. It will be easier.
38.
Post the matter. Urgency ಏನಿದೆ ಮೇಡಮ್?
Urgency passport application ಇದೆ. Job he is losing.
ಇದನ್ನ ಅದು ಸೇಮ್ ಆರ್ಡರ್ you implead Shanti Bhushan will grant. Sorry, implead RPO.
Writ is pending. That writ
Which writ?
ಬೇರೆ ಇದೆ.
Number ಕೊಡಿ. Writ number ಕೊಡಿ madam.
I'll furnish me.
Kodi will tag this petition along with so and so. Yes, next.
If this is disposed of, that clears me.
ಅದು ಟ್ಯಾಗ್ ಮಾಡ್ಬೇಡ ಬಿಡಿ. ಒಂದೇ ಸರಿ ಎರಡು ಮಾಡಿದ್ರೆ. Next.
139.
This case, I am.
ಅದು first tag ಮಾಡಿ. It will come post the matter on 13th. Yes, next.
In this case, I am for the petitioner.
Post immediately after service of notice upon the first respondent.
This is not necessary because the petitioner is the complaint before the trial court. He filed a PCR. PCR was in the PCR source statement recorded.
ನೀವೇ ಹಾಕಿದ್ದು ಅಯ್ಯೇ.
The recording of the source statement, Milad, 55 documents are marked. After marking up the documents,
list day after tomorrow in the fresh matters list. Learned counsel submits that is filed an application not to press. ಅಯ್ಯೇ ಒಂದೇನು?
not
to press the application seeking stay. The submission is placed on record. IA 1 of 24 is disposed as not pressed. Next.
140.
My lord, I am permitted to represent the petitioner.
CC of 2019, sir.
Yes, my lord. Now the charges are not framed. The only allegation is that while I was the manager, I had sanctioned the loan for a sum of rupees 49 lakhs. It is essentially a suit which ought to have been filed for recovery, my lord. Now the amount that is claimed for 49 lakhs 67,000 by the company.
Yes, 1 HCGP2 emergent notice. Yes.
My lord, may I request, my lord, so far as petitioner number 4 is concerned, the order of taking cognizance is very bad.
The only petitioner here is accused number 4. Yes.
Therefore, my lord, if the proceedings,
sir. Yes.
The only difficulty that we are facing is that, my lord, if charges are framed, very purpose of petition.
No problem. You have filed a petition, we've issued notice. Even charges are framed, we'll take care of it.
My lord, may I request for a shorter date, my lord, since emergent notice is ordered.
Yes. Please. Next.
My lord, may I request for a shorter date?
What is the civil suit number?
It's 1802 of 2014.
All right. Anyway, in the meantime, next.
Public.
142.
Represent petitioners, my lord. Arising out of the Copyright Act in respect of the same matters, CC number 1005/24. On 2/2/24, my lord has granted the stay order, stay of the further proceedings.
2/2/24, not my order.
My lord,
Where is that page?
It's page number 22, my lords. I have stated so, but I could not keep the order on my hand. Page number 22, I have mentioned it.
If it's 2 to 24, it's not my order.
No, page. Three criminal petitions have been entertained by this court with reference to
Page
page number 22, grounds for interim relief. Criminal petition 5620/23.
Tag this petition. Heard the learned senior counsel MP Nargund appearing for the petitioner. Tag this petition along with ಇಲ್ಲಿ ಇದು ಹಾಕಿದ್ದೇನೆ.
Criminal petition 1005/24.
ಮೂರಿದೆ. ಅದ್ರಲ್ಲಿ ಏನ್ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಮಾಡಿ. ಅದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಮಾಡಿ. Yes.
43.
List them all on 30th. Yes. The meantime, next.
144.
13th. Sorry, 20th.
Just not take more than half a month.
ಆಯ್ತು ಮಾಡ್ಲಿ ಬಿಡಿ. ನಾನು ಕೇಳಿದೆ ನಿಮ್ಗೆ ಸರ್ಕ್ಯುಲರ್ ಕೊಡಿ DA ಕೇಸಲ್ಲಿ ಸಸ್ಪೆಂಡ್ ಮಾಡಬಾರ್ದು ಅಂತ. Where is that circular? Government circular. Where is it? ಅದು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ಇಲ್ಲಿ ಪಾಸ್ ಮಾಡೋದ್ರೆ ಯಾರು ಕೊಡ್ತಾನೆ ಇಲ್ಲ ಸರ್. ವೆಂಕಟೇಶ್ ದಳ್ವೆ ಅವ್ರಿಗೂ ಹೇಳಿದೆ. Get it tomorrow?
Only one submission.
All right, your submissions tomorrow.
Yes.
Yes. Next.
145.
7A. 7A, 13th.
Please, man.
This time.
Permitted to notify. No.
Learned counsel B. Latif is directed to accept notice for the respondent. Registry to print the name of counsel B. Latif as appearing for the respondent. Petitioner to serve set of papers upon so and so. List on 13th. Other matters are there on 13th.
Please. In the meanwhile,
Heard the learned senior counsel. In the meanwhile, 13th. Yes. Yes.
Please.
In the meantime, serve on the counsel.
It's covered by your lordship's order
Ah,
from the
I know.
Kalburgi bench.
Kodi. But you have to serve.
Please.
17A, yes. Learned HCGP is directed to accept notice for the respondent. Second respondent yaru? Same.
The
Learned
competent
HCGP is
authority.
directed to accept notice for the respondents. List the matter on 26th till such time further proceedings where the petitioner shall remain stayed in the light of the submission of the counsel for the petitioner that the issue in the list stands answered by the judgment rendered by this court and writ petition so and so valid. Next.
147, my lord.
A1.
A1 may
No.
urge your lordship that he requires protection.
Sheet file ಮಾಡಿದ್ದಾರೆ.
170/24, charge sheet number.
Challenge that.
Please.
Yes, so on. A1 even then have to make out a case. Others, no problem. Yes.
Please.
48.
For the petitioners, my lord. There are the 3 complaints and 4th complaint is before the learned magistrate. And first complaint NCR is dated 19/122 and second complaint NCR is on 24/11/23.
1 emergent notice, 2 HCGP. The emergent notice returnable by 27th in the meantime. Yes, next. Date, sir.
49.
Stayed.
149 appearing for the petition, lordship. Still is in summon stage, lordship.
FB post, yes, in the meantime. Yes, next.
Obliged.
150.
323 and
Correct. 2016 crime.
yes, my lord. Kindly see the
TC 20, petition 24. ಎಲ್ಲ 4 ವರ್ಷ ಗ್ಯಾಪ್ ಅಲ್ಲಿ.
Please see the annexure B, my lord.
What is C, sir?
Annexure B, my lord.
No.
Annexure B ನಲ್ಲಿ ಅಲ್ಲಿ ಕೂಡ ಏನು ಅಲಿಗೇಷನ್ ಹೇಳುದು ಅದು ಕೂಡ
ಪರವಾಗಿಲ್ಲ 8 ವರ್ಷ ಆಗಿದೆ.
ಅದ್ರ ನೇತ್ರಾವತಿನ ಕೈ ಬಿಡಬೇಕು ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅದ್ರ ಕೂಡ annexure B.
What's the stage, madam?
ಇದುವರೆಗೂ ಕೂಡ
We'll call this matter in 2028. 4 years gap ಆಗುತ್ತೆ ಎಲ್ಲದು ಕರೆಕ್ಟ್ ಆಗವ.
Please see the annexure B.
Yes. 1 HCGP 2 emergent notice returnable by 27th.
Stay, my lord.
No, sir.
Kindly please see the annexure B, my lord. ಅದ್ರಲ್ಲಿ ನೇತ್ರಾವತಿನ ಕೈ ಅವು ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಆದ್ರೂ ಕೂಡ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಮೇಲೆ.
ಆಯ್ತು, ಈಗ ಏನಾಗಿದೆ ಅಲ್ಲಿ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಇನ್ನು ಏನು ಮಾಡಿ
ಏನಾಗಿಲ್ಲ ಅಲ್ವಾ? ಏನು ಆಗಲ್ಲ ಬಿಡಿ. 27th next.
Please see the
27th, yes sir.
151.
B report is filed, madam.
ತಾಳಿ ಒಂದ್ ನಿಮಿಷ. ಅರವಿಂದ್ ನೇಗ್ಲೂರ್ ಅವರೇ ಒಂದ್ ನಿಮಿಷ ತಾಳಿ. ಏನ್ ನೋಡ್ಬೇಕು?
Case counter case.
ಒಂದ್ ನಿಮಿಷ. ಏನ್ ನೋಡ್ಬೇಕು ಹೇಳಿ?
Please, next B, my lord.
Page
26, madam.
ಹೇಳಿ. ಫಿರ್ಯಾದಿ ಹೇಳಿಕೆ.
Yes, my lord. ಇದು undated statement, my lord.
ಸರಿ, ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ಬೇಕು?
ಆಮೇಲೆ ಪ್ಲೀಸ್ ಸಿ ದಿ ಸೆಕೆಂಡ್ ಪ್ರಕರಣದಲ್ಲಿ ನನ್ನ ಮರು ಹೇಳಿಕೆ ಏನೆಂದರೆ 17-11-16 ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿಕೆ ನೀಡುವಾಗ ಘಟನೆಯ ಸಮಯವನ್ನು ರಾತ್ರಿ 10 ಗಂಟೆ ಎಂದು ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುತ್ತೇನೆ. ಆದರೆ ನಾನು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಪಡೆಯುತ್ತಿದ್ದರಿಂದ ಗಾಬರಿಯಲ್ಲಿ ಘಟನೆ ನಡೆದ ಸಮಯ 11:30 ಆಗಿರುತ್ತದೆ. ದೇವರಾಜು ರವರು ಸೌದೆ ಪಾಳಿನಿಂದ ನನ್ನ ಎಡ ಕೈ ಮುಂಗೈಗೆ ಹೊಡೆದು ರಕ್ತ
11:00 ಇನ್ಸಿಡೆಂಟ್ ಆದ್ರೆ 10 ಗಂಟೆಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಶುರು ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಪ್ಲೀಸ್ ಮುಂದುವರೆದ ಮೇಲೆ
wait. Heard the learned counsel appearing for the 1 HCGP 2 emergent notice. The statement of the complainant is as vague as vagueness could be, as the incident narrated is at 11:30, but he gets admitted to the hospital for treatment at 10 p.m., 1.5 hours before the incident. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Sorry. Yes. Next.
151.
B report has been filed, madam.
B report.
Please.
Same order. Kavya.
52.
The petitioner is before this court calling in question so and so. The proceedings instituted would clearly indicate, proceedings instituted through the private complaint would clearly indicate that the same is instituted for the purpose of recovery of money, which the apex court in the case of Lalit Chaturvedi reported in 2024 SSC Online SC page 171 has observed that such proceedings should not be permitted to be continued. Therefore, there shall be an interim order of stay. So on. Next.
This
is a matter where we have sought for bail, my lords.
Bail?
How this is the matter, my lords. 50 cases that were registered against him. He gets bail. 51st, totally 110 cases, my lords, against him. 110 andre ಒಂದು ದೊಡ್ಡ plot ಅಲ್ಲಿ, my lords, different survey numbers. They say that he's cheated using various survey numbers by getting certain orders from the court. Now, my lords,
Coca court rejected the bail petition of the accused.
But that doesn't. I'll just please I'll point out 3 illegalities, my lords, on the basis of which the entire arrest becomes illegal. My lords, the first is 41A notice issued to me, my lords. On the basis of 41A notice, I approach the concerned police. Police arrest me. Now that goes contrary to Satyendra Arthin's case, my lords, where you can't. 41A notice, if you are going to be complying with, you can't be arrested. Then, my lords, after I'm arrested, in that particular case, my lords, I get bail. After I get bail, I'm not released. They say in the other crime number, we show your arrest, we continue.
What to do if you have done 110 cases? Ondalla ondralli olage irtira.
Illa. No, my lords, now the position of law is this. A person can be detained in jail only in one case.
Slightly modified. What is not there in this is, my lords, it is only an investigating officer who can give.
No, I'm only asking a simple question.
Please.
According to you, the petitioner has not done anything that is relatable to it. Sir, you're appearing for the complainant?
No, your lordships are saying petitioner is accused.
Petitioner is accused. That is what I'm saying. According to you, you are for the government, right?
Please.
Now, your suggestion is that petitioner has not taken any decision or recommended anything that would become an offense as is that your submission?
Please. No, your lordship.
No.
No, I'm not on that. That's the legal position, my lord. In order to invoke 17A, that is a condition precedent, my lords. As your lordship pointed out. Here, I'm slightly one step further to entertain an application, my lord, under 17A. There should have been a preliminary inquiry.
That I understood.
Please.
What you're saying is even for an application seeking prior approval under 17A, there should be a preliminary inquiry as is necessary in Lalit Kumari and the SOP that is by the Government of India. That's your submission. So here there is no preliminary inquiry and the competent authority himself has now acted instead of referring it to the police for preliminary inquiry as an approving authority conducting inquiry himself and passing an order. That is your submission.
Second submission. And The third is, my lord, what your lordship felt, if the petitioner decision or recommendation and holding the post. So these are the three requirements, my lord. If I may read section 17A, so what is required is relative recommendation, decision by the public servant. Third most important, in discharge of his official.
Correct. That is the soul of that is the soul of 17A.
17.
In discharge of his official duty, if there is anything recommended or any decision taken, this can be set into motion. That is the purport of 17.
And your lordships have said what is the object and purpose also of 17A
Yes,
is to
sir.
protect the thing, and why it should not be abused also. Your lordships have dealt in Dr. Ashok and Pradeep Kumar and all those cases.
All right.
Keeping those in mind, my lord, the question what your lordships lordships will decide is, my lords, not only in this case, any other, I mean, on a principle of law, my lords, a trigger-happy complaints are filed day in, day out against various public servants to the competent authority, my lords. Then the nature of inquiry, again, which ought to have been done, hearing the complainant, hearing the accused, then a decision being taken, my lord, that will send a very bad precedent or a proposition of law insofar as granting prior approval for investigation, my lord. It will defeat the purpose of section 17A. So therefore, investigating officer has to be only a police person, my lord.
Oh, you're coming at that.
I've been trying to come at that.
Yes. All right. Yes.
So therefore, my lords, ultimately, unless that report is there, that is what they say, the investigating officer forms an opinion. That ultimately, my lords, it is for the competent authority to decide on the material, to grant or not to grant. He may not be bound by the
report of the investigator.
He independently, he gives approval to, therefore, my lord.
Approval for what if there is already a report by the investigating officer?
No, therefore he may accept it or reject it.
No, approval granting in case he wants to grant approval. For what does it grant approval?
Investigation.
It is already done.
No, he forms an.
You said investigating officer submits his report and seeks approval. For what does he give approval? For investigation again?
Please, my lord. So therefore, my lord, that is, I'll just put it. Preliminary inquiry is with regard to cognizance on offence which the investigating officer forms in view of the bar under 17A. He has to seek permission from the competent authority, and the competent authority gives approval to that. So without the approval, he can't investigate. That is why he seeks the approval.
You're trying to blow hot and cold. Now, prior to approval, you said there should be some inquiry or some report prepared.
That is what Lalit Kumar has said.
That makes sense. You're hinting upon Lalit Kumar's principles.
Principle. Then, my lord, your lordship, the lordship circular also may be kindly seen. My lord,
Lordship circular, High Court circular.
Your pursuant to your lordship's
order.
pursuant to your lordship judgment in Dr.
Dr. V. Ashok or something is.
Please, my lord.
Page, sir.
That is at page number, my lord, volume 1.
Citation, madam. Volume 1.
Page 260. 260. In fact, my lord, what you're keeping in mind, the object of 17A, my lord, what your lordship said. 260, volume 1.
1 second, sir. Of the
Petitioner's paper. Petitioner's volume.
Petitioner's paper.
I'm sorry. I took it for granted that your lordships know all the page number, but I need not.
No, how volume ಅಂತ ಹೇಳಿದ್ರೆ volume also I should know. 1 minute. Because that SOP you said was last 3 pages of that paper book.
So
that's why.
Easy to remember.
ಹಾಗಂತ ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ ಅಂತ. Yes, sir. Page 260.
First, it refers to Priyanka Shivasa, my lord.
And Yashwant Sinha later.
Please, my lord.
Yes.
That is affidavit 173-1 and 173-4. I'll come to that, my lord. Here, page 261, my lord. The language, what your lordships has said at page 261 is, my lord, even if not to entertain such complaint if they do not comply with the following. That is, my lords, one is registration of the complaint, then prior approval in case of a prior complaint. Then last paragraph, my lord, these directions become necessary in the light of the fact that once the matter is referred for investigation, the police will have no choice but to register the crime. Therefore, such approval being appended to the private complaint is signed for maintainability of the complaint, except in cases where concerning disproportionate, which your lordship gave, such complaint shall bear the scrutiny. So therefore, my lord, pre-requirement is compliance of 154 or 173, then 17A. So therefore, my lord, again, my lord, here comes back to Lalit Kumari once again, my lord, because it has there is no application of mind or not application of mind, no preliminary inquiry. I put it the language used by the Supreme Court, my lord, no preliminary inquiry done in this matter, my lord. And coming back to insofar as 154 and 173, your lordship may kindly see on the 3 volumes were given by the Counsel for the Governor, the Solicitor General, my lord. If your lordship sees, my lord, on those volumes, there is no complaint is given by respondent number 3. Respondent number 3 on 18th July and 25th July, my lord. And the immediately next day,
26th July.
26th July, immediately next day, prior approval is sought. So therefore, my lord,
prior approval is sought and show cause notice is issued.
No, the points I'm trying to make here is, my lord, the question is...
No preliminary inquiry.
So therefore, he had not given an opportunity to conduct that inquiry. If he had given, we don't know whether the police officer themselves might have or might not have sought for prior approval.
No, if your submission is accepted, that permission was not given up to sufficient time or whatever, 17A ಆದ್ಮೇಲೆ ಅದೇ ಆಗೋದು.
No, that's a different aspect, my lord. No. Just because it's going to happen after 17A,
not just because, only because.
No, only because, my lord, your lordship, go by to the Supreme Court judgment and the SOP, judgments of your lordships and the SOP cannot given a go by because it is likely to, the scope of that is entirely different. My lord, once the complaint, 156.3, that's entirely scope. I'm not on.
No, if you're hinting on some inquiry, investigation should happen. Now, if the impugned order, I mean, like by the impugned order, what is done is that only.
That he could not have done. That's the whole point, my lord. He is a competent authority, not a preliminary inquiring officer.
All right. Yes.
That is what is prohibited in law.
All right.
Sum and substances. So therefore, in fact, para 3 and para 9 of the written submission says, we have done preliminary inquiry. We have not given prior approval. Your lordship may kindly see the written submission given by them.
By whom?
The Solicitor General, my lords. All they say that we have done a preliminary inquiry as required in Lalit Kumari.
That is prior to giving approval.
By the competent authority.
Prior to giving approval.
By the authority.
So according to you, police officer should do that.
That's what the law says. Your lordship, that is the requirement, my lords. So therefore, the application of...
There are 2 things.
Please.
If the crime is registered before the police, now if it or the locaयुct or whatever it is, if it is touching upon or an amalgam of offence under the Prevention of Corruption Act and the IPC, prior approval will have to be sought.
Correct.
All right. The police officer or whoever files a prior approval before the competent authority to inquire or investigate. Permission comes, then he starts investigation.
Correct.
Starts investigation by what? By registration of a crime. Yep. All right. Now it is a private complaint. Straight away, a private complainant goes before the court. He seeks reference under 156.3, now under 175 of the BNSS. Now, if the matter is straight away referred, now say it is
not permissible.
No, that's what I'm telling you. If the matter is straight away referred for investigation to any authority, to a jurisdictional police or to XYZ, no choice but to register the crime.
Correct.
So what happens to 17A?
So therefore, what?
By way of a private complaint, you obviate the process under section 17A and straight away get a crime registered where 17A, if it is before the police station or before the officer in charge of a particular police station, be it the Lokayukta, 17A would be required. All right.
Correct.
Now, 17A, the approval is sought before the competent authority. Here, the competent authority is the governor. Governor initiates certain process, do not that day it is granted or what day it is granted. How it has been granted?
I'm
will
not on
answer.
that, Manoj.
Yes. So according to you, Lalit Kumari had to be followed, preliminary inquiry had to be conducted. Now in the written submissions, the learned SG says that preliminary inquiry is conducted
by the
as contemplated under Lalit Kumari by the competent authority.
Which is not.
That is your submission.
It's virtually impermissible. He does not act as a investigating officer under law. He only is a approving authority. What is sought by the investigating officer? That's the summon. And what the whole case and the record shows that 25th was the complaint, 26th the file movement. He was heard, show cause notice issued, and reply sought for, and a decision is taken, clarification sought from the complainant, and then a decision is taken, which according to them is a preliminary inquiry is what they have done. Can I read para 3, Manoj? It is of the written submissions.
Yes, sir. Page?
Page 9, para 3. It is submitted that the stage of granting approval under 17A of the Prevention and Corruption Act, it is not a stage where claims and counterclaims have to be weighed or weight of the allegation is to be tested. It is submitted the only test that ought to have been adopted is whether there is an allegation which discloses the commission of a cognizable offence and apprehension exists that offence may have taken place, requiring an investigation to be conducted in accordance with law. Para 9, can I request, Muda?
Yes.
That is at page number 12. It is submitted the order to further understand the scope of inquiry at the stage of approval for investigation. The principles laid down in the case of Lalit Kumari versus so-and-so, the Honorable Supreme Court ought to be referred to. In the case, the Honorable Supreme clearly held that once the cognizable offence is disclosed in a complaint, the FIR must necessarily follow. The said principle was laid down in the light of statutory provision and so-and-so, and the understanding that the FIR is merely the starting point of a lawful means to uncover the truth of the matter. So the point here is, Malad, who has to do this preliminary inquiry? It's not in dispute according to them also, Malad, that preliminary inquiry need not be done. According to them also it has to be done. He says, I will do the preliminary inquiry. So therefore, my lords, there is no doubt that preliminary inquiry has to be done, even according to them. Then, my lords, page 14, para 10.
Right.
I'm sorry.
Yes. No. For whatever is to be done, preliminary or otherwise, 70.
Please,
all right. Yes.
My lords, what my submission is preliminary, as your lordship in the initial start, preliminary inquiry cannot be read into 17A.
All right. We'll consider. Yes.
Para 10, it is submitted that for the approval of investigation must be exercised guided by law laid down by the Honorable Supreme Court. It submitted in the case of information given to the police, discloses the commission of a cognizable offence. The approval for investigation is to be granted unless the allegation appears to be wholly biased, motivated, and false. In furtherance of the aforesaid, it is submitted that the intent of the Honorable Governor was to ensure the proper investigation is conducted in the present matter, to merely uncover the truth in the matter and not to take any specific sides.
So according to you, according to them, preliminary inquiry is conducted by the competent authority.
Please. Ultimately, what they said, we have followed Lalit Kumari. Then one of the important aspects, Malot, with regard to your lordships, I have held in Dr. Ashok's case also. Malot. In this case, Malot, insofar as respondent number 3 is concerned, my lords, as I pointed out, complaint is given, not even 24 hours is what was ordered to be waited for before approaching the governor on the 26th. Immediately, my lords, he is heard on the same day. That is one aspect of the matter, my lords. Whether you could have heard
After a few days.
No, not after. Whether it could have been heard at all. At all. And what was thought to be argued, like the procedure need not have been followed. The question is, there's no such procedure. Rightly, my lord, there's no such procedure to hear a private citizen or a complaint. My lord, especially, my lord, when at the cost allegations is made against an accused, whoever that may be, my lord, without his presence. And subsequently, my lord, issuing show cause notice, the whole procedure is not contemplated in the eye of law at all. When that being the case, my lord, the question what your lordships will consider whether application of mine, principle of natural justice, reason order, I don't want to go into those aspects.
So you're at the root.
The root.
It cuts at the root.
Because the 3rd, 4th and the 5th complaint, my lords, here also I have not sought to give follow the requirement of section 154 or 173, my lords. If your lordship may kindly take the few dates in the written submission, my lords. Your lordship may kindly page 7, my lords.
Page 7?
Page 6, page 5, I'm sorry, my lords.
Oh, this table.
This table, which is forthcoming from the compilation of documents given from the governor's compilation, my lords. On 18th July is the complaint given to the Inspector of Police, my lord, Lokayukta.
No, but it was argued that you had tendered an opinion saying that it is, they only have to seek the prior approval at 17A.
No, I'll come to my opinion later.
No, that's what I said. Because
no, they have.
No, now you're saying that police officer has to register, police officer has to seek permission.
No, what, they're slightly different what the opinion is given, what I'm submitting, my lord. Here, my lord, if they had complied with 154, my lord, as I submitted earlier, he would have done a preliminary inquiry, then sought, as your lordship just pointed out, my lord, he would have, if it's a cognizable offense, he would have sought for a prior approval under 17A. The question is, my lord, whether 154 or 173 was sought to be compliant. My lord, this 154 argument comes when private complaint is filed. But what my submission here is, my lords, the entertainment of the competent authority ought to have seen whether that procedure is followed prior to entertaining an application under 17A, my lord. The reason is this, my lords. If that was not followed, you should have seen that such a procedure is followed so that that material was with him. Here, my lord, 154.1 is not followed, or 173.1 or 173.3.4 also is not sought to be.
151.
1 and 3 has not been. Please, ma'am. So therefore, my lord, to entertain that application also, application 17A, my lord, this crucial aspect, whether the compliance of 154, my lord, was done, or 173, 1 and 4 was done, was very crucial. If that was not done, my lord, it ought to have been returned back, saying that comply with the said procedure, then you file an application. In fact, insofar as Pradeep Kumar is concerned, my lord, that is respondent number 5, no such complaint is given at all. And insofar as respondent number 4 is concerned, my lord, application is filed subsequent to filing a complaint before the competent authority. And the competent authority has considered the application dated 5th July 2024, which pertains not seeking prior approval, but seeking CBI inquiry. So therefore, my lords, insofar as application of respondent number 4 for grant of sanction was not there, neither in the file of the competent authority, the Honorable Governor, my lords, or in the statement of objection. So therefore, my lords, the application sought for ought to not been entertained on this count also.
Yes.
Then finally, my lords, one of the point coming to now the aid and advice, my lords.
163.
163. Insofar as courts, MP police establishment, and they've all said, my lord, the discretion is with the governor. The question is, what is this discretion? How he has to exercise this discretion? For example, my lords, on the basis of if the aid and advice or there is material, we'll take a situation, my lords, where recommendation is given, the aid and advice is to grant sanction, and the same is rejected. It can work both ways. In this case, my lords, the advice is not to grant sanction, it has been granted. There may be cases, my lords, where recommendation is to the other.
Not to grant sanction, but sanction is to grant sanction, sanction is not granted.
Not granted.
All right.
So therefore, my lord, this discretion is not.
48.
Please. Page 41 for a moment, my lords.
The discretion begins there. Your submission is at page 48.
Okay. Note on points with regard to.
Yes.
So therefore, my lords, with regard to limited discretion, narrow scope of discretion, reason and caution, my lords, keeping that in aside, my lords, I'll just where that your lordship may kindly turn to page 55, my lords. At point number 4.
MP police.
Which has been reiterated in AG para 4. My lord. It is pertinent to note, as evident from the impugned order and the materials put forth by the governor, there has been assumption of bias contrary to the legal principle established in MP police establishment, Nawab Rabia, and so on and so on. So the exception carved out in this landmark judgment for when a governor may act against the advice of the Council of Ministers have not been addressed or satisfied in the present case. The impugned order and the material produced by the Honorable Governor fails to provide any substantive reasons from deviating from the aid and advice given by the Councils of Ministers, nor does it demonstrate how the Cabinet's recommendation against granting sanction was irrational or unsupported by material evidence or suffered from bias. Furthermore, the order lacks a reasoned explanation to establish its own rationality or to show that it is based on through consideration of relevant materials. This absence of reasoning, coupled with apparent haste in the decision making, raise serious question how the propriety and legality of the impugned order protection infringes upon the constitutional scheme and governance principle of federalism.
Yes.
Your Worship, may turn to page 43, Malats, for a moment.
Yes.
The 43 last paragraph, Malats, 4.2.15.
Yes.
Explains, referring to Shamsher Singh and MP Punchi's commission's report, Malats. It's just been culled out over there.
Yes.
Which page 43 highlighted portion, Malats. Thus, the scope of discretionary power as provided in exception to clause 1 and in clause 2 of article 163 has been limited by clear language of two clauses. It is an accepted principle that in a parliamentary democracy with a responsible form of government, the power of the governor as a constitutional or formal head of the state should not be enlarged at the cost of real executive with the Council of Ministers. The scope of discretionary power has to be strictly construed, effectively dispelling the apprehension, if any, that the area of exercise of discretion covers all or any of the function to be exercised by the governor under the Constitution. In other words, Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. This area of exercise of his discretion is limited. Even this limited area, his choice of action should not be arbitrary or fanciful. It must be choice dictated by a person, actuated by good faith and tempered by caution.
So this caution. All right.
So, my lord, this is the, so therefore, my lord, the lordships will see, my lord, whether the impugned order comes within the four walls of this aspect. So therefore, my lord, the reasoning that the impugned order says it is my discretionary because there is bias apparent and evident is not a ground. As already pointed out, my lord, it should be by reasons with which the reasons should be in the order itself, not in the file, my lord. I would just like to take your lordship to the file for a moment, my lord.
Which file?
The governor's file.
Right.
Just an line with that, my lord. Just want to point out 2 or 3 aspects in that, my lord.
Madam, copy ಕೊಟ್ಟಿಲ್ಲ.
Volume.
No, it's in volume
1.
That's the order.
The order sheet.
All
Proceeding.
Yes. Page.
My lord, page 1, my lord. If your lordship sees, my lord, the reference subject is sanction for prosecution, my lord, of so and so. Petition so and so dated 26/7. Kindly produce petition by so and so, serial number 1. Then next page number 2, my lords. Please pursue papers, pre-paras, the complaint addendum. Then next at page 3 on right on top, my lords. I have heard so and so in person and gone through the petition and supporting documents submitted by him. Prima facie, I am of the view there might be irregularities and misuse of power. Hence, show cause notice to so and so within 7 days. So this is what the preliminary inquiry sought to be done, my lord. Then can I request, my lord, page 7. Speaks about, my lord, the reply given by the petitioner, then the proceedings. Then last at para 20, my lord, put up along with the comparative statements of petition, Chief Minister.
Sorry.
They recently contested not in the elections also.
ಅದು ಮಾಡಿದ್ರಾ?
ಏನ್ ಮಾಡದೇನಿಲ್ಲ.
ಗೆದ್ರ?
ಅಲ್ಲ, ಕೆರೆ ನೀರನ್ನು ಕೆಳಗೆ ಚೆಲ್ಲದ್ರ ಅಷ್ಟೇ. ಈ ಲಾಸ್ಟ್
ಗೆದ್ರ ಇಲ್ವಾ? ಆಲ್ ರೈಟ್.
ಗೆಲ್ಲೋರು ನಮ್ಮಂತೆ. ಗೆಲ್ಲೋರು ಆ ಕಡೆ ಹೋಗ್ತಾರೆ.
ಆಲ್ ರೈಟ್. ಎಸ್. 12th. ಅವತ್ತು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಮುಗಿಸ್.
ಗ್ರೇಟ್.
Same conditions. All conditions.
15 minutes. Hate speech.
One ನಿಮಿಷ.
Interim order is there, can be taken on 19th.
List on 26th. Interim order subsisting shall continue till the next date.
34 also. Same petitioner.
ಯಾವುದು?
34.
ಬರ್ಲಿ ಅಲ್ಲಿಗೆ. Yes.
Second respondent filed a complaint on behalf of the third and fourth respondent.
Respondents ಅಲ್ಲಿ interim order ಇದೆಯಾ?
Interim.
Same 26th IO.
My lords, short accommodation.
Interim order ಇದೆಯಾ?
Yes, my lords.
26th IO. Next.
This case. It's a civil case, please, my lords, blown out of proportion. What transpires, my lords have captured the whole issue, please, my lords, in the interim order.
Interim order ಕೊಟ್ಟಿಲ್ಲ.
What transpires, my lord, they have sold the property to us for consideration of 9 crore rupees. Consideration is passed on. Thereafter, please, my lord, they go institute a suit, my lords, for declaration and injunction. Interim orders are not granted. After that, my lord, they come up, my lords, before the police to say, Lords, I am making development.
There is a detailed order, right?
Please, it will only cover, the same thing will have to be.
Respondent ಬರ್ಬೇಕಲ್ಲ.
ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ, somebody.
ಎಲ್ಲಿದ್ದಾರೆ?
They gave us the objection statement also.
All right. Learned counsel for the respondent seeks time to file statement of objections. List on 26th. Interim order granted earlier. Stands extended to the next date of hearing. Next.
Nice. Grateful.
ಇದೇನ್ ಮತ್ತೆ?
Date ಕೊಟ್ಟಿದ್ದು ಅಂತ.
Well, it's appearing for proxy counsel, man. Senior is in the out of station.
Out of station? Hello, what is this?
Not the one, what the order has been not observed by your lordship is not 195 capital A. You want whether 195 is a bar, may not.
Oh, this I
threatening
granted an
witness-
interim order.
Threatening witnesses. But I'll just bring to your lordship kind notice, maybe heard on some
Senior
other day.
relevant.
Alla, same, it
We'll
can
take
be
it
heard
on.
on some other day, but your lordship may have to may not consider 195 capital A of CRPs.
ಅದೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ
ಅಲ್ಲ 195 ಮಾತ್ರ ಮಾಡಿದ್ರು 195 capital A ಮಾಡಿಲ್ಲ.
ನೋಡಿ ಇಲ್ಲಿ ಆರ್ಡರ್
But 195.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ನೋಡಿ.
I'll,
It's a 4-page entry order.
please, I'll.
195 capital A.
Then I'll prepare myself on this
Exactly, sir.
grounds.
No, what if 195 capital A is introduced later by way of an amendment?
Please.
That does not take away the procedure to be followed under 340. No procedure is followed.
Well,
Who has to
complaint
take-
really-
and which court has to complain? You have gone and registered the complaint before court at Dharwad. Everything has happened here before the special court. How do you do that?
ಅದ್ರಲ್ಲಿ I'll.
ಮತ್ತೆ ಅಷ್ಟೇ. I remember what I have granted. Yes. Heard, they list the matter on 26th interim order subsisting shall continue till the next date of hearing.
Please.
Nodi, I have, yeah, interim order, it's a detailed interim order that I have granted, just see it.
Number 20.
20 minutes I appeal for the petitioner. Minutes senior appears, he's on his legs. Minutes, your lordship may kindly have it on Monday, minutes coming.
Then we'll vacate the interim order.
Minutes, he is. he
This the
appears-
matter on 26th interim order subsisting shall continue till the next date of the hearing. Yes, sir.
One. Appealing for petitioner memos.
Non-compliance of office objections.
1 week time maybe.
ಓ ಇದೇನಾ ನೀವು ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದು? ಎಸ್. A week's time is granted to comply. Weeks, ಏನ್ covered ಏನು?
ಇದಲ್ಲ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಇನ್ನೊಂದಿದೆ ಕೋರ್ಟ್
ಇನ್ನೊಂದಾ?
ಮೆಜರ್ಮೆಂಟ್
Week's time is granted to comply with the office objections. Interim order subsisting shall continue till the next date of hearing. ಇದು interim order ಇದೆಯಲ್ಲ ಫೋನ್? Yes, 26th IO. Oh, 21, sorry. 20 ಹೇಳಿದ್ದ ಈಗ? 21. No, 1 week time is granted to comply with the office objections. 26th, yes, Paul.
3 and 153A.
Correct. Take ಕೊಟ್ಟಿದೀವಲ್ಲ?
Yes, Lord. While my Lord distributing the Mantrakshara of the Ram Mandir.
ಮಂತ್ರಾಕ್ಷರ.
Yes, Mantrakshara of Ram Mandir.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ.
Charge sheet has been.
ಸ್ಟೇ ಇದ್ದಾಗ ಹೆಂಗಾಗ್ತದೆ ಚಾರ್ಜ್ ಶೀಟ್?
Before he files the petition itself, charge sheet came to be filed.
Then why have you not stated that?
No, my Lord. It is transferred from Dharwad bench to Bangalore bench.
All right.
Yes, my Lord.
ಇಲ್ಲಿ ಟ್ರಾನ್ಸಿಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರ ಇಲ್ವಲ್ಲ?
Charge sheet filed on 13/2/2024.
13?
Sir,
13/2/2024.
that is after the filing of the petition before the grant of the interim order.
Because my Lord, I have made my Lord application immediately before.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಸರ್.
Please, my Lord. In the
Interim
meantime,
order ಇರೋದ್ರಿಂದ ಅಮೆಂಡ್ ಮಾಡಿ.
please.
Yes. Counsel for the learned additional SPP submits that the charge sheet has been filed prior to the grant of the interim order, albeit after the filing of the present petition. Therefore, in the light of the pendency of the interim order, I deem it appropriate to permit the petitioner to raise a challenge to the charge sheet.
Interim order is only to not to precipitate, not.
Whatever, sir. So and so. List the matter on 26th. Needful be done by then. Any interim protection subsisting shall continue till the next date of hearing.
Please. My Lord, next one is my Lord 153(1) and 153(2). Though there is my Lord such provision.
ಇಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ.
Interim order ಇದೆಯಲ್ಲ?
But no provision, my Lord, available under the offense under section 153(2). But even though there is no definition.
ಪಾರ್ಟ್ ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ ಪಾರ್ಟ್ ಬಿ ಗೆ they indicate it as 2. 506 ಅಲ್ಲಿ there is no part, there is no B, but they say 506B, it is part 2.
Correct, my Lord, but here 153(1) and 2 simultaneously, that is not correct.
ಉಂಟಲ್ಲ?
Stay unto.
Yes.
Stay. My Lord, this is also my Lord.
You should correct them. 506B ಅಂತ ಹಾಕ್ಬಿಡ್ತೀರಾ?
ಕೆಲವು ಕಡೆ B ಅಂತ
Part
ಹೇಳ್ತಾರೆ,
two.
ಕೆಲವು ಕಡೆ part 2 ಅಂತ.
Part 2 actually, because 506 is a non-cognizable offense. If you see part 2, it is a cognizable offense.
Then my Lord, there is no mens rea here, my Lord. There is no mens rea. He has a my Lord
List on 26.
has a 7-time MP of the my Lord
ಅದಕ್ಕೆ ಮೆನ್ಸ್ ರೇ ಇರಬಾರ್ದು
just
ಅಂತಿದೆಯಾ?
represented the.
ಅಲ್ಲ ಅದಕ್ಕೆ ಮೆನ್ಸ್ ರೇ ಇರಬಾರ್ದು ಅಂತ.
ಏನು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ wait. List on 26th interim order subsisting shall continue till the next date of hearing. Yes.
54.
I appear for the petition. This is 153 capital A minutes.
All these 153 years will take one day and finish it.
No, this is through WhatsApp, my lord. Well, is that?
ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಸರ್.
5/4/2020.
There's a detailed order.
Yes. Of course, your lordships also interpreted in Raja Singh Thakur's case. Two
153.
groups should be a sine qua non for.
Yes, sir. That is following the judgment of the apex court.
Yes, yes. And
Javed
so
Hajam-
far as the WhatsApp is concerned,
Javed Hajam and
Javed Ahmad.
Javed Hajam and Shiv Prasad Semwal,
Yes.
about 2024. Yes, heard the learned senior counsel appearing with the petitioner. List on 26th, the interim order granted on 5/4/2024 shall continue to the next date of hearing. Yes, next.
For petitioners.
Then Leka.
Lord, some defamatory article, my lord, was published in a newspaper. Allegation that he, my lord, give a bite in the media. That is the allegation, my lord. And my lord,
You're going to give bites?
we are ready with the matter, my lord.
Yes, sir. You're ready with the matter. Why are you
Because the
ready?
interim order was granted
Is
earlier.
the interim order?
Ready?
Ready now? Really, sir. Yes, sir.
Lord, petitioner was a deputy speaker, my lord, from 6/3/2018 to 17/3/2020, my lord.
ಇದು ಅವಾಗಿಂದ ಇದು?
ಅವಾಗಿನ ಇನ್ಸಿಡೆಂಟ್ ಕಾಗ್ನಿಸೆನ್ಸ್ ಟೇಕನ್ ಲೇಟರ್, my lord.
All right.
My lord,
Complaint is registered when time?
yes, my lord. It was registered in 1 month, my lord, after the incident, alleged incident taken
All
place.
right.
But the background is this, my lord. Petitioner was a deputy speaker, against which, my lord, the respondent makes reckless allegation of, my lord, land grabbing and all. Lord, for which, my lord, he lodges the complaint, my lord, and that was registered as NCR. Then, my lord, the respondent was called to the police station and he was advised, my lord, and then endorsement has been issued to the petitioner. Lord, suppressing all these facts, he files this present complaint, my lord, on 25/11/2019, 13/12/2019, my lord. The NCR was, my lord, closed on, my lord, 25/11/2019. But the allegation is this, my lord, the paper publication, which is produced, my lord, at annexure, my lord, page 58.
Yes.
My lord, right side. Lord, this is, my lord, stated in the context, my lord, where he made reckless allegations. And, my lord, NCR was registered and the endorsement was given. He says, my lord, ಹುಚ್ಚ ಮೂರ್ಖ ಅಜ್ಞಾನಿ ಏನನ್ನ ಬೇಕು ಅರ್ಥವಾಗುತ್ತಿಲ್ಲ. This is the only allegation, my lord, against the petitioner.
How can you term someone as mad?
Lord, this is not he is saying ಹುಚ್ಚ ಅಥವಾ ಅಜ್ಞಾನಿ ಏನನ್ನ ಬೇಕು ಅರ್ಥ ಆಗುತ್ತಿಲ್ಲ, because he makes reckless allegation without there any basis. And, my lord, he simply, my lord, it is like a hit and run case, my lord. He gives
500,
499 and 500.
Correct, 499.
My lordship, first contention is that that I have not filed affidavit before the trial court.
ಅದು ಹಾಕಿದ್ದೀನಿ ಅಂತ you
ಹಾಕಿದೆ.
take it as your fight.
Yes.
Yes, don't get into that contention. ಆಮೇಲೆ
Second contention is that I have not taken the sanction.
That also you have taken.
No, sanction is not required because there is no nexus between the press meet and the discharge of his
Official duties. ಆಮೇಲೆ
So, third contention is that the trial court has not taken the cognizance and proceeded to record his own statement. In this regard, I want to cite a citation, my lordship.
citation ಕೊಡಿ.
ಹೌದು, ಸತ್ಯಸಾಯಿನ.
Page 25, 27, my lordship.
My judgment only you are giving.
This one.
My order.
Yes, my lordship.
Pradeep Odeyer, sir.
Yes, my lordship.
Curable defect.
Curable defect, and there is no necessity of mentioning in the order sheet. It is presumed to take as a sanction has been taken.
ಆಮೇಲೆ
And fourth contention is that these words doesn't fall under the definition of 499 and 500. He cannot call any person as a mad idiot.
Idiot?
Yeah.
ಹುಚ್ಚ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಮೂರ್ಖ.
Okay.
Agnani. And it sends a wrong message to the society.
Correct.
Hence, I pray this honorable court to
dismiss the petition. Yes, sir.
Now, my lord, the grounds urged are, my lord, one is, my lord, that this is filed as a, my lord, counter blast and afterthought. Number one, my lord.
But the statements are statements. They are facts. Facts are stubborn.
I'll come to, my lord.
Yes.
Now, my lord, that is number one, my lord.
Yes,
The
sir.
second ground is, my lord, the complaint has been filed with the oblique motive in order to harass and humiliate and tarnish. But
ಯಾಕೆ ನೀವ್ ಹೇಳೋದು ಅಬ್ಲಿಕ್ ಮೋಟಿವ್
ಅಲ್ಲ, ಅವ್ರು ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ನಮ್ಮ ಮೇಲೆ ಹಾಕಿ he makes reckless allegation and I, my lord,
ನೀವು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿಲ್ವಾ?
no, I gave a complaint, my lord, police that was registered as NCR.
You should have filed a private complaint for defamation.
No, my lord, he also holds a press conference against me, my lord.
ಆಯ್ತು, ಆಲ್ರೆಡಿ he also ಬಿಡಿ, ನಿಮ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇದೆ, ನೀವು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿಲ್ಲ. You have to answer that.
Yes. But my lord, he gives a statement before the police.
4 grounds, 4 replies.
No, my lord.
Straight reply, straight answer.
No, my lord.
No beating around the bush.
No, my lord. There is no independent witness, my lord, supported the claim or contention of the complainant.
It's a press conference, public domain.
Lord, now the sworn statement has been recorded, which is very bald and vague, my lord. Kindly see, my lord, page 55 is, my lord, 52, CW1, my lord, the complainant. Lord, he says, my lord, only, my lord, the defamatory statement has been made. Only that he says, my lord. And, my lord, there is a difference between, my lord, the date given in the complaint and also, my lord, in the sworn statement. The complaint, my lord, he says, my lord, on 16th, the press meet was held. Then, my lord, in the sworn statement.
Press meet is a matter of fact. ಯಾವತ್ತಾಗಿದೆ ಅಂತ ಡೇಟ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದ್ರೆ that does not absolve you. ಆಮೇಲೆ.
But, my lord, it is a bald sworn statement where there is, my lord, no ingredients has been attracted to attract, my lord, section 499. Next, my lord, the CW2, who is supposed to be independent witness, my lord, he should have stated 2 things, my lord. The complainant, my lord, is a reputed person and his reputation is tarnished by virtue of the alleged defamatory statement given. He has not stated, my lord, anything, only vague statement. Kindly see page 55 for a moment, my lord.
So only a reputed person can be,
no, my lord,
reputed person's image can be tarnished.
Not so, my lord. He should, my lord, state 2 things, my lord. Independent witness should come and say.
You mean to say reputation is only of a reputed person?
Reputation was there and it has been tarnished. Now both is missing, my lord, in this case. Kindly see page 55. It's a vague sworn statement, my lord. Therefore, my lord, my respectful submission is even 202 is not complied.
In 202 is not. What 202 is not?
My lord, the cognizance is taken by the special court. But, my lord, accused, my lord, while issuing, my lord, process, he has not complied 202. Inquiry has not been conducted.
Why inquiry?
My lord, he is residing outside the jurisdiction. My lord, the complaint was earlier filed before the regular magistrate. Then it was
transferred to the special court.
Special court, my lord. But now, my lord, while
special court is not there everywhere.
Lord, now
it's only one.
Yes, my lord.
So the 202 goes next.
My lord, the inquiry as contemplated, my lord, in order to satisfy himself.
There is only one court.
In order to satisfy himself that, my lord, the matter requires, my lord, issuance of process. That has not satisfied, my lord, is my respectful submission. Lord, the other ground is counterblast, my lord. The moment I filed a complaint, he filed this private complaint. That is one. My lord, another ground is, my lord, suppression of fact. The complaint which was filed earlier, my lord, against him is not, my lord, nowhere mentioned in the complaint or in the sworn statement. That is another aspect. And, my lord, delay of 30 days is there, my lord. That is another one. Lord, the other ground is, my lord, the ingredients are not attracted so far as 499 is concerned, my lord.
Why? You can call anybody this, is it?
No, not so, my lord. This is in the context of, my lord, case and counter case, and after thought, my lord, it has been filed. And, my lord, here there are few judgments, my lord. It says even calling merely by naming or calling something like this, my lord, does not attract, my lord, 499 unless, my lord, there is an intention to, my lord, defame.
All right, let's see. Yes.
And he is a habitual complainant, my lord. He has lodged many complaints, my lord, against so many people.
List on
he is a petition, my lord.
Senior counsel, so and so, and the council list on 19th for dictating orders.
Not only one
order subsisting shall continue till the next
one submission, my lord. There is one judgment we are relying upon, my lord. We placed on record, which says, my lord, politicians are, my lord, they should be thick-skinned. Yes, my lord. He is a, my lord, he claims a politician, social worker, my lord, and also,
Vinod Kumar is given